This lecture is presented by Target for IQ, mentored and guided by Successor. Hello and welcome everyone. If you're preparing for the Judicial Services PCS-J APO or aiming for a civil judge position, you are in exactly the right place.
Absolutely. We know you're deep in your preparations and the new criminal laws are probably at the top of your revision list.
And they should be. The landscape has completely changed. We're moving on from the old CRPC, the 1973 code.
That book is closed, yes. Today we're opening the new one, the Bharatiya Nagarik Suraksha Sanhita 2023, or as we'll call it, the Bnss.
Our goal today is very, very specific. We are doing a comprehensive slide-by-slide analysis of chapters 1 to 4.
And we need to be clear, this isn't just a summary. We're going deep into the Bear Act language, the conceptual changes, and most importantly,
the traps, the little details examiners love to use to catch you out.
Exactly. So get your notebooks ready, maybe have the Bear Act nearby, and let's get started.
Okay, let's bring up the first slide, the title slide. It definitely sets a certain tone.
It does, doesn't it? It's very authoritative. So what you're seeing on the screen is the title slide for the Bnss 2023.
And right there on the left, you've got the national emblem, the lion capital of Ashoka.
And that's not just decoration. It's placed there very deliberately to signify the sovereign power of the state. It's a visual reminder.
A reminder of what, exactly?
That criminal law is always the state versus the individual. The state is the prosecutor. So that emblem represents the full might of the state.
Got it. And next to it, the classic gavel on a law book, this one labeled Bnss 2023.
Right, signifying the transition. Old book closed, new book opened. And of course, you see the logo for Target for IQ, mentored by Successor.
Now let's look at the text itself. It reads, the Bharatiya Nagarik Suraksha Sanhita 2023, and then bill number 122 of 2023.
That bill number, I'd circle that.
Really? Is that likely to come up?
In a prelims paper, absolutely. Examiners love these little factual details to differentiate candidates. So if you see a question on the bill number, it's 122 for the Bnss. Lock that in.
Good tip. And below that, there's a green box. It says enactment focus, to consolidate and amend the law relating to criminal procedure.
Now, those words, consolidate and amend, are crucial. Why not just say amend?
I was wondering that. It sounds like legal jargon.
It is, but it has a specific meaning. The old CRPC from 1973 had been amended so many times it was becoming, a bit of a patchwork.
Like an old coat with too many patches.
Exactly. So to consolidate means you gather everything, all the old laws, all the amendments, all the Supreme Court judgments that interpreted the law, and you put them all into one single, unified, fresh code.
So it's not just a repair job, it's a complete rebuild.
It's a hard reset, a new foundation. That's the legislative intent behind using that specific phrase.
Okay, that makes sense. Let's move on to the next slide then. Section 1, extent and applicability.
Right, the very beginning of the act. And the visual here is a map of India.
And most of the country is in one color, beige, but the northeast region is highlighted in a darker orange shade.
That orange highlight is key. It's showing us the exception. So let's look at the text. First bullet point. The act applies to the whole of India.
And this is a change from the old CRPC, right? Which used to exclude Jammu and Kashmir.
Precisely. Post-2019, that's gone. Under Bnss, whole of India really means the whole of India, with one major exception, which is what that orange highlight is about.
Which is the next point. The exceptions, or the proviso, it does not apply to the state of Nagaland or the tribal areas.
Correct. But here's where it gets interesting. There's an exception to the exception. The slide notes, however, chapters 9, 11, and 12 apply to these areas.
Okay, so why those three specifically? Chapter 9, 11, and 12.
There's a clear logic to it. Chapter 9 deals with the maintenance of wives, children, and parents. That's a social welfare provision.
So justice in social matters should be universal, regardless of where you live.
Exactly. And chapters 11 and 12 are about preventive action of the police and information to the police, so filing FIRs, investigations.
Right. You can't have a lawless zone. The police still need the power to investigate a crime, even if the trial procedure might be governed by local customs.
That's the core idea. The investigation machinery remains uniform. And there's another layer of flexibility. The state government, say of Nagaland, can choose to apply other provisions later on by issuing a notification.
It's not an all-or-nothing system, then?
No, it allows for progressive adoption. Now look at the green box at the bottom, the definition of tribal areas.
It says, territories included in tribal areas of Assam immediately before 21st January 1972.
And right next to it is the red box, the trap alert. It warns Do not confuse the date. It is 1972, not 1950.
That's a classic examiner's trick. Our minds automatically go to 1950 or 1947 when we think about the Constitution.
And that's what they're counting on. As Satyendra Sir always emphasizes, this date, January 21st, 1972, is from the Northeastern Areas Reorganization Act. If you mark 1950 in an MCQ, you've just lost a mark.
And it also mentions excluding Shillong municipality.
Right, because Shillong is an urban center. It follows the regular law. The exception applies to the tribal territories around it, as defined in the 6th schedule.
So the key takeaway here, memorize the date, 1972, and the chapters that still apply, 9X, ELMs, and 12.
Memorize those Roman numerals 9, 11, and 12. It's a high probability question.
All right, moving to slide 3. This one looks very modern. We're seeing icons of a server, a smartphone, a video camera. We're talking about new digital definition.
Yes, Section 2. And this is a massive update. The old CRPC was written in 1973. It had no concept of the internet, of digital evidence.
It was a paper-based world.
Entirely. The Bnss is the first procedural code we've had that natively understands and defines these things. Let's look at the first one, Section 2A. Audio, video, electronic.
The slide says it includes video conferencing, recording of processes like identification and search and seizure, and electronic communication.
This is a huge deal for trial procedure. Lawyers used to spend hours arguing whether a witness appearing via video call was technically present in court.
Or if a raid recorded on a policeman's personal phone was valid evidence.
Exactly. Section 2A ends that debate. It codifies the process. Notice it explicitly says recording of search and seizure. Under Bnss, videographing the crime scene and seizure process is now formalized.
So that video file is no longer just a secondary piece of evidence.
It's primary to the procedure. It's defined in the law itself. Now look at the next one, Section 2F, electronic communication.
This definition seems incredibly broad. Communication of written, verbal, pictorial info, or video content transmitted via electronic devices.
It covers everything. WhatsApp messages, emails, photos, you name it. And it's designed to be future-proof, so the law doesn't become obsolete in 5 years when a new technology comes along.
And the yellow exam alert box drives the point home. These are new definitions, so expect direct questions.
For sure. They'll ask, under which section is audio-video electronic defined? You have to know it's 2A. It's the very first definition in the Act, which tells you how important digital evidence is in this new system.
Okay, let's go to the next slide, which deals with two very fundamental concepts: complaint versus police report.
And we have a classic visual here, the golden scales of justice. On one side, magistrate, complaint, and on the other, police report.
It visualizes the two different ways a criminal case can be set in motion.
Precisely. The private route versus the state route. Let's start with the left side, complaint, which is Section 2E.
The text describes it as an allegation, oral or written, made to a magistrate with a view to taking action.
So this is when you, as a private citizen, bypass the police station and go directly to the court. You tell the magistrate a crime has been committed.
It's not an FIR.
Absolutely not. An FIR is with the police. A complaint is with the magistrate. And notice the bold text excludes police report. In its primary definition, they are mutually exclusive.
And on the other side of the scale, we have police report, Section 2. This is the report the police forward to the magistrate under Section 12961.
Right. This is what we commonly call the charge sheet or challan. It's a final report after the investigation is complete.
So it seems pretty clear-cut. Private person goes to magistrate, that's a complaint. Police investigating report, that's a police report.
It seems that way, but the law loves its exceptions. And that brings us to the green box, the deeming provision.
It says a police report in a non-cognizable case is deemed to be a complaint, and the police officer is deemed the complainant. This sounds complicated.
Let's break down this deeming fiction. Imagine a police officer investigates what he thinks is a serious, cognizable offense, like a robbery. He does all the work, collects evidence, and files his report.
Okay.
But the magistrate looks at it and says, "Officer, based on the facts, this isn't a robbery. It's a minor, non-cognizable dispute. You shouldn't have investigated without my permission."
So is all that work wasted? Does the case just get thrown out?
No, and that's the beauty of this provision. The law says, okay, we won't waste the investigation. We will deem this police report to be a complaint. And since a complaint needs a complainant,
The police officer is deemed to be the one who complained.
you've got it. It transforms a police case into a complaint case to prevent a technicality from defeating justice.
But the red trap box reminds us of the general rule. A complaint does not include a police report.
That's the key. For an exam question, the default answer is they are separate. The deeming provision is a very specific exception.
This brings us to slide 5, which is labeled Successor's analysis. The visual is a fountain pen writing, so I assume we're talking about applying this for exams.
Exactly. As we teach at Target for IQ, knowing the section is just step 1. You need to know how to use it. The first point is a trend analysis.
It notes that examiners are shifting focus to those electronic evidence definitions we just talked about.
Yes, sections 2A and 2F. Be ready for a short note question in the mains exam on the digital definitions in Bnss.
The next point is a mains tip about the definition of investigation.
This is a golden rule. Investigation, under Section 2J, is the collection of evidence, and it is always conducted by a police officer or another authorized person. It is never conducted by a magistrate.
So if you write in your exam that the magistrate investigated, that's a fundamental error.
A huge blunder. A magistrate holds an inquiry or a trial. They weigh the evidence. They don't collect it.
The next common mistake listed is confusing inquiry with trial.
Right. Think of it like a timeline. The police investigate, then they file their report. The stage where the court first looks at that report before framing charges is the inquiry. The judge is asking, is there enough material to even proceed?
And only after that, if the answer is yes, does the trial begin.
Exactly. Inquiry is the judicial process that happens before the trial. The final point here is about interlinking definitions.
It connects warrant case with summons case.
And the dividing line is 2 years. A warrant case is for a serious offense, one punishable with death, life imprisonment, or a jail term of more than 2 years.
And a summons case is just anything that isn't a warrant case.
Simple as that. So if the punishment is 2 years or less, it's a summons case. More than 2 years, it's a warrant case. You have to memorize that 2-year threshold. It dictates the whole procedure that follows.
Okay, let's move into Chapter 2 of the Bnss. Slide 6 is on Section 6, the classes of criminal courts.
And we have a gold pyramid here showing the hierarchy. It's a very clear visual representation of the court structure.
At the top, we have the high courts. Below that, courts of session.
Then judicial magistrates of the first class, and below them, judicial magistrates of the second class. And at the very base of the pyramid, executive magistrates.
But the exam alert box in yellow points out something that's missing.
And this is probably the single biggest structural change in the court system under the Bnss. It says, note the specific exclusion of metropolitan magistrates which existed in CRPC.
So what does that mean in practice?
Under the old CRPC, big cities like Delhi, Mumbai, Kolkata, with over 1 million people, were designated metropolitan areas. And in those cities, the judges were called metropolitan magistrates, or MLAs.
I remember that, CMMs and MS.
Right. The Bnss completely abolishes that distinction. It unifies the system. Now, whether you're in a small village or a big city, the judge is a judicial magistrate first class. The title Metropolitan Magistrate is gone.
So mentioning it in an answer about the Bnss would be a mistake.
A major one. It shows you haven't updated your knowledge. This is a crucial point for anyone who studied the old law.
The green box also notes that this is besides the high courts.
Yes, that's just a constitutional point. The high courts are established by the Constitution itself, Article 214. The other courts in the pyramid are statutory courts created by this act, the Bnss.
Let's climb up that pyramid to the Court of Session on slide 7. The visual here is a large golden throne, signifying its importance.
It is the highest criminal court in the district, so the throne is fitting. Now let's break down the points on the slide.
First, the state government establishes court for every sessions division. But the next point says the High Court appoints the presiding judge.
And that distinction is the trap. Look at the red box at the bottom. The state gov establishes the court. The High Court appoints the judge. Don't swap them.
So how should we remember this?
Think of it this way. The state government, the executive branch, is like the builder. They provide the physical courthouse, the budget, the infrastructure. They create the post or the institution.
But the person who sits on that judicial throne
is chosen by the judiciary, the High Court. This maintains the separation of powers. The executive builds the court, the judiciary staffs it. Don't mix those two up.
The slide also talks about where the court holds its sittings.
Yes, Section 8, subsection 6. Ordinarily, it's at a place notified by the High Court, but there is a convenience rule.
It says the court can sit elsewhere in division with consent of prosecution and accused for witness examination.
Imagine a crucial witness is in a hospital and can't be moved, or a high-risk accused cannot be safely brought to the main court. The judge can temporarily move the court to the hospital or a secure facility.
But only under a specific condition.
a very specific one. Both the prosecution and the accused must consent. The judge can't just decide on their own to hold court somewhere else. It requires agreement from both sides.
Got it. Now, moving down the hierarchy, Slide 8 covers judicial magistrates.
Sections 9 to 11. The visual is a branching tree showing how the magistracy is structured within a district.
At the top of this branch is the CJM, the Chief Judicial Magistrate.
Correct. Under Section 10, the High Court appoints one JM first class to be the CJM for the district. He's the administrative head, the team leader for the other magistrates.
And there can also be an additional CJM and a subdivisional JM.
Yes, an additional CJM has all the same powers. A subdivisional JM is a JM first class who is given administrative charge of a specific subdivision or tehsil within the district.
Then the slide discusses special judicial magistrates under Section 11. Why would we need a special magistrate?
It's usually to handle a sudden surge of specific cases. Say, after a riot, you might have hundreds of accused persons, or a huge backlog of check-bouncing cases is clogging up the system.
So you bring in reinforcements.
Exactly. The government can request the High Court to appoint a special magistrate just for those cases. It's usually a retired judge or a government servant with a law degree.
And the term is very specific, not exceeding 1 year at a time.
It's a temporary appointment to clear a backlog. And the green bar clarifies that they are given the powers of a standard JM first or second class. They don't have extra powers, just a focused jurisdiction.
So how does the chain of command work? Slide 9 talks about the subordination of judicial magistrates.
Section 13, and the visual here is a vertical flow chart. It's all about who reports to whom.
The chart shows the judicial magistrates at the bottom reporting up to the chief judicial magistrate,
Who in turn reports up to the sessions judge at the top. It's a clear chain of command.
But the red trap box adds a nuance. It says, every judicial magistrate is subordinate to the CJM, subject to the general control of the sessions judge.
That phrase, subject to the general control, is important for Maine's answers. Think of it this way. The CJM is the immediate boss. He handles the day-to-day stuff, like distributing cases among the other magistrates.
He makes the daily roster.
Yes, but the sessions judge is the big boss of the district. He has overall supervisory control. He doesn't manage the daily work, but he oversees the entire judicial machinery in the district.
Okay, that clarifies the difference between direct subordination and general control.
Precisely.
Now, slide 10 takes us out of the judiciary and into the executive branch with executive magistrates.
Sections 14 to 17. And the visual is a government building, like a collector's office, because these officials are part of the district administration.
And as you guide students at Target for IQ, I imagine understanding this distinction is crucial.
It is. A judge constantly interacts with and reviews orders from these executive magistrates. So the first point is key. Appointments are made by the state government.
Not the High Court.
Not the High Court. That's the separation of powers again. The state government appoints the district magistrate, or DM, the ADM, and the subdivisional magistrate, or SDM.
These are the officials who handle law and order, things like Section 144 curfews.
Exactly, and there's a special provision under 14.6 that's very relevant for urban areas. The state government can give executive magistrate powers to a commissioner of police.
So in big cities, the police commissioner can issue those law and order directives themselves.
Yes, it integrates the functions. And in terms of subordination, it's simple. All executive magistrates in the district are subordinate to the DM. The DM is the head of the district administration.
So the exam alert here is a reminder. State government appoints the DM, High Court appoints the CJM. Don't mix them up.
You get that wrong, you've missed a fundamental principle of the Constitution.
Let's move to slide 11, section 18, which is about public prosecutors. The visual is a lawyer's black robe.
The public prosecutor, or PP, is the lawyer who represents the state in a criminal case. Remember, it's the state versus the accused.
So what are the eligibility requirements? The slide has a table.
For a PP in the High Court or the District Court, the magic number is 7 years of practice as an advocate.
7 years. What about a special PP?
For a special public prosecutor who is appointed for a specific, usually high-profile case, the requirement is higher. 10 years of practice. The logic is that for more complex cases, you need a more experienced lawyer.
The slide also mentions a panel that's prepared. What's that about?
That's a crucial check and balance. The district magistrate prepares a list, a panel, of eligible lawyers, but he must do it in consultation with the sessions judge.
So the judiciary gets to vet the candidates that the executive wants to appoint.
Exactly. The sessions judge essentially signs off on the list, ensuring that the lawyers on it are competent and fit to be prosecutors. It prevents purely political appointments.
And there's a grain note here about the victim's rights.
This is a very important victim-centric reform. The court can permit the victim to hire their own private lawyer to assist the prosecution.
So the private lawyer doesn't take over the case?
No, and the word assist is key. The PP is still the captain of the ship, leading the case for the state, but the victim's lawyer can provide support, submit written arguments, and ensure the victim's perspective is fully represented.
That seems like a significant step forward. Now, slide 12 introduces the Directorate of Prosecution.
Section 20. This is an organizational structure, a flow chart designed to professionalize and monitor the prosecution system.
At the top is the Director of Prosecution. What's the eligibility for that post?
It's a very senior position. You need 15 years of practice as a lawyer, or you must have been a sessions judge.
15 years. And below the director?
You have deputy directors with the same eligibility, and then assistant directors. For an assistant director, the requirement is 7 years of practice.
And their functions are divided based on the seriousness of the crime.
That's right. The director personally monitors the most serious cases, those punishable with 10 years or more, life imprisonment, or death. The deputy and assistant directors handle cases with lesser sentences. It's a system of tiered supervision.
So the exam alert is straightforward.
Yeah.
Memorize the numbers. 15 years for the director, 7 for the assistant.
Yes, don't confuse the two.
On to slide 13, another Satendra Sir's analysis slide. This one is about the constitution of courts.
Right, connecting the dots again. The
Yep.
first point links the appointment process back to the Constitution.
The separation of powers. JM appointments by the High Court, EM appointments by the state government.
And you should absolutely mention Article 50 of the Constitution in your mains answer on this topic. It's the directive principle that mandates the separation of the judiciary from the executive.
The next point is about a common mains question. Discuss the subordination of criminal courts.
If you get that question, you must discuss both hierarchies. You need to cite Section 13 for the judicial side, with the sessions judge at the top, and Section 17 for the executive side, with the DM at the top. Covering both is essential for full marks.
And the key shift, again, is the removal of metropolitan magistrates.
Yes. If a question asks you to compare the Bnss with the old CRPC, this is your headline. The abolition of the metropolitan cadre is a major reform aimed at creating a uniform system.
Great. Let's move on. Slide 14 brings us to the power to try offenses under Section 21.
This section tells us which court gets to hear which case. The general rule is that an offense is tried by the High Court, the Court of Session, or the court specified in the first schedule.
The first schedule being that big table at the back of the act.
Exactly. It's the directory. It tells you for any given crime, say theft, which court has the jurisdiction to try it.
But there's a special proviso on this slide concerning women.
A very important one. It says that for certain offenses against women under the new Bharatiya Nyaya Sanhita, or Bnss, and the green box clarifies these are sections related to rape and similar crimes.
What's the rule?
The trial must, as far as practicable, be conducted by a court presided over by a woman.
To make the victim more comfortable and to ensure a more sensitive trial process.
That's the clear intent. If a female judge is available, she must be assigned the case. It's a mandatory directory provision aimed at protecting the victim from re-traumatization.
Now we're getting to the teeth of the matter. Sentencing powers. Slide 15 covers the superior courts.
Section 22. And the visuals show a grand high court and a standard sessions court. First, the high court. The slide is very clear.
It says, it may pass any sentence authorized by law.
They have unlimited power. Death, life imprisonment, any amount of fine, whatever the law prescribes as the maximum, they can award it.
And for a sessions judge or additional sessions judge.
The same. They can also pass any sentence authorized by law, including the death penalty.
But there's a huge but here, highlighted in the red box.
And this is a fundamental safeguard in our legal system. Any sentence of death passed by a sessions judge is subject to confirmation by the High Court.
So the sessions judge can announce the death penalty, but it can't be carried out immediately.
Correct. The case file automatically goes to the High Court for review. A bench of at least 2 judges will re-examine the evidence. The execution can only happen if and when the High Court confirms the sentence.
It's a mandatory second look for the most serious punishment.
Yes. The law says taking a life is so grave that one judge's decision is not enough.
All right, now for the slide that you said will definitely be on the exam. Slide 16. Sentences for magistrates.
Section 23. And at Target for IQ, we tell students to memorize these numbers cold because they have all changed from the old CRPC.
Okay, let's go through them. First, the Chief Judicial Magistrate, the CJM.
The CJM can award imprisonment for up to 7 years. The fine can be any amount authorized by law, but they cannot give a death or life sentence.
7 years. Now, for the Judicial Magistrate First Class.
Imprisonment is up to 3 years. And the fine, this is the big change, is up to 50,000 rupees.
50,000. What was it under the old CRPC?
It was only 10,000, so that's a 5-fold increase. It's a huge jump.
And for the Judicial Magistrate Second Class?
Imprisonment up to 1 year, and the fine limit is now 10,000 rupees, up from 5,000 previously.
So the yellow alert box is not kidding. Memorize these new fine limits. 50,000 for JM First Class, 10,000 for JM Second Class.
It's almost a guaranteed MCQ. They will give you the old numbers as an option to trap you.
What happens if someone can't pay that fine? That brings us to slide 17, imprisonment in default of fine.
Section 24. The visual here is a calculator next to jail bars. If you don't pay the fine, the court can sentence you to extra jail time.
But there's a limit to that extra time, a formula.
Yes, and the key part of the formula is the 1/4 rule. The default imprisonment term shall not exceed 1/4 of the maximum term the magistrate is competent to inflict.
Okay, can you give an example? The slide has one.
Let's take the JM First Class. His maximum power to imprison is 3 years.
Which is 36 months.
Right, so it's 1/4 of 36 months, 9 months. So the maximum additional jail time a JM First Class can give you for not paying a fine is 9 months. It cannot be more than that 1/4 limit.
That's a very specific calculation they could ask about.
Absolutely. They love practical application questions based on these rules.
Speaking of calculations, slide 18 deals with consecutive sentences. The visual is a metal chain.
Right, linking sentences together. The default rule is that if you're convicted of, say, 2 different crimes in one trial, the sentences run consecutively one after the other.
So 3 years for crime A and 3 years for crime B means you serve a total of 6 years.
Correct, unless the judge specifically orders them to run concurrently at the same time, the default is back-to-back.
But there are limits to how long this chain can be.
Yes, 2 important limits. First, a hard cap. The total aggregate punishment cannot exceed 14 years. Second, a competency limit.
What's that?
The aggregate punishment cannot exceed twice the punishment the court is competent to inflict for a single offense. This is the 2x rule.
Okay, this sounds like we need another math problem. I see slide 20 is dedicated to this.
Yes, let's jump to that. It's a chalkboard with an equation. The scenario is, a JM First Class convicts someone for 2 offenses, each with a max of 3 years. Can he sentence the person to 6 years total, consecutively?
So his normal single offense power is only 3 years, but he wants to give 6 years.
Right. And the answer is yes, he can. Because of the 2x rule, his competency is 3 years. Twice that is 6 years. So the aggregate sentence of 6 years is perfectly legal for him to pass.
It's within his 2x limit and also well below the 14-year overall cap.
Exactly. But if he tried to give, say, 7 years total, that would be illegal because it exceeds his 6-year aggregate limit.
So the key takeaway is to practice both the 14th rule for default of fine and this 2x rule for consecutive sentences.
They are staples of the mains examination.
Got it. And just quickly going back to slide 19, that was about powers and successors.
Yes, sections 26 to 29. This is mostly administrative. The visual is 2 hands passing a baton, symbolizing continuity. It just means that powers are attached to the office, not the person. When a judge is transferred, the new judge takes over seamlessly.
And if there's any doubt about who the successor is, the sessions judge or CJM decides.
Correct. It ensures the courts never stop functioning because of a transfer.
All right, let's wrap up with the last couple of slides. Slide 21 is Chapter 4, Public Aid to Magistrates and Police.
This is about civic duty. The visual shows civilians helping a police officer. Section 31 is the core here.
It says the public is bound to assist when asked to help in an arrest or to prevent a breach of peace.
And the red trap box highlights that the duty is mandatory, not optional. If a police officer is making a lawful arrest and asks for your help, you are legally obligated to provide it.
And Section 33 says you must give information about certain serious offenses if you know about them.
Yes, for things like offenses against the state or murder plots. In these situations, silence is an offense in itself. You have a legal duty to report what you know.
And finally, slide 22, the final exam cheat sheet, a checklist.
This is the rapid-fire recall slide, a mental screenshot of the most important numbers we've discussed.
Let's run through them. Tribal areas date.
21st January 1972, not 1950.
JM first class fine limit.
50,000 rupees, not 10.
JM second class fine limit.
10,000 rupees, not 5.
PP eligibility.
7 years practice.
Director of Prosecution eligibility.
15 years practice.
And the 2 calculation rules.
Consecutive limit is 14 years, or 2x the court's competence. And default imprisonment for a fine is 14th of the court's competence.
If you know those 7 facts, you're in a much better position for the prelims.
Much better. These are the details that separate the top ranks.
Well, that was an incredibly detailed breakdown of the first 4 chapters of the Bnss.
We've covered the new extent and definitions, the new court hierarchy without metropolitan magistrates, and of course, the new sentencing powers.
This has been a comprehensive analysis presented by Target for IQ under the guidance of Jharkhand.
My advice to all of you listening is to go back now and read these Bare Act sections yourself. And please, practice those sentence calculation problems.
Absolutely. We wish you the very best in your preparation. Keep learning, keep revising.
John.
Let's understand the next point from here. If you are sitting there with your Bare Act open, wondering how the machinery of justice actually moves, how, a piece of paper turns into an arrest, or how a summons travels digitally, you are in the exact right place.
Precisely. We're moving beyond the theoretical what is crime and getting into the real nuts and bolts, the practical how is law enforced.
We're diving deep into the Bharatiya Nagarik Suraksha Sanhita, the Bnss. And specifically, we're covering a massive, massive chunk of procedural law today.
A really foundational part. We're looking at sections 28 through 94.
And to set the context right away, we are approaching this as senior judiciary faculty associated with Target for IQ and working under the guidance of Jharkhand.
Absolutely. This session is designed for the serious aspirant. So if you're aiming for PCS-J, APO, or the civil judge exams, these sections are, well, they're the bread and butter of your prelims and mains papers.
And our promise to you is this. We are going to go slide by slide. We will cover every single bullet point, every visual, and most importantly, every exam trap. No skipping.
Not a single word. So let's get right into it.
Okay, let's bring up slide 1, which is our title slide.
The visual here really sets the tone for our entire discussion today. We see a classic library setting. There's this green banker's lamp casting a very focused light.
Right.
And right in the center, dominating the whole frame, you have the scales of justice.
It's a classic image. We've all seen it. But in the context of sections 28 to 94, it has a very, very specific meaning. I mean, what are we really balancing here?
That's the crucial question. We are balancing state power against individual liberty.
Okay.
On one side of that scale, you have the state's power to arrest, its power to compel appearance, to attach property. On the other side, you have the fundamental rights of the citizen.
And the books in the background.
The books represent the depth of legal knowledge, the procedure that's required to keep that balance. If the police arrest procedure is flawed, the scale tips, and, well, justice fails. It's that simple.
The title on the slide reads, Powers, Arrest, and Processes to Compel Appearance.
And the subtitle, of course, Bharatiya Nagarik Suraksha Sanhita, Bnss, Procedural Analysis, Sections 2894.
You called this the heart of the procedural code earlier. Why that specific word?
Because if this part of the system fails, the whole body collapses. I mean, think about it. If the police don't follow the steps we're about to discuss, if they mess up the arrest memo, if they serve the summons incorrectly, the entire trial can be vitiated.
So it falls apart before it even really begins.
Exactly. It's the foundation upon which everything else is built.
All right, let's turn to slide 2. This one is titled Withdrawal of Powers and Successor in Office, and it covers sections 28 and 29. The image here is quite evocative. It shows a scepter or maybe a baton being passed from one hand to another.
That baton is the perfect symbol. It represents authority, power. It's a visual metaphor for the concept of a successor in office.
But before we get to passing the power, the slide first talks about taking it back.
Right. Look at the flowchart on the left side of the slide. It's for section 28, hierarchy of withdrawal.
The flowchart is split into 2 very clear tiers. Tier 1 shows the High Court state government.
And the arrow from that tier points to the text. They can withdraw powers conferred by them. Sec 28.1. The principle here is just so simple and logical.
What's the principle?
You can only take back what you gave. I mean, if the state government gave a magistrate special powers, for example, only the state government can withdraw them. The CJM can't.
Okay, that makes sense. And Tier 2 in the flowchart shows the Chief Judicial Magistrate. CJM,
Mhm.
or the district magistrate.
And it's the exact same logic. They can withdraw powers conferred by them, and that's under Section 28, subsection 2.
So for our students, what's the core teaching point here? What's the takeaway?
The teaching point is hierarchy. It's all about jurisdiction. A CJM cannot wake up one morning and decide to withdraw powers that were granted by the High Court. That would be a complete jurisdictional error.
You have to respect the source of the power.
You must. That's the essence of Section 28.
Now, let's look at the other part of the slide, Section 29, Successor in Office. The text on the slide reads, powers and duties constitute a continuum. If doubt arises, the successor is determined by written order.
Continuum is the key word there. You should highlight that in your notes.
Continuum.
Yes. The office, say that the office of the district judge, is permanent. The person holding it is temporary. So if Judge A retires today and Judge B joins tomorrow, Judge B steps right into Judge A's shoes immediately. The legal authority doesn't just pause for a coffee break. The work continues.
Right. But what happens if there's confusion? Who decides who the successor is?
Now you're getting to the exam question. Look at the key box analysis at the bottom of the slide. This is where they trap you.
The fact is simple enough. A successor exercises the same powers as the predecessor.
Easy enough.
Yeah.
But now look at the trap. This is critical.
Okay, the trap reads, a sessions judge determines successor for judges, but the CJM determines it for magistrates.
And that is a classic prelims trap. They'll give you a scenario and ask who has the power to decide. If there's a dispute about who the successor is, let's say a court's jurisdiction has been altered or something, you need to know who the deciding authority is.
So for assistant sessions judges, it's the sessions judge.
Correct. That's under Section 29, subsection 3. But if you are dealing with a controversy regarding magistrates, the power goes to the CJM. That's Section 29, subsection 2.
And the exam alert on the slide is practically flashing in red letters. Memorize Section 29.2 versus 29.3.
Do not mix them up. Sessions judge for judges, CJM for magistrates. It's a simple binary, but under exam pressure, it's easy to get it wrong.
Got it. Okay, moving on to slide 3. Public duty to assist, which covers sections 31, 33, and 34. The slide uses 3 simple gold icons here, a shield, a chat bubble, and a document.
And these aren't just decorative clip art. They represent the 3 fundamental modes of public duty that the Bnss talks about. The shield represents prevention.
Okay.
The chat bubble represents giving information. And the document represents formal reporting.
Let's start with the shield then. Section 31, bound to assist. The slide says the public must assist the magistrate or police if it's reasonably demanded.
Must is the operative word. This is a mandatory provision. You can't just be a bystander and walk away. And the slide lists 3 very specific conditions where this duty kicks in.
Right. Number 1 is taking or preventing the escape of an offender.
Number 2 is the prevention of a breach of the peace.
And number 3, prevention of injury to public property.
Yeah.
Like, say, vandalism.
Exactly. So let's take your example from earlier. A police officer is chasing a thief past your house and yells, "Stop him." What does Section 31 say?
It makes it my legal duty to intervene, to assist.
Yes, unless, of course, you have a reasonable excuse, like you're physically incapable, you have a broken leg or something. But otherwise, you are bound to assist. Apathy is not an option under the law.
Next up is the chat bubble icon. Section 33, duty to give information. The text says this is mandatory for specific offenses.
And please note that word specific. This isn't about reporting every minor argument you overhear. The section lists serious offenses, things against public tranquility, against life, coin and currency counterfeiting, and so on.
So if you have credible information about a murder plot or a major counterfeiting ring, silence is not an option. You have a legal duty to inform.
You do.
Yeah.
And look at the key box analysis. This is an interesting point. The fact is, the burden of proving a reasonable excuse for not helping lies on the person. Sec 33.
So it's a reverse onus.
It completely shifts the burden. If you're charged under this section for not giving information, you have to stand up in court and prove why you had a reasonable excuse for not doing so. The prosecution doesn't have to prove you could have. It's a very strong provision.
And the exam alert points us to Section 34. This covers village officers and residents.
This is a favorite area for state-level administrative questions. Village officers, like the village headman, have a higher, more specific duty.
What do they have to do?
They must report specific threats. Things like the presence of thugs, robbers, or any proclaimed offender who might be hiding in their village. They're considered the eyes and ears of the district administration in rural areas.
Okay, that's clear. Now for a really critical slide. Slide 4, the title is Power to Arrest Without Warrant, Sec 35. And I see our branding here. As we teach at Target for IQ, understanding this arrest matrix is absolutely non-negotiable.
It is the core of police powers and one of the most significant changes in the Bnss. The visual here is the arrest matrix, a flowchart that splits the screen. On one side, we have a notice document, on the other, a pair of handcuffs.
And that visual perfectly represents the major reform, this philosophical shift in the law, doesn't it?
It really does. So let's break down the matrix. The first branch is scenario A. Imprisonment is less than 7 years. The rule here has completely shifted. Under the old code, arrest was almost automatic. Now, the slide is very clear. Arrest only if conditions are met and AD reasons are recorded. The conditions are things like preventing a further offense, ensuring proper investigation, or preventing tampering with evidence.
So for a vast number of crimes, the default position is now to issue a notice, not to immediately slap on the handcuffs.
Correct. Arrest is now the exception, not the rule for these offenses. And critically, the officer must record the reasons for the arrest in writing. It can't be arbitrary.
Okay, then we have scenario B. Imprisonment is more than 7 years, or it's a death penalty case.
Here, the handcuffs come out much more readily. The rule is simpler and gives more discretion to the police. It's credible information plus reason to believe arrest.
Because the crime is so severe, the law gives wider latitude.
Precisely. The risk of the accused absconding or committing another serious crime is much higher.
Now, the key box analysis has a very important fact. Police must record reasons in writing for making an arrest or for not making an arrest.
This is a check and balance on both sides. It creates a paper trail, which leads to accountability. You have to justify your decision either way. You can't just ignore a complaint, and you can't just arrest without cause.
And the trap here is crucial for students. It says, for offenses less than 7 years, reasonable suspicion alone is not enough. The officer must be satisfied with the necessity clauses.
Students miss this nuance all the time. Let's be very clear. I had a reasonable suspicion might be enough to justify an arrest for a murder case under Section 35(1).
But not for a minor theft.
Exactly. It does not work for a minor theft, which falls under Section 35(2). For these less severe crimes, you need suspicion plus a documented necessity to arrest. For example, you have to be satisfied that the accused will run away, or that they will destroy evidence if not arrested.
Got it. And the exam alert reminds us. This section replaces the old Section 41 of the CRPC. It is absolutely vital for mains problem-based questions.
If you get a hypothetical problem in your mains exam about an illegal arrest, your answer must start with a detailed analysis of Section 35.
That leads us perfectly into Slide 5, which is a continuation. Notice of appearance, Section 35(3)(7. And the visual is a piece of parchment paper stamped with the word notice in big red letters.
This is the legal substitute for arrest that we were just talking about. This is the default option for those less than 7-year offenses. The slide outlines the procedure in 4 simple steps.
Okay, step 1. Police issue a notice to the accused to appear at a certain time and place.
Step 2. It is the legal duty of that person to comply with the notice.
And step 3 is the big one. If the person complies, no arrest.
That's the incentive. That's the get-out-of-jail-free card, so to speak. If you cooperate and show up as required, you stay free. But the police can change their opinion later if new facts emerge, but again, they have to record reasons for it.
And what if they don't comply? Step 4?
Failure to comply with the notice, or even failure to properly identify yourself, gives the police the power to arrest. That's under Section 35, subsection 6.
Now, there's a very important part of this section highlighted on the slide, Section 35(7). The slide calls this special protection.
And it is special. This is a new, very humanitarian provision in the Bnss that everyone should be aware of. The text reads, and I'll quote it clearly, infirm persons or those over 60 years of age involved in offenses punishable with less than 3 years cannot be arrested without the prior permission of the Deputy Superintendent of Police, DSP.
And you should highlight that rank. It's not the inspector, not the SHO, the DSP.
Correct. The law wants a more senior supervisory officer to apply their mind and check for any potential bias or unnecessary hardship before an elderly person is arrested for a minor offense.
But as always, there's a massive trap in the key box. It says, the protection for those over 60 only applies if the offense is punishable with less than 3 years.
This is a crucial distinction. It's a 2-part test. Age over 60, 80, punishment under 3 years. If a 70-year-old is accused of murder or even a serious fraud that's punishable by, say, 5 years, this Section 35(7) protection does not apply at all.
They can be arrested immediately, just like anyone else.
Exactly.
And the exam alert nails it. Section 35(7) is a high probability topic for MCQs because it has those specific details: a specific age, 60, a specific punishment period, less than 3 years, and a specific rank, DSP. Perfect for an MCQ.
Absolutely. Memorize those 3 components.
All right, let's move to slide 6. Memorandum of Arrest and Rights, Sec. 364147. The visual here is a clipboard with a document titled Memorandum of Arrest.
This piece of paper, this documentation, is the citizen's shield against illegal detention and custodial abuse. The requirements under Section 36 are listed very clearly on the slide.
Okay, first requirement. The arresting officer must bear visible, clear, and accurate identification. A name tag, their rank. No anonymous police.
You have the right to know who is arresting you. The second requirement is the memorandum of arrest itself.
And it has 2 key components. It must be attested by a witness.
And that witness can be a family member of the person being arrested, or if no family member is available, a respectable member of the locality where the arrest is made.
And it must be countersigned by the arrestee.
Yes. The person being arrested has to sign it too, confirming the time and date of arrest.
What's the third requirement listed?
The right to inform. The police have a duty to inform a relative or a friend of the arrestee about the arrest and the place of detention, unless, of course, the memorandum was already attested by a family member.
The slide also briefly mentions Section 41. What's that about?
That's arrest by magistrate. It just clarifies that any magistrate, whether executive or judicial, can personally arrest someone for an offense committed in their presence within their local jurisdiction.
Okay, let's look at the key box analysis. The fact is, Sec. 47 requires police to forthwith communicate full particulars of the offense to the arrestee.
Forthwith, meaning immediately. You have a right to know why you are being handcuffed, what are the grounds, what is the offense.
The trap is interesting. A magistrate can arrest for an offense committed in their presence, but it is subject to bail provisions. They aren't above the law regarding bail.
Exactly. Just because a judge arrests you personally doesn't mean you lose your right to seek bail. The regular bail procedures will still apply.
And the exam alert here is absolutely critical. It says, failure to prepare the memorandum, Sec. 36, vitiates safeguards. And it specifically says we must mention the DK Basu guidelines.
We must. For your mains answer, this is a golden point. Section 36 is the statutory implementation, the codification, of the landmark Supreme Court judgment in DK Basu versus State of West Bengal.
So you have to link them.
You must link Section 36 to DK Basu. It shows the examiner you understand the history and the constitutional underpinning of these rights.
Great point. Now, slide 7 covers private arrest and mode of arrest, section 40, 42, 43.
Yeah.
The image here shows a pair of hands held up and a badge that says stop.
This is the so-called citizen's arrest. Section 40 lays down the very limited circumstances in which a private person can make an arrest.
And what are they?
There are 2 main conditions. First, if a non-bailable and a cognizable offense is committed in their presence.
Both conditions have to be met. Non-bailable and cognizable.
Yes. Or the second condition is if the person they're trying to arrest is a proclaimed offender.
And there's a big constraint mentioned. Must hand over to police in less than 6 hours.
Right. You cannot keep the person in your private custody. You make the arrest and immediately, without unnecessary delay, hand them over to the nearest police officer or take them to the police station. The 6-hour limit is an outer limit to account for travel from remote areas.
Then the slide moves to section 43, mode of arrest. It says, touch or confine body, unless submission by word of action.
This means if a person says, I surrender, and complies, you don't need to physically tackle them. But if they resist, the law allows for touching or confining the body to effect the arrest.
And there's a special provision for women.
A very important one. The law presumes a woman's submission to custody on oral intimation. A male police officer cannot touch the person of a woman while making an arrest. The arrest has to be made by a female officer.
Now, the key box trap here is critical. Private persons cannot arrest based on suspicion, only for offenses committed in their presence.
This is the biggest difference. A police officer can arrest on reasonable suspicion. You, as a private citizen, cannot. You have to have seen the non-bailable, cognizable offense happen with your own eyes.
And the exam alert is a classic question, Sec. 43.5. No woman shall be arrested after sunset and before sunrise.
Except in exceptional circumstances, and then only with the prior permission of the judicial magistrate of the first class, JMFC.
Note the rank again, JMFC. Not an executive magistrate, not a tehsildar. It has to be a judicial magistrate of the first class.
This is a frequently tested question. Make sure you remember the rank.
Okay, let's look at slide 8. This is a very specific, very new provision. Use of handcuffs, Sec
Yeah.
43.3. And the slide reminds us, under the guidance of Successor at Target for IQ, we emphasize this list because it's a completely new statutory provision.
Exactly. The visual shows a pair of handcuffs with a big restricted use sign over them. This is because the law now says handcuffing is no longer routine, it is an exception, and it's permitted only in specific cases.
And the slide provides the entire list.
It does. And for the exam, you need to be familiar with these categories. I'll read them out clearly. First, a habitual or a repeat offender who has escaped from custody. Second, a person accused of organized crime, a terrorist act, or drug-related crimes. Third, someone accused of illegal possession of firearms or ammunition.
Oh.
Then, the most serious crimes against the person: murder, rape, acid attack. Also, sexual offenses against children and human trafficking, offenses against the state, like sedition, and finally, economic offenses.
And that last one is the big trap highlighted in the key box. It says economic offenses are included in the list.
This is a really important point. Students often have this misconception that white-collar crime means no handcuffs. But the Bnss explicitly allows for it. So if someone is accused of a massive financial fraud, a major scam, the law permits them to be handcuffed.
That's a huge clarification. The examiner says this is a new explicit statutory list which replaces the earlier system of judicial discretion based on case law.
Correct. The law has now codified it, so you need to memorize these categories.
Let's turn to slide 9. Medical examination of accused, Sec 51, 52, 53. The visual is a medical cross intertwined with a DNA helix.
A perfect image. This is where science meets criminal procedure. To make this easy to understand, the slide uses a comparison table to differentiate the three key sections.
Okay, let's go through it. First is Sec 51, general.
This is on the request of a police officer, not below the rank of sub-inspector. The examination is done by a registered medical practitioner, RMP, and the purpose is straightforward: to find evidence.
Next is Sec 52, rape accused.
This is more specific. The request is again from a police officer, SI or above. The examination must be done by a government or local authority, RMP, and the report is very detailed. It includes DNA profiling material, evidence of injuries, age of the accused, etc.
And the third one is Sec 53, mandatory.
This one is different. It's not about finding evidence for the prosecution. This is a right of the accused. The examination is done by a medical officer or RMP soon after the arrest to document the health and any injuries on the accused's body.
So, Section 53 is the crucial check against police torture or custodial violence. It creates a record of the accused's condition before they go into lockup.
Precisely. The key box fact notes that the Sec 52 report for a rape accused must state precisely the reasons for each conclusion. You can't just say DNA matches. You need to explain the scientific basis.
And the exam alert is a powerful point. Sec 52.1 allows for the use of such force as is reasonably necessary for the examination.
Yes. An accused in a rape case cannot refuse to give a blood or DNA sample. The law allows for reasonable force to be used to collect that evidence.
Moving to slide 10, identification and safety, Sec 54, 55, 56. The visual is the classic silhouette of a police lineup.
Right. Sec 54 covers the test identification parade, or TIP. The slide says the court can direct an arrested person to subject himself to identification by any person or persons.
And the proviso here is critical.
Very. If the person who is supposed to identify the accused is mentally or physically disabled, the process changes. It must be supervised by a judicial magistrate.
Not just the police.
No, a JM must be present, and the entire process must be video recorded. This is a major safeguard to ensure fairness for vulnerable witnesses.
The slide also mentions Sec 56.
A simple but vital duty. The person who has custody of the accused, usually the police, has a legal duty to take reasonable care of the health and safety of the accused.
And the exam alert brings up Section 55. What's the trap here?
Section 55 allows a senior police officer to depute a subordinate officer to make a warrantless arrest on their behalf. But the trap is that this deputation must be done via a written order.
So a verbal command from a senior isn't enough.
Not legally. The junior officer needs that piece of paper, that written order, specifying the person to be arrested and the offense. It's their legal protection.
Got it. Now, slide 11, a cornerstone of constitutional law, the 24-hour rule, Sec 57, 58. The visual is a gold clock with its hand stopped just before the 24-hour move, pointing to a magistrate icon.
It's a fundamental right, enshrined in our Constitution and codified here. Section 58 is very clear. No police officer shall detain in custody a person arrested without a warrant for a longer period than is reasonable under all the circumstances.
And the law defines that reasonable period with a maximum limit.
Exactly. 24 hours.
But there is a very, very crucial exclusion mentioned on the slide, one that's often tested.
Yes. The 24-hour period excludes the time necessary for the journey from the place of arrest to the magistrate's court.
So if someone is arrested in a remote village and the travel to the nearest court takes 6 hours?
Then the police effectively have 24 plus 6, so 30 hours, to produce them before the magistrate.
The key box trap is another interesting point. Police cannot just discharge an arrested person on their own.
Right. Once you are arrested and in the system, the police can't just say, oops, our mistake, you can go home. The release has to be on a bond, on bail, or on the special order of a magistrate.
And the exam alert reminds us that this section directly aligns with Article 22 of the Constitution of India.
It's the procedural manifestation of that fundamental right.
Okay, that was a lot on arrest. Slide 12 shifts gears a bit. It's titled Analysis, Arrest in Custody, Main Strategy. The image is an open book with a yellow highlighter, which seems appropriate.
Yes. This slide is specifically for our students preparing for their mains exam. It's about how to structure your answers.
So it gives an example. If the question is, discuss the rights of an arrested person.
Then your strategy should be to link multiple sections together. Don't just list them, weave them into a coherent answer. You should talk about Sec 36, the memo, Sec 47, right to be informed of grounds, Sec 56, right to health and safety, and Sec 58, the 24-hour rule.
And if the question is, when can police arrest without a warrant?
Then your answer needs to show strict adherence to the conditions laid out in Section 35. You have to explain the arrest matrix, the difference between offenses punishable with less than and more than 7 years.
The slide also lists some common mistakes to avoid.
Yes. First, confusing Section 51, which is for collecting evidence, with Section 53, which is about protecting the accused's health. Second, completely forgetting to mention the new statutory handcuffing list in Section 43.
And the key concept to remember is that the procedure established by law under Article 21 is satisfied only by strict compliance with all these rules in Chapter 5.
The tip is a good one. Always mention the DK Basu principles when you're discussing arrest safeguards, even if the question doesn't ask for it directly. And the trap is a warning. Do not write the old CRPC section numbers in your exam. Use the new Bnss references or you will lose marks.
Excellent advice. Okay, let's move on to the next set of procedures. Slide 13, summons, form an electronic service, Section 6364. And I see the branding again. As we teach in our judiciary classes at Target for IQ, the law is modernizing and you have to keep up.
You absolutely do. The visual here perfectly captures this modernization. It shows an old-fashioned scroll turning into an email, which has a digital seal on it.
So let's look at the form of summons under Section 63.
There are two parts. The first is the traditional form. 1. It must be in writing, in duplicate, signed by the presiding officer, and bear the seal of the court.
And the second part is the new addition.
Yes. Part 2 says a summons can also be an encrypted or other electronic communication that bears a digital image of the court's seal.
That image of the court seal is what makes it legally valid, right? It's the digital equivalent of the physical seal.
Precisely. Now, Section 64 covers service. The slide notes that service can be done by a police officer, an officer of the court, or another public servant. And look at the note about a digital register.
It says courts must now maintain a register of email addresses and phone numbers.
That's right. It's to facilitate this electronic service. The system is being built to support the new law.
Okay, what's the key box trap here?
It says, electronic service is subject to rules made by the state government. This is a key point. It's not a uniform central rule for the whole country. Each state will frame its own IT protocols and rules for how this will work in practice.
And the exam alert is clear. The very definition of a summons in the Bnss now explicitly includes encrypted electronic communication.
You might get a direct question on that.
Slide 14 continues this topic. Modes of service, Sec 65, 66, 67, 68. There's a flow chart showing a hierarchy. Corporation, family, saxing.
This flowchart shows the logical progression the serving officer must follow. You have to try these methods in order.
Okay, so step 1 is corporation, Sec is 65.
Right. If the summons is for a company, you serve it on the secretary, a local manager, or a director. You can also send it by registered post. And note the explanation. Company, for this purpose, also includes a society registered under the Societies Registration Act.
What if the summons is for an individual who can't be found? That's step 2.
That's Section 66. If you can't find the person after due diligence, you can serve the summons on any adult male member of the family residing with him.
Male member.
Ah, my mistake. The BNSS has updated this. It's now any adult member of the family. The gendered language is gone. Good catch. The key is adult and residing with him.
And this leads to the classic trap. A servant is not a member of the family for the purpose of Section 66.
Correct. You cannot just give the summons to the domestic help or the gardener. It has to be a family member.
And what if that fails too? No one is home. Step 3.
Service failed. Sec 67. Then, the serving officer must affix one of the duplicates of the summons to some conspicuous part of the house where the person ordinarily resides.
Like the front door.
The front door is the usual place. And finally, step 4, Goffed servant, Sec 68. If the person to be served is a government employee, the court can simply send the summons to the head of the office in which that person is employed.
And the head of office is then legally bound to serve it.
Yes, and return the duplicate with an endorsement. It's a much more efficient process for government servants.
Slide 15 deals with a common problem. Service outside jurisdiction, Sec 69, 70, 71. The visual is a map of India with house icons in different states connected by a dotted line.
A perfect visual for this. What happens when a court in Delhi needs to serve a summons on someone in Mumbai? That's what this covers.
So what's the process under Section 69?
The Delhi court won't send its own officer to Mumbai. Instead, it will send the summons in duplicate to a magistrate within whose local jurisdiction the person resides.
And then the Mumbai magistrate will get it served.
Exactly, as if it were a summons issued by their own court.
But how does the Delhi court get proof of service? That's Section 70.
Traditionally, the serving officer would submit an affidavit along with the endorsed duplicate. But look at the modern provision, Section 73. It deals with electronic proof.
What does it say?
It says an electronic summons is considered duly served. The court just needs to keep an attested copy of the electronic communication as proof of service. This is a game changer.
And the trap here points out that Section 71 applies specifically to witnesses.
Yes, Section 71 is a special provision just for witnesses. It allows a court to issue a summons by registered post or electronic communication, sometimes simultaneously with other methods, just to ensure the witness gets the notice. The system really wants witnesses to show up.
Okay, we've covered summons. Let's move up the ladder of compulsion. Slide 16, warrant of arrest, Section 72, 73. The visual is a scroll that says warrant of arrest, sealed with a red wax seal. Very official.
It has to be. A summons, as we've said, is an invitation. A warrant is a command. It's an order to the police to arrest a person and produce them before the court.
Let's look at the form under Section 72.
It must be in writing, signed by the presiding officer, and bear the seal of the court. Same as a summons in that respect, but the duration is completely different.
How so?
A summons is for a specific date. A warrant, the slide says, remains in force until it is executed or it is canceled by the court which issued it.
So a warrant has no expiry date?
None at all. It can remain pending for years. It lives forever until it's either executed or the court formally cancels it. That's a huge fact in the key box.
And what about a bailable warrant under Section 73?
This is a middle ground. The court, while issuing the warrant, may make an endorsement on it that if the person arrested executes a bond with sufficient sureties, they can be released from custody.
And the endorsement specifies everything?
Yes. The number of sureties, the amount of the bond, and the time they need to attend court.
And the trap here is the word may.
Exactly. Section 73 is discretionary. May, not mandatory, shall. The court does not have to make the warrant bailable. It's a choice based on the facts of the case.
All right, now for the execution. Slide 17. Execution of warrants. Section 75479. The image is a police badge and a silhouette.
This is about who carries out the order. The direction of the warrant under Section 74 is ordinarily to one or more police officers.
But it says if urgent mado police available to any person.
That's Section 75. In certain specific situations, like for an escaped convict, a proclaimed offender, or someone accused of a non-bailable offense who is evading arrest, the court can direct the warrant to any person, a private citizen, for execution.
And what's the geographic scope under Section 79?
This is very important. A warrant of arrest may be executed at any place in India.
So there are no state borders when it comes to executing a warrant?
None. A warrant issued by a court in Kanyakumari can be executed in Kashmir. This confirms the unified criminal justice jurisdiction across the country.
The key box trap has a point about private persons executing warrants.
Yes. If a private person executes a warrant under Section 75, they have the same duty as under private arrest. They must hand over the arrested person to the nearest police officer without unnecessary delay. They can't hold them in their own private custody.
That makes sense. Now for the tricky part, slide 18. Warrants outside jurisdiction, Sec 8082. And the note says, as taught by Successor, this flowchart is complex, but absolutely vital.
It is complex, but it's a common scenario. The visual shows a flowchart with arrows crossing a district border. This is the procedure when, say, the Delhi police goes to Mumbai to execute a warrant.
Okay, let's break down the flowchart. What's Method A?
Method A is the formal route. The Delhi court forwards the warrant to an executive magistrate or a DSP or a commissioner of police in Mumbai. That Mumbai official then endorses the warrant with their own name and gets it executed by their local police.
And Method B?
This is the more common, faster route under Section 81. The Delhi police officer takes the warrant directly to a local magistrate or the SHO of the local police station in Mumbai to get it endorsed.
But what if there's an emergency? What if getting that endorsement would cause a delay and allow the person to escape?
That's the provision in Section 81.3. In such an emergency, the police officer can execute the warrant without a local endorsement.
And once the arrest is made, what's the procedure?
They have to take the arrested person to the local magistrate or DSP unless the court that issued the warrant is less than 30 kilometers away.
Ah, the 30-kilometer rule. That's the exam alert.
Absolutely. Memorize the 30-kilometer rule in Section 82.1. If the original court is just across the border, say 25 kilometers away, you take the arrested person straight there. You don't need to bother the local magistrate in the other jurisdiction.
Very clear. Okay, what happens when even a warrant fails? Slide 19. Proclamation for absconding, Sec 84. The visual is a classic wanted poster pasted on a brick wall.
A perfect image. If a warrant can't be executed because the person is hiding, the court moves to the next level: public shaming and notice.
What are the conditions for issuing a proclamation?
2 conditions must be met. 1, the court must have reason to believe that the person has absconded or is concealing themselves. And 2, the warrant issued against them cannot be executed.
And the order itself?
The court will publish a written proclamation requiring that person to appear at a specified place and time, and that time must be not less than 30 days from the date of publishing the proclamation.
The slide lists the publication methods.
Yes, it has to be publicly read in the town or village where the person resides. It has to be affixed to their house and to the courthouse, and optionally, it can be published in a daily newspaper.
Now for the trap. This is a big one. It's the difference between a proclaimed person and a proclaimed offender.
A very subtle but crucial distinction. Under Section 84, a person can be declared a proclaimed offender only if they are accused of very serious offenses, those punishable with 10 years or more, life imprisonment or death, or certain other specified crimes.
So a person accused of a minor theft who is absconding is just a proclaimed person.
Correct. They are not a proclaimed offender in the legal sense of the term, and the consequences are different. Don't confuse the two.
In the exam alert, the 30-day period counts from the date of publication, not from the date the judge signs the order.
That's a common point of confusion. It's from the date it's made public.
And if the person still doesn't appear, slide 20. Attachment of property, Sec 85. The visual is a gavel smashing a house. Economic coercion.
That's exactly what it is. If public notice fails, the court attacks their financial interests. The timing is usually after the proclamation has been issued.
But there's a proviso for simultaneous attachment.
Yes. If the court has reason to believe, based on an affidavit or other evidence, that the person is about to dispose of their property or remove it from the court's jurisdiction, it can order attachment at the same time it issues the proclamation.
The methods can be seizure, appointing a receiver, or a prohibitory order. And the trap is about property in another district.
Right. To attach property that's outside the court's district, the attachment order must be endorsed by the district magistrate of the area where the property is located.
Okay, what if someone else has a claim on that property? Slide 21. Claims, objections, and restoration, Sec 87 to 89. The visual is a timeline arrow, 6 months minus 1 year minus 2 years.
This timeline is the key to understanding these sections. Let's break it down. First, 6 months. Any third party who has an interest in the attached property can file a claim or objection within 6 months from the date of the attachment.
Okay, what's the 1 year mark for?
If the court disallows that third party claim, that person then has 1 year from the date of the court's order to file a civil suit to establish their right to the property.
And the 2 years? That's for the absconder themselves.
Yes. If the proclaimed person appears voluntarily or is apprehended within 2 years from the date of the attachment, and they can prove to the court that they did not abscond to evade justice, the court will return their property.
But there's a trap here.
A huge one. The absconder has to prove 2 things. that they did not abscond or conceal themselves, and that they did not have notice of the proclamation. Both conditions must be met to get the property back.
Okay, a few more rules to wrap this up. Slide 22. Other rules for processes, Sec 9094. The visual is the bond scroll and a digital device, like a smartphone.
These are some miscellaneous but powerful provisions. Section 90 allows a court to issue a warrant in lieu of a summons.
When would they do that?
If the court has reason to believe the person won't obey the summons, or if they have already failed to appear on a prior summons, but the court must record its reasons in writing.
And Section 91, bond for appearance.
A very useful tool. A court can require any person who is present in the court to execute a bond with or without sureties for their appearance in that court on a future date.
And Section 94 is the modern one, summons to produce a document or thing.
Yes, and the law now clarifies that this includes communication devices, which are likely to contain digital evidence. So your phone, your laptop, your hard drive, they can all be summoned by the court as a thing or document.
That's a critical update. Okay, let's look at the final analysis slide. Slide 23. Analysis. Processes to compel, main strategy. The visual is a pyramid showing levels of compulsion.
This is a great way to summarize everything for a mains answer. The pyramid shows the escalating steps the law takes. At the base, the widest part is the summons. It's a polite invitation.
Level 2.
The warrant. It's a command, backed by the threat of force.
Level 3.
Proclamation. This is public shaming and legal notice.
And at the very top, the sharpest point is attachment.
That's the ultimate economic coercion to force appearance.
The tip on the slide is good. In mains, draw the timeline of restoration from Section 88 to score extra marks.
It shows you have a visual and clear understanding of the procedure. It's much better than a dense paragraph.
Finally, we come to slide 24. Final thoughts and mentorship. The visual is a gavel and a gook.
Yes. Let's reflect for a moment. There's a famous quote on the slide. Procedural law is the handmaid of justice, not its mistress.
What does that mean in this context?
It means all these rules we've discussed, from the arrest memo to the proclamation timeline, they exist for a reason. They exist to serve the ultimate goal of justice. They are not supposed to be obstacles or technicalities to block justice.
So mastering sections 28 to 94 is really about mastering that balance between state power and individual liberty.
That is the perfect summary. That is the entire goal.
So the final action item for our listeners today. Review the handcuffing list in Section 43 and the new rules on electronic summons in Section 63 today.
Do it today while all of this is fresh in your mind. Those are two of the most significant changes.
This deep dive was brought to you by Target for IQ under the guidance of Satendra Sir. Thank you for joining us. Keep revising those traps we highlighted, especially for your prelims.
Keep learning, keep revising. Jai Hind.
Let's understand the next point from here. Today, we're opening up a toolbox. But I don't want you to picture, a handyman's kit with a wrench and a screwdriver.
No, not that at all.
I want you to imagine you are a magistrate. You're sitting on the bench, high up in a courtroom, and you're carrying this massive weight of the state on your shoulders.
It's an immense responsibility. It's really the friction point where the theoretical power of the state meets the messy reality of human behavior.
Exactly. So the question we're asking today is, what tools do you actually have? Do you have a hammer to smash things open, a scalpel to dissect the evidence, a magnifying glass, or is it just a rubber stamp?
It's a great metaphor, and truthfully, the law gives you all of the above, provided you know where to look and, more importantly, how to use them. Today, we're doing a deep dive into the Bharatiya Nagarik Suraksha Sanhita, or the Bnss.
Which, for those who haven't quite memorized all the new acronyms yet, is the new procedural code that's replacing the old Code of Criminal Procedure, the CRPC, in India.
Correct. And specifically, we are dissecting sections 94 through 144.
Now, on paper, that sounds incredibly dry. Sections 94 to 144. It almost sounds like a catalog number from a library.
It does.
But we've been going through a really comprehensive visual breakdown of these statutes. Our source material for this deep dive is actually quite unique. It's a set of educational slides prepared specifically for judicial aspirants.
Right, from an organization called Target for IQ under the guidance of Satendra Sir.
And I think that context is really important because these materials are designed to teach future judges the actual skeleton of the law. So what we're looking at here isn't just a list of rules, it's a structural breakdown of the state's power.
It really is. It bridges that very murky gap between the investigation, What the police do on the street and the trial, what happens in the courtroom. It's the how.
We're calling this the magistrate's arsenal because that's really what it is. It's the entire range of weaponry available to the court to force the truth into the light.
And it's an arsenal that has been significantly, and I mean significantly, modernized with this new code. We aren't just talking about how to catch a thief anymore. We're talking about digital evidence, we're talking about international asset freezing, and even social justice.
So we've organized this discussion into 3 main branches to keep it structured, following the logic of the source material. First, compelling production, basically, how the law grabs documents, digital devices, and sometimes even people.
Right. The nuts and bolts of evidence collection.
Second, reciprocal arrangements, which is a very formal way of saying how we chase criminals and their assets across international borders.
Going global.
And third, preventive and social justice. That third one is the part that I think usually surprises people. It's not about punishing a crime that's already happened.
No, it's about the state stepping in to keep the peace, or in some cases ensuring a family doesn't starve. It's a completely different function of the law.
So let's unpack this. Let's start with branch 1, the power to compel. This covers Chapter 7 of the Bnss.
Right. And the fundamental question here is simple. The police know evidence exists. Maybe it's a file, maybe it's a laptop, maybe it's a murder weapon. How do they legally get their hands on it?
Let's set a scene to make this really concrete.
Yeah.
Imagine the police are investigating a complex fraud case. They know for a fact that a certain bank has a specific ledger, or perhaps a suspect has a laptop with a whole folder of incriminating emails. Can they just ask nicely, hey, can I see that?
Well, they can certainly ask nicely, but the law doesn't rely on politeness. If you want to build a case that's actually going to hold up in court, you need a process. You need a paper trail. And this starts with Section 94, the General Production Order.
Okay.
It's the most basic tool in the kit. The source material shows it as the first, simplest key on the key ring. And it's an order that can be issued by a court or, and this is important for investigations, an officer in charge of a police station.
So not just any cop on the beat. It has to be the station house officer, the SHO.
Exactly. Someone with authority. And they issue a written order. It's very binary, very direct. We need this document. We need this device. You are hereby ordered to bring it to us.
Okay, that seems pretty standard. It's a summons. Show up with the thing. But I want to drill down into a specific nuance that the source material highlights because it really stood out to me. They call it the postal trap in Section 95.
Ah, yes, the postal trap.
This genuinely surprised me, and I consider myself pretty well read on this stuff.
It catches a lot of law students off guard, too. That's precisely why it's highlighted as a trap in the educational material from Target for IQ. It's a legacy of how our legal system views the sanctity of the mail.
So let's walk through this trap. Imagine a police officer gets a solid tip. They believe a package containing illegal contraband, let's say it's drugs or maybe smuggled gold or even fake currency, is sitting right there at the local post office.
Okay.
The officer walks in, flashes their badge, slams a hand on the counter and says, I know you have a package from Mr. X. Hand it over right now.
And the postmaster, if they know the law, should rightly look at that officer and say, no.
No. Even if the officer knows it's there. Even if they have probable cause and everything.
That is the trap. Under Section 95, a police officer, even an SHO, cannot require the postal authority to deliver that parcel to them. The police officer has the power to tell the postal authority to detain it.
Okay, so distinguish those two for me. Detain versus deliver. What's the practical difference?
Detain means freeze this package. Don't let it leave the building. Don't deliver it to the addressee. Don't return it to the sender. It is now in legal limbo. But the police cannot take custody of it. They can't put it in their evidence bag and walk out the door.
And that seems like a massive bureaucratic hurdle. I mean, if the cop can't take it, who gets to actually open it? Who has that authority?
That power is reserved strictly for the judiciary and senior executive magistrates. Only a district magistrate, DM, a chief judicial magistrate, CJM, a court of session, or the high court can order the actual delivery of that postal item.
Why is that distinction so important? I mean, why not just let the cop take it if they've already identified it? What's the big picture reason for that extra step?
Privacy. It's all about privacy. Correspondence is considered a high-value private zone. Think about it historically. The mail was the only way people communicated privately over long distances. If any police officer could just seize mail on a whim, it would open the door to unchecked surveillance.
Right. You could intercept political strategies, personal love letters, legal defenses between a lawyer and a client.
Anything. The law requires a high-ranking judicial or administrative mind, a magistrate, to sign off on it before the state gets to read your mail. It's a check and balance. It's a safeguard.
So the police officer's role is just to freeze the situation. They find the package, tell the post office, don't move this. Then they have to run to the magistrate's court, explain the situation, get the formal order.
And then go back to the post office with that order to get the package. Precisely.
Oh.
It puts a crucial layer of judicial oversight between the police and your private communications.
Okay, so that's a summons asking for something. But let's be real. Suspects aren't always cooperative.
That's putting it mildly.
In fact, if I'm a criminal and I get a letter in the mail saying, please bring us the murder weapon, well, I'm probably not going to do that.
No, you're probably going to throw it in the nearest river.
Exactly.
Yeah.
So what happens if the suspect says, I don't have that document, or they just ignore the summons or actively hide the evidence?
Then we have to escalate. The system has to have more teeth. We move from a summons to a search warrant under Section 96. Think of it as upgrading from a polite knock on the door to, well, legally kicking the door down.
The source material outlines 3 specific conditions. It labels them conditions A, B, and C, where a court can issue a search warrant. It's not just a free-for-all. You need to fit into one of these boxes. What are the thresholds here?
Right. It's a structured decision. Condition A is basically non-compliance. This is exactly what you just described. The court has reason to believe the person would not produce the item even if they were summoned.
So they anticipate the refusal.
Yes, or they believe that if you ask for it, it will disappear. It's an anticipatory move. You have a reasonable belief that a summons will just act as a warning to the criminal to destroy the evidence.
Okay, that makes perfect sense. So what's condition B?
Condition B is about the unknown. The document or thing is not known to be in the possession of any specific person. You know the evidence exists, maybe the stolen royal jewels are somewhere in a specific apartment complex, but you don't know which specific tenant has them.
Ah, so you can't summon a specific person because you don't know who to summon.
Exactly. So you can't use Section 94. You need a warrant to search the general premises where you believe the item is located.
And condition C. This one sounds a bit broader.
It is. That's the catch-all. Condition C is when the court considers that a general search or inspection would serve the purpose of an inquiry or trial. It's a broad discretionary power. It's the court saying, look, we need to look through this entire area to find the truth, even if they aren't looking for one specific identifiable document. It's for situations where the contours of the evidence are still fuzzy.
But I have to circle back to the postal rule, because I have a feeling it's going to apply here too.
You have good instincts. It absolutely does.
Let me guess. Even with a powerful search warrant, the police can't just raid the post office and start tearing through bags of mail.
Precisely. The fortress remains. Even if you have a general search warrant, if the item you're looking for is in postal custody, only the district magistrate or the chief judicial magistrate can grant a warrant to search for it there.
So the sanctity of the mail is protected very, very fiercely in the Bnss structure.
Incredibly so. You cannot bypass that specific magisterial check just because you have a general search warrant for a location. That warrant doesn't magically unlock the post office doors unless a specific high-ranking magistrate says so. It's a separate, higher level of scrutiny.
It's just fascinating how that one institution, the post office, has such a fortress around it legally. It's a holdover from a different time, but it still has teeth.
It does, and it's one of those things that as we teach a target for IQ, aspirants often overlook. They see search warrant and assume it's a master key, but it's not. There are special locks, and the post office is one of them.
Let's move to something that feels a lot more modern. We're talking about Section 105. The source material calls this a game changer and refers to it as the digital shift.
This is, and I don't think it's an exaggeration, arguably one of the most significant updates in the new code compared to the old CRPC. We are talking about enforcing transparency in the search process through technology that is now commonplace.
We've all seen the trope in movies or heard the real-life horror stories where the police raid a house. It's chaotic, drawers are being pulled out, things are flying everywhere.
Total chaos.
And then, magically, a small packet of drugs appears on the coffee table. And the suspect screams, "The police planted that. That wasn't mine. I've never seen that before in my life."
That classic he said, she said dynamic has plagued the justice system for decades. It completely erodes trust. If the jury believes the suspect, a guilty person might go free. If the jury believes a corrupt officer, an innocent person goes to jail.
So how does Section 105 try to fix that?
It tries to fix it mechanically. It introduces a mandatory provision. It says that the process of search and seizure shall be recorded, not maybe, not should be, but shall be recorded through audio, video, electronic means.
And the source notes, preferably a cell phone, which is key.
Right. It acknowledges reality. Everyone has a high-definition camera in their pocket now. We don't need to wait for a specialized forensic film crew to arrive. The investigating officer has a smartphone. The entire search, from the moment they enter to the preparation of the seizure list where they write down every single item they took, has to be on video.
So literally the camera needs to be rolling as they open the drawer and find the gun.
Yes. Ideally, the video shows the officer entering the room. It shows the room in its original state. It shows them approaching the drawer, opening it, revealing the item, and then logging it. It captures the entire context. No jump cuts.
But here is where I get a little skeptical. Having a video is great, but digital files can be manipulated. We live in the age of AI and deepfakes. What's to stop an officer from editing the video or losing the footage if it doesn't look good for them, or just conveniently filming the parts they want and not the parts they don't?
That's a completely valid concern, and the Bnss attempts to plug that potential hole with a very important procedural safeguard. The source notes that the recording must be forwarded to the district magistrate, the subdivisional magistrate, or the judicial magistrate first class. And this is the key phrase, without delay.
Define without delay. Is that 24 hours? A week?
It means immediately, as soon as the operation is concluded. You can't keep the video on your personal or department phone for a week. By forcing the immediate transfer of the digital file to the magistrate, you create a chain of custody for the digital evidence itself.
So once it's logged with the magistrate's office, the police can't touch it. They can't edit it. It's logged in.
It's locked in. It protects the suspect from planted evidence, but, and this is an important point, it also protects the honest police officer from false accusations.
That's a fair point. If the body cam or the cell phone video clearly shows the suspect pulling a knife or trying to hide the drugs under a cushion, there's no argument later. It saves a lot of court time and protects officers who are doing their job correctly.
Exactly. And this works hand in glove with Section 103, which is an older provision that's been retained regarding witnesses.
Right. The respectable inhabitants rule. I love the phrasing of old laws. Respectable inhabitants. It sounds so Victorian.
It sounds quaint, but the principle is practical and sound. The search must be witnessed by 2 or more independent and respectable inhabitants of the locality. Not the officer's buddies, not informants, but neutral neighbors.
And the occupant of the place, the homeowner, has the right to be present.
Yes, they have the right to attend. They can't be kicked out of their own house while the search happens unless there's a serious officer safety issue. And crucially, they must receive a signed copy of the seizure list before the police leave the premises.
So they know exactly what was taken.
They know what was taken. It prevents things from disappearing from their house that aren't on the official list.
So you have the video, you have the independent witnesses, and you have the signed list given to the owner. It's a triangulation of truth.
Ideally, yes. It tightens the net on procedural misconduct from every angle. If the video, the testimony of the witnesses, and the seizure list don't all match up perfectly, the case for the prosecution starts to fall apart.
Let's pivot to some of the specific types of warrants, because the outline mentions some really dramatic scenarios. We have Section 97 for stolen property, which is straightforward. Then Section 100 for wrongful confinement, literally finding someone locked in a basement.
A very powerful tool for immediate rescue. It's a writ of habeas corpus in a more urgent, practical form for the police to execute.
But then we get to Sections 98 and 99 banning books.
The forfeiture of publications. It sounds archaic, doesn't it? Like something from the colonial era or a dystopian novel. But the state absolutely retains the power to ban books, newspapers, or any document it deems harmful.
How does that actually work in a modern democracy? Can a police officer just walk into a bookstore, decide a book is offensive, and start seizing it from the shelves?
Absolutely not. A single police officer has zero authority to make that kind of judgment call. This is a very high-level executive decision. The process, as laid out in the source flowchart, starts with step 1. The state government forms an opinion.
The entire state government?
Yes, the executive branch. They have to formally believe that the content of the publication violates specific pre-existing laws, usually things like sedition, obscenity, promoting enmity between groups, or threatening national integrity.
So it has to be more than just, we don't like the ideas in this book.
Yeah.
It has to be tied to a specific violation of the law.
Precisely. It has to be argued that the content is likely to incite violence or cause public disorder or threaten the integrity of the nation. It's a high bar.
So the state government says, this book is illegal. Then what happens? Does it just vanish?
Not quite. The next step is that they must issue a formal notification. And in that notification, they have to state the grounds for their opinion. They can't just say banned, they have to say why. We are banning this book because the passage on page 40 constitutes an incitement to violence under section XYZ of the Penal Code.
And once that notification is out,
Then the police can act, they can seize copies of the publication, and a magistrate can issue a warrant to search for them in warehouses, bookstores, and so on.
that sounds incredibly powerful. If the state government decides a book is seditious, is that the end of the story? Is there any way for an author or a publisher to fight back? Because, let's be honest, governments can be thin-skinned sometimes.
That is where Section 99 comes in, what the source material calls the safety valve. It's the judicial check on that executive power. If your book gets banned, you, as the aggrieved person, the author, the publisher, even a concerned reader, can apply to the High Court to have that ban set aside.
Is there a time limit on that?
Yes, and it's a strict one. You have 2 months from the date the ban was published in the official gazette. You have to act fast.
And the source mentions a specific exam detail here that's interesting regarding who in the High Court hears the case. This is crucial.
It is. This is a classic question for judiciary exams. The application cannot be heard by a single judge. It must be heard by a special bench of 3 judges. If the High Court has 3 or more judges, a 3-judge bench is mandatory.
Why 3? Why not just 1 judge, like in most cases?
Because banning a book is a direct, serious infringement on the freedom of speech and expression, a fundamental right. It cuts to the very heart of democracy. The law requires a consensus, or at least a majority vote, of 3 senior judicial minds to either uphold or overturn that ban.
So it prevents one ideologically biased judge from making a monumental decision that impacts the intellectual freedom of the entire society.
That's the entire philosophy behind it. It raises the bar for the state to justify its act of censorship. They have to convince not 1, but 3 judges. Under the guidance of Successor, we always emphasize that these procedural safeguards are just as important as the powers themselves.
It's a heavy safeguard. It's comforting to know that a politician can't just ban a book without eventually having to face 3 High Court judges.
Okay, let's follow the money. We're moving into Part 4, Seizure and Victim Relief. This covers Sections 106 and 107.
Follow the money is exactly the right phrase. Section 106 is the basic provision. It allows police to seize property that is suspected to be stolen or is found under circumstances which create suspicion of the commission of any offense. That's fairly standard police work.
Right.
But Section 107 is where the real innovation lies, especially in the context of the new Bnss. The source calls this the Robin Hood provision. I love that nickname, but is it accurate? I mean, Robin Hood stole from the rich to give to the poor.
Well, in this case, the law is taking from the criminal to give back to the victim, so it's pretty close. It fits the spirit. Section 107 specifically deals with the attachment of property that is derived from or used in criminal activity.
So let's create a scenario. You have a fraudster who ran a sophisticated crypto scam. He swindled 100 people out of their life savings.
A classic white-collar crime. Happens every single day.
And what does he do with the tens of millions he's stolen? He buys a luxury villa, a fleet of imported sports cars, designer watches. He's living the high life, while his victims are destitute, maybe lost their homes.
That's the part that drives people and the justice system crazy. It feels like the criminal is profiting while the victims suffer.
So how does Section 107 tackle this?
Okay, so under 107, the police have reason to believe that the villa and the cars are proceeds of crime. They can't just seize them. They have to get approval from a senior officer, a superintendent of police, or a commissioner, and then they apply to the court.
So there's a supervisory check.
Yes. Then the court issues a notice to the suspect, giving him 14 days to explain the source of the funds for that property. The burden of proof shifts. The notice effectively says, show us the receipts. Prove you bought this villa with legal, hard-earned money.
And what if the suspect sees the writing on the wall and just vanishes? Or he shows up but refuses to talk because he knows he can't prove it?
Then the court can pass what's called an ex parte order.
For those who skipped law school, define ex parte.
It means from one party, or for one side. The court can make a decision even if the other side, in this case the suspect, doesn't show up to defend themselves. If the suspect faces the court, the legal process doesn't grind to a halt. The court can attach the property immediately.
And why is that important?
It prevents the suspect from quickly selling the villa and wiring the cash to an offshore account while the trial is pending. It freezes the assets before they can disappear.
But here's the real Robin Hood part.
Yeah.
Section 107, subsections 6 and 7. This is what really caught my eye in the slides. This feels new and powerful.
This is the aha moment. Usually, when the state seizes criminal assets, where does that money go?
To the government treasury, the general consolidated fund of the state.
Exactly. It disappears into the giant pot of government funds. It helps the budget, sure, but it doesn't directly help the grandmother who lost her entire pension to that crypto scam. But under Section 107, the court can direct the district magistrate to take that attached property or the money from selling it at auction and ratably distribute it to the victims of that specific crime.
Ratably, meaning proportionally.
Yes. If the total fraud was $10 million and they only recovered $5 million from selling the villa, then every victim gets 50% of their lost money back. It's a direct reimbursement.
That is incredible. So instead of the money just going to the state as a fine, it actually goes back into the pockets of the people who were ripped off.
Precisely. And the timeline is tight. The source emphasizes a 60-day window for this distribution to be carried out. It's a direct legislated attempt to provide tangible victim relief. It's a paradigm shift that acknowledges that justice isn't just about putting the bad guy in jail. It's about trying to make the victim whole again.
However, looking at the notes here, there is a trap for students and practitioners regarding who does what. We talked about this earlier, the separation of powers.
Yes, the division of labor is key, and it's a very common exam question. The court, the judicial magistrate, is the one who orders the distribution. The judge makes the legal decision. Yes, these people were victims, and yes, they deserve this money.
But the judge doesn't actually handle the money.
No. The district magistrate, the executive, is the one who affects it. The DM is the one who actually handles the logistics, the bank transfers, the paperwork, the auctioning of the sports car. The judiciary decides. The executive executes.
That distinction is so important. It prevents the judges from getting bogged down in administrative tasks, becoming accountants and auctioneers.
And it keeps the executive branch from making judicial decisions about who is guilty or who deserves compensation. It respects the proper lane of each branch of government.
Now, crime doesn't stop at the border. We see this all the time with cybercrime, international financial fraud, cross-border smuggling. So, Part 5 of our deep dive looks at reciprocal arrangements in Chapter 8.
This is where the magistrate's arsenal goes global. We are dealing with contracting states, which is the legal term for countries that have signed mutual legal assistance treaties with India.
The source outlines something called letters of request in sections 112 and 113. It sounds very formal, very diplomatic. I am writing you a letter.
It is formal because it has to be. You are asking another sovereign nation to use their police force and their legal system for your benefit. It's a serious request. And we have two types, outbound requests and inbound requests.
Outbound is India asking for help.
Yes. An Indian court is overseeing a trial and needs an investigation done in London or New York. Maybe they need to interview a key witness who lives there or get certified bank records from a London-based bank. They issue a letter of request to the appropriate authority abroad. Inbound is simply the reverse. A foreign court asks India to help with an investigation here.
And who's the middleman in all this? Can a judge in Mumbai just email a judge in New York or pick up the phone?
Absolutely not. That would be a diplomatic and procedural disaster. Imagine a local judge trying to interpret complex international treaties on the fly. The central government, specifically the Ministry of Home Affairs, acts as the gatekeeper.
The single point of contact.
A single official channel. All of these requests flow through the central government to ensure they align with diplomatic protocols and don't create sovereignty issues. The judge sends it to the ministry, and the ministry formally transmits it to the foreign government.
The source also mentions international forfeiture in sections 115 to 117. This seems to be the international version of the Robin Hood provision we just discussed.
It is. It's about freezing assets abroad. If a court in India has reason to believe that property located in a foreign country was obtained from a crime committed in India, they can issue an attachment order. But there is a crucial timeline pressure here that the source highlights, specifically for a seizure under Section 117.
Section 117, right? What's the pressure?
Yes. If a police officer seizes property under this section, let's say they freeze a bank account that is linked to an international hawala transaction, that seizure order has no legal effect unless it is confirmed by the court within 30 days.
Only 30 days. Why that specific window? That's not a lot of time.
It's designed to prevent the indefinite freezing of assets without judicial oversight. Imagine the police freeze your business's main bank account because of a suspicion in an international investigation. You can't pay your employees, you can't pay your suppliers, your business grinds to a halt.
And then, silence. The police just leave it frozen while they investigate for 2 years.
That destroys a life. It destroys a business, potentially an innocent one. So the law says to the police, you have 30 days to go to a judge and convince them that this seizure is necessary and justified. If you can't, the freeze is automatically lifted. It forces the police to do their homework quickly. It puts a clock on the disruption to a citizen's life and property.
That's a vital protection. It's easy to forget that freezing assets isn't an abstract concept. It means stopping someone from buying groceries or making payroll.
Exactly.
Now let's shift gears completely. We've been talking about investigating crimes that have happened and seizing the assets from them. But Part 6 of the outline is about preventive justice.
This is where the entire mindset of the law shifts 180 degrees. We are no longer asking who committed the crime. We are now asking how do we stop a crime from happening in the first place? These are what we call quasi-criminal proceedings.
The source breaks this down into two main players with preventive powers, the judicial magistrate and the executive magistrate. Let's start with the judicial side, Section 125.
Right. Section 125 is about security for keeping the peace on conviction. The key phrase is on conviction. This happens after a trial has concluded. Let's say someone is convicted of assault or rioting or criminal intimidation. The court finds them guilty and sentences them to a fine or probation.
Okay.
But the judge looks at this person and thinks, this individual is angry, they're vindictive. The moment they walk out of this courtroom, they're going to go right back to causing trouble.
So the punishment for the past crime isn't enough to guarantee future good behavior.
Precisely. The punishment addresses the past. Section 125 addresses the future. At the time of sentencing, the judge can say, in addition to your sentence, you are also ordered to execute a bond.
A bond to keep the peace, a sort of good behavior contract.
Exactly. It's a financial guarantee. You will sign this bond for 50,000 rupees with or without sureties, guaranteeing you will keep the peace for the next 3 years. If you break the peace again, you forfeit this money. It hangs over their head like a financial sword of Damocles. It can last for up to 3 years.
Then we have the other side of the coin, the executive magistrate. The source calls their powers the preventive trio, sections 126, 127, and 128. These aren't for people who have been convicted of anything yet, right?
Correct. This is pure prevention. These are for potential threats to public order. These are incredibly powerful on-the-ground tools for maintaining public order. Section 126 deals with breach of peace. If an executive magistrate, like a subdivisional magistrate or SDM, receives information that someone is likely to commit a breach of the peace or disturb public tranquility, they can demand security from them.
Give me an example. Like if two rival groups in a town are gearing up for a big fight during a religious festival.
That is the classic example. The magistrate can haul in the leaders of both groups and say, each of you will sign a bond for 1 lakh rupees that your group will remain peaceful. If anyone from your side throws a single stone, you lose the money. It creates a very strong financial incentive for the leaders to control their followers.
And what about sections 127 and 128?
Section 127 is for disseminating seditious or obscene matter. It's about stopping the spread of inflammatory material that could cause riots or public outrage. And Section 128 is a bit more cloak and dagger. It's for suspects who are concealing their presence with the intent to commit a cognizable offense.
And cognizable means a serious offense where the police can arrest without a warrant.
Correct. We're talking about serious crimes. If the police find a known gang member with a history of bank robbery hiding in a warehouse at 2 a.m. with tools to break in, you don't wait for him to actually rob the bank. You use Section 128 to bind him over and prevent the crime from happening.
And what's the duration for these executive magistrate bonds? Is it also up to 3 years?
No, these are shorter. The maximum period is 1 year. The logic is that these immediate threats to public order are usually temporary or situational. You don't need to bind someone down for a decade. You just need to cool the situation down for the next few months.
But then there's Section 129 for habitual offenders. This sounds much more serious, much more long-term.
It is. This targets the career criminal. This is a distinction we really focus on in our judiciary classes at Target for IQ. We are not talking about a one-time hothead who gets into a fight. We are talking about habitual robbers, housebreakers, thieves, forgers, or people who habitually deal in stolen property or illicit drugs. The source describes them as individuals who are desperate and dangerous to the community.
So this is for the person whose job, for lack of a better word, is crime.
Yes, and because the threat they pose is habitual and ongoing, the leash is tighter and longer. The executive magistrate can demand security for good behavior from them for up to 3 years. It's significantly longer than the standard preventive trio because the risk isn't seen as situational, it's seen as being entrenched in the person's lifestyle and character.
Now, I saw something in the outline called the inquiry clock regarding sections 130 135. It says the inquiry must be completed within 6 months. Why is that provision there? What does it protect against?
This is a crucial civil liberty protection. I can't overstate its importance. Think about the power we just described. The state is dragging you into court, not because you did something wrong, but because they think you might do something wrong in the future. That is a very dangerous and easily abused power.
It's literally pre-crime. It's Minority Report territory.
Exactly. So imagine the state accuses you of being a habitual offender or likely to breach the peace. They start an inquiry, but then it just drags on. For years, you are living under this constant cloud of suspicion, constantly having to go to hearings. Maybe your travel is restricted, your reputation is ruined in the community, but they never actually prove anything or come to a conclusion.
Sounds like a form of harassment by the state.
It is harassment if it's open-ended, so the code puts a hard stop on it. The law says that if the inquiry into whether you are a threat isn't completed within 6 months from the date it began, the proceedings stand terminated. They are automatically dropped.
The state has to put up or shut up.
That's the perfect way to put it. They have 6 months to make their case. They can't keep an inquiry open indefinitely just to annoy you or control your life. It's a vital check on the misuse of preventative powers.
What happens if someone refuses to give the security? Say the magistrate orders a bond for 50,000 rupees and the person says, no, I refuse to sign it on principle. Or maybe just, I don't have the money.
Then they go to prison. That is the hard edge of preventive justice. You aren't in prison because you were convicted of a crime. You are in prison because you refused to provide a guarantee that you wouldn't commit one.
That feels like a very fine, almost philosophical line. You're jailing someone for non-compliance with a prevented order.
It is. But there is a nuance in the nature of imprisonment that the source points out, which softens it slightly depending on the reason for the bond. If you fail to give security for keeping the peace, that's the situational stuff, the public tranquility cases under Section 126, it is only simple imprisonment. But if you fail to give security for good behavior, that's for the habitual offenders under Section 129, the imprisonment can be rigorous.
So the law treats the career criminal much more harshly, even in the preventive stage, than the guy who just got into a heated political argument.
Yes, it differentiates between a perceived situational threat and a perceived character flaw. The consequences are scaled accordingly.
Finally, we reach Part 7, which feels like it belongs in a different law entirely. Maintenance, under Section 144. This isn't about criminals or public disorder. It's about families.
It is social justice disguised as criminal procedure. It's been part of the procedural code for a very long time, and its primary goal is to prevent vagrancy and destitution. The state is essentially saying, we have a social interest in making sure people take care of their dependents so they don't become a burden on the public. So if a person has sufficient means but neglects or refuses to maintain their wife, children, or parents, the law can step in and force them to pay.
Who specifically can make a claim for this maintenance?
The list is very clear. A wife who is unable to maintain herself, minor children, and this is important, whether they are legitimate or illegitimate, who cannot support themselves. It also covers adult children if they have a physical or mental abnormality that prevents them from working, and importantly, parents who are unable to maintain themselves.
It's really interesting that it explicitly includes illegitimate children. The law doesn't care about the marriage license. It cares about the welfare of the child.
Correct. The child needs to eat regardless of the parent's legal relationship. The biological link creates the responsibility.
And the source specifically highlights a proviso in this section regarding a minor female child. What's that about?
Yes, this is a very specific and important provision that addresses the tragic child bride scenario or issues related to early marriage, which unfortunately still exist. The proviso says that if a minor female child is married, but her husband does not have sufficient means to support her, the magistrate can order her father to continue paying maintenance until she attains her majority, which is 18.
So she doesn't fall through the cracks. The father can't just marry her off at 16 to a penniless boy and wash his hands of her.
Exactly. It ensures she is protected. It places the financial responsibility back on the father if the husband is destitute. It prevents a father from using an early marriage as a way to get a daughter off his expense sheet if the husband can't actually support her. It's a powerful social protection measure embedded in this code.
So we've looked at the whole arsenal,
Mm-hmm.
from the postal trap where the police can only detain mail, to the digital shift requiring video evidence of every search, to the Robin Hood provision that actually pays victims back, and finally, these social justice measures that ensure families are fed. It's an incredible range.
When you look at the synthesis, what the analysis slide in our source material calls it, it describes the Bnss as a graduated toolkit.
That's a great way to put it. It's not one size fits all.
Not at all. It goes from the mildest tool, the summons, which is just asking for something, all the way up to the most severe, a search warrant, which is forcing entry. It goes from asset forfeiture, which is taking the money, to preventive detention, which is taking the liberty.
And the ultimate goal, as the source says, isn't just about punishment.
No. The source explicitly states, the ultimate goal is not just punishment, but the preservation of social order and justice for victims. It's a much broader mandate.
It really makes you think about that constant tension, that balancing act between liberty on one side and security on the other. The state has these massive powers we've discussed, but at almost every turn, there seems to be a checker requirement to go to a magistrate, a strict time limit, a requirement for video evidence.
And that is the entire design philosophy of a good procedural code. A system without power is ineffective and can't protect anyone. But a system without checks and balances is tyrannical. The Bnss, with all these new provisions, really tries to walk that fine line.
Here's a final thought to leave our listeners with. We all complain constantly that the justice system is too slow. Justice delayed is justice denied, right? It's the most common criticism.
It's the #1 complaint about the Indian legal system, without a doubt. The delays are legendary.
But look at two very specific things we talked about today. Section 105, mandatory technology, the mandatory video recording of searches, and Section 107, direct financial restitution to victims with a 60-day timeline.
Yes. Where are you going with this?
Do you think these two specific, very practical changes, forcing the truth into the light immediately with video and forcing the money back to the victims quickly, will be the keys that finally bridge that enormous gap between law as it's written and justice as it's felt by the common person? Or will they just be more rules that look good on paper but get bogged down and fail in practice?
That is the million-dollar question, isn't it? The tools are now in the toolbox. They are sharper and more modern than ever before. Now we have to see if the magistrates are willing and, just as importantly, able to pick them up and use them effectively.
Thanks for listening to The Deep Dive. We'll see you next time.
Let's understand the next point from here. Welcome back to Deep Dive. Today, we are standing on the precipice of what you could call a massive shift in India's legal landscape.
It's more than a shift. It's a seismic event for anyone in the legal field.
That's a good way to put it.
Right.
We are talking about the transition that every legal professional, every student, and certainly every judicial aspirant is grappling with right now. The move from the old CRPC to the new Bharatiya Nagarik Suraksha Sanhita, or the Bnss.
It is indeed a monumental change. And, it's not just a renaming exercise. It's a structural overhaul of how procedure works in this country.
Yeah.
It effectively rewires the entire machinery of justice.
Exactly. And for today's deep dive, we are going to get very, very specific. We aren't doing a 30,000-foot view. We're zooming right in for a comprehensive slide-by-slide breakdown of what's called the procedural chronology. We are covering chapters X through 4 which takes us from Section 144 all the way through to Section 201.
And this is really the heart of the procedural engine, isn't it? We are moving from Social Security measures like maintenance right through to the nitty-gritty, the mechanics of investigation and jurisdiction.
So it's a full journey.
It's a journey from preventing vagrancy, basically, to solving complex crimes. It's the whole spectrum.
Now, before we jump in, I want to be crystal clear about where this goldmine of information is coming from. We are walking through the expert teaching material provided by Target for IQ, which has been developed under the mentorship of Satendra Sir.
And that is such an important context because the material we are analyzing isn't just a dry recitation of the law. It's not a textbook. It's designed specifically for judicial services aspirants, the PCS-J.
Right.
So you'll hear us talk a lot about things like exam alerts and traps because Satendra Sir's approach has always been about decoding not just the law itself, but how to actually pass the exam.
I love that. It's like having a cheat sheet for the test. And looking at the first visual in our stack here, it really sets the tone perfectly. We see these four big pillars: maintenance, public order, investigation, and jurisdiction. And right there at the bottom, there is this guiding principle, this quote: procedure is the handmaid of justice.
That is the core theme. That's the lens through which you have to see all of this. Procedure isn't some obstacle course designed to trip you up. It is the path that leads you to justice. If you master the process, the timeline, the how, the why of law enforcement, you master the exam.
Right.
The visual just reminds us that all these rules, they serve a higher purpose.
A fantastic starting point. So let's start with that first pillar, Chapter X, social justice and maintenance. Now, this is Section 144 in the Bnss.
Right. And immediately, any seasoned student, anyone who's studied the old CRPC, they might feel a little twitch. Because Section 144 of the old code...
That was curfews, right? Unlawful assembly.
Exactly. It was about public order. In the Bnss, Section 144 is now about maintenance. It's a complete swap.
That's a huge mental shift right off the bat. The slide here has a big golden shield icon with a little family inside it. It says, order for maintenance. What's the core concept we should be thinking of here?
The core concept and the reason for that shield is the prevention of vagrancy. This isn't a penal provision in the strict sense. It's a piece of social legislation. The Judicial Magistrate First Class, or JMFC, has the power to order maintenance to ensure that people aren't left destitute. The shield icon represents the law protecting the vulnerable from starvation and homelessness.
Okay, let's unpack who exactly is covered by this shield. Who can claim maintenance under this new Section 144?
All right, the slide breaks it down very clearly into four main categories. First, and most obviously, the wife.
The wife.
But here's where it gets interesting. This is where the law really shows its heart. The definition of wife in Explanation B to the section explicitly includes a woman who has been divorced by or has obtained a divorce from her husband and has not remarried.
So, even if the marriage is legally dissolved, the obligation to prevent her from falling into destitution can remain, provided she hasn't married someone else.
Precisely. The logic is that if she gave, her prime years to the marriage and is now left without any means of support, the state shouldn't have to bear the burden if the former husband has the means to provide for her. It keeps the responsibility within that family structure, even post-divorce.
That makes sense. Okay, what's the second category?
Next, we have minor children. And the law is very broad here. It applies whether they are legitimate or illegitimate, and whether they are married or unmarried.
The law is blind to the status of the child's birth in this context. A child is a child and needs support.
Exactly. But there is a crucial proviso here, a condition, regarding a married minor daughter. This is an exam favorite.
Wait, married minor children? That seems like a contradiction.
It is. Child marriage, while illegal, unfortunately still creates factual realities that the law has to deal with. The proviso states that if a minor daughter is married, the father is only liable to maintain her if her husband is not possessed of sufficient means to do so.
Ah, so it's a safety net for the safety net. The primary duty shifts to the new husband.
Correct. But if he's broke, or perhaps a minor himself, and unable to earn, the duty boomerangs back to the father until she attains majority.
Got it. Okay, moving on to the third category, major children. Usually once you turn 18, you're considered on your own?
Generally, yes. But here we see a very specific, very compassionate condition. A child who has attained majority can only claim maintenance if, by reason of any physical or mental abnormality or injury, they are unable to maintain themselves.
So this is for adult children with severe disabilities who can't be independent.
Yes, exactly. The duty of the parent continues in those exceptional circumstances.
Now I'm looking at a bright red trap alert on the slide. This seems like a big one for the exams, doesn't it?
It is a classic trap, one of the most common mistakes students make. The slide highlights it in red for a reason. A married daughter who has attained majority is specifically excluded. She cannot claim maintenance from her father under Section 144(1)(c).
So even if she has a disability?
Even then, the law presumes that once she is an adult and married, the responsibility for her maintenance shifts entirely to her husband's family or to herself. Her paternal link for maintenance is severed.
That is a detail that could easily cost you marks if you're just skimming. So if the exam question presents a scenario, a 25-year-old married daughter with a physical disability seeks maintenance from her father, the answer is a clear no.
A clear no maintenance from father under this section. You have to watch out for that very specific exclusion. It's a perfect MCQ question.
Right. And the final fourth category?
The fourth category is parents. a father or mother who is unable to maintain themselves.
It's a reciprocal duty, then.
It is. The law reflects the moral fabric of society. You care for the child when they are young. The child cares for you when you are old and unable to support yourself. It's codified social responsibility.
Okay, so that's who can claim. Now, let's talk about the process, the how. We have a visual here of an hourglass with 60 days written right next to it. We're looking at sections 144 through 147 now.
This hourglass, this represents one of the most critical updates in the entire Bnss timelines. The Bnss, you'll see, is obsessed with speed and efficiency.
So what does the 60 days refer to?
Under Section 144, Proviso 2, the magistrate has the power to order interim maintenance. That's a monthly allowance that can be paid while the main trial is still pending.
That makes sense. Because court cases can take forever, and people need to eat now. You can't just wait.
Exactly. You can't tell a hungry person to wait 3 years for a final verdict.
Yeah.
But here is the kicker, the part that makes the Bnss different. The application for that interim maintenance must be disposed of within 60 days from the date of service of notice on the other party.
That is fast. That puts real tangible pressure on the system to act.
It's statutory speed. The magistrate cannot just adjourn the interim application endlessly. The law gives them a deadline. And there's another crucial timeline here for recovery. This is another big exam alert.
Yeah.
The limitation period for recovering any amount due is 1 year from the date it became due.
Can you explain that with a quick example? I think that would help.
Of course. Let's say the court orders a husband to pay 10,000 rupees a month. He stops paying in January 2024. If the wife waits until, say, March 2025 to file for recovery of those arrears.
So 14 months later.
Right. She can only legally claim the payments going back to March 2024. She loses the right to claim the money for January and February 2024 because they are now outside that 1-year window.
So you can't just let it pile up for 5 years and then show up asking for all that. You have to be vigilant.
Correct. The law helps the vigilant. If you sit on your rights for more than a year for any given month's payment, you lose the remedy for that specific period.
And what about enforcement? If someone just refuses to pay?
If someone refuses to pay without sufficient cause, the magistrate can issue a warrant for levying the amount, just like a fine. And if they still don't pay, the final step is imprisonment for up to 1 month for each month's unpaid allowance.
There's also a green box here on the slide labeled defense. It talks about disqualification. When can a wife actually be refused maintenance?
The law lays out 3 specific grounds under Section 144, subsection 4. 1, if she's living in adultery. 2, if she refuses to live with her husband without any sufficient cause. And 3, if they are living separately by mutual consent.
And the slide notes an important point here. It says that contracting another marriage or keeping a mistress by the husband is considered a just ground for the wife to refuse to live with him.
Yes. So this balances the obligations. If the husband comes to court and says, Your Honor, she won't live with me, so I shouldn't have to pay, but it turns out he has a mistress at home, the court will say, well, she has a very valid reason to leave. You still have to pay.
Okay, that clarifies that. Now let's move to Section 146, alteration and cancellation. We have a visual of the scales of justice here.
This section is really practical. It recognizes that life isn't static. Circumstances change. Salaries go up or down, people get sick, people remarry. The magistrate has the power to alter the maintenance allowance if there's a proven change in circumstances.
And what happens if a civil court gets involved in the matter, say during divorce proceedings?
That's a key point of hierarchy. The civil court is the big boss when it comes to determining substantive rights. Its determination is final. So, if a competent civil court makes a decision that varies the maintenance status or amount, the magistrate must alter their order to follow suit. The criminal court's summary order is always subservient to the civil court's detailed determination.
There is a red trap box here again. It asks a question. Does the civil court order automatically cancel the magistrate's order?
And the answer, which trips up many students, is a resounding no. It's not automatic. The magistrate must pass a specific, consequential order to either cancel or vary their own order in consequence of the civil court's decision.
So it doesn't just happen by magic?
No. Procedural steps must be taken. The husband can't just stop paying. He has to take that civil court judgment, go back to the magistrate, file an application, and say, look, your order needs to be changed based on this superior court's decision.
Right. Now let's look at the specific grounds for cancellation post-divorce under Section 146.
There are 3 main scenarios here. First, if the woman remarries, the maintenance order is canceled from the date of her new marriage. That's straightforward.
Okay.
Second, if she receives the whole of the sum, which, under any customary or personal law, was payable on such a divorce. So like a lump sum alimony or settlement.
A final settlement.
Exactly.
Yeah.
And third, if she voluntarily surrenders her right to maintenance after the divorce.
As we teach at Target for IQ, and this is something Satinder Sir always stresses, understanding these specific triggers for cancellation is vital. It's not just for MCQs, but for the mains exam where you might have to draft a hypothetical order.
Absolutely. Knowing the when and why of cancellation is just as important as knowing the what of granting maintenance.
Okay, let's shift gears now. We are leaving the domestic sphere of maintenance and moving out to the streets. Chapter 11, Public Order and Unlawful Assemblies.
Yes, we are now in the realm of prevention and the use of force. This is where the state flexes its muscle to keep the peace and prevent chaos.
The visual here is really striking. On one side, we have a standard blue police cap, and it's labeled Civil Force. On the other side, there's a green combat helmet labeled Armed Force. This creates a very clear visual hierarchy.
That hierarchy is the absolute key to understanding sections 148 through 151. It's all about escalation. You don't start with a tank, you start with a police whistle and a baton.
So let's start with the cap, Section 148.
Section 148 deals with civil force. Here, an executive magistrate, EM, or an officer in charge, OIC, of a police station, or even a sub-inspector, if no OIC is present, can command an unlawful assembly to disperse.
And if they refuse to go home,
then the police can use the necessary civil force to disperse them. This is your classic baton charge, your water cannon, the physical arrest and confinement of the ringleaders. It's about restoring order with the minimum force required.
But what if that's not enough? What if things are getting really dangerous and out of hand?
That is when we cross the line on our visual, from the police cap to the combat helmet. That's Section 149, the use of armed forces. But notice the trap highlighted on the slide here. A sub-inspector cannot authorize this.
Right. The slide is very clear. It says if public security is manifestly endangered and the assembly cannot be dispersed otherwise, only the executive magistrate of the highest rank available can authorize dispersal by the armed forces.
Exactly. The level of authority must match the level of force. A sub-inspector can command his men under Section 148, but they absolutely cannot call in the Army or the CRPF under Section 149. That requires a deliberate decision from a senior executive magistrate.
And that's a safeguard, isn't it?
It's a massive safeguard. It prevents low-level officers from making decisions in the heat of the moment that could lead to mass casualties.
There's also Section 150. This is the emergency provision. What if the magistrate is stuck in traffic and can't be reached?
In that rare and urgent situation, if no EM can be communicated with, a commissioned or gazetted officer of the armed forces can act independently to disperse the assembly if public security is at immediate risk. But they have a duty to communicate with a magistrate as soon as it is practically possible. It's an act now, report immediately kind of provision.
And wrapping up this part, Section 151 covers protection.
Yes. It's an indemnity clause. It essentially says that if an officer acts in good faith under these sections, they can't be prosecuted in any criminal court without the sanction of the central or state government. It protects officers doing a very difficult job from frivolous or malicious lawsuits.
Okay, let's move to Section 3 of our outline. Nuisance and disputes concerning immovable property.
Here we're looking at Section 152 first. The visual on the slide is quite interesting. It shows icons of a falling tree, some factory smoke, and a tiger.
A tiger. I have to ask about the tiger.
Yes, the tiger represents dangerous animals. Section 152 empowers the district magistrate, DM, a subdivisional magistrate, SDM, or any other executive magistrate empowered by the state government to issue what we call conditional orders for the removal of a public nuisance.
So things like unlawful obstructions on a public path, dangerous buildings that might fall, an unfenced well near a road, or yes, a dangerous animal that needs to be confined or, in extreme cases, destroyed.
The procedure here is very important. It's called a conditional order for a reason. The magistrate issues an order telling the person, fix this nuisance within this time or hour, appear before me, and show cause why this order should not be made absolute.
So it's due process. You get a chance to argue your case.
Exactly. You can come and explain why your tree isn't actually dangerous or why your factory isn't causing a nuisance.
And the key fact highlighted here says these orders cannot be questioned in a civil court.
That's a crucial point. It's to prevent people from stalling urgent public safety measures by filing endless civil suits. If a building is about to collapse on a school, the authorities can't wait 5 years for a civil trial to conclude. The magistrate's order on the nuisance is final.
Now here is a big one. Urgent cases of nuisance. The slide shows a gavel stamped with the word urgent.
This is Section 163 in the Bnss.
And this is formerly the one everyone knows.
Formerly the famous or infamous Section 144 of the CRPC. This is the source of so much potential confusion for students. I can't stress this enough. If you write Section 144 in your exam when referring to a curfew or an urgent nuisance order, you will lose marks. It is now Section 163.
So let's repeat that. Old 144 is now 163, and the new Section 144 is maintenance. That is a critical swap to remember.
Absolutely critical.
So what does this new Section 163 actually do? What's its scope?
It allows the DM, SDM, or empowered EM to issue an immediate order in urgent cases to prevent things like injury, danger to human life, or a riot or a fray. It can even be passed ex parte, meaning without hearing the other side, if the emergency is so great that there's no time for a notice.
But it's a temporary measure, right? It's not a permanent law.
Yes. The misconception box on the slide clarifies this perfectly. It creates temporary remedies, not permanent laws. The order generally lasts for a maximum of 2 months.
Can it be extended beyond 2 months?
Yes, the state government can extend it, but the total duration from the initial date of the order cannot exceed 6 months. It is meant to be a short-term Band-Aid to handle an urgent crisis, not a permanent solution.
Under the guidance of Successor, we always emphasize understanding the difference between the public nuisance of Section 152 and the urgent nuisance of Section 163.
And that's a key distinction. Section 152 is about removing a persistent thing, a dangerous tree, a noisy factory. Section 163 is about preventing an imminent event, a riot, a public health crisis. One is about an object, the other is about an emergency situation.
Got it. Okay, next up, disputes related to immovable property, Section 164. The visual is a map pin stuck right between two arrows that are pushing against each other.
Perfect visual. This section deals with fights over land or water that are so heated they're likely to cause a breach of the peace. The executive magistrate steps in not to decide who owns the land, that's a job for a civil court, but to decide who is in actual possession right now, just to stop the violence.
The slide says scope. The magistrate does not decide title, only possession. That's the core distinction.
And here is the exam alert for this section, the 2 months rule.
Okay, how does that work? It sounds important.
It's very important. If a person was forcibly and wrongfully dispossessed of the property within 2 months, immediately prior to the police report being filed, the magistrate can treat that person as if they are still in possession.
So let me get this straight. If I bully you off your land today and you go to the police and the report comes to the magistrate next week, the magistrate can essentially put you back in possession.
Exactly. It prevents the might is right approach, where someone can just use force to grab a property and then claim, I'm in possession now. The law rewinds the clock by 2 months to undo that act of aggression.
Fascinating. There is also a flowchart here for sections 165 through 167 regarding attachment of the property.
Yes. This is what happens if the magistrate simply can't decide who is in possession, or if it's a grave emergency. They can attach the subject of the dispute, literally lock it down and take it into state custody, and appoint a receiver to manage it.
And what if a civil court appoints its own receiver later on?
Then the criminal court must hand over the property. The civil court always wins on substantive property rights. The magistrate's role is just temporary, to keep the peace.
And there is a final trap here distinguishing Section 164 from Section 166.
Right. Section 164 is about possession of tangible things like land or water. Section 166 is about the right of user, or easements like the right to walk across a neighbor's field or use a community well. They are different legal concepts with different procedures. Don't mix them up in the exam.
Okay, we are moving into what the slide calls the engine of the process now. Chapter 12, Preventive Action of the Police.
This is where the rubber really meets the road. Section 168 starts it off, and it states that every police officer shall prevent the commission of any cognizable offense. Note the word shall. It's a mandatory duty. They can't just stand by and watch a crime happen.
And Section 169 follows that up, imposing a duty to communicate information about such designs to their superiors.
It's about ensuring the chain of command is aware. Intelligence has to flow upwards so that a coordinated response can be planned.
Then Section 170 gives them the power to arrest without a warrant if that's the only way to prevent the crime from being committed.
But look at the limitation here. The exam alert on the slide says detention under this specific preventive section, Section 170, is strictly limited to 24 hours, unless their further detention is authorized under another law.
So you can't just lock someone up indefinitely on suspicion saying you're preventing a crime.
Absolutely not. You have to produce them before a magistrate within 24 hours. It's a fundamental safeguard.
Now, let's talk about the starting point of most investigations. The FIR. Section 173. The visual here is very modern. It shows a smartphone right next to an old traditional scroll.
A great image. It perfectly represents the collision of the old and the new. Section 173 covers information in cognizable cases. And the big news in the Bnss is that it now explicitly recognizes electronic communication.
So, an EFIR. I can email the police or send a message through a portal.
Yes, you can. But there is a very important catch-a condition that Successor always highlights in our classes. If you send information electronically, it must be signed by the person giving it within 3 days.
Ah, so it has to be formalized.
It has to be. The information is taken on record immediately, but that signature is required to formalize it and attach responsibility to the informant.
So you can't just tweet an accusation at the police and then disappear. You have to stand by your statement and verify it.
Exactly right. It filters out anonymous trolling and unsubstantiated claims from becoming formal investigations.
The slide also makes special mention of women and vulnerable victims here.
This is incredibly important. For specific offenses like rape, which are covered under Section 64 and 66 of the new Bharatiya Nyaya Sanhita, the information must be recorded by a woman police officer. And if the victim is temporarily or permanently disabled, videography of their statement is now mandatory.
These are measures to ensure sensitivity and accurate recording.
Yes, and to reduce the trauma for the victim.
Now, we arrive at one of the most talked about and perhaps controversial parts of the new law, the preliminary inquiry under Section 173. The visual is a magnifying glass hovering over a calendar page marked with the number 14.
This is a major procedural addition, and it's a potential minefield for exam questions. It applies to offenses that are punishable with imprisonment for 3 years or more, but less than 7 years.
So this is for the mid-level offenses, not the very minor or the very heinous ones.
Correct. For these specific cases, the police don't have to automatically register an FIR upon receiving information. They can, with prior permission, first conduct a preliminary inquiry.
To do what, exactly?
To ascertain whether a prima facie case even exists. Is there any substance to the complaint? Or is it a frivolous or civil matter being given a criminal color?
But they need permission for this, right? It's not their own discretion.
Absolutely. They need prior permission from an officer not below the rank of Deputy Superintendent of Police or DSP.
And the timeline. That's the 14 on the calendar.
That's it. The inquiry must be conducted and concluded within 14 days.
The trap noted here is important. Is this preliminary inquiry mandatory for all offenses?
No. And that is the trap. It is not mandatory. It is discretionary. And it is specifically targeted only at that 3 to 7 year bracket of offenses. It's designed to filter out frivolous complaints, especially in categories like business disputes that are often dressed up as criminal cheating cases.
Okay, that clarifies it. Moving on to investigation powers and dealing with witnesses, that's sections 175 to 179.
Section 176.3 introduces a massive change regarding forensics. For any offense that is punishable by 7 years of imprisonment or more, the collection of forensic evidence from the crime scene and the videography of that process are now mandatory.
So no more excuses like, we forgot the camera or the kit wasn't available.
Exactly. It forces a shift toward scientific investigation. The aim is to increase the conviction rate by relying on hard, scientific evidence rather than just eyewitness testimony, which can be unreliable or witnesses can turn hostile.
Then we have Section 179, attendance of witnesses. The police can order people to come to the police station for questioning, but there are important exceptions.
The proviso. This is a huge point of protection. Males under the age of 15, males over the age of 60, women of any age, and any person with mental or physical disabilities or acute illness. These individuals cannot be required to attend at the police station. They must be examined at their residence.
The key fact on the slide emphasizes that a woman of any age is exempt from attending the police station under Section 179.
Yes. They cannot be forced or coerced to come in. The police officer must go to them. In our judiciary classes at Target for IQ, we emphasize that this is a strict, non-negotiable rule. If a police officer violates this and summons a woman to the station, he is acting in violation of the prescribed procedure.
Okay, sections 180 to 182, the examination of witnesses. The visual here is a book, like a case diary, stamped with a big red no signature.
This refers to Section 181, which contains the famous ban. A statement made to a police officer during the course of an investigation shall not be signed by the person making it.
And what's the logic behind that? Why no signature?
It's a fundamental protection against coercion. If you're forced to sign a statement, it feels binding. The police could potentially write anything, force an uneducated person to sign it, and then hold that signed document over them. The law prevents this by making the statement unsigned and therefore less formal and intimidating.
So what is its evidentiary value then? Can it be used in court at all?
Very limited value. The slide is clear on this. It can only be used by the accused and with the permission of the court by the prosecution to contradict the witness during the trial.
So not to corroborate their story.
Never for corroboration. Only to catch them in a lie if they change their story on the witness stand later. This is linked to Section 148 of the new Kartya Saksha Adhiniyam 2023, which replaces the old Evidence Act.
Right. Next is the very serious matter of confession, Section 183.
The rule here is extremely strict. Only a judicial magistrate can record a confession. A police officer, even a senior one who might have been given some magisterial powers for other purposes, cannot record a confession under this section.
And the magistrate has to give a warning.
A very clear warning. You are not bound to confess. If you do, it can and will be used as evidence against you. The magistrate must be fully satisfied that the confession is being made voluntarily, without any threat, promise, or inducement for the police.
There's a yellow exam alert box here highlighting something about advocate presence.
Yes, this is a key detail and a progressive step. The proviso to this section allows an advocate for the accused to be present during the recording of the confession, though they may be kept at a distance. It's a powerful safeguard to ensure the accused knows their rights and that procedure is followed.
What about medical examinations? That's Section 184.
For a rape victim, the first and most important principle is consent. The slide is very clear. Nothing renders a medical exam lawful without consent. The victim's consent is paramount.
And the timelines here are very tight as well.
Extremely. The victim must be sent to the medical examiner within 24 hours of the information being received by the police. And that medical report, in turn, must be forwarded to the investigating officer within 7 days. Again, speed is a priority to preserve crucial evidence.
Okay, now we get to Section 187, remand and detention. The slide dramatically calls this the game changer.
It absolutely is. This single section fundamentally changes the landscape of police custody and investigation. Under the old law, police custody was generally limited to the first 15 days of arrest.
And now, what's the change?
The visual shows a calendar with 15 days, highlighted, but with arrows stretching out from it. The magistrate can now authorize detention in police custody for a total term not exceeding 15 days. But, and here's the change, this can be in the whole or in parts at any time during the initial 40 days or 60 days of detention.
Let's break that down. So, the police can take an accused into their custody for, say, 2 days, send them to judicial custody, jail, and then pull them back out for another 3 days of police custody next week.
Exactly. As long as the total number of days in police custody doesn't exceed 15, and as long as it happens within that initial window, 40 days for offenses punishable up to 10 years, and 60 days for more serious offenses, it gives investigators much more strategic flexibility to interrogate the accused as new evidence or co-accused are found.
And what about default bail under Section 1873? Is that still there?
Yes, that crucial safety valve remains. If the investigation is not complete within the prescribed period, 90 days for very serious offenses, like those punishable with death or life imprisonment, or 60 days for most other offenses, the accused is entitled to be released on bail. It's often called statutory bail. It's an indefeasible right.
We also have Section 185, search by police.
The main focus here, reflecting the times, is on electronic evidence. Any search conducted by the police shall be recorded through audio-video electronic means, preferably a mobile phone. And a copy of that recording must be sent to the magistrate within 48 hours.
That 48-hour timeline is another exam alert.
Yes, is a measure to ensure transparency and prevent allegations of planting evidence or procedural misconduct during a search. The record has to be submitted promptly.
We are nearing the end of the procedural chain now. Section 193, completion of investigation.
This is about the filing of the police report, what we commonly call the charge sheet. Again, timelines are key. For cases of rape and PCS-J, the investigation must be completed within 2 months from the date the FIR was recorded.
And there is a new update requirement for the victim.
Yes, a very important one. The police must inform the victim or the original informant about the progress of the investigation, including by electronic means, within 90 days. They can't just leave the victim in the dark for months or years on end.
Inquests, that's sections 194 to 196.
The main thing to know here is the distinction between a police inquest under Section 194, which happens for most cases of suicide or accidental death, and a mandatory magistrate inquiry under Section 196.
When is a magistrate inquiry mandatory?
The trap is here. It's mandatory for any death or disappearance of a person or a rape alleged to have been committed on a woman while that person is in the custody of the police. And it must be a judicial magistrate, not an executive one.
Why a judicial magistrate?
Because the police themselves are the potential suspects. An executive magistrate often works closely with the police, so to ensure impartiality, an independent judicial mind is required to inquire into a custodial death.
And finally, we get to jurisdiction chapter 14th. The visual is a map with pins for act done and consequence ensued.
This brings us to Section 199. The general rule, which is in Section 197, is lex loci. The trial happens where the offense was committed, but Section 199 clarifies a common problem. It says if an act is done in one place, say you injure someone in Delhi, and the consequence ensues in another, say they die in a hospital in Noida, the trial can be held in either place.
That flexibility must prevent a lot of jurisdictional ping-pong where courts just bounce the case back and forth.
That's precisely the purpose. It ensures the case is heard efficiently, rather than getting lost in procedural technicalities about which court has the proper jurisdiction.
So, looking at the final summary slide here, we have a clear procedural chain.
Yes, it flows logically. You start with prevention, maintenance, unlawful assemblies. Then you move to action, the FIR, the investigation. Then the process, examining witnesses, conducting searches, then custody, remand appointment, and finally the conclusion, the police report and jurisdiction.
And the key takeaway, printed in big green letters at the bottom. What's the one thing students should burn into their memory?
Memorize the timelines. 14 days for a preliminary inquiry, 60 days for an interim maintenance application, 90 days for giving a progress update to the victim. The Bnss is absolutely defined by these new, strict timelines.
It seems like a perfect place to end with the quote from Successor that's on the slide. Procedural law is not an obstacle. It is a path to justice. Master the timelines and you master the exam.
That is the absolute truth of it. For any aspirant listening to this right now, my advice would be to go back and reread Section 187 on remand and Section 173 on information and the preliminary inquiry tonight. Those are your highest probability question areas from this entire discussion.
Thank you so much for decoding all of this with us. This has been an incredibly detailed deep dive into the Bnss, powered by the materials from Target for IQ. Good luck with your prep out there, and we'll see you in the next one.
Keep learning, keep reading.
Hello, and welcome back to the deep dive. Today, we're doing something a bit different. Think of this less as a general discussion and more like you're walking into a specialized lecture hall.
Exactly. Find your seat, front row, get your notebook out.
We are really shifting gears today into high-level coaching, specifically for judicial services aspirants. So if you're preparing for PCS-J, APO, or civil judge exams, you are in the right place.
That's right. And we're approaching this with the seriousness it deserves. This is not a casual overview. We're conducting this deep dive, of course, under the banner of Target for IQ, and we're following the very specific guidance and pedagogy of Successor.
Our focus is razor sharp. We are breaking down the Hratyanagarak Suraksha Sanhita, the Bnss, specifically jurisdiction, cognizance, and complaints.
And this is going to be rigorous. We're simulating a slide-by-slide classroom lecture.
Right. So I'm going to be Ari Reyes here, describing every visual, every bullet point on the screen. And my colleague, our senior judiciary faculty, is going to break down the why and the how.
And, more importantly, I'll be pointing out all the little traps that examiners love to set in these papers. We're not skipping a single word. If it's on a slide, a proviso, a diagram, anything, we are discussing it in detail.
It's all about building that conceptual framework you need for both prelims and mains.
Precisely.
Let's understand the next point from here. Okay, so we're looking at our title slide now. It sets a very serious tone right from the start. The visual is a wooden gavel. It's resting very heavily on a thick book that's titled Bnss. And in the background, there's this vintage-style map of India, sort of like old parchment. It really grounds the whole topic.
And that image is not accidental. You see, the map represents the territory, the physical ground where the law of the land applies, and the gavel. Well, the gavel is the jurisdiction. It's the power to speak the law, the judicial, within that specific territory.
I see. So the text on the slide reads jurisdiction, cognizance, and complaints. It then cites its source. Hartiya Nagarik Suraksha Sanhita, chapters 14-15.
The heart of the matter.
Below that, in a green box, it says scope, sections 197 to 225. Then there's a yellow box, exam focus, procedural jurisdiction versus territorial jurisdiction. And finally, a very bright red warning box. It says, warning, do not confuse with civil jurisdiction principles.
Okay, let's just pause and unpack that first slide. The scope alone, sections 197 to 225, this is the engine room of criminal procedure.
Yeah.
I mean, before a trial can even begin, you have to answer the fundamental question. Where do we start? That's what this is all about.
And that yellow box, procedural versus territorial, what's the key distinction there for an aspirant?
This is where so many get tripped up, especially in the interview stage. Look, territorial jurisdiction is just geography. It's the borders of a district. Simple. But procedural jurisdiction, that's the legal authority given to a specific court, say a magistrate of the first class, to hear a specific kind of matter within that geography. One is about the map, the other is about the power.
Right, and that red warning box. Why is it so dangerous to mix this up with civil jurisdiction?
Oh, it's a classic trap. It's probably the most common fundamental error. In civil law, under the Code of Civil Procedure, jurisdiction often follows the person. You want to sue someone for money, you usually go where the defendant lives or works. The law, in a way, chases the person.
Okay.
But in criminal law, under the Bnss, the law chases the crime. We are obsessed with the locus delicti, the scene of the crime. Generally speaking, we don't care where the accused lives. We care where the offense was committed. If you mix those two principles in a mains answer, you're signaling a fundamental lack of understanding. It's a huge red flag for the examiner.
So it's all about the act, not the address of the person who did the act.
Precisely. You've nailed it. It's about the act.
Let's understand the next point from here. All right, moving to slide 2. The title here is Section 197, the general principle. The visual is really interesting. It's a 3D isometric map, looks like a city grid, and there's a large red location pin, you know, the kind from a digital map, stuck right in the middle of an intersection. It's pinning down one specific spot.
And that pin, that's our locus delicti. That's the seat of the offense. It's visually telling you this is where it happened. This is what matters.
Okay, I'm going to read the statutory text verbatim from the slide. It says, every offense shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. Below that text, we have 3 boxes. First, a green one. Key concept. The word ordinarily implies there are exceptions provided in the Sanhita.
Stop right there. That one word. I want every student listening to this to focus entirely on that single word, ordinarily.
Okay.
In your mains answer, you must underline this word. Why? Think about it. If the law just said, every offense shall be tried where it was committed, the system would grind to a halt. What if a crime happens on a moving train? What if a body is dumped, but you don't know where the person was killed? Ordinarily is the safety valve. It means this is the default rule, unless we tell you otherwise in the following sections. It sets the general principle, but immediately opens the door for all the necessary exceptions.
That makes sense. It builds in flexibility from the very start. The yellow mains question box asks, explain the general rule regarding the place of inquiry and trial.
And that's a very common question.
Then there's a red trap box. It says, trap. This section applies to both inquiry and trial.
Yes. And I see you've noticed what's missing.
It doesn't say investigation.
That is very, very sharp observation. And it's exactly why we put that trap box there. Investigation, that's the domain of the police. The police have their own set of rules about territorial limits, which are actually quite broad. Section 197 is a directive aimed squarely at the judiciary. It's the law telling the magistrate, do not touch this case unless it happened in your backyard, ordinarily. It's a limitation on the judicial power of inquiry and trial, not on the police power of investigation.
So for that mains question, how should a student structure their answer?
The way we teach this at Target for IQ is to build your answer like a pyramid. You start with the broad base, the general rule from Section 197. You explain the sanctity of the local area, the locus delicti, but then you immediately pivot. You say, however, the legislature in its wisdom recognized the complexities of modern crime and human interaction, and thus provided a series of exceptions in Sections 198 onwards. You frame the entire answer as the rule and its necessary exceptions. That shows a mature understanding. Got it. The rule is only the starting point. Exactly. Let's understand the next point from here. Slide 3 takes us directly to those exceptions. It's titled Section 198, Uncertainty in Multiple Areas. And the slide is dominated by a big flowchart answering that what-if question you just raised. Yes, and this is prime territory for problem-based questions in the prelims. They love to give you a scenario that fits one of these boxes.
Okay, let's walk through it slowly. The chart starts with the title, Section 198, and it branches down into 4 distinct scenarios. Scenario 1, uncertain in which of several local areas offense committed.
So you're not sure if it was District A or B.
Scenario 2, offense committed partly in one local area, partly in another.
An arm was in A, a leg was in B. Classic example.
Scenario 3, continuing offense continues in more local areas than one.
The crime is on the move.
And scenario 4 consists of several acts done in different local areas.
A conspiracy, for instance.
Now, all 4 of these arrows point down to a single powerful result box, which reads, may be inquired into or tried by a court having jurisdiction over any of such local areas.
And ANY is the magic word there. That's what you need to remember. This entire section is designed to prevent a failure of justice. Imagine a body is found lying right on the border between, say, Gurgaon and Delhi. It's not clear which side of the line the murder actually happened.
Right.
Without this section, the Gurgaon court could say, not our problem, and the Delhi court could say the same. The case would just hang in legal limbo forever. Section 198 cuts through that. It says, stop fighting about it. Both of you have jurisdiction. Either one of you can take up the case. Go.
The slide has a green rule box that puts it neatly. The law expands jurisdiction to prevent failure of justice.
That's the jurisprudential basis.
Then a yellow exam alert says, continuing offense is a frequent keyword in prelims options.
Ah, yes. Continuing offense. This is absolutely critical. Kidnapping is the classic example you should memorize. If I abduct someone in District A, drive them through District B, maybe stop for food in District C, and then hide them in District D, the crime of kidnapping is not just happening in A, it is continuing through B, C, and D.
So every district on that route has a claim.
Every single one. Therefore, the police or the magistrate in any of those 4 districts can take up the case. You don't have to send the victim all the way back to District A to start the process.
That's very practical. Now, the red misconception box is interesting. Students often think the High Court must decide immediately here. Actually, any relevant magistrate can proceed. I would have made that mistake. If there's doubt, you go to a higher authority, right?
It's a logical assumption, but it's legally incorrect for this section. You see, Section 198 resolves the doubt by itself. It does that by granting concurrent jurisdiction to multiple courts. You don't need to pause the case and file an application with the High Court to decide the venue. The statute itself gives the magistrate in District A, B, C, or D the power to just proceed.
I see.
Students often confuse this with Section 206, which we'll see later. That's about resolving doubts when 2 courts are actually fighting over a case. But under 198, if your facts fit into one of these 4 boxes, you just pick a court and you go.
That must save an incredible amount of time.
It saves years of litigation. It's a brilliant piece of procedural law.
Let's understand the next point from here. Okay, slide 4 covers sections 199 and 200, acts, consequences, and relations. The visual here is very clear. It's a realistic image of a metal chain, 2 links. On the left link, it says act done, and on the right, it says consequence ensued. They are locked together.
Cause and effect. The unbreakable chain of causation. That's the legal concept being visualized.
I'll read the text for section 199. When an act is an offense by reason of anything which has been done and of a consequence which has ensued, an arrow from this points to a simple rule. Try where act done or consequence ensued.
Simple but powerful.
Then for section 200. When an act is an offense by reason of its relation to any other act which is also an offense, or which would be an offense if the doer were capable of committing an offense. This one's a bit more wordy. The arrow points to try where either act was done.
Okay, let's break down that legalese. Look at the green box on the slide, the one labeled example logic. What does that say?
It gives a very clear scenario. If A hits B in District X and B dies in District Y.
This is the example you must memorize for Section 199. It's the classic case. A assaults B with a fatal blow in District X. B is rushed to a better hospital in a neighboring district, District Y, where unfortunately he succumbs to his injuries a week later.
So where's the trial for murder?
Exactly. The act, the assault, happened in X. But the consequence, the death which makes it murder, happened in Y. Section 199 gives the prosecution a choice. You can try the case in District X or in District Y. The court in District X cannot wash its hands of the case and say, oh, he didn't die here, so it's not our murder case. No. The consequence is chained to the original act.
Okay, that's clear. But Section 200 seems more complex, and the red trap box for it says, trap. Section 200 applies even if the doer of the related act is incapable of committing an offense, for example, a child.
This is beautiful. Beautiful nuance of the law. It's designed to catch masterminds. Imagine I am in District A. I want to have a watch stolen from a house in District B, but I don't want to go there myself. So I find a 6-year-old child and I convince him to go into the house in District B and bring me the watch.
A 6-year-old can't be prosecuted.
Precisely. Under the law, a child under the age of 7 is dolly incapax, legally incapable of committing a crime. So the child is innocent. But what about me? I have committed the crime of abetment of theft. Now, Section 200 says that even though the child's act in District B was not an offense, my act of abetment in District A is related to it. Therefore, I can be prosecuted for my crime in District A, where I instigated the child, or R in District B, where the actual theft took place. The legal innocence of my agent doesn't break the jurisdictional link for me.
Wow. That's incredibly tricky. It ensures the puppet master can't hide behind a lack of jurisdiction just because they used an innocent puppet.
That's the perfect way to put it. It catches the puppet master no matter where they pull the strings from.
Let's understand the next point from here. All right, slide 5 is dense with information. It's titled Section 201, Specific Offenses and Jurisdiction, and it's very visual with 4 distinct icons. I can see a mask, for dacoity. There's a silhouette of a person for kidnapping, a money bag for theft, and a hand giving an item to another, which must be misappropriation.
Yes, and as we always emphasize in our judiciary classes at Target for IQ, these are specific statutory exceptions. You cannot use general logic here. You must know what the specific rule is for each of these listed offenses. Memorization is key.
Okay, I'll read them out word for word because the slide has a note that says memorize verbatim.
Please do.
First one, dacoity, escaping custody, where committed or accused found.
Kidnapping, abduction, where kidnapped, abducted, or conveyed, or concealed, or detained.
Theft, robbery, where committed or stolen, property possessed, received, retained.
Criminal misappropriation, breach of trust, where committed or property received, retained, or required to be returned and accounted for.
Okay, let's pick that apart, piece by piece. Look at the green key addition box on the slide. It highlights 2 words, accounted for. This phrase is specific to criminal breach of trust. This is what I call the white-collar clause. Suppose you're a sales agent for a company that's based in Delhi, but your territory is Mumbai. You collect cash payments from clients in Mumbai. Your employment contract says you're supposed to send the accounts and the money back to the head office in Delhi.
Okay.
If you pocket the money in Mumbai, well, obviously Mumbai has jurisdiction, but because you failed to account for that money in Delhi, as you were legally required to do, Delhi also has jurisdiction. This is a huge help for businesses, allowing them to prosecute defaulting employees at their head office location.
That's very practical for corporate crime. And the yellow exam alert focuses on dacoity.
Yes, where the accused is found. This is a major extension of jurisdiction. Think about dacoits. They are often roving gangs. They might loot a village in Bihar and then flee to West Bengal to lie low.
So do the Bihar police have to go get them?
They could, but what if the West Bengal police catch them first? Does the court in Bengal have to send them all the way back to Bihar for trial? No. Section 201 says if you find a dacoit or an escaped prisoner in your jurisdiction, you can try them right there. It's a kind of possession rule, but for people, it's about convenience and speedy justice.
And the red trap box for theft.
Possession of stolen property gives jurisdiction even if the theft happened elsewhere. This is another crucial one. If a thief steals a car in Chandigarh and drives it to Pune and is finally caught with the stolen car in Pune, the Pune court can try him for the theft that happened in Chandigarh.
Even though the act of stealing didn't happen in Pune.
Correct. The law sees the continued dishonest possession of the stolen property in Pune as an extension, a continuation of the original offense of theft.
So, as Successor would likely advise, the key is to look for the connectors, where the person went or where the property ended up.
That's it exactly. Follow the movement. Follow the person or follow the thing. That's where you'll find jurisdiction.
Let's understand the next point from here. Okay, slide 6 feels very contemporary. The title is Section 202, Electronic Cheating in Marriage Offenses.
This is where the Bnss really shows its updates over the old CRPC.
We've got 2 large icons. On the left, a gold smartphone with an envelope icon flying out of the screen, which obviously symbolizes electronic messages. And on the right, 2 interlocking golden wedding rings.
Cybercrime and family law, side by side.
So reading the text for electronic cheating, which is Section 202, subsection 1, Deception via electronic communications letters. Jurisdiction, where sent or where received. And there's a subpoint for delivery of property, where delivered by deceived person or are received by accused. Then, for bigamy and other marriage offenses, under subsection 2, it lists 3 options. 1. Where offense committed or R2. Offender last resided with spouse by first marriage or R3. Wife by first marriage has taken a permanent residence after offense.
Okay, let's start with the electronic part. Look at the green update box. It says, explicit mention of electronic communications is a Bnss update. In the old days, the law talked about letters. But what about a fraudulent WhatsApp message?
Exactly.
If you send that message from Bangalore to a victim who is sitting in Hyderabad and you trick them into transferring money, where is the crime? Section 2021 makes it crystal clear. Jurisdiction lies where the message was sent, so Bangalore, AD where it was received, so Hyderabad. It covers email, SMS, instant messaging, everything. It removes all the ambiguity of cyber fraud jurisdiction.
That's a much-needed update.
Right.
Now, for the marriage offenses, this is really important. The red trap box highlights a specific part. The permanent residence clause applies specifically to the wife by the first marriage.
This is a critical protective provision, and you need to listen to this carefully. If a husband commits bigamy, he marries a second wife while his first marriage is still valid, it's often the first wife who is left vulnerable. She might be thrown out of her matrimonial home. She might have to go back to her parents' home in a completely different state.
And it would be a hardship to force her to go back to file a case.
A massive hardship. The law used to say she'd have to go back to where the husband lives or where the second marriage took place to file a case. That's just further harassment. This law changes that, it says. No. If the wife by the first marriage has taken up permanent residence, say at her parents' home after the offense, she can file the case right there. The court comes to her.
But the trap is that this is a one-way street.
It is. It is a provision designed to protect the vulnerable party. It applies only to the wife by the first marriage. The husband cannot use the fact that he has moved to a new city to create a new jurisdiction for himself. And the key is permanent residence, not just checking into a hotel for a week.
That feels like a very powerful tool for women facing such a situation.
It is. It's meant to balance the power dynamic in such disputes.
Let's understand the next point from here. Slide 7 has a lovely illustration. It's a vintage steam train on tracks and a classic sailing ship on blue water. The title is Section 203, Offenses on Journey or Voyage.
This section creates what I like to call a corridor of jurisdiction. It moves along with the traveler.
The scenario text reads, offense committed whilst the person by or against whom, or the thing in respect of which, the offense is committed is in the course of performing a journey or voyage. And the rule is, inquired into or tried by a court through or into whose local jurisdiction that person or thing passed in the course of that journey or voyage.
So let's look at the green scope box.
Right.
It clarifies. Applies to both the person committed against and the thing in respect of which offense is committed. This is important. It's not just about assault on a train, it's also about theft.
So give us a practical example.
Okay. Imagine you're on the Rajdhani Express going from Delhi to Mumbai. You board at night, have your dinner, and fall asleep somewhere near Mathura. You wake up the next morning near Kota, and you realize your suitcase is gone.
We have no idea where it was stolen.
None at all. Was it stolen in UP Rajasthan? You were asleep. Section 203 says you don't need to know. Every single district that the train passed through while you were on that journey has jurisdiction. The jurisdiction is like a passenger on the train with you. You can file the complaint in Mumbai when you arrive, or you could file it back in Delhi, or at any major station in between.
That makes it so much easier for the victim. But there's a red trap box with a warning. It says, does not apply if the journey was broken, stopped for a long duration, unconnected to the travel.
Yes, this is the limit. The protection is for an uninterrupted journey. Let's change the facts. Suppose you get off the train at Kota, you check into a hotel for 2 days to visit some friends, and on the second night, your bag is stolen from your hotel room in Kota.
The journey was broken.
Exactly. You cannot then go to Mumbai and try to file a case under Section 203. Your journey was broken when you checked into the hotel for a separate purpose. The offense happened at a stationary place, the hotel. So, the normal rule of Section 197 applies. Only the court in Kota has jurisdiction. The journey protection ends when the journey itself effectively pauses for reasons unrelated to the travel itself.
So the absolute key is the continuity of the movement.
Correct. The phrase is in the course of performing a journey. Once you're no longer in that course, the section no longer applies.
Let's understand the next point from here. Okay, slide 8 moves on to sections 205 and 206, transfer powers and deciding doubts. The visual here is a clear hierarchy flowchart. It shows the High Court at the top, an arrow pointing down to the state government, and another arrow down to the various courts.
And this slide is important because it highlights a power structure that often confuses students, specifically the role of the state government.
I'll read Section 205, which is about the power to transfer. It says, the state government may direct that any cases or class of cases committed for trial in any district may be tried in any sessions division. And there's a proviso, must not be repugnant to High Court, Supreme Court directions. Then we have Section 206 for deciding doubts. It has 2 rules. 1, if subordinate to same High Court, decided by that High Court. 2, if not subordinate to same High Court, decided by High Court within whose local limits proceedings were first commenced.
Okay, let's focus on 205 first, and the yellow hierarchy box. What does it say?
It says, note that Section 205 gives power to the state government, not just the courts.
Right. We usually think of transferring a case as a purely judicial act. One judge transfers to another. But Section 205 gives this power to the executive, the state government. The question is why? Well, it's usually for reasons of public order. Imagine a very sensitive trial is happening in District A, and it's causing riots and unrest.
The government might want to move it to a calmer location.
Precisely. The state government can issue an order saying, for the sake of public peace and safety, move this trial to the Sessions Court in District B. It's an administrative safety valve to maintain law and order.
Now let's look at Section 206 in the red trap box. This seems critical. It says, in different AGC jurisdictions, priority goes to where proceedings commence first, not where the offense happened.
This is the ultimate tiebreaker rule. It's a fantastic prelims question. Suppose a massive cybercrime affects thousands of people in both Uttar Pradesh and Madhya Pradesh, 2 different states, 2 different high courts. The police in both states investigate, and proceedings begin before magistrates in both states. Now, who decides which state will ultimately handle the main trial?
It seems like a jurisdictional stalemate.
It would be, without this rule. The law says, forget about where the server was or where the main victim lives, look at the clock. Did the magistrate in UP take cognizance of the case first, or did the magistrate in MP? If the UP proceedings began at 9 a.m., and the MP ones at 11 a.m., then the Allahabad High Court in UP gets to decide the doubt. It gives absolute priority to the court that moved first.
It's a first in time, first in right principle, but for deciding who gets to decide.
That's a perfect summary. It prevents an endless tug of war between 2 high courts.
Let's understand the next point from here. Slide 9 takes us international. The title is Sections 208 and 209, Offenses Outside India. And the visual is powerful. It's a globe. But stamped across it in big, gritty red letters is the phrase sanction required.
Extraterritorial jurisdiction. This is for when Indian citizens commit offenses on foreign soil.
The text first defines who it applies to. Who? Citizen of India, anywhere, or non-citizen on an Indian ship aircraft.
So it follows the person, if they're a citizen, or the territory, if it's an Indian-flagged vessel.
Then it defines the jurisdiction. Dealt with as if committed at any place within India where he may be found. Or where offense is registered in India.
And that's the key phrase, as the yellow exam focus box points out, where he may be found.
And finally, the big one, the condition precedent. Previous sanction of the central government is mandatory.
Okay, so let's use an example. An Indian citizen commits a murder in London and then flees back to India to escape British justice. Now, obviously, the crime didn't happen in India, so where do we try him? The law says it's simple. Wherever you find him. If he's arrested at the airport in Chennai, the Chennai court gets jurisdiction. If he makes it to his ancestral village in Punjab and is caught there, the local court in Punjab gets jurisdiction.
It makes it very flexible.
It has to be, because there is no Indian locus delicti. The jurisdiction attaches to the person of the accused once they are on Indian soil.
But that red box is very stark. Absolute bar. No inquiry or trial without central GUFT sanction.
This is non-negotiable. And it's all about international diplomacy and state sovereignty. You can't just have a local court in India starting a trial for something that happened in another sovereign country without the central government's approval. Maybe the act wasn't even a crime in that country. Maybe there's an extradition treaty that needs to be considered. The central government, specifically the Ministry of External Affairs and Home Affairs, acts as the gatekeeper. Without that piece of paper, that sanction order, the court has zero power to proceed. It's an absolute bar.
The slide also has a green evidence box referencing Section 209. It says, Central Govt may direct depositions made before diplomatic officers to be received as evidence.
That's a practical tool to solve a logistical nightmare. How do you get witnesses from London to come and testify in a court in Punjab? It's difficult and expensive. So Section 209 provides a solution. The witnesses can go to the Indian High Commission in London, give their statement on oath before a designated diplomatic officer, and that written deposition can then be sent to India and used as evidence in the trial. It bridges the geographic gap.
Very clever. It allows the trial to proceed with foreign evidence.
Without it, most such trials would be impossible.
Let's understand the next point from here. All right, we're now moving into a new chapter, Chapter 55. This is Slide 10, titled Section 210, Cognizance by Magistrates.
Okay, if jurisdiction was about where the trial happens, cognizance is about how it starts. This is the heartbeat of the criminal process. Nothing moves forward without this step.
The visual is quite metaphorical here. It's a golden lock and a key. The key is labeled Judicial Mind. And there are 3 arrows pointing from different sources towards a central box that just says cognizance.
That's the perfect image. The case is locked until the magistrate uses the key of their judicial mind to open it.
So the slide lists the 3 sources, the 3 ways a case can be opened under Section 210. First, Source 1, Complaint of Facts, S-210-1.
This is a private citizen coming to court.
Second, Source 2, Police Report, recorded in any mode including digital mode.
S-210-1B.
The charge sheet, filed after an investigation. And third, Source 3, Information Non-Police or Own Knowledge, S-210-1C.
This is the magistrate acting on their own.
Now, the yellow new edition box points something out in Source 2. It says, digital mode is explicitly mentioned regarding police reports in Bnss.
Yes, and this is a simple but important update. It formally validates the e-courts project. A police report or charge sheet no longer has to be a massive physical stack of papers carted into the courtroom. It can be a secure digital file submitted through the official portal. The law now explicitly recognizes and enables this. It's about modernization.
The green definition box gives us the core concept: cognizance, application of judicial mind to suspected commission of offense.
Students, you need to tattoo this concept on your brain. The word cognizance is not defined anywhere in the code. It's a judicial concept developed through case law. It is that crucial moment when the magistrate looks at the papers in front of him, be it a private complaint or a police report, and applies his mind to the facts and decides, yes, on the face of it, it appears a crime has been committed, and I will now set the legal process in motion. It is the moment the court officially takes notice.
And the red trap box has a statement that seems fundamental. Taking cognizance is of the offense, not the offender.
This is a favorite mains question. It's a subtle but vital legal distinction. When a magistrate takes cognizance, he is taking note of the crime. For example, a dead body is found. He takes cognizance that an offense of murder under Section 302 appears to have been committed. At that stage, he does not need to know who did it. The police report might name Mr. X as the accused, or it might say the accused is unknown. It doesn't matter for cognizance. The cognizance is of the what, not the who.
So the focus is on the act itself, the offense, and the specific individuals come into the frame later in the process.
Exactly. If you write in your exam that the magistrate takes cognizance of the accused, it's a fundamental error. It shows you don't understand the sequence of the criminal trial.
Let's understand the next point from here. Okay, Slide 11 is titled Safeguards and Session Court Limitations. The visuals are a big red S.P sign icon and a blue arrow labeled Transfer.
These are the checks and balances within the system to ensure fairness and proper procedure.
I'll read from Section 211, which deals with cognizance on own knowledge. It says, when magistrate takes cognizance on own knowledge, Clause C, accused must be informed of right to be tried by another magistrate. If accused objects, case shall be transferred to another magistrate specified by CJM.
Now, the green justice principle box explains the why behind this. It says, S211 ensures impartiality. A judge cannot be a witness in his own cause. This is the principle of nemo judex in causa sua.
Give us an example of how that would work.
Of course. Imagine a magistrate is walking down the street on his way home, and he personally witnesses a man punching another man. The next day in court, he can't find a police report or a complaint. So he says, I take cognizance of this assault under Clause C based on my own knowledge because I saw it happen.
So now he's both the witness and the judge.
And that's a massive conflict of interest. It violates natural justice. So Section 211 provides the solution. It says to the magistrate, if you do this, you must stop and tell the accused, look, I personally saw what happened. Do you still want me to be the judge in your case, or would you prefer a different, impartial judge? If the accused objects, the case must be transferred.
The red trap box really emphasizes this point. Failure to inform the accused under S-211 is an illegality, not just an irregularity.
This is a huge distinction. An irregularity is a minor procedural error that can often be cured. But an illegality is a fundamental defect that voids the entire proceeding. If the magistrate forgets to inform the accused of this right and goes ahead and convicts him, that conviction will be set aside on appeal. The whole trial is a nullity. It's a powerful safeguard for the accused.
Then we have Section 213 on the Court of Session. No court of session shall take cognizance as a court of original jurisdiction unless the case is being committed to it by a magistrate, except as expressly provided.
This establishes the hierarchy. The Sessions Court is a superior court. It typically deals with serious offenses like murder or rape, but it doesn't usually take cases directly from the police or the public. The procedure is that the case first goes to the magistrate, who conducts preliminary proceedings. If the magistrate finds there is a case to be tried by the Sessions Court, he then commits it, sends it up to the higher court.
So the magistrate acts as a filter.
Exactly. It's a court of second instance for most offenses. Now, the slide notes there's an exception, which the yellow exam alert mentions, regarding defamation of high dignitaries. We'll get to that specific exception a bit later.
Let's understand the next point from here. Slide 12. The title is Section 215, Prosecution for Contempt and Public Justice. And the visual is a silver shield, and it's labeled Public Justice.
This section isn't about protecting an individual victim. It's about protecting the machinery of the law itself from being undermined.
The table on the slide lists the offenses covered. It includes things like contempt of lawful authority, offenses against public justice with perjury in parentheses, and offenses relating to documents and evidence. The next row specifies the requirement. Complaint in writing is mandatory. And the last row asks who files. The answer, public servant concerned or superior, the court concerned.
Okay, now look at the red trap box. This is where the money is. It says, a police report, FIR, is not sufficient here. A written complaint from the public servant or court is required.
So what does that mean in practice?
It's vital. Let's take the example of perjury. A witness comes into court, takes an oath, and then tells a blatant lie. This is a crime. But can the judge just pick up the phone and tell the local police station to file an FIR against the witness for perjury? The answer is no. Absolutely not.
Why not?
Because perjury is an offense against the court's dignity and authority. The law wants to keep the police out of the internal administration of the court. So the procedure is that the court itself must conduct a preliminary inquiry, form an opinion that a prosecution is necessary, and then draft a formal written complaint. That complaint is then sent to a magistrate for trial. The police cannot initiate this process on their own.
So it's a closed loop. The complaint has to originate from the public servant or the court that was affected.
Precisely. It prevents misuse and ensures that prosecutions are only launched in serious cases, not just because a public servant feels insulted.
The green withdrawal box also notes, the authority who filed the complaint can also order its withdrawal if the trial hasn't concluded.
Yes. That's a sort of forgiveness clause. If the witness who lied comes back the next day, apologizes profusely to the court, and corrects their statement, the court might decide that a full-blown prosecution is no longer in the interest of justice and can withdraw its own complaint. It provides an off-ramp.
Let's understand the next point from here. Slide 13 is about Section 217, Offenses against the State and Conspiracy. The visual is a set of flow arrows linking different types of offenses to their specific sanctioning authorities.
Right. This is all about crimes that affect national security and public order. The law says you can't just have any individual filing a case accusing someone of, say, waging war against the state. It needs a high-level check.
I'll read the content from the slide. For Chapter 6, Bnss, Offenses Against the State, the sanctioning authority is the central or state government.
The highest level.
For S-15351 Bnss, promoting enmity between groups, etc., the authority is central government, state government, or district magistrate.
Ah, a new player enters.
And for criminal conspiracy, for offenses punishable with less than 2 years, the requirement is the consent of state goited or district magistrate.
Okay, the yellow exam alert is key here. It says, focus on the district magistrate, DM. Note exactly where the DM has power versus where only the government has power. This is a classic prelims question. They'll give you an offense and ask who can grant sanction.
So for the most serious offenses like waging war, it's only the central or state government. The DM is too junior.
Correct. But for something like promoting enmity between groups under Section 195, which is more of a local law and order issue, the district magistrate is empowered to grant that sanction. You have to create a mental chart which offense maps to which authority.
And the red trap box points out a proviso. No consent is needed for conspiracy if Section 215 applies.
This is a classic legal interpretation rule. The specific overrides the general. Let's say you conspire with someone to commit perjury in court. Perjury is an offense covered by Section 215, so which rule do you follow? The general rule for conspiracy under 217, or the specific rule for perjury under 215?
The specific one.
Exactly. The law says you follow the Section 215 procedure, a complaint by the court. You don't need a separate government sanction for the conspiracy part under Section 217. The special law for the main offense overrides the general law for conspiracy. It's a very neat legal point.
And, as always, a great place to set a trap in an exam.
Always.
Let's understand the next point from here. Slide 14. This one has a very dignified image of a judge's chair and gavel. The title is Section 218, Prosecution of Judges and Public Servants.
This is the famous protective sanction provision. The idea is to provide a shield to public servants so they can perform their official duties without fear of frivolous or malicious prosecution. If every time a judge denied bail, the accused's family could file a criminal case against them, the system would collapse.
So let's see who it applies to. The slide says, who? Judge, magistrate, or public servant not removable save by or with the sanction of the government.
So this generally covers senior officials.
The condition is very specific. Offense committed while acting or purporting to act in the discharge of his official duty.
A crucial phrase.
And the requirement. Previous sanction of central government or state government is required.
Now let's talk about that condition. Acting or purporting to act in the discharge of official duty. This is the key. There has to be a reasonable connection or nexus between the act and the official duty. If a police officer takes a bribe to not register an FIR, that act of taking a bribe is connected to his official duty of registering FIRs. So you'd need sanction.
But what if the same officer commits a murder in a personal property dispute?
Then there is no connection to his official duty. Committing murder is not part of a police officer's job. In that case, no sanction would be required. The act must be something that can be seen as related to the job, even if it was done wrongfully.
The green timeline box points at a major procedural update in the Bnss. Government must decide on the sanction request within 120 days, else it is deemed to have been accorded.
This is a game changer. In the old system, under the CRPC, getting sanction was a nightmare. The government department would just sit on the file for years and years, effectively giving the corrupt official a permanent shield through inaction.
A pocket veto.
A pocket veto, exactly. Now, the Bnss puts a clock on it. It tells the government, you have 120 days from the receipt of the request. If you don't say no within that time, the law will assume you have said yes. Silence now equals consent. It's a major step towards accountability.
That prevents the government from blocking justice simply by doing nothing. But there's a big red exception box that says, no sanction required for sexual offenses, like S63, 64 Bnss, or for trafficking.
And this is absolutely vital. The logic is simple and powerful. Committing rape or sexual assault can never, under any circumstances, be considered part of a public servant's official duty. You cannot claim you were purporting to act as a police officer while committing a sexual crime. So, for these specific heinous offenses, the shield of sanction is completely stripped away. The police can investigate, and the court can take cognizance immediately without waiting for any government permission.
It's a clear statement that some acts are so far beyond the pale that they can never be protected.
Exactly. It's a much-needed exception.
Let's understand the next point from here. Okay, slide 15 is titled Section 219, Offenses Against Marriage. The icon is a simple family stick figure, parents and a child.
This section reflects a general legal policy. The state generally treats marriage as a private institution. It prefers not to interfere in domestic matters unless a member of the family complains. It's not the state's job to police every marriage.
So the general rule on the slide says, no court shall take cognizance, except upon a complaint made by some person aggrieved by the offense.
The word aggrieved is key. The complaint must be filed by the victim, the person who has been wronged. A random neighbor or a social activist generally cannot file a complaint for bigamy.
But then the slide has a flow of exceptions under the heading, who else can file? It's quite a list.
Yes, because the law recognizes that the aggrieved person may not always be in a position to file a complaint themselves.
So first, if the aggrieved person is a minor, mentally ill, or a partnation woman, the complaint can be filed by some other person with leave of the court.
Right, so a father can file on behalf of his minor daughter, but he needs the court's permission.
Next, if the husband is in the armed forces and can't get leave, The complaint can be filed by an authorized person.
A practical exception for soldiers.
And the longest one, if the wife is aggrieved by bigamy, S81 Bnss, the complaint can be filed by her father, mother, brother, sister, son, daughter, or any other relative by blood, marriage, or adoption.
Look at how exhaustive that list is. It's the wife's entire support network. Why? Because in many parts of our society, a woman whose husband marries a second wife is often left vulnerable, intimidated, and financially dependent. She might be too scared to file a complaint herself. So the law empowers her entire family, her safety net, to file the complaint on her behalf. It's another protective provision.
That makes sense. But the red trap box points out a very specific limitation. It says, for enticing a married woman, S83 Bnss, only the husband is considered aggrieved.
Yes, this is a bit of a historical holdover. The offense of enticing or taking away a married woman is legally considered a wrong committed against her husband. It's about the violation of his marital rights. So in that specific case, the wife's father or brother cannot file the complaint. Only the husband, or in his absence, the person who is caring for the wife on his behalf, is considered the aggrieved person who can set the law in motion. It's a very specific distinction you need to remember.
So for bigamy, the wife's family can complain, but for enticing, only the husband can.
In essence, yes. You have to look at who the law considers the primary victim of that particular offense.
Let's understand the next point from here. Slide 16 zooms in on some very specific limitations. The title is Sections 219.6, 220, and 221. And the visual is a calendar icon with 1 year written on it and a big red prohibition or ban symbol over it.
Yes, this slide is all about limitation periods and specific procedural bars. Very, very sensitive and important area.
First, under the heading Marital Rape Exception, Acts 219s, the offense is described as sexual intercourse by a man with his own wife, the wife being under 18 years of age. And then the crucial part, the limitation. No cognizance shall be taken of this offense if more than 1 year has elapsed from the date of the commission of the offense.
Now, this is what the yellow limitation box is highlighting. The 1 year bar in S219.6 is a strict limitation period unique to this offense. The law, as it stands, recognizes that sexual intercourse with one's own wife, if she is under 18, is an offense, as the general age of consent is 18. However, the legislature has also decided that to, preserve the sanctity of the marital relationship and to prevent stale cases from being filed years later, potentially for malicious reasons, it needs to put a strict clock on it.
So you have to complain within a year.
You must. If the complaint is filed 1 year and 1 day after the alleged act, the court is legally barred from taking cognizance. The door is shut. It's a very strict and absolute limitation.
Then the slide lists two other sections. Section 220, which relates to Section 84, the Bnss adultery, says the complaint can be by the aggrieved person or relatives. And Section 221, relating to Section 67 Bnss, cruelty within a marital relationship, says cognizance only upon complaint by wife against husband.
Okay, now look at the red trap box. It's comparing these different provisions. What does it say?
It says, contrast S220, which allows a police report or a complaint, versus S219, which is strictly complaint-based.
This is a critical distinction for procedure. You have to look at the first schedule of the code or text of the section itself to see if an offense is cognizable or non-cognizable. A cognizable offense means the police can register an FIR and investigate on their own. A non-cognizable offense means the police cannot get involved without an order from a magistrate. The process must start with a private complaint to the court. You have to know which marriage offense falls into which category. It's a very common exam question.
So some family matters allow police intervention and others strictly require the family to go to court first.
That's the essence of it, yes.
Let's understand the next point from here. All right, slide 17. The title is Section 222, Prosecution for Defamation. The visual is very fitting. It's a gold podium with several microphones on it, looking like a formal press conference setup for a high-level official.
Exactly. This is the dignitary section. It carves out a special procedure for when high public functionaries are defamed.
The slide first states the general rule, which is that a defamation case requires a complaint by the aggrieved person. But then it highlights the exception for certain dignitaries. President, vice president, governor, ministers, and other public servants for acts done in the discharge of their public functions. And the procedure for them is unique. A court of session may take cognizance of such offense without the case being committed to it, upon a complaint in writing made by the public prosecutor.
And this directly answers the question we raised back on slide 11. Can a sessions court ever take original cognizance of a case bypassing the magistrate?
Yes.
This is the primary example.
So why this special procedure?
The thinking is that if, say, a union minister is defamed in relation to his official duties, it's not just a personal insult, it's an attack on the office itself. So the state can take up the prosecution. The public prosecutor, who is an agent of the state, can file a complaint directly in the higher court, the Court of Session. It's meant to expedite the process and give it a certain level of gravitas, avoiding having high dignitaries go through the entire process in the lower courts.
But the red clarification box adds an interesting point. The private right of the person to file a complaint personally is not affected by this.
This is very important. This special procedure is an additional option, not a replacement. The minister in our example can still choose to file a regular private complaint like any normal citizen in the magistrate's court if he wants to. The public prosecutor route is an extra privilege given to the office, not a restriction on the individual's personal legal rights. He has two paths to choose from.
That's a key distinction. It's an alternative, not an exclusive route. Let's understand the next point from here. Slide 18 brings a lot of these ideas together. It's titled The Sanction Matrix, and it's a summary table, a revision chart.
Exactly. And this is a slide that, as we say at Target for IQ, if you can just memorize this table, you can probably secure at least 2 marks in your prelims paper. It's that high yield.
Okay, I'll read out the rows of the matrix.
S215, contempt justice, complaint by court public servant.
S217, state conspiracy, sanctioned by a central state government or district magistrate.
S218, judges public servants, sanctioned by Government, central state.
S219, 222, private wrongs like marriage defamation, complaint by aggrieved with its own exceptions.
It lays it all out. Now, look at the green memory tip on the slide. It provides a useful shorthand.
It says, offenses against the state involve the district magistrate. Offenses against judges and senior public servants involve the government.
That's a good way to quickly differentiate between 217 and 218. The district magistrate, as the chief administrative officer of the district, is concerned with local public order stuff, which is often what Section 217 offenses relate to. But the government, central or state, is responsible for its own employees, the public servants, which is what Section 218 is about.
And the yellow box asks the fundamental question. Why have these bars to cognizance at all? The answer given is to prevent frivolous and malicious litigation against the machinery of the state and in private domestic matters.
And that's the whole point. These sections 215 to 222 are filters. They are gates that a case must pass through before it can even start. The idea is to protect public servants from harassment and to keep the courts from being flooded with trivial or vexatious domestic disputes. They ensure that only serious, credible matters proceed to trial.
So they're to check on the misuse of the legal process itself.
Perfectly put.
Let's understand the next point from here. Okay, slide 19. The title is Section 223, Examination of Complainant. The visual is a clipboard with a checklist on it and a process flow with 4 steps.
Listeners, I need you to wake up now. Put down whatever you're doing. This section, particularly the first proviso to it in the Bnss, is arguably the single most critical procedural update in this entire part of the code. This changes everything about how complaint cases start.
Wow. Okay, I'll read the basic steps first, which are similar to the old law.
A magistrate taking cognizance of an offense on complaint
Shall examine upon oath the complainant and the witnesses present, if any.
The substance of such examination shall be reduced to writing.
And shall be signed by the complainant and the witnesses and also by the magistrate.
That's the standard procedure. Now read the green critical update box. This is the revolution.
It's in all caps. Critical update. Provided that no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard. First proviso to S223.
Let that sink in. Under the old CRPC, the accused person had no idea a complaint had been filed against them at this stage. The magistrate would read the complaint, examine the complainant and his witnesses in a closed room, and if he was satisfied, he would issue a summons. The first time the accused heard about the case was when the summons arrived at their door.
But this changes that completely.
Completely. The new Bnss in Section 223 introduces a massive, radical change. It says the magistrate cannot take cognizance, cannot even start the case without first giving the accused person a chance to come and be heard. This means before the case is even officially registered, the accused gets a notice and an opportunity to appear and say, Your Honor, this complaint is completely false, and here is the evidence to prove it.
So it brings the principle of audi alteram partem, hear the other side, right to the very threshold of the case.
Precisely. The yellow major shift box on the slide summarizes it. The accused now has a right to be heard even at the precogniment stage in a complaint case under S2233. It could potentially weed out a lot of false and malicious cases right at the beginning.
That's a huge shift in the rights of the accused.
It is. It changes the entire defense strategy. You don't wait for the trial to start. You fight to prevent the trial from ever starting. It's a massive development.
Now, the red trap box notes an old exception that remains. If the complaint is made in writing, this examination is not needed if the complaint is filed by a public servant acting in his official capacity or a court.
Yes, that part remains the same. The law presumes that when a public servant or a court files a written complaint, they have already applied their mind and are acting responsibly. We trust them, so we don't need to put them on oath immediately. But for all private complaints filed by citizens, this examination on oath, and now, crucially, the opportunity for the accused to be heard, is central to the process.
Let's understand the next point from here. All right, slide 20. This one covers sections 224 and 225, competence and postponement. The visuals are a pause button and a forward arrow icon.
This slide deals with the administrative side of things. What does a magistrate do if they get a complaint but realize, wait a minute, I can't or shouldn't handle this right now?
Okay, so section 224 is for when the magistrate is not competent to take cognizance. The procedure is simple. If the complaint is in writing, the rule is to return it for presentation to the proper court. If it's not in writing, the magistrate should direct the complainant to the proper court.
A very simple, straightforward administrative rule. If it's a piece of paper, hand it back with instructions. If it was an oral complaint, just tell them where they need to go. No fuss.
Right. Now, section 225 is about postponement of issue of process. This seems more substantive. It says it is mandatory if the accused is residing at a place beyond the area in which he exercises his jurisdiction.
This is the pause button.
And the action required is to postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made by a police officer for the purpose of deciding whether or not there is sufficient ground for proceeding.
This is a hugely important safeguard against harassment. Imagine you live in Bangalore. Someone with a grudge against you travels to a remote court in, say, Assam, and files a completely false complaint against you.
And the Assam court just issues a summons.
Under the old system, that could happen, and you'd have to travel all the way from Bangalore to Assam just to deal with this fake case. It was a tool for harassment. Section 225 puts a stop to that. It tells a magistrate in Assam, if the accused in this complaint lives outside your jurisdiction, you cannot just issue a summons blindly. You are mandated by law to first press pause. You must conduct some kind of inquiry yourself or ask the local police there to verify the claims just to make sure the case is not frivolous before you drag a person across the country.
So the red trap box on the slide is absolute. It says, process cannot be issued against a person residing outside the court's jurisdiction without first conducting this mandatory inquiry.
Yes, the Supreme Court has been extremely strict about this. This inquiry is not optional. It is the shield that protects citizens from being harassed through geographically distant and malicious litigation.
Let's understand the next point from here.
Okay.
Slide 21 is the master flow chart, pre-process stages and cognizance. This lays out the entire sequence we've been discussing in a single horizontal timeline.
This is your revision tool. This is the structure you should have in your mind when you're writing a mains answer on this topic. It helps you visualize the sequence of events.
I'll read the flow from left to right. It starts with offense committed, then an arrow to check jurisdiction, S-197-209, then to initiation of proceedings via complaint, police report, or info, S-210. From there, an arrow points to a crucial step. Check for bars of cognizance, need sanction, public servant, marriage offense, S2 of 15-222.
And notice the order. You check for the bars before you take cognizance. You cannot take cognizance if a mandatory bar, like the lack of a required sanction, exists.
Right. After that check, the next step is cognizance is taken by the magistrate. And immediately after that, the new step we discussed. Accused given an opportunity to be heard, S223 proviso.
The new safeguard.
Then another check. Check for residence of accused. Is it outside jurisdiction? If yes, use S225. And only after all of that, the final step, issue a process summons warrant.
You see that sequence. Jurisdiction first. Then the mode of initiation. Then checking for any legal bars. Then the magistrate applies his mind. Then the accused gets a say. Then a final check for out-of-state accused. And only at the very end of this long process does a summons actually go out. This is the timeline you must reproduce in your exam to show you understand the flow.
The red final warning box at the bottom says, missing a bar to cognizance, like sanction, is a fundamental error that invalidates the entire trial.
It's a jurisdictional defect. If a court takes cognizance and holds a full trial without a mandatory sanction having been obtained first, the entire trial is a waste of time. The High Court, on appeal or through its inherent powers, will quash the whole thing. It's a fatal flaw.
Let's understand the next point from here. We're on our final content slide, slide 22. The title is Mains Answer Writing, Strategy and Tips. The visual is a simple pen and paper icon.
And this is what Successor always emphasizes in our programs. Knowing the law is only half the battle. You have to be able to present that knowledge effectively under exam pressure.
So the slide lists 4 key tips. The first is cite specifics. Don't just say jurisdiction applies. Cite S-20113. For theft, where stolen property is found.
Be precise. It shows the examiner you know your stuff, not just the general idea.
Second tip, the or factor. In jurisdiction questions, always look for the alternative venues. The validity of a trial can often be saved because jurisdiction existed in place B, even if there was a doubt about place A.
Good point. Always think about concurrent jurisdiction.
Third, bars as exceptions. Frame your answer on sections 215, 222 as exceptions to the general rule of cognizance under section 210.
That's about structure. It shows analytical thinking, not just rote memorization.
And the last tip, which seems very important, new Bnss updates. Explicitly mention the changes like S202, electronic communications, and the S223 proviso, accused opportunity to be heard, to score bonus marks.
This is your gold mine. This is how you differentiate your answer from the thousands of others. The examiners are tired of reading the same old answers based on the old CRPC. When you mention a specific new provision from the Bnss, like the Section 223 proviso, you are signaling to the examiner that you are updated, diligent, and have studied the new law properly. That is how you get those extra 2 or 3 marks that can make all the difference.
The yellow final thought box has a famous quote. Procedure is the handmaid of justice, not its mistress.
A beautiful legal maxim. It means that procedural rules, like the ones we've discussed, exist to help justice be done in an orderly way. They are not meant to be hyper-technical traps that prevent a just outcome. That's why we have sections like 198 to resolve uncertainty and other sections to cure minor irregularities. The ultimate goal is to decide a case on its merits, not to get stuck fighting over the venue forever.
And the final red box, a word of caution under avoid. Do not write section numbers if you are unsure. It is better to write as per the relevant provisions of Bnss than to write the wrong section number.
That is the golden rule of answer writing. Writing the wrong section number is a negative. It's better to be vaguely correct than precisely wrong. If you're not 100% sure it's section 198, just say, the relevant provision dealing with uncertainty of jurisdiction, you're safe, and you've still shown you know the concept. Be smart.
And that brings us to the end of our slides. This has been a really comprehensive word-for-word, slide-by-slide walkthrough of these critical chapters of the Bnss.
It has. We've journeyed all the way from the geography of crime under jurisdiction to the power of the magistrate to start a case under cognizance, the various bars and filters on that power, and finally, the crucial new rights given to the accused at the very threshold. For any judicial services aspirants, sections 197 to 225 are not just dry procedure. They are the fundamental rules of engagement for every single criminal case you will ever handle.
We really hope this detailed audio companion helps you visualize, understand, and most importantly, memorize these critical sections for your exams. This has been a deep dive explanation for Target for IQ conducted under the direct guidance of Successor.
Keep revising, keep practicing your answer writing, and keep learning the nuances. All the best.
Thank you for listening.
Let's understand the next point from here. Welcome back to the Deep Dive. Today, we are really shifting gears. We're moving from more general topics into something incredibly specific, incredibly procedural, and frankly, high stakes for anyone looking to join the judiciary.
That's right. We are essentially stepping into the magistrate's chambers today. We're going to be looking at the Bharatiya Nagarik Suraksha Sanhita, the Bnss, and really focusing on that critical journey, the path from a private citizen's complaint all the way to the formal framing of a charge.
And it really is a fascinating procedural journey. I mean, for you listening, especially if you're an aspirant for civil judge, APO, or aiming to clear those PCS-J exams, this isn't just another discussion. We want this to feel like a masterclass.
We're going to try and decode what the slides call the pre-trial proceedings. I always think of this as the engine room of the judiciary. It's where the real work happens before you even get to a trial.
Absolutely. And to guide us through this, we have what is essentially a full set of lecture slides. Think of this as the gold standard material you'd get from a top-tier judiciary coaching center. Our plan is to walk through this slide by slide.
And we won't be rushing. We want to really squeeze every single ounce of value from sections 223 right through to 234 of the Sanhita.
So the mission for today is clear, isn't it? It's about understanding how the machinery of justice actually works, how it filters out the noise.
Precisely. How does a magistrate distinguish between a complaint born from a genuine crime and, say, a frivolous grudge filed just to harass someone? That is what these sections are fundamentally all about.
Okay, let's jump right in with the first slide. I'm looking at it now. The title is The Procedural Chronology, From Complaint to Charge. And visually, it's quite powerful.
It is, isn't it?
You have this heavy, dark wood gavel, and it's resting on a stack of old, letter-bound law books. In the background, sort of faded but still prominent, are the scales of justice.
And that imagery, it's not just for decoration. It's chosen very deliberately. That gavel you mentioned, it represents the immense weight of the magistrate's decision-making power at this specific stage.
Right, because this is the pre-trial stage.
Exactly. Before the trial proper begins, the police have done their part for now, and the magistrate is really the director of the show. They're in control. The subtitle on the slide confirms our scope. A comprehensive analysis of sections 223-234 of the Sanhita.
And the slide breaks this journey down into 3 distinct chapters, which I think is a great way to structure it. First, we have Chapter 6.6, which deals with complaints.
The starting point.
Then Chapter 8, which is about the commencement of proceedings.
Getting the accused to court.
And finally, Chapter 19, which is simply titled The Charge.
The formal accusation. And look, right away, the slide gives us our first exam alert. It's highlighted in red. It says that knowing this chronology, this sequence, is absolutely vital for mains answer writing.
Why is that so critical?
Because procedural law is all about logic and sequence. Your answers have to flow logically. You can't just list sections. You have to show you understand the process. If you write an answer where the charge is framed before the process is even issued to the accused,
You fundamentally misunderstood the entire system.
you failed the question. It shows a complete lack of conceptual clarity.
The slide also has this big yellow warning label. It says trap. And the trap is, do not confuse inquiry with investigation. I have to admit, in everyday language, people use those words almost interchangeably.
They do all the time.
Yeah.
But in the Bnss and in criminal procedure, generally, they're practically enemies. They mean completely different things. Let's define them simply, just like the slide suggests.
Okay.
Investigation, you should always associate that with the police. Their job is the collection of evidence. It's finding the weapon, taking fingerprints, interviewing witnesses on the street. It's an executive function.
So investigation is about gathering the raw material.
Perfectly put. Now, inquiry is the domain of the magistrate. An inquiry is a judicial proceeding. Its purpose is the determination of truth, or at least prima facie truth. It's the magistrate sitting in court, looking at the material gathered and asking, is there enough substance here to proceed against this person?
So investigation collects the facts and inquiry weighs those facts.
That is the core distinction. If you remember that one line, you'll avoid this trap in every exam. It's a foundational concept.
That's incredibly clear. Okay, let's move to the next slide. This one has a great visual. It's titled The Life Cycle of Pretrial Proceedings, and it shows this sort of 3D winding road that connects 3 distinct phases. Phase I has a magnifying glass icon over it.
And that magnifying glass is the perfect symbol for scrutiny. This represents Chapter 16, the chapter on complaints. This is the very beginning where the machinery of justice is initiated, often by a private citizen, not the police. The magistrate is using that magnifying glass to look very, very closely at the complaint to see if it even has legs.
If it's worth pursuing at all.
Exactly. Is there any substance here, or is it just smoke?
The road then curves into phase 2. This one is marked with a courthouse icon, but it has these little arrows showing documents being exchanged. The slide labels this commencement of proceedings under Chapter 8.
This phase is all about a cornerstone of our legal system, natural justice. It's about ensuring the accused person is actually brought before the court and, crucially, receives all the documents the prosecution has against them.
Because you can't fight a ghost.
You can't defend yourself if you don't know what you're being accused of or what evidence they claim to have. This phase makes sure the playing field is, at least procedurally, level.
And that winding path ends at phase 3. The icon here is a combination of a gavel and a charge sheet. This, of course, is Chapter 19, the charge.
This is the culmination of the pretrial process. It's the moment the court formally defines the accusation. It's the precise legal formulation of the offense that the accused will have to answer for during the trial.
Now, the slide emphasizes something in bold text. It says this is a strictly logical sequence, and it lays it out with arrows. Cognizance leads to process, process leads to documents, and documents lead to the charge.
It has to be in that order. There is no other way. Think about it logically.
So why that specific order? What's the thinking behind it?
Well, you can't frame a charge against someone who isn't even aware they're part of a case, right? So first, you take cognizance, you apply your mind, then you issue process a summons or warrant to get them to court.
Okay, that makes sense. You have to bring them into the system first.
Then, once they're there, you have to give them the documents. Because how can they prepare their defense if they don't have the police report or the witness statements?
Right.
And only after they have appeared and received the documents can the court finally frame the charge, at which point the accused can plead guilty or not guilty. Any other order would be a violation of natural justice.
The slide also points out another trap here, and it's jumping straight to charge. It says very clearly that without establishing process, which means getting the accused to court, any charge framed is invalid.
It's void. You can't do it. It's a fatal flaw in the procedure.
And one last thing on this slide, for all the prelim students listening in, it notes that exams very often ask for specific chapter numbers. So this trilogy is one to memorize, 6th for complaints, 8th for commencement, and 90X for the charge.
Absolutely. As we often teach at Target for IQ, memorizing the chapter sequence and what each chapter contains is just as important as knowing the individual sections for those rapid-fire prelims questions. They love to ask, the issue of process is contained in which chapter?
Good tip. Let's zoom in now. The next slide takes us to the very first step in this process, Section 223, which is titled Examination of Complainant. And the slide has a very simple, clear flowchart.
It does. It goes, complaint filed, which leads to examination on oath, then the substance is reduced to writing, and finally it's signed. It's a 4-step microprocess.
So this is the first filter for any private complaint.
This is the very first test. The core concept text on the slide explains that a magistrate who has jurisdiction, upon taking cognizance of an offense on a complaint, shall examine the complainant and any witnesses present on oath.
Okay, the word shall is doing a lot of heavy lifting there, so this is not optional. It's mandatory.
It's absolutely mandatory. The magistrate has no discretion here. If it's a private complaint, they must conduct this examination. And the reason for the oath is critical. It's about verification.
To ensure the person isn't just making things up.
Exactly. Anyone can write a defamatory letter. But when you swear an oath before a magistrate, you're now under the scanner for perjury if you're found to be lying. It immediately raises the stakes and helps weed out the frivolous stuff.
The slide also emphasizes a key fact, which seems important for record keeping. It says the substance of this examination must be reduced to writing, and it has to be signed.
Yes, signed by the complainant, any witnesses who were examined, and importantly by the magistrate as well. This isn't just an informal chat. This document becomes a permanent, signed legal record. It can be used later in the trial, for instance, to contradict a witness if they change their story.
Now, at the bottom of this slide, there's a huge, crucial exam alert highlighted in a red box. It's about a new proviso in the Bnss.
And this is, without a doubt, one of the most significant changes from the old Criminal Procedure Code. If you take away only one thing about complaints in the Bnss, this should be it.
And the proviso reads, no cognizance shall be taken without giving the accused an opportunity of being heard.
This is massive. It's a paradigm shift. Under the old system, a magistrate could receive a complaint, examine the complainant, and if they were satisfied, they could immediately issue a summons to the accused. The accused person's first inkling that there's a case is when a police officer shows up at their door with a summons.
They were completely ambushed.
Completely. Now, the Bnss has inserted this new layer of protection. It's a pre-cognizance safeguard. It's designed to protect people from malicious or false complaints being filed just to harass them. The magistrate cannot skip this step.
So, just to be clear, before I am even officially named as an accused and summoned to court, I get a chance to appear and say, Your Honor, this complaint is baseless, and here's why.
That's the essence of it. It prevents that initial harassment of being dragged into the system on a frivolous complaint. It's a mandatory proviso now, and you can be sure examiners will be asking about this.
That seems like a really important change for civil liberties. But are there exceptions to this whole examination process? I'm looking at the next slide now, titled, When is Examination Not Required? And it has a list with check marks.
Yes, the law is always practical. It recognizes that in certain situations, the source of the complaint is inherently trustworthy, so you don't need that initial oath-based verification. The slide lays out 3 specific scenarios.
Okay, what's the first one?
The first is if a public servant, acting in the discharge of his official duties, makes the complaint. The key phrase there is discharge of official duties.
Right. So why the exception for a public servant?
Because there's a legal presumption of regularity. We presume that a public servant, like a food inspector filing a complaint about an unhygienic restaurant, is acting responsibly as part of their job. They're not presumed to have a personal vendetta, so we don't need to put them on oath immediately to test their veracity.
That makes sense. The second exception listed is if a court makes the complaint.
Again, that's logical. If a court itself is complaining about something, for example, someone committing perjury in its presence, it has official standing. The complaint is coming from a judicial body, so it's taken at face value.
And the third exception is case made over, under Section 212. What exactly does made over mean in this context?
Just needs transferred. Let's say Magistrate A is the chief judicial magistrate. He receives the complaint and properly examines the complainant on oath. Then, he decides to transfer the case to Magistrate B for further proceedings. In that situation, Magistrate B doesn't need to re-examine the complainant. The work has already been done correctly by Magistrate A. The record is there. It would be a waste of judicial time to do it all over again.
The slide points out a key fact about Section 217 compliance for public servants, but the main exam alert seems to be that phrase, discharge of official duties. That's the key word for prelims, isn't it?
That's the money phrase. They will build an MCQ around that. They'll give you a scenario where a public servant files a complaint about his neighbor's dog. That's not in his official duty, so he would have to be examined.
Ah, I see.
And the trap on the slide is just as crucial. Do not confuse the public servant exemption with private complaints. For any private citizen, the examination is a must. The exemption is narrow and applies only to public servants acting in their official capacity.
This reminds me, under the guidance of Successor, we always emphasize that the exceptions to a rule are where the questions almost always come from. If there's an exception, you can bet there's an MCQ waiting to be made from it.
It's the golden rule of studying procedural law. The general rule is for your understanding. The exception is for testing that understanding.
Okay, so let's say the complaint is filed in the wrong place. This brings us to the next slide. Section 224. Procedure by non-competent magistrate. The slide poses the question, what happens if the magistrate receiving the complaint cannot take cognizance? And it presents a decision tree.
Yes, and the procedure depends entirely on how the complaint was made. The tree immediately splits into 2 paths. Was the complaint made in writing, or was it not in writing, meaning it was made orally?
Let's follow the in-writing path first. Someone has submitted a written document to the wrong court.
In that case, the magistrate's duty is clear. They must return it for presentation to the proper court. But they can't just hand it back over the counter. The slide correctly notes that they must make an endorsement on the document itself.
An endorsement, what does that entail?
It's a formal note written on the complaint. The magistrate has to briefly state the date of presentation, the date of return, and the reason for the return, namely, lack of jurisdiction. This creates a formal record.
And what if the complaint was just oral? Someone walks in and starts narrating their grievance to the magistrate.
Then the procedure is much simpler. There's no paper to endorse. The magistrate simply directs the complainant to the proper court. They'll just tell them, sir, this court doesn't have jurisdiction. You need to go to court number 4 down the hall.
Now, there's a trap listed here that seems absolutely vital. It says, a non-competent magistrate cannot dismiss the complaint.
This is a favorite trick question in exams. Dismissal is a decision on the merits of the case. It implies the magistrate has heard the matter and found it to be weak or baseless.
But a non-competent magistrate can't do that.
They have no power to. Their only power is to decide on their own jurisdiction. If they don't have jurisdictions, they cannot comment on the merits. So their only options are to return a written complaint or direct an oral one. They can never, ever dismiss it. That's a huge procedural error.
Got it. Return or direct, but never dismiss. Now, let's say the complaint is with the right magistrate. Does they have to issue a summons right away? The next slide, Section 225, is about postponement of issue of process.
This is a very important discretionary power. The slide has a 4-step process flow. Step 1 is receipt of the complaint. Step 2 is the crucial decision point.
The header on the slide says the magistrate may postpone, so it's a choice.
It is. This section acts as a shield. The entire logic behind postponing is to avoid harassing potentially innocent people. Instead of immediately issuing a summons and forcing someone to come to court, the magistrate can hit the pause button to be extra sure. They do this to decide if there is sufficient ground for proceeding.
The slide highlights a key fact, though. It says this postponement is mandatory. It uses the word shall in one specific situation.
Yes, and this is another important provision. The postponement becomes mandatory if the accused person resides in an area beyond the magistrate's own jurisdiction.
Why is that specific rule there?
This is a direct response to a huge, long-standing problem in India: the filing of false, harassing cases in remote jurisdictions. Imagine you live in Delhi, and a business rival files a completely fake complaint against you in a small court in Kanyakumari.
Just the travel and logistics would be a nightmare, a punishment in itself.
Exactly. So the Bnss says that if the accused lives outside your jurisdiction, you, the magistrate, must postpone issuing the summons. You must first verify the truth of the allegations before you drag someone across the country.
So once the decision to postpone is made, what happens? Step 4 on the flowchart is the action. It says the magistrate can inquire himself or direct investigation. So the magistrate can play detective.
In a limited judicial sense, yes. They can conduct an inquiry themselves, maybe by calling a few more people to court, or they can direct an investigation to be done by a police officer, or even by any other person they think is fit. But, as always, there's a catch.
And I'm guessing that catch is on the next slide. Yes, here it is. Section 225, Provisos and Powers. There's a big red no entry or prohibited icon over a document.
Right. The slide lists the restrictions on this power to direct an investigation. The first one is critical. No investigation direction if the offense is triable exclusively by the Court of Session.
Why that restriction? Sessions cases are the most serious ones. Murder, rape, dacoity. Wouldn't you want a police investigation for those?
You would, but not at this specific stage of a private complaint. The logic is that for such grave offenses, the law prefers the magistrate to personally apply their judicial mind first. They must call the complainant and all their witnesses and examine them on oath themselves, following the procedure in Section 223. You don't just hand off a private complaint of murder to the police for investigation without first conducting a thorough judicial inquiry yourself.
Okay, so judicial scrutiny comes first for the most serious cases.
Precisely. The second restriction is that you can't direct an investigation if the complaint was not made by a court, unless you have already done the examination on oath under Section 223. The examination is the prerequisite.
The slide also talks about investigator powers under Section 225, subsection 3. It says a person not being a police officer has police powers, but with a major exception.
Yes, and this is a classic question. Say the magistrate appoints a retired, trusted official to investigate. That person is given all the powers of a police officer in charge of a police station for that investigation. They can search, they can seize evidence, but they do not have the power to arrest without a warrant.
So all police powers minus the power of arrest.
Exactly. That power is specifically excluded. And I should mention, this is a point that, under the guidance of Successor, we emphasize is a favorite for interview questions. They'll test if you know the specific limitation on the powers of a non-police investigator.
Good to know. Okay, so we've gone through scrutiny, inquiry, investigation. Now comes the moment of truth. Section 226, dismissal of complaint. The slide has a very final-looking image of a file with a big red dismissed stamp on it.
This is the end of the road for weak or frivolous complaints. After considering the statements on oath and the result of any inquiry or investigation, if the magistrate is of the opinion that there is no sufficient ground for proceeding, they dismiss the complaint.
But it's not a silent dismissal, is it? The slide lists a key requirement. It says the magistrate shall briefly record his reasons for doing so.
This is a non-negotiable requirement. A silent, unreasoned dismissal is illegal. The magistrate must write down, even briefly, why they are dismissing the case.
And why is that so important?
It's crucial for two reasons. One, it ensures the magistrate has applied their mind. Two, and more importantly, it allows the complainant to challenge the dismissal in a higher court, like in a revision petition. If there are no reasons recorded, the higher court has no basis on which to review the decision.
The slide has a trap here as well, and it's about the standard of proof. It warns that no sufficient ground does not mean proof beyond reasonable doubt.
A very common mistake for beginners. We are not at the trial stage yet. The magistrate isn't asking, is this person definitely guilty? The standard is much lower. They're only asking, is there a prima facie case? Is there enough smoke here to suggest there might be a fire worth investigating further in a trial? You must not confuse the pretrial standard with the final trial standard.
That distinction is key. Now, we've reached a sort of strategic pause in the slides. This one is an analysis slide for the whole of Chapter 16 on complaints. It has a magnifying glass hovering over the section symbol, suggesting a closer look.
It is. It's asking us to step back and look at the chapter from an examiner's perspective.
Yeah.
It points out that this chapter is really a mix of mandatory and discretionary powers.
For example.
Section 223, the examination of the complainant, is mandatory. The magistrate shall do it. Section 226, recording reasons for dismissal, is also mandatory. They shall record them. But Section 225, the decision to postpone and direct an investigation, is discretionary. The magistrate may do it. Understanding this distinction is key to a high-scoring answer.
The slide also highlights a common mistake, which you've already touched on. It's forgetting that new proviso in Section 223, the accused's right to be heard before cognizance.
And I can't stress this enough. That is the single biggest update in the Bnss compared to the old CRPC on this topic. If you write a mains answer about the procedure for complaints and you fail to mention this new proviso, your answer is fundamentally incomplete and outdated.
Finally, there's a fantastic answer writing tip. It says to use the phrase, "The purpose of this chapter is to weed out frivolous and vexatious complaints."
That is a golden phrase. If you use that in the introduction or conclusion of your mains answer, it immediately signals to the examiner that you understand the policy and the purpose behind the law, not just the black letter text. It shows deeper understanding.
A great tip. Okay, let's move on from weeding out complaints to actually starting the case. We're now in Chapter 8, Commencement of Proceedings. The first section here is 227, Issue of Process. The slide presents a simple comparison table, summons case versus warrant case.
Right. Issue of process is the formal term for the court calling the accused to appear. Now, the procedure depends on the seriousness of the case. For a summons case, a less serious offense, the rule is simple. The magistrate shall issue summons.
And for a more serious warrant case, the slide says the magistrate may issue a warrant or a summons.
That's the nuance, and it's important. A warrant case involves serious crimes, those punishable with death, life imprisonment, or imprisonment for more than 2 years. Logically, you'd think an arrest warrant is automatic, but the law gives the magistrate discretion.
So even in a serious case, they can start gently.
Exactly. If they believe the accused is a respectable person who will appear voluntarily, they can choose to issue a summons first instead of an arrest warrant. They are not forced to issue a warrant immediately.
The slide also lists a couple of strict prerequisites before any process can be issued.
Yes, 2 conditions must be met. First, a list of prosecution witnesses must be filed with the complaint. And second, any required process fees must be paid. The slide puts it bluntly, no fee, no process. It's an administrative but essential step.
And there's an exam alert here highlighting a very modern update. It says process can be issued through electronic means.
Yes, this is a big step towards modernization in the Bnss. A summons sent via email or another verified electronic method is now legally valid. It's about speeding up the process and adapting to technology.
So the accused has been summoned. Do they have to appear in person every single time? Section 228 on the next slide deals with dispensing with personal attendance. The visual is a silhouette of a lawyer standing in for the accused.
This is a practical provision for efficiency. The section says the magistrate may dispense with the personal attendance of the accused and permit them to appear by their pleader, which is the legal term for their lawyer.
But the slide has a caveat in bold. It warns, magistrate can direct personal attendance at any stage if necessary.
Absolutely. This is not a blanket permission to never show up. The magistrate can, at any point, order the accused to appear in person if it's necessary, for example, for the formal framing of charges, for identification by a witness, or, of course, for sentencing.
So the trap here, as the slide points out, is for students to think this is an absolute right of the accused.
It is not a right. It is entirely at the magistrate's discretion. The law says if he sees reason so to do, the control remains with the court.
Let's talk about smaller cases. Section 229 is titled Petty Offenses and Summary Disposal. The main visual here is a price tag icon showing max fine, $5,000.
This is a fantastic mechanism for clearing the massive backlog of cases in our system. It's for handling very small cases quickly and efficiently without a full-blown trial.
The slide defines a petty offense as one punishable only with a fine, and that fine cannot exceed 5,000 rupees.
That's the key definition, and the process is very simple, almost like a traffic ticket. The summons sent to the accused will state that if they wish to plead guilty, they could do so in writing and just remit the fine amount by post or messenger, without having to appear in court.
So it's basically summons followed by a written plea of guilt and then fine remittance.
Exactly. It saves time for everyone, the accused, the court, the police. But notice the exclusion on the slide. It specifically says this does not apply to Motor Vehicles Act offenses.
Why is that?
Because the Motor Vehicles Act has its own separate challan and summary disposal system. So this section doesn't interfere with that.
And the key fact on the slide adds another layer. It says the state government can actually empower magistrates to use this summary procedure for other types of cases too.
Yes. For certain compoundable offenses under Section 359, or even for cases where the punishment is imprisonment up to 3 months. But for your exams, the general rule and that 5,000 rupee figure is the most important thing to remember.
That figure is definitely a classic prelims question.
A very frequent one.
Okay, let's move into the crucial phase of document supply. Section 230 is about supply of documents in cases that started from a police report. The slide header calls this the right to know.
And that's exactly what it is. It's a manifestation of the principles of natural justice. As we emphasize in our judiciary classes at Target for IQ, the timeline here is absolutely critical. You simply cannot expect an accused to defend themselves against secret evidence.
The slide provides a clear list of the documents that must be supplied. It includes the FIR, the police report itself, the charge sheet, statements of witnesses recorded by the police, any confessions, basically the entire police file.
Everything the prosecution plans to rely on. And the key fact highlighted is the timeline. The copies must be furnished without delay, and in any case, within a maximum of 14 days from the date the accused is produced or appears in court.
That 14-day cap is strict. It's there to prevent the police or the court from dragging their feet and delaying the trial.
It is. And the exam alert notes that electronic supply is now valid. If the documents are provided in a duly furnished electronic format, that complies with the law.
But what if the case file is massive? The slide points out a trap here regarding voluminous documents.
Right. Imagine a complex financial fraud case where the charge sheet runs into thousands, maybe tens of thousands of pages. It would be an incredible waste of resources to photocopy all of that.
So what's the solution?
The law is practical. In such cases, the magistrate is not forced to provide physical copies. Instead, they can direct that the accused or their lawyer be allowed inspection of the documents in court. They can come to the courthouse, sit down, and read the entire file. This balances the right to know with practical constraints.
So access is guaranteed, but not necessarily a personal copy. Now, what about cases that didn't start with a police report? Section 231 covers supply of documents, other cases. The visual here is a folder labeled Sessions Case Complaint Instituted.
This section is a bit more specific and often misunderstood. This applies to cases instituted otherwise than on a police report, so private complaint cases, but only if that case is triable exclusively by the Court of Session.
So this doesn't apply to every single private complaint case?
No. In a normal, minor complaint case tried by a magistrate, the evidence unfolds as the witnesses are examined in court. The accused sees it as it happens. But for a very serious sessions case, like a private complaint for a major crime, the accused needs all the material beforehand to prepare their defense for the big trial.
And the slide lists the documents to be furnished. It includes the statements recorded under Section 223 and 225, which we discussed earlier.
Essentially, all the statements recorded on oath by the magistrate during the precognizance inquiry. And the exam alert on the slide reminds us of a crucial point. These copies must be provided free of cost.
Justice can't have a paywall.
Exactly. This is a statutory right of the accused. They get these copies for free to ensure a fair trial.
The next slide, number 15, is another analysis slide, this time focusing on sections 230 and 231 under the title, The Right to Know. The visual is powerful, the scales of justice with documents sitting on each scale.
The visual represents balance and fairness. The core legal principle underpinning these sections is that Latin maxim audi alterum partem, which means let the other side be heard. No one should be condemned unheard. And you cannot be properly heard if you don't know the case against you.
There's a really interesting key fact on this slide. It says that Section 230 explicitly mentions supplying copies not just to the accused, but also to the victim if they are represented by a lawyer.
This is a very important and progressive step in the BNSS. It formally recognizes the victim as a key stakeholder in the criminal justice process. It ensures that the victim's also kept in the loop and has access to the case documents, which empowers them.
Now, moving on. What happens when a magistrate realizes a case is too serious for them to handle? Section 232 on the next slide covers commitment to court of session. The key visual is a calendar icon showing 90 days.
This is the procedural handover. When a magistrate takes cognizance of a case that is exclusively triable by the court of session, think of a murder case, they know they cannot conduct the trial themselves. Their job is to commit the case, which means to send it up to the higher court.
The slide lists the steps. First, you comply with the document supply rules in 200 or 231. Then you remand the accused to custody. Then you send the entire record of the case up. And finally, you notify the public prosecutor.
The magistrate here is acting almost like a post office. Their job is not to weigh the evidence or record witness testimonies for the trial. Their job is just to facilitate the smooth transfer of the case and the accused to the sessions court, which has the power to try it.
And that 90-day calendar icon is about the timeline, isn't it?
It is, and it's a strict timeline. These committal proceedings are to be completed within 90 days from the date of taking cognizance. This can be extended up to 180 days, but the magistrate has to record their reasons in writing. It's a provision designed to ensure speedy trials, especially in serious cases.
Now for a tricky situation. Section 233 deals with clubbing of cases. The visual here is very clear. It shows two arrows, one labeled complaint case and the other police investigation, merging into a single icon for clubbing of cases.
This addresses a common scenario. Imagine you are robbed. You're frustrated with the police, so you go to court and file a private complaint against the thief. At the same time, unknown to you, the police are also actively investigating the same robbery.
So you could have two parallel proceedings for the exact same crime.
Precisely. And that's a recipe for chaos. You could end up with two conflicting judgments from two different courts. The law wants to avoid that.
So what's the procedure? The slide says the steps are stay proceedings, then call for a report, and then club the cases if the report is submitted.
That's it. If the magistrate is hearing your private complaint and learns that a police investigation is also underway for the same offense, they shall, it's mandatory, stay the proceedings in the complaint case. They will then call for a report from the police.
And if the police file a charge sheet against the same person,
then the two cases are clubbed together. And the key fact on the slide is critical. The joint case then proceeds as if it was started on a police report. The private complaint effectively merges into the police case.
But the trap here warns. This applies only if the investigation relates to the same offense.
Yes, the facts must be the same. If your complaint is about a robbery on Monday and the police investigation is about a separate theft on Tuesday, even if the accused is the same, you can't club them. The underlying incident must be the same. Precision is key.
We're nearing the final stage now. We've reached Chapter 918, the charge. Section 234 details the contents of charge. The slide shows a legal scroll with 4 main requirements listed.
And this is the culmination of the entire pretrial process. The charge is the formal notice given to the accused, telling them exactly what they're being tried for. It'd have to be incredibly specific. It's not enough to vaguely say, you broke the law.
So what are the 4 requirements on the slide?
First, the offense itself must be stated. Second, the name of the offense, if it has one, like theft or murder. Third, the definition of the offense must be clear enough to give the accused notice. And fourth, the specific law and section of the law under which they are being charged must be mentioned. For example, theft under Section 379 of the Bharatiya Nyaya Sanhita.
And the exam alert on the slide makes a profound point. It says that the act of framing a charge is equivalent to a legal statement that every legal condition required to constitute the offense was fulfilled in this particular case.
That's a very high-level concept. It means the court has applied its judicial mind to the facts and the law and has concluded that, prima facie, all the ingredients of the offense are present. It's a significant judicial act.
The slide also mentions a specific requirement regarding previous convictions. The visual is a separate criminal record folder being attached to the main charge sheet.
Yes, this is for cases where a previous conviction can lead to an enhanced punishment for the current offense, for example, with habitual offenders. In such cases, the charge must specifically state the fact, date, and place of that previous conviction.
And if you don't put it in the charge,
then you cannot award the enhanced punishment. The accused must have noticed that their past record is being used against them for sentencing.
But the slide does mention a saving clause. It seems like an error can be fixed.
It can. The law is flexible here. If the court omits this detail from the charge by mistake, it can be added or amended at any time before the sentence is passed. So it's a curable error, but it must be cured before the final sentence.
Okay, we've gone through the entire journey in detail. Now, slide 20 brings it all together. It's titled The Master Flowchart. This is the bird's eye view of everything we've discussed.
And it connects every single dot. It starts with the complaint under 223. The first question is the magistrate competent? If not, the case is returned or directed. If yes, you move to examination on oath. From there, you reach the big decision point. Either issue process under 227 or dismiss the complaint under 226.
And if you issue process, the next step is to supply documents. Then other question, is this a sessions case?
Right. If yes, you commit the case to the Sessions Court under Section 232. If no, you, the magistrate, proceed to frame the charge yourself. It's the entire pretrial phase in one visual.
As we always advise our students, you should practice drawing this specific flowchart from memory. If you get a 15 or 20 mark mains question on trace the procedure from complaint to charge, this flowchart is basically your entire answer structure.
It absolutely is. It turns a complex narrative into a clear, logical structure that examiners love to see. It shows you're not just repeating text, you're thinking procedurally.
And finally, our last slide, number 21, is the exam readiness checklist. This looks like a rapid-fire recap of the most testable points.
It is. Let's run through it.
Okay. Section 223, what's the key phrase?
The new proviso. Accused opportunity to be heard.
Section 225.
Postponement of process. It's mandatory if the accused is outside the jurisdiction.
Section 229.
Petty offense.
Yeah.
And you have to remember the monetary limit.
Which is 5,000.
5,000 rupees.
Yeah.
Correct.
Section 230.
Supply of documents. The time limit is 14 days.
And finally, Section 232.
Committal to Sessions Court. The timeline is 90 days, extendable to 180.
The final tip on the slide says it all. Success in judiciary exams lies in the precision of section numbers and timelines.
It's not about writing long, flowing essays. It's about being accurate, precise, and citing the correct provision for every statement you make.
As we always say at Target for IQ, keep revising, and most importantly, stick to the language of the BEAR Act. The answers are all there.
And if I could give one final piece of advice, it would be to go back and read that Section 223 proviso again. It is, without a doubt, going to be a hot topic in the upcoming exams.
Excellent advice. And that brings us to the end of our structured analysis. But before we sign off, here's a final provocative thought for you to mull over. We've talked at length about how the new proviso in Section 223 gives the accused a right to be heard before cognizance is even taken.
Yes, a major step for fairness.
It sounds great on paper for preventing false and malicious complaints. But let's play devil's advocate. Could this new precognizance hearing also give a wealthy, powerful, and guilty accused a crucial head start? A chance to find out a case is brewing against them and then use their resources to tamper with evidence or intimidate the complainant and witnesses before the official machinery of the state even fully kicks into gear.
That is the perennial challenge of criminal law, isn't it?
It is. The question is, does this new layer of fairness to the accused potentially come at the cost of the victim's security and the integrity of the evidence? It's a delicate balance.
A very delicate balance that the law constantly struggles with. There are no easy answers there.
Something for you to explore on your own. Thank you for joining us for this deep dive.
Goodbye, and keep studying.
Let's understand the next point from here. We are back on the deep dive. And today, we are doing something a little different.
Oh, yeah.
Yeah, we're not just skimming the surface of the law. We are, you could say, popping the hood of the Indian justice system to see exactly how the engine runs.
I like that analogy.
We're looking at the procedural backbone, the very structure that dictates whether a criminal trial is fair, fast, or, flawed.
It is a massive topic.
Yeah.
Most people, and even a lot of law students, they get obsessed with the penal code itself.
Right, the Bnss.
The Bharatiya Nyaya Sanhita, exactly.
Yeah.
They want to know the definition of murder, the definition of theft, the specific years of punishment, and that's all important, of course. That's the what. But that how, the procedure, that's where the game is actually played. Procedure is where a case can be won on a technicality or where it can be lost because someone missed a critical deadline. It's really the chessboard on which the entire game of justice is played out.
Exactly. And to guide us through this labyrinth, really, we have a really comprehensive set of materials to work with today.
We do.
We're looking at a presentation created by Successor for Target for IQ. Now, For our listeners who are judicial services aspirants, you already know that Target for IQ is pretty much the gold standard for getting into the granular details you need for these exams.
Absolutely. And what I love about Satyendra Sir's materials, and we see this in all our classes, is that they are designed with the exam mindset.
The exam mindset. What do you mean by that?
Well, they don't just list the sections of the Bharatiya Nagarik Suraksha Sanhita, the Bnss.
Right.
They don't just say Section 234 says this. Instead, they highlight the traps. They point out the tricky spots. They show you exactly where an examiner is trying to trip you up.
Ah, so it's a strategic guide.
Precisely.
Yeah.
And today, we're going to walk through chapters 19, 20, and 21 of the Bnss.
Okay, so that covers the framing of charges, the trial before a court of session, and the trial of warrant cases. It's basically a roadmap for the entire life of a serious criminal case.
It is, from start to finish.
But before we get lost in all the section numbers, let me start with a scenario, a hook, if you will.
I'm listening. Lay it on me.
Okay, let's say I'm a court clerk. It's 4:55 p.m. on a Friday. I'm typing up a formal legal charge against, say, a guy accused of a serious robbery. I'm tired, I want to go home, and I make a mistake. A typo.
Happens all the time.
Right. I get the date of the crime wrong. Maybe I write the 15th instead of the 16th, or I misspelled the name of the street where it happened. My question is, does the criminal walk free? Is that a golden ticket for the defense attorney to storm in and get the entire case dismissed?
That is the classic Hollywood legal trope, isn't it?
It is.
The sharp lawyer finds a typo in a dusty law book, the judge bangs the gavel, and the credits roll. But in reality, under the BNSS, the answer is usually no.
Usually.
It all depends on a very specific, very practical legal concept called failure of justice.
Failure of justice. It sounds incredibly dramatic.
It is, and it's the ultimate litmus test. The law doesn't ask, was there a mistake? It asks, did this mistake actually confuse the accused to the point where they couldn't defend themselves properly? If the answer is no, the trial goes on. We're going to explore that in a lot of detail.
Okay, I'm looking forward to that. And alongside that concept, we have what the outline calls the time limit trap.
Oh, this is the headline story of the new BNSS. This is massive. We are seeing strict statutory deadlines being introduced everywhere, 30 days for this, 60 days for that.
And these aren't just suggestions.
Not at all. As we teach at Target for IQ, this is a game changer for exam answers. If you're in a mains exam and you write, the court will decide in a reasonable time, when the law now specifies within 60 days, you are losing marks, period.
Precision is key.
Precision is everything now.
Okay, let's unpack this. We're starting at the very foundation, Chapter 19 of the BNSS, the charge.
Legally, this covers sections 234 through 236, the absolute bedrock of a trial.
So what exactly is a charge? I mean, is it just the police report saying you did it?
No, it's so much more formal than that. Think of the charge with one word in mind. Notice, that is the core concept Satyendra Sir emphasizes in his presentation. It is a specific formal notice given to the accused.
Notice of what?
It's the state, through the court, telling a person, here's exactly what we think you did, and here is the specific law you broke. It frames the scope of the entire battle to come. Once the charge is framed, you can't suddenly start arguing about a completely different crime. The boundaries are set.
Okay, so it has to be precise. What does it have to look like? I'm looking at the slide titled Correct Law. It has a few key points.
Right, so Section 234 lays down the absolute basics. First, the charge must state the specific offense. You can't be vague.
No. You're a bad person who did bad things.
Exactly. You can't say you were a bad person who stole things. You have to say you committed theft. And crucially, and this is point 2, you must cite the specific section of the law. If it's from the Bharatiya Sanhita, you have to write down the actual section number.
So it's labeled and categorized. But that doesn't tell the whole story, does it? What about the details?
That's the next step. That brings us to Section 235. This is all about the particulars. A label isn't enough. The charge must include the time the offense happened, the place it happened, and the person against whom it was committed.
A who, what, where, and when.
That's it, the fundamental building blocks of the accusation. But here is where it gets really interesting, and this is the first trap that Satyendra Sir highlights in the notes. We often just assume that you have to explain how the crime was committed, the manner of the offense.
Right, like did they pick the lock? Did they smash the window with a brick? Did they use a crowbar? The methodology.
But Section 236 says, not necessarily. The manner of committing the offense is not always required.
Really? That seems like critically important information for the defense. How can you defend yourself if you don't know the how?
It is important, But legally, it's only required if the particulars of time and place are insufficient to give the accused proper notice. Let's think about it with an example. If I charge you saying, you murdered person A at 5 p.m. in Connaught Place, Delhi on Tuesday, that is incredibly specific. You know exactly what incident I'm talking about. Whether you shot him or stabbed him will come out in the evidence for sure, but the charge itself is clear enough for you to begin your defense. You know the event you need to account for.
I follow. The time and place pinpoint the event perfectly.
But compare that to a crime like cheating or fraud. If I just charge you saying, you cheated person A, that is impossibly vague, isn't it?
Yeah, how?
When?
How did you cheat him? Did you sell him a fake watch? Did you forge a signature on a document? Did you lie about the terms of a contract? In that situation, the manner becomes absolutely necessary because without it, the accused is genuinely misled. They have no idea what they're supposed to be defending against.
That makes perfect sense. So for what you might call event-based crimes like murder or assault, the time and place are usually enough. But for narrative-based crimes like fraud or conspiracy, you need to explain the manner. That's a fantastic way to put it. Precisely. And there's one more exam alert on this slide, which is really important. It's regarding Section 234, subsection 7.
Oh, I see that. It mentions previous convictions.
Yes. This is crucial for students to remember. If an accused person has a previous conviction that affects the punishment for the current crime, what we call enhanced punishment for repeat offenders, the charge must state the fact, the date, and the place of that previous conviction.
And why is that mandatory? Seems a bit prejudicial to bring up their past right at the start.
It seems that way, but it's about fairness. It's about notice. If the law says you're going to get put away for 10 years instead of 5 because this is your second offense, you cannot spring that on the person as a surprise at the end of the trial.
I see.
It has to be on the charge sheet from day one. The accused has the right to know the maximum jeopardy they're facing from the very beginning.
Okay, so that's the perfect charge. It's specific, it has particulars, and it includes any relevant past history for sentencing. But let's go back to my typo scenario. What happens when there are errors? The human factor.
This is the real world of law, and it takes us to sections 237 through 240. And this is where we can really talk about that failure of justice scale image from the presentation.
So Section 238 is the one that directly answers my question about the typo.
It is. It states that no error in stating either the offense or the particulars is considered material, and material means significant enough to overturn a verdict unless 2 conditions are met. It's a 2-pronged test.
What are they?
First, the accused must have been actually misled by the error, and second, and this is the crucial part, that it occasioned a failure of justice. Both have to be proven.
Can you give us a real-world example of how a judge would decide that? The difference between being misled and not?
Sure. Let's stick with a date typo. Imagine the charge sheet says a murder happened on the 12th of February. But all the evidence brought by the prosecution, the witness statements, the CCTV footage, it all points to the 13th of February.
Okay.
Now, during the trial, if the accused brings an alibi for the 13th, say, a plane ticket and hotel receipts showing he was in Mumbai on the 13th, then clearly he wasn't misled by the typo on the charge sheet. He knew the trial was really about the 13th. He defended himself against the actual allegation effectively.
So in that case, the typo is irrelevant. The court would just say, clerical error, moving on.
Exactly. But now slip it. What if he trusted the official document? He brings in 10 witnesses to prove he was at a family dinner on the 12th, because that's what the charge said. He builds his entire defense around the 12th.
And then he gets convicted based on evidence about the 13th.
Now, he has been misled. That is a clear failure of justice. In that scenario, an appellate court would almost certainly set that conviction aside.
That is a very practical, common-sense distinction. Now, can the court fix these errors if they catch them in time? Or is the document set in stone once it's filed?
No, it's not set in stone at all. And this is a key power of the court under Section 239. The slide is very clear. The court can alter or add to any charge at any time before the judgment is pronounced.
Anytime. I mean, are we talking even after all the witnesses have gone home and the lawyers are just about to give their closing arguments?
Even 5 minutes before the judgment is about to be read, the power is that wide. However, Section 239 also imposes a duty on the court. If the court alters the charge, every such alteration must be read out and explained to the accused.
And then what? Does the trial just carry on?
Not necessarily. The court then has to apply what's called the prejudice test.
Prejudice as in unfairness to the accused.
Yes. The judge has to pause and ask themselves, if I change this charge right now, from simple theft to, say, robbery. Is that unfair to the accused? Are they unprepared to defend against this new, more serious allegation?
And if the answer is yes,
If the court feels it would be prejudicial, it might need to order a completely new trial. Or, more commonly, it will adjourn the proceedings for a specific period to give the defense time to prepare for the altered charge.
and I see a note here about witnesses. That's Section 240, right?
That is the logical next step. It's the corollary to changing the charge. If you change the charge, you've essentially changed the rules of the game mid-play.
So everyone gets a do-over with the witnesses.
In a sense, Section 240 allows both the prosecutor and the accused to recall witnesses.
Recall meaning bring them back to the witness stand.
Exactly. The defense lawyer can stand up and say, "Well, Your Honor, now that you've changed the charge from theft to criminal breach of trust, I have a few new questions for that accountant who testified last week." And the court generally has to allow this.
Is there any exception to that? Can a judge say no?
Only in a very limited circumstance. The court can refuse, if it records, in writing, its reasons for believing that the request is made for the purpose of vexation or delay.
So if the defense is just trying to stall the trial for months by recalling every single witness.
Precisely. If it's a delaying tactic, the judge can shut it down, but they have to justify it on paper.
Okay, so that's the single charge, its creation and its correction. But as we know, crime is rarely neat and tidy. Often you have one person committing multiple crimes or a whole gang of people acting together. This brings us to Section 2 of our outline, joinder of charges.
The slide title says, "Complicating the Chessboard," and that is very accurate. This is where things get technical, and it's a favorite area for exam questions.
Let's start with the general rule then. What does Section 241 say?
The general rule is simple and logical. For every distinct offense, there should be a separate charge and a separate trial. One crime, one trial.
That sounds incredibly fair, but also incredibly inefficient.
Incredibly inefficient. Imagine a serial thief. He steals a wallet today, a mobile phone tomorrow, and a car next week. Do we really want to hold 3 separate full-blown trials for that?
No, the system would grind to a halt.
It would completely collapse. You'd need 3 sets of dates, 3 sets of witnesses being called, 3 judgments. So, of course, the law provides exceptions.
And this is where we get to the flowchart Satendra Sir has in the materials.
Yes, a fantastic flowchart that simplifies a complex area. The first big exception is what's known as the 3 offenses rule under Section 242. Although under Bnss, it's really the 5 offenses rule.
Okay, walk us through this flowchart. I want our listeners to be able to visualize it.
Okay, so imagine a funnel. To get multiple charges combined into one trial under Section 242, the facts have to pass through 3 filters.
Filter number 1.
Test 1. The offenses must be of the same kind.
And what does same kind mean legally? Does it just mean they're both theft-like?
It's more precise than that. It means they are punishable with the same amount of punishment under the same section of the law. So theft and theft are the same kind, but theft and robbery are not because robbery involves force and has a different section and punishment.
Got it. So they have to be legally identical offenses. What's the second filter?
Test 2. They must have been committed within a period of 12 months. From the first crime in the series to the last one, no more than 1 year can have passed.
Okay, so a string of identical crimes within a 1-year window. And what's the final part of the test?
The result? If you pass those 2 tests, you can try any number of them together. But there's a cap.
I see it on a slide. It says max 5 offenses.
That is the limit. The slide emphasizes it in bold. Any number not exceeding 5 can be tried at one trial.
Why is 5 the magic number?
It's a balance. It used to be 3 under the old Criminal Procedure Code. The Bnss expanded to 5, likely to improve efficiency and speed up justice. But the limit exists to protect the accused. Imagine trying to defend yourself against, say, 50 different theft charges all at once.
You wouldn't know where to start. Your defense would be spread too thin.
Exactly. It would be impossible to mount a proper defense. So 5 is seen as a manageable number.
Okay, so up to 5 thefts in 1 year can be handled in a single trial. Simple enough?
Yes, but now let's move to the next layer of complexity. This is where, as we see in our judiciary classes at Target for IQ, students often get confused. Section 243 versus Section 244. The slide calls this complex joinder and trap.
Okay, Section 243 is about something called the same transaction. How is that different from same kind?
Right, this is the key distinction. Same kind is about the category of the crime, as we just discussed. Theft and theft. Same transaction, on the other hand, is about the story or the narrative of the crime. It's about a series of acts that are so connected they form one continuous event.
Can you give us an example of that?
The classic textbook example is this. A person breaks into a house. That's one offense, housebreaking. Inside, he shoots the security guard who confronts him. That's a second, completely different offense, murder. Then he steals the owner's car from the garage to escape. That's a third offense, theft.
Okay, so those are three totally different crimes, different sections of the law, different punishments.
Exactly. They're definitely not of the same kind. But they form one continuous story, one single transaction. It's one movie with a beginning, middle, and end. Because of that narrative link, Section 243 allows them all to be tried together in one trial.
I see. And the slide mentions a specific combination, criminal breach of trust plus falsification of accounts.
Yes, that's the quintessential white-collar crime special. It's specifically mentioned in the section. If you're an employee and you embezzle money, that's a criminal breach of trust. But to hide it, you almost always have to cook the books. You have to make false entries. That's falsification of accounts.
They're two separate crimes, but one can't happen without the other.
Well, one is done to conceal the other. They're intimately connected in the same criminal enterprise, so they are tried together.
Now, what about this doubtful offenses rule? Section 244.
This is a fascinating one. This is for situations where the prosecutor is scratching their head. The facts of what happened are clear, but the correct legal label for those facts is ambiguous.
How so?
Let's use another example. I give you a gold ring to keep safe for me while I go on a trip. You sell it and run off with the money. Now, what crime is that? Is it theft? Is it criminal misappropriation? Or is it criminal breach of trust? It depends on very technical legal definitions of possession versus custody and the nature of our agreement.
So if the prosecutor isn't 100% sure which one fits, do they have to just pick one and hope they're right?
No, that would be risky. Section 244 provides a solution. It allows the prosecutor to charge for all of them or to charge in the alternative. The charge sheet can literally say, you are charged with theft or are, in the alternative, criminal breach of trust.
And what happens at the end of the trial, at the judgment?
This is the powerful part. If the court finds you not guilty of theft, but the evidence presented during the trial clearly proves you committed criminal breach of trust, the conviction for criminal breach of trust is valid, even if it was only the alternative charge.
That's a huge safety net for the prosecution. It prevents criminals from getting off on a technicality of legal definition.
It is. Now, here's the big trap that Successor warns about for exams. You must not confuse Section 243, same transaction, with Section 242, same kind.
What's the trap?
The trap is the numbers. In Section 242, same kind, remember there is a number limit, maximum 5 offenses. In Section 243, same transaction, there is no number limit.
Oh, right.
If you committed 50 different crimes during the course of a single continuous bank robbery and hostage situation, all 50 of those charges can be tried together.
That is a crucial distinction. Same kind equals a limit of 5. Same transaction equals no limit.
Correct. You have to have that clear in your head.
Now, let's add more people to the mix. What about a joint trial of persons under Section 246? The slide here shows what it calls a matrix of joint accused. It looks like a 3x3 grid.
It looks complicated, but it's actually very logical. The law allows people to be tried together if their alleged crimes are linked in specific ways.
So what's in the first category?
Category 1 is the most obvious. Persons accused of the same offense committed in the course of the same transaction. So the 3 guys who robbed the bank together, they can all be tried together.
Makes perfect sense.
Category 2. Persons accused of an offense and persons accused of abetment of or attempt to commit that offense. So you can try the guy who actually robbed the bank, and in the same trial, the guy who drew the map for him and gave him the gun, the principal and the abetter.
They're part of the same criminal web.
Exactly. And look at another interesting one, Category E in the Act. Persons accused of theft, extortion, or cheating tried together with persons accused of receiving or retaining stolen property from that crime.
So this connects the thief to the fence, the guy who buys the stolen goods.
Precisely. Even though the fence wasn't at the scene of the original crime, his crime is directly dependent on the theft. So the law says we can deal with them in one trial.
And there's a specific call out here for counterfeit coin offenses. Why is that singled out?
Yes, that relates to offenses under Chapter 12 of the Bnss. It's singled out because counterfeiting is usually a ring operation, a conspiracy. You might have one person who makes the die, another person who stamps the coins, and a third person who distributes them. Section 246 allows the entire ring to be prosecuted in a single trial.
What if a scenario falls outside this nice, neat grid. What if two people commit crimes that are connected but not in one of these specific ways?
The procedure allows for some flexibility. If a situation falls outside these specific categories, the magistrate or the court of session can still try them together if all the accused persons apply for it in writing and the court is satisfied that it won't be prejudicial to them.
Why would the accused want a joint trial?
Several reasons. It might save a lot of money on lawyers, or it might help them coordinate their defense strategy. Sometimes it's strategically advantageous for them.
Interesting. Okay, we have the charge, we have the joinder rules. Now let's get into the courtroom drama. Section 3 of the outline, trial before a court of session. This is chapter 20 of the Bnss.
Right, and a court of session is where the most serious cases are heard. Murder, rape, dacoity. Cases that are punishable with death, life imprisonment, or imprisonment for a term exceeding 7 years.
So how does a trial like that begin?
It officially starts with the public prosecutor, or the PP. Section 248 says the PP is responsible for conducting the trial on behalf of the state. Then Section 249 says the PP opens the case.
Like an opening statement in the movies.
Exactly that. The PP stands up, describes the charge to the judge, and gives a summary of the evidence they plan to bring to prove the charge. Your Honor, we will prove through eyewitness testimony and forensic evidence that the accused is guilty beyond a reasonable doubt.
But right after this opening, we hit a critical fork in the road, don't we? Discharge, Section 250.
A very critical fork. Discharge means the accused can go home before the trial even really begins.
On what grounds?
If, after hearing the PP's opening statement and looking at the case records and documents filed by the police, the judge considers that there is no sufficient ground to proceed, they will discharge the accused. And significantly, the judge must record their reasons for doing so. They have to explain on paper why the case is too weak to continue.
And here's our first major time limit trap that Successor highlights. This is new.
Yes, this is a huge change in the Bnss. The accused has the right to file an application for discharge, but they can't wait forever to do it. The application must be filed within 60 days from the date of committal of the case to the session court.
60 days, that is a very tight window.
It's designed to stop delay tactics. In the old system, defense lawyers would sometimes wait a year or two, let the case drag on, and then file for discharge, stalling the trial even further. Now, the law says you have a 2-month window. Use it or lose it.
Okay, so let's assume they aren't discharged. The judge finds there is sufficient ground to proceed. What happens next?
Then we move to the next formal step. Framing of the charge, which is under Section 251. The slide here shows this as a decision tree, which is a good way to look at it.
Right. The judge asks a question. First one is the offense exclusively triable by the court of session?
If the answer is yes, if it's a murder or rape case, then the session court itself frames the charge in writing. Simple. But what if the judge looks at the facts and says, wait a minute, the police have charged this as grievous hurt, but based on the medical report, this is just simple hurt. This doesn't belong in my court.
So it doesn't belong in the big leagues, so to speak.
Exactly. In that case, the session judge still frames the charge for the lesser offense, but then transfers the entire case down to the Chief Judicial Magistrate, CJM, or a Judicial Magistrate First Class, JMFC, for the actual trial.
And is there a timer on this framing process as well?
Absolutely. This is another key deadline. Section 251(1)(b mandates that the charge must be framed within 60 days from the date of the first hearing on the charge.
Another 60-day rule. So 60 days to apply for discharge, 60 days to frame the charge. The system is really pushing for speed at the initial stages.
That is the clear legislative intent of the Bnss. Now, once the charge is framed, it is read and explained to the accused, and they are asked the classic question, do you plead guilty or do you claim to be tried?
Let's talk about that for a second. Section 252, plea of guilty. If the accused says, yes, I did it, is it automatically game over?
Not automatically. The law says the judge may convict the accused. It's discretionary. The judge needs to be absolutely sure that the plea is voluntary, that it's not made under any pressure or coercion. But in practice, if the plea is accepted, yes, it leads to a conviction.
And if they say, I claim to be tried, then we move to the evidence stage, sections 253 and 254.
Correct. And this is where the Bnss introduces a very significant modern provision. Section 254 mentions that the evidence of witnesses can be recorded by audio, video, electronic means.
That is huge. Video conferencing in trials.
It is revolutionary for the Indian system. Specifically, Section 2542 says the deposition of police officers or other public servants may be taken through audio-video means, as may be prescribed.
Why single out police officers and public servants?
Because they get transferred all the time. An officer might investigate a serious case in Delhi and then, a year later, get transferred to Mumbai. Under the old system, that officer would have to travel all the way back to Delhi for every single hearing date, wasting days of travel time and a huge amount of state money.
But now they can just log in from their office in Mumbai.
Exactly. It's a massive saving in terms of time, money, and efficiency. It should really help speed up trials.
That could change the logistics of justice completely. But there's a trap noted here regarding cross-examination. What's that about?
Yes, this is an important power given to the judge under Section 2543. The judge has the discretion to defer the cross-examination of a witness.
Defer. What does that mean in practice?
Normally, the process is prosecution witness gives their main testimony, examination in chief, and then the defense lawyer gets to cross-examine them immediately. But the judge can say, no, hold on, you can't cross-examine this witness yet. We are going to wait until these other two prosecution witnesses have been examined first.
Why would a judge do that? What's the strategic advantage?
It could be to prevent the defense from tailoring their questions to one witness based on what they anticipate a future witness might say, or perhaps to protect a vulnerable witness until the full context of the case is established by other evidence. It's a tool for the court to control the flow of the trial and ensure fairness.
Okay, so we've had the opening statement, the charge, the evidence. Now get to the end game, acquittal or judgment. Sections 255 to 258.
Correct. The timeline on the slide is very clear. First, under Section 255, if after taking prosecution evidence the judge finds no evidence that the accused committed the offense, they issue an acquittal order right there.
And if there is evidence?
If the accused is not acquitted, they are then called upon to enter their defense. That's Section 256. After the defense evidence is done, we move to arguments under Section 257. The prosecutor sums up their case, and the accused or their lawyer gets to reply.
And then the final step, the judgment.
And here we find the third critical deadline in the Bnss, Section 258. The judgment must be delivered within 30 days of the completion of arguments.
30 days, that's a month.
It can be extended, but only for specific reasons that have to be recorded in writing. And the extension shouldn't ordinarily exceed 45 days, and in some exceptional cases, up to 60 days. Gone are the days where a judge could reserve a judgment for 6 months or a year.
That is a significant shift towards accountability. And what happens if there is a conviction? Is the sentence announced right away?
No. Then comes the mandatory sentencing hearing. The judge must hear the accused on the question of the sentence, unless they are proceeding under Section 401 of the Bnss, which deals with releasing someone on probation. But generally, you have a separate dedicated hearing where you have the right to argue why you deserve a lighter sentence.
Okay, so that's the session trial. Heavy duty, lots of steps, and now very strict timelines. Let's pivot now to Section 4 of the outline, the trial of warrant cases. This is Chapter 21.
And this is an area where, under the guidance of Successor, we always tell our students to be extra careful, because there are two paths for the same type of case, and it's easy to get them mixed up.
Right. The slide poses the question directly, why are there two different sets of rules for the same type of serious case?
The answer depends entirely on how the case started, how it was instituted.
Which are?
Pass A covers cases that were instituted on a police report. That's Sections 261 to 266. Path B covers cases that were instituted otherwise, which, for all practical purposes, means on a private complaint. That's Sections 267 to 270.
So Path A is when the cops do the investigation and file a charge sheet. Path B is when a private citizen, like me, goes directly to the magistrate and files a complaint against someone.
That's the distinction perfectly, and the procedure for each is radically different.
Let's start with Path A police report cases. What does that look like?
This process is more streamlined because there's already been a police investigation. Step 1 is compliance, under Section 261. The magistrate's first job is to ensure that all the documents mentioned in Section 230, like the police report, witness statements, etc., are supplied to the accused.
So everyone has the same information. Then what?
Step 2 is considering discharge, under Section 262. Just like in a sessions trial, if after considering the report and documents the magistrate considers the charge to be groundless, they discharge the accused.
And is there a time limit for that application?
Yes, it follows the same principle. The discharge application must be preferred within 60 days from the date of framing of charges being heard, essentially. The goal is to settle this preliminary issue early on.
And if they are not discharged, we move to framing the charge under Section 263.
Again, there's that time limit. It must be done within 60 days of the first hearing on the charge. If there is ground to presume that the accused has committed an offense, the magistrate frames a formal charge in writing.
So to summarize the flow in a police report case, it goes: Police report is filed, documents are supplied, the question of discharge is settled, a charge is framed, and then the evidence begins.
Correct. The key feature is that the charge is framed early in the process. The evidence, under Section 265, follows the framing of the charge.
Now, let's compare that to Path B complaint cases. The slide calls this the inverted process and mentions a staircase visual.
Yes, because in a complaint case, the process is flipped on its head. You start with evidence.
Wait, evidence comes before the charge is even framed.
Yes. Under Section 267, the magistrate's first step is to hear the prosecution, the complainant, and take all the evidence they produce. This happens before any formal charge is framed against the accused.
Why the huge difference in procedure?
The logic is to act as a filter. Private complaints, unlike police reports, haven't been through an investigative process. They can sometimes be frivolous or malicious. I could file a complaint against you just to harass you.
So the court needs to see some proof first.
Exactly. Before the court puts a person through the ordeal of being formally charged with a crime based on a private allegation, the magistrate needs to see some actual proof. They need to hear from some witnesses and decide if there's any substance to the complaint at all. It's a mechanism to weed out the nonsense early.
That makes perfect sense. It's a safeguard.
It is. And Section 268 gives the magistrate a special power in this regard. They can discharge the accused at any previous stage of the case if they find the charge to be groundless. If the complainant's first witness gets on the stand and talks complete nonsense, the magistrate can end the case right there and then.
And only if the evidence holds up and seems credible do they move to Section 269, framing the charge.
Yes, and here is another unique procedural quirk of the complaint case path, the recall of witnesses.
What's that about? I see it's in Section 269-4.
Think about it. The prosecution's evidence was taken before the charge was formally framed. At that early stage, the accused might not have cross-examined those witnesses fully, or at all, because the exact nature of the charge wasn't clear yet.
Ah, I see.
So, once the charge is formally framed, the accused gets the right to say, okay, Your Honor, now that I'm officially charged with this specific offense, I want to recall those witnesses who testified earlier and cross-examine them properly.
That seems like a vital protection for fairness.
It is. But there's an exam alert on the slide for this. If the prosecution witnesses cannot be secured for this cross-examination, despite the court taking reasonable measures, the magistrate may close the evidence and proceed with the trial. You can't hold the trial hostage forever if a key witness has disappeared or is untraceable.
Got it. So let me just recap the key takeaway. Police report case. Charge first, then evidence. Complaint case. Evidence first, then charge.
That is the fundamental distinction you have to remember.
Now let's wrap up with Section 5. Some special provisions and the conclusion of these trials.
Right. Section 271 covers the formal conclusion of a warrant trial. It's simple enough. It ends in either acquittal or conviction. But there's an important procedural note here about previous convictions again.
This is Section 271-3.
Yes. If the accused is charged with a main offense and also with having a previous conviction for the purpose of enhanced punishment, the charge relating to the previous conviction is only addressed after the accused has been convicted on the main charge.
Why wait until the end?
To avoid bias. It's a rule of fairness. If the judge is hearing a theft case and they hear right at the beginning, by the way, this person also robbed a bank in 2010, it might subconsciously prejudice their view of the current case.
So they decide on the facts of today's crime first, in isolation.
Exactly. If and only if they find the person guilty of today's crime, then they open the file on the past crimes to decide the appropriate sentence.
Smart. Now what about Section 272, absence of the complainant?
This happens quite often in private complaint cases. The complainant files the case with a lot of energy, and then for whatever reason, they just stop showing up to court hearings.
So what happens to the accused? Are they stuck in limbo?
No. If the offense is one that can be lawfully compounded, meaning it can be settled privately, or if it's a non-cognizable offense and the complainant is absent on the day of the hearing, the magistrate has the power to discharge the accused.
Is there any grace period for the complainant?
Yes, the slide mentions a limit on this power. This discharge can happen any time before the charge has been formally framed. And the Bnss has added a provision that the magistrate should generally give the complainant 30 days time to appear before discharging the accused.
Next up, Section 273, compensation for groundless accusations. This sounds important.
It's the penalty for abusing the legal system. If an accused person is discharged or acquitted in a complaint case, and the magistrate finds there was no reasonable ground for making the accusation in the first place, they can order the complainant to pay compensation to the person they accused.
How much can they be ordered to pay?
Up to the amount of fine the magistrate is empowered to impose. And if the complainant doesn't pay the compensation,
What's the penalty?
simple imprisonment for a term of up to 30 days.
Can you appeal an order like that?
Yes. An appeal is available if the compensation ordered is more than 1,000 rupees.
And finally, a brief intro to summons cases mentioned in the context of Section 274.
Right, we won't do a deep dive into summons cases today. That's a whole other topic. But the big difference slide highlights the most important distinction. In a summons case, it shall not be necessary to frame a formal charge.
So no formal charge sheet, just state the particulars of the offense.
Exactly. The magistrate just states the particulars of the offense to the accused and asks if they plead guilty. It's a much faster, more summary procedure reserved for less serious offenses.
Wow. We have covered a massive amount of procedural ground, from the precise wording of a charge to the 3x3 grid of joint trials, all the way to the inverted staircase of complaint cases.
It is a lot, but understanding these structures is what separates a law student from a future judge or a practicing lawyer. As we always say at Target for IQ, mastering these procedural nuances is absolutely the key to cracking the judiciary exams.
Okay, let's do the Mastering the Exam recap. This is straight from the outro of the presentation. We really need to drill these new timelines into our heads.
Let's do it. Everyone listening, get ready to memorize. First, the discharge application, in both session trials and police warrant cases. What's the time limit?
60 days.
Correct. Next, framing the charge, again in both session trials and police warrant cases.
60 days.
And finally, the delivery of the judgment after arguments are completed.
30 days.
60, 30.
Yeah.
You have to know these numbers.
And Satendra Sir's note here is highlighted in yellow. It says, precision in days will differentiate your answer. Don't write reasonable time when the law specifies 60 days.
That is the golden rule for the new Bnss. The law is not vague anymore on these points. It's precise, and your answers must be too.
As we wrap up, I'm just reflecting on how structured and time-bound this all feels compared to the old code. The emphasis is so clearly on speed and efficiency.
Speed and accountability, absolutely. But as Satendra Sir notes in the final slide, there is a provocative question we should leave our listeners with.
And what's that?
It's this. With the new provision allowing audio-video evidence recording, are our courts physically ready to handle the digital transformation of the session trial? It's one thing to write it in the law. It's a completely different thing to have the high-speed internet bandwidth, the high-definition screens, and the secure servers in, say, a rural district court in a remote part of the country.
That is a very real, practical challenge. The law is ready for the 21st century, but is the infrastructure.
That's something for all of us to mull over. The letter of the law versus the reality on the ground.
Thank you so much for guiding us through this procedural maze. To our listeners, especially those of you preparing for your exams, go back and look at those slides from Target for IQ. Memorize that 5 offenses rule flowchart and the joint accused grid. They really are lifesavers.
Absolutely. Good luck with all of your studies.
That's it for this deep dive. We'll see you next time.
Let's understand the next point from here.
Exactly. And that brings us to the start of a very focused deep dive today.
I am ready. I have the materials in front of me, and frankly, I'm a little intimidated. We have a slide deck here titled Trial Procedures and Special Tracks. It looks heavy.
It is heavy, but that's precisely why we're here to break it down. As we teach at Target for IQ, under the guidance of Satendra Sir, the goal isn't just to read the law, but to really visualize it, to understand its flow.
Well, the visual on this first slide is definitely setting a tone. We have this high-resolution image of a wooden gavel resting on a stack of thick, leather-bound legal books. It just screams authority and finality.
It represents the weight of procedural law. It's not just about what's right or wrong, it's about the process. What we're looking at here is the code within the code.
The code within the code, I like that.
Specifically, today we are covering chapters 22 to 25 of the Sanhita, the Bnss. This is the core procedural engine for a certain class of trials.
I see the scope defined here on the slide. It says we're covering summons cases, summary trials, plea bargaining, and the attendance of prisoners. That's a lot of ground.
It is, but they are all interconnected. And look at that yellow box on the slide, the one labeled Exam Focus. This is crucial for anyone listening who's preparing for the PCS-J or any state judiciary exam.
It highlights procedural flow and limitation periods.
Because that's what they test. They don't just ask, what is Section 274? They give you a scenario and ask, what happens next? You have to know the flow.
And there's a very prominent red warning box on the bottom right. I can't miss it. It says, in all caps, warning, do not confuse summons procedure with warrant procedure. Is that a common mistake?
It's a fatal mistake. I mean, truly fatal in an exam context. If you apply the steps of a warrant procedure to a summons case question, you lose all the marks for that question instantly.
Wow. Why is it so different?
The logic is different. The speed is different. The entire philosophy is different. A summons case is for less serious offenses, so the procedure is designed to be quicker, more streamlined. A warrant case is for serious crimes, so it has more checks and balances.
So our mission today is to decode these tracks, slide by slide, to make sure that confusion never, ever happens.
That's the plan.
Okay, I'm sold. Let's crack this code. Moving to the second slide, we're starting with Chapter 22, Trial of Summons Cases. This is the foundation, I take it.
Yes, this is the beginning, Section 274.
The visual here is really interesting. It's very clear. There are two 3D document icons side by side. The first one says Formal Charge Sheet, and it has this big glowing red X over it.
Right.
And the second one says Substance of Accusation, and that one has a bright green check mark. So a big no to one and a yes to the other.
That visual is the absolute heartbeat of this chapter. It is the core concept of a summons trial, all encapsulated in that one image. It's about what you don't do.
And what you don't do is frame a formal charge.
Exactly. Now let's read the text on the slide for Section 274. It says, when the accused appears or is brought before the magistrate, the particulars of the offense shall be stated to him. He shall be asked whether he pleads guilty or has any defense.
It sounds so simple.
It is designed to be simple. Let's break that down. The core concept here, as we said, is the distinction in how the trial starts. In a warrant case, a more serious case, the court has to draft a very specific legal document, the formal charge outlining the exact law and the exact allegation. It's a whole process.
But here, in summons cases, we see that red X, again, formal framing of a charge is not required.
Yeah.
So what exactly is the substance of accusation? Is it just a casual conversation?
It's not casual, but it is less formal. It's exactly what it sounds like. The magistrate looks at the accused, who is standing in the dock, and explains the situation in plain language. Sir, you are accused of driving rashly on this date at this location and causing a minor accident. That is the allegation against you.
So no complex legal jargon, no reading of a long document.
Precisely. As the green box on the slide says, concept, substance of accusation is sufficient. It's about communicating the essence of the allegation so the accused understands what they're facing.
And then immediately after that, the magistrate asks them if they plead guilty.
Immediately. The flow is, here's what you're accused of, now what's your answer? Do you admit this, or do you have a defense you want to present? It cuts right through the procedural red tape you'd see in a more serious trial.
There's an exam alert in the yellow box at the bottom of this slide. It reads, Section 274 is the starting point of the trial. That seems important.
It's one of the most fundamental points for your prelims. They'll give you options. When does a summons trial begin? A, when the FIR is filed. B, when the police file their report. C, when the accused appears and the substance is stated.
And the answer is C.
Always C. The trial formally commences at that exact moment in the courtroom under Section 274. In our judiciary classes at Target for IQ, we always tell students that when you're writing a mains answer on summons procedure, this section number must be the very first thing you write. It shows the examiner you know the starting point.
Got it. Foundational. Okay, let's move on to slide 3. This one looks a bit more complicated. It's titled Effective Absence or Non-Appearance of Complainant.
Right. So what happens if the person who made the complaint doesn't even show up to court? This is one of the most technical areas, so you really need to pay close attention to the flow chart.
Okay, I see the flow chart. It starts with a box that says Case Instituted Upon Complaint. And from there, it splits into two distinct paths, Path A and Path B.
And notice the visuals on the right side. There's a 3D hourglass with sand trickling down, and below it, an empty wooden witness stand.
Ah, so the hourglass symbolizes time limits, and the empty stand is literally the missing complainant.
Exactly. The visuals are there to help you remember the concept. Now, let's look at the first path. On the left, Path A.
The box there says, Before charged substance framed.
This is critical. The timing is everything. We're at the very beginning of the case. The substance of the accusation from Section 274 hasn't even been stated yet.
Okay.
If at this very early stage the complainant is absent, and this is a double condition, the offense is either compoundable, meaning it can be settled, or it's non-cognizable, meaning a minor offense, then we look at Section 272.
And the box below that says magistrate may discharge, Section 272.
Two things to note there. The word may, it's a discretion, not a compulsion. And the word discharge.
And there's a red trap box at the bottom that highlights this. It says, discharge happens before the charged substance is framed. Why is that distinction so important?
Because students constantly confuse discharge with acquittal. A discharge means the court is simply letting the accused go because there's no ground to proceed at this early stage. The trial hasn't even really started. An acquittal, which we'll see in a moment, is a verdict of innocence after the trial process has begun.
Okay, so discharge is like being let go before the race starts. Acquittal is winning the race.
A perfect analogy. Now let's look at the second path on the right side of the flowchart. This one is labeled Day of Appearance Adjourned Hearing. So this is later in the process. Yes, this is on the day the court has ordered the accused to appear, or any subsequent hearing date. So the process is already underway. If the complainant does not appear on this crucial day, we shift gears and look at Section 279.
The box for that path says, magistrate shall acquit, Section 279.
See the difference? Shall acquit. That is a powerful mandatory command. It's not may, it's shall. If the complainant can't be bothered to show up to prosecute their own case, the magistrate is mandated by law to acquit the accused. The case is over. Finished.
But there's a dotted box underneath that one, an exception.
Yes. There's always an exception in law, isn't there? It says, unless magistrate thinks it proper to adjourn or a-plane, complainant is represented by a pleader.
So if the complainant's lawyer is there and has a good reason, like the complainant is sick.
Right. Or if the judge just thinks, maybe the complainant is stuck in a major traffic jam, let's give them one more chance, the court can adjourn. But the default rule, the general rule, is acquittal.
The green box on the slide really emphasizes this. Section 279 mandates acquittal upon non-appearance. And there's a yellow note about time limits, too. Section 272 mentions giving 30 days time to the complainant.
Yes, that connects back to Path A, the discharge. Under Section 272, the magistrate might say, the complainant isn't here today. I'll issue a notice and give them 30 days to show up. If they still don't appear, then I will discharge the accused. It's a fairness buffer.
This distinction between discharge in 272 and acquittal in 279, this feels like a classic exam question.
It is the classic trap. You will see it in prelims, you will see it in mains. Remember, discharge is letting them go before the trial really grips them. Acquittal is a clean slate, a verdict of innocence because the person pointing the finger failed to show up.
Understood. That's crystal clear. Let's go to slide 4. Accusation without reasonable cause, Section 273.
Section 273. This is the shield against harassment. This is the law's way of pushing back against people who use the courts as a weapon.
The visual is beautiful here. It's the golden scales of justice. On one scale, there's a heavy, rough-looking silver weight labeled false accusation. And on the other side, balancing it perfectly, are stacks of shining gold coins labeled compensation.
That image of balance is the core concept. It's about punishing frivolous complaints. If you drag someone to court, disrupt their life, and make them hire a lawyer based on a lie or with no real basis, you have to pay for it.
The slide lists the mechanism in 3 clear steps. Step 1, magistrate discharge sequits and finds no reasonable ground for accusation.
That is the absolute prerequisite. The magistrate can't just award compensation in every acquittal. They have to make a specific finding. They have to write it down in the judgment. I find there was no reasonable ground for making this accusation.
So a simple failure to prove the case isn't enough. It has to be baseless.
Baseless, frivolous, vexatious. That's the standard.
Step 2 is show cause notice issued to complaint informant.
This is natural justice. Before penalizing the complainant, the court has to give them a chance to be heard. The notice essentially asks, tell me why I shouldn't order you to pay compensation to the person you wrongly accused.
Makes sense. And step 3 is the outcome. Order. Payment of compensation not exceeding the amount a fine magistrate is empowered to impose.
Right. So every magistrate has a certain financial jurisdiction, a maximum fine they can impose. The compensation awarded under this section cannot exceed that limit. It's capped by their power.
What happens if they're ordered to pay but they just refuse? The slide lists consequence of default.
The consequence is simple imprisonment, or SI. But look at the limit. It's not very long, not exceeding 30 days. And it specifically references sections 68 and 69 of the Bnss, the Bharatiya Nyaya Sanhita, which deal with the procedures for imprisonment in default of paying a fine.
There are 3 colored boxes at the bottom that seem to add more detail. The green one says, Appeal, available if compensation euro 1,000 euro. Magistrates second class.
Right. So if a second-class magistrate orders you to pay, say, 1,500 rupees as compensation, you have a right to appeal that order. If it's just 500 rupees, you can't.
Then the red box says Liability. It reads, Order does not exempt from civil criminal liability. What does that mean?
This is very important. Just because you, the complainant, paid compensation in the criminal court, it doesn't mean you're off the hook. The accused person can still turn around and file a separate civil lawsuit against you for malicious prosecution and claim much larger damages. This order is just an immediate penalty.
So it's a summary penalty, not a final resolution of all claims.
Exactly. And finally, the yellow box reiterates the most important point. Magistrate must record that there was no reasonable ground. I can't stress this enough. If that finding, that specific phrase, is missing from the judgment, any compensation order made is illegal and will be overturned on appeal. As we teach at Target for IQ, you must look for this phrase in the problem questions. It's the trigger for everything else in Section 273.
Okay, moving to slide 5. We're getting into the conviction part of the process now. Conviction on plea of guilty, sections 275 and 276.
Yes, so the magistrate stated the substance of the accusation, and the accused says, yes, I did it. What happens then? There are 2 ways this can play out.
The visual is a 3D envelope with a document inside it, and that document has a big red guilty stamp on it. Very clear.
Section 275 is the standard scenario, the in-court plea.
The flow on the slide is simple. Accused pleads guilty. Magistrate records plea in accused words. Discretion to convict.
Now, look at the green box there, the one about recording. It says, plea must be recorded as nearly as possible in the words used. The magistrate can't just write a summary like he admitted his guilt.
Why is that so strict?
Because the exact words are crucial. If the accused says, yes, I hit him, but only because he insulted my mother, the magistrate must write exactly that.
Because I hit him because he insulted my mother might not actually be a pure guilty plea. It might be a plea of provocation, a defense.
You've got it. The exact words reveal the true nature of the plea. A judge has to be sure it's an unequivocal, unambiguous admission of guilt before they can convict on it.
That makes perfect sense. Then we have section 276 on the slide, which is labeled Petty Cases Absentia.
This is a fantastic provision for efficiency. Think about minor traffic offenses or, being ticketed for littering, small things with small fines.
So you don't have to take a day off work to go to court for a 100 rupee fine.
Correct. The flow here is a summons is issued under Section 229. The accused can then transmit a letter admitting guilt, plus the fine amount mentioned in the summons, and the magistrate can convict them in their absence.
It's a convenience measure for both the public and the courts.
Absolutely.
But the red TRA box at the bottom of the slide has a warning. It says, magistrate may convict, not shall. It is discretionary. This seems to be a recurring theme.
It is the essence of judicial function. The magistrate is not a robot. Even if someone pleads guilty, the judge isn't bound to convict them. If the facts alleged don't even constitute an offense, or if the magistrate suspects the plea was coerced, they can refuse to accept the plea and say, no, we're going to have a proper trial. It's a vital safeguard.
Right, so the discretion is always there. Okay, slide 6 takes us to the other side of the coin. Procedure when not convicted, sections 277 and 278.
So the accused said not guilty back at the start. In Section 274, now we have to actually conduct the trial. Now we fight.
The visual is a classic scroll labeled evidence with a large magnifying glass hovering over it, like it's being scrutinized.
A very apt image. Section 277 is the trial proper. It's where the evidence is presented. The procedure is straightforward. The magistrate first hears the prosecution and takes all their evidence. Witnesses are called, documents are shown.
And after the prosecution is done,
Then the court hears the accused and takes any defense evidence they wish to present. It's a two-sided process.
and after all the evidence is in, we move to section 278, which covers the result: acquittal or conviction.
Look at the flow chart on the slide. It starts with finding. It then splits into two paths, A and B. Path A. If the magistrate's finding is not guilty, that leads directly to an order of acquittal.
Simple enough.
Path B. If the magistrate's finding is guilty, that leads to the next step, which is sentence according to law.
The red box here is interesting. It talks about prejudice. It says, conversion of finding allowed only if accused is not prejudiced. What does that mean?
This refers to a specific provision, Section 278, subsection 2. Suppose you were on trial for simple theft, but during the trial, the evidence actually shows that you committed criminal misappropriation, a different but related offense. The magistrate can convict you for misappropriation, even though it wasn't the original allegation, but only if the accused is not prejudiced by this. Not prejudiced means they had a fair opportunity to defend themselves against the facts that constitute misappropriation. If all the evidence was already on record and they had a chance to challenge it, it's usually considered fair.
So you can't be caught completely by surprise with a new charge at the last minute.
Exactly. Fairness is key. And there's also a yellow box about witnesses here. It says, expenses may be required to be deposited in court, Sec. 2773.
Yes, this is a practical tool to prevent delays. If an accused person says, I want to call 50 witnesses from all over the country just to drag the case out,
The court can step in.
the court can say, fine, you can call them, but you have to deposit the money for their travel and daily expenses in court first. It's a way to filter out frivolous requests.
That's a clever mechanism. Okay, slide 7. Special powers. Stopping proceedings and conversion. These are two very specific powers. And as Satendra Sir always highlights, these are critical for the mains exam. They love to ask about these.
The visual is a road sign, a blue circle with a white arrow doing a complete U-turn.
That U-turn perfectly represents Section 282, which is conversion. But let's look at Section 281 first, the power to stop proceedings.
The slide breaks down.
Yeah.
Magistrate first class or others with CJM sanction, so not a junior magistrate on their own.
Correct.
Condition. Case instituted otherwise than upon complaint.
And what does that usually mean?
A police report case. A case started by the police, not a private citizen.
Exactly. This power doesn't apply to private complaint cases.
The effect of stopping the proceeding is split into two outcomes. After principal witnesses recorded acquittal, and any other case, release parole, which amounts to discharge.
Right. So under Section 281, sometimes a case is just going nowhere. Maybe the evidence is incredibly weak, or the main witness has turned hostile. The magistrate can just stop it. If the main witnesses have already given their evidence and there's nothing there, it's a full acquittal.
But if they stop it before the main evidence is recorded,
Then it's just a release, which has the legal effect of a discharge. The accused can be called back if new evidence emerges. It's not a clean slate like an acquittal.
Okay, now for Section 282, conversion to warrant case. This is the U-turn from the visual.
Yes. This is when the court realizes it's on the wrong track. The trigger for this is offense punishable with imprisonment 6 months.
And the reason, interests of justice require warrant procedure.
Let me give you an example. Imagine we start a summons trial for what looks like a simple assault, which has a short sentence. But during the evidence, the doctor testifies that the victim's injury is actually grievous hurt, causing a permanent disability. That's a much more serious crime.
A crime that would normally be tried as a warrant case.
Precisely. So the magistrate realizes that the simplified summons procedure is no longer appropriate. The interests of justice demand the more rigorous, detailed procedure of a warrant trial.
So what's the action they take? The slide says, rehear case and recall witnesses.
They essentially hit the reset button, they scrub the timeline, they go back to the beginning and restart the entire process using the warrant case procedure. That's the U-turn.
And the witnesses have to come back and testify all over again.
Yes, because the rules of evidence and examination are different and more detailed in a warrant trial. It's necessary to ensure a fair trial for the more serious offense.
The yellow box summarizes a key point. Effect. Release under Sec. 281 before evidence amounts to discharge.
Correct. It's a reminder to always distinguish between release, discharge, and a full acquittal. They are not the same thing and have very different legal consequences.
Slide 8 covers the analysis, summons cases, examiner's perspective.
This slide is pure gold for students. This is us telling you how the examiner thinks.
The visual is a clipboard labeled Common Errors with a checklist. Let's look at the first part, why questions are asked.
Why do they focus on this chapter?
Point 1. To test knowledge on discharge versus acquittal, Sec. 272 versus 279. We've discussed that one in detail.
And you can see why. It's a classic point of confusion.
Point 2. To calculate the compensation limits in Sec. 273.
Yes, they will give you a problem-based question. A magistrate of the first class acquits an accused and finds the complaint was vexatious. What is the maximum compensation they can award? To answer that, you have to know the general finding power of a first-class magistrate.
Under common student mistakes, point 1 is confusing the substance of accusation with framing of charges.
We established that right at the beginning. Summons equals substance. Warrant equals charge. You have to burn that into your memory.
And point 2, forgetting that Sec. 281, stopping proceedings, does not apply to complaint cases.
Again, a small detail that can cost you marks. The section explicitly says, instituted otherwise than upon complaint. If you apply it to a complaint case in an answer, you're fundamentally wrong.
The branding note here says, as emphasized by Jharkhand, the main's focus is, write the conditions for converting summons to warrant, Sec. 282.
Yes, this is a standard 5-mark or 10-mark question in the mains exam. You need to be able to list the conditions cleanly. 1, the offense appears to be punishable with more than 6 months imprisonment, and 2, it is in the interests of justice. Simple, but you have to know it perfectly.
Okay, that wraps up summons cases. A very thorough overview. We're now moving to Part 2, Summary Trials, which is Chapter 23. This is on Slide 9.
Summary trials. If summons trials are about being streamlined, summary trials are all about pure speed. This is the legal system's express lane.
The slide is titled Chapter 23, Summary Trials, Competency. The visual is a shiny gold badge, like a sheriff's badge, that reads Judicial Authority.
Competency is the legal term for who has the power to do this, who is authorized to run this express trial.
The slide lists Section 283, subsection 1, and under that, A, any chief judicial magistrate, CJM, and B, any magistrate of the first class, JM1.
So the senior magistrates, the CJM and the JM1, have this power inherently. It's part of their job description. They don't need to ask for special permission.
But then we have Section 284, which lists magistrate of the second class, JM2.
The JM2, they are the most junior magistrates in the hierarchy, so they have restrictions.
The slide lists those constraints. First, authority, high court may confer power, and second, constraint. Only for offenses punishable with fine only or imprisonment not exceeding 6 months.
This is a vital distinction. A second-class magistrate cannot just wake up one morning and decide to try a case summarily. First, the high court of their state has to issue a notification specifically empowering them to do so.
And even after they get that power.
Even then, their power is limited. They can only touch the really small cases, those where the maximum punishment is 6 months in jail or just a fine. They can't summarily try something that has a punishment of, say, 2 years.
The colored boxes on the slide summarize this. Green says, authority, CJM and JM1 have inherent power via Sanhita. The red box warns. Constraint, JM2 needs high court authorization.
And look at the yellow box, discretion. It says, the magistrate may try summarily, not shall. This is another key point.
So even if the crime is on the list of things that could be tried this way, the judge can refuse.
Absolutely. The judge might look at the file and say, you know, on the face of it, this is a minor theft, but the legal questions involved are very complex. It's not suitable for a summary trial. So they'll opt for a regular, more detailed summons trial instead. It's never mandatory.
Let's understand the next point from here. Slide 10. Offenses triable summarily, Section 283.
Okay, so now we get to the specific shopping list of crimes that can be put in this express lane.
The visual here is a price tag like you'd see in a store, and it's labeled $20,000 max.
That price tag is the key to remembering the most common category.
Let's go through the specific offenses listed on the slide. 1. Theft under Sections 301, 303, or 304 of the Bnss 2023, where the value of the property stolen does not exceed 20,000 rupees. 2. Receiving or retaining stolen property under Section 315 of Bnss 2023, where the property's value does not exceed 20,000 rupees. 3. Assisting in the concealment or disposal of stolen property, also Section 315 Bnss 2023, where the value is not more than 20,000 rupees.
Do you see the pattern?
Yes. It's all theft-related offenses, and the value of the stolen item is capped at 20,000 rupees.
Exactly. If the value of the stolen phone is 20,000 rupees, it can go to summary trial. If it's 20,001 rupees, it has to go to a regular trial. It's a strict monetary cutoff.
The list continues. Point 4. Offenses under Section 330, 350, insult with intent to provoke breach of peace, and 349, criminal intimidation of Bnss 2023.
These are minor offenses against a person's peace and tranquility, not causing physical harm, but things like insulting someone to start a fight or simple threats.
And point 5 is an old one, an offense under Section 20 of the Cattle Trespass Act, 1871.
A legacy provision, but it's still in the book, so you need to know it for the exam.
Now, there's a residual clause mentioned on the right side of the slide under Section 283.2. It says, offense is not punishable with death, life imprisonment, or for a term exceeding 3 years. Wait, this seems very broad. Does this mean any offense with up to 3 years punishment can be tried summarily?
That is an excellent question and a common point of confusion. No, it doesn't mean any such offense. This clause is read in conjunction with the power of the magistrate. The magistrate has to be of the opinion that the case, if proved, would not warrant a sentence of more than 3 months anyway. So it's about trying cases which are not on the specific list but are still minor in nature. The ultimate restriction, as we'll see, is on the sentence that can be passed.
So it's a catch-all for other minor offenses, but it's not a blanket power.
Precisely. And the exam alert at the bottom is very practical. Memorize the specific Bnss section numbers mentioned, 301, 315, etc. Yes, examiners love to ask these direct questions in prelims. Which of the following sections of the Bnss is triable summarily? You just have to know that Section 315 refers to stolen property. It's pure memory work.
Understood. Moving to slide 11. Procedure and judgment in summary trials.
Okay, so we know who can do it and for what crimes. Now, how do we actually do it?
The visual is an open law book, but instead of dense text, the page just has bullet points that say summary notes.
That's the essence of it. Section 285 says the procedure to be followed is the procedure of a summons case.
So it's the substance of accusation again, no formal charge.
Yes. It's basically an even faster version of a summons trial. But now look at the most important part on this slide, the sentence limit.
It's in a big red box. No sentence of imprisonment for a term exceeding 3 months shall be passed in the case of any conviction.
This is the golden rule of summary trials. This is the trade-off. Even if the crime of theft you're trying could theoretically get someone 2 years in jail, if you, the magistrate, choose to try it summarily, the maximum sentence you can possibly give is 3 months.
So if you think the person deserves more than 3 months, you can't try it this way.
You have to switch to a regular trial. It's a huge trade-off, as you said. The system trades sentencing power for incredible speed.
Section 286 describes the record. It says, the magistrate enters particulars in such form as the state govit may direct. And it lists things like serial, date of offense, complainant's name, plea of the accused, the finding, the sentence.
It's basically a form-filling exercise. The judge doesn't write a long narrative judgment. They just fill in the columns in a register. It's designed for high volume and quick disposal.
Section 287 covers the judgment. If accused does not plead guilty, magistrate shall record the substance of the evidence and a judgment containing a brief statement of the reasons for the finding.
The key words there are substance of the evidence and brief statement of the reasons. Not a 50-page thesis, just a couple of lines. I believe prosecution witness 1 because his testimony was consistent. I do not believe the defense witness because he contradicted himself. Therefore guilty. Brief and to the point.
The red box at the bottom really hammers the point home. Strict rule, max imprisonment is 3 months. Sec 285-2.
Never, ever forget that number. 3 months. It's the most tested aspect of this chapter.
Okay. Slide 12 is an analysis, summary versus regular summons trial.
The comparison slide. This is great for clarifying your concept.
The visual is a giant VS graphic, like for a boxing match, between regular summons trial and summary trial.
Let's run through the comparison points.
First, procedure. The slide says both follow summons procedure.
Correct. The basic framework is the same. Substance of accusation, not formal charge.
Second, the record. In a regular trial, the slide says full evidence recorded, Sec 274. But in a summary trial, it's the substance of evidence only, Sec 287.
This is a major difference. In a regular trial, the judge has to write down, as nearly as possible, everything the witness says. It's a detailed record. In a summary trial, they just write down the gist of it. Witness said he saw the accused run away. That's it.
And third, the sentence. Regular is according to law for that offense. Summary is max 3 months.
That is the big one we just discussed. The sentencing power is severely curtailed in a summary trial.
The slide also mentions a recall power under Section 283(3). It says, if at any stage it appears to the magistrate that the case is one which is of a character which renders it undesirable that it should be tried summarily, the magistrate shall recall any witnesses and proceed to rehear the case in the manner provided by the Sanhita.
That's the escape hatch we talked about. If the judge is halfway through a summary trial and realizes, whoa, this is far more complicated than I thought, or this accused actually deserves more than 3 months, they can hit the reset button, recall the witnesses, and start over as a regular summons trial.
And the yellow box notes a procedural point. Signature. The record in judgment must be signed by the presiding magistrate, Sec. 288.
A small point, but a mandatory one. An unsigned judgment is not a valid judgment.
Okay, that covers summary trials. Now, Part 3, plea bargaining. Chapter 24. This is on slide 13.
Yes, plea bargaining, a relatively modern addition to our criminal procedure and a very important one. It's about finding a middle ground, a form of restorative justice.
The visual reflects that. It's a firm handshake happening over a scroll that looks like a contract.
It really is a lot like a contract negotiation. It's a deal between the prosecution and the accused, overseen by the court.
The slide starts with the scope under Section 289. Applies when a report has been forwarded by the police under Sec 193 or cognizance has been taken on a complaint.
So right away, we know it's available in both police cases and private complaint cases.
The next point is the offense threshold. The offense is not one for which the punishment is death or imprisonment for life or for a term exceeding 7 years.
That is the ceiling, the absolute upper limit. If you've committed a crime that is punishable by, say, 10 years in prison, plea bargaining is off the table. You have to go to a full trial. This is for mid-level offenses.
And then there's a list of exclusions, strict. This seems very important. 1, offenses affecting the socioeconomic condition of the country. 2, offenses committed against a woman. 3, offenses committed against a child below the age of 14 years.
These are non-negotiable absolute bars. You cannot plea bargain your way out of a crime against a woman or a child. The law considers these offenses too serious for any kind of deal-making. And socioeconomic offenses, things like large-scale financial scams, food adulteration, corruption, are also excluded because they harm society as a whole. The central government publishes a list of these specific offenses.
The yellow box specifically highlights the child age, specifically below the age of 14 years.
Yes, the law draws a very specific line. You have to remember that exact age for the exam. If the victim is 15, this particular exclusion doesn't apply. It has to be a child below 14.
Okay. Slide 14 explains the application process, Section 290.
So how does an accused person actually ask for a deal? What are the steps?
The visual here is a yellow camera icon inside a circle.
That camera represents the most crucial step in this process, the in-camera examination. We'll get to that.
Let's follow the flow on the slide. It starts with, accused files a written application plus an affidavit. The affidavit must state that the plea is voluntary and that they have no previous conviction for the same offense.
2 very important conditions. First, it has to be voluntary. Nobody can force the accused to plea bargain. Second, you can't be a repeat offender for the same crime. This is generally seen as a one-time offer from the justice system.
After the application is filed, the next step is court issues notice to the public prosecutor complainant.
Of course, the other side has to be informed that a deal has been proposed.
And then comes the key step. Appearance and in-camera examination of the accused. The other party is not present.
This is the heart of ensuring fairness. The judge asks everyone else, the prosecutor, the police, the complainant's lawyer, to leave the courtroom. It's just the judge and the accused. And the judge asks direct questions. Did anyone threaten you to file this? Did anyone promise you something to sign this? Do you understand the consequences?
And doing it in camera without the police present ensures the accused can speak freely.
Precisely. It removes any possibility of coercion at that stage.
The decision phase then splits. If voluntary, provide time, max 60 days, for working out a mutually satisfactory disposition, MSD. But if involuntary previous conviction found, the court proceeds with the regular trial.
So if the judge is satisfied it's a genuine voluntary request, they start the clock. They give the parties up to 60 days to negotiate a deal. But if the judge smells a rat or finds out the accused lied about a past conviction, the application is thrown out and the trial proceeds as if nothing happened.
That 60-day clock seems important.
It is. It's a statutory time limit.
Slide 15 covers that negotiation phase. Mutually satisfactory disposition. Sec 291-292.
Yes, the MSD. This is the negotiation itself.
The visual is great. It shows 3D figures sitting around a roundtable discussion.
Because that's what it is. Section 291 is about the meeting.
The slide says the notice is given for a meeting that includes the public prosecutor, the investigating officer, the accused, and the victim.
Notice who is at the table. A lot of students are surprised to see the investigating officer, the police officer, is part of the negotiation. They think the police's job is over. But they're there to represent the facts of the investigation and assist the prosecutor.
And the victim's presence is key for restorative justice, I imagine.
Absolutely. The victim gets to participate in the resolution, and throughout this, the slide notes the duty of court to ensure the entire process is voluntary. The judge acts as a referee, making sure no one is being bullied into a deal.
Section 292 is about the report. If an MSD is worked out in sympathy court, the court prepares a report signed by the presiding officer plus all the participants. But if no disposition is reached, the court records this and proceeds with the regular trial from the stage the application was filed.
Right. So if they agree on a deal, maybe compensation for the victim and a lesser sentence, they all sign a report. That report goes to the judge. If they can't agree, the judge makes a note of it, and the plea bargaining process ends. We go back to the trial.
Okay, slide 16 is disposal and sentencing formulas, section 293. This looks like the math section.
This is the math section. Get your mental calculators out. This is where the bargain part of plea bargaining comes in.
The visual is a golden calculator with fractions floating around it. 12, 14, 16.
Okay, under the guidance of Satyendra, sir, we always bring this down into 3 clear rules, A, B, and C, to avoid any confusion.
Rule A says probation. If the law allows, like the Probation of Offenders Act or Sec 401 of Bnss, the court can release the accused on probation or after due admonition.
This is the best possible outcome for the accused. No jail time at all, just a warning or supervision under a probation officer. This is usually for very minor cases and young offenders.
Okay, then Rule B. This applies when a minimum punishment exists for the crime.
Right. Suppose the law for an offense says punishment shall not be less than 4 years but may extend to 7 years. There is a mandatory minimum, a floor.
If that's the case, the rule is sentence equals half of the minimum punishment.
So in our example, if the minimum is 4 years, the plea bargain sentence would be half of that, which is 2 years.
But there's a parenthesis here that seems new. First-time offender, 1/4 of the minimum.
Yes. This is an important update in the Bnss. It gives an extra discount for first-time offenders. So if it's your very first offense and the minimum sentence is 4 years, you would get 1/4 of that. Just 1 year.
That's significant reduction. Now, Rule C. This applies when there is no minimum punishment.
So the law just says something like, shall be punished with imprisonment, which may extend to 7 years. There's no bottom limit.
In that case, the rule is sentence 1/4 of the maximum punishment provided.
So if the max is 8 years, the sentence would be 1/4 of that, which is 2 years.
And again, there's a parenthesis, first-time offender, 1/6 of the punishment provided.
Exactly. First-timers get an even better deal here, too. They would get 1/6 of the 8 years. This 16th fraction is a very specific detail you need to remember for the Bnss.
The green box on the slide clarifies this well. First-timer benefit gets 14th in a min punishment case or 16th in a no min punishment case.
It is confusing, I admit. You have to memorize it. Is there a minimum sentence? Yes. Then the fractions are 12 or 14. Is there no minimum? Then the fractions are 14 or 16. Practice with a few examples and it will stick.
Got it. Okay, slide 17 is about finality, set-off, and savings. Sec 295-300.
This is about wrapping up the deal and its consequences.
The visual is a large, solid silver padlock, suggesting the case is now locked and closed.
It is. Section 295 makes that very clear. The judgment delivered by the court shall be final. There shall be no appeal.
So once you take the deal, that's it. You can't turn around and appeal your conviction.
Correct. But there's a small exception listed. SLP, Art 136, and Writ, Art 226227.
Meaning, you can't file a regular appeal under the Code of Criminal Procedure, but you can still approach the Supreme Court or High Court on constitutional grounds, like if the whole process was a fraud.
Yes, those constitutional remedies can never be taken away. But for all practical purposes, the judgment is final. The padlock is locked.
The slide also mentions confidentiality under Section 299. Statements given by the accused in the application can be used only for the purpose of this plea bargaining chapter.
This is a crucial protection. Imagine I file an application and admit my guilt in it, but then the negotiation fails and we go back to trial. The prosecutor cannot use my application as evidence against me in that trial.
So what happens in the plea bargain negotiation stays in the plea bargain negotiation.
Precisely. It's privileged information. Otherwise, no one would ever apply.
Slide 18 gives us the analysis plea bargaining exam perspective.
The common traps examiners set for you.
The visual is a dartboard with several arrows hitting the bullseye, labeled target.
Let's look at the common traps.
Number 1, thinking it applies to all offenses.
We know that's wrong. You have to remember the 7-year punishment cap and the absolute exclusion for crimes against women and children.
Number 2, confusing the sentencing fractions, 14 versus 16.
We just went through the math. You have to practice it. They will give you a problem where you have to calculate the sentence.
And number 3, thinking the police officer, investigating officer, isn't involved in the meeting.
Another common mistake. Section 291 explicitly puts the IO at the negotiation table.
Okay, moving to the final part of our deep dive today, Part 4. Attendance of persons confined or detained in prisons, Chapter 25, and we're on slide 19.
This is a very practical, logistical chapter. How do you get a prisoner from the jail to the courthouse?
The visual is a heavy, riveted metal prison cell door. Very imposing.
The first slide here, 19, deals with sections 301 and 302. Section 301 just provides definitions. Detained includes people held under preventive detention laws, and prison is defined broadly to include any place like a subsidiary jail, a reformatory, or a borstal institution for young offenders.
Section 302 gives the power to require attendance.
It says any court may make an order requiring the officer in charge of the prison to produce any person.
And for what purpose? The slide says for answering a charge or for giving evidence as a witness.
Right. So you need the prisoner in court for one of two reasons. Either they are the accused person in your trial, or they are a witness who saw something important.
There's a restriction noted here. A magistrate of the second-class order must be countersigned by the Chief Judicial Magistrate, CJM.
There it is again. The junior magistrate, the JM2, has a check on their power. They can't just issue an order to a jail superintendent to move a potentially dangerous prisoner. Their order has to be reviewed and signed off on by their superior, the CJM. The CJM acts as a filter to make sure the request is necessary and proper.
That makes sense from a security standpoint. Okay, slide 20. Power to exclude persons from operation of this chapter, section 303.
Sometimes moving a prisoner is just too dangerous or not in the public interest.
The visual here is a 3D red stop hand gesture. Very clear message.
The authority to make this decision lies with the state government or the central government.
And the power they have is to direct that any person or class of persons shall not be removed from the prison in which they are confined.
So the government can issue a blanket order. For example, all prisoners being held under the National Security Act in Bihar Jail are grounded. They will not be produced in any court.
And the slide says the effect is that this government order overrides a court order issued under Section 302.
Yes. In this specific matter of prison security, the executive's order trumps the judiciary's order. It's a separation of powers issue related to security.
The slide also lists the grounds for such an order under Section 303 too. It can be based on the nature of the offense, the grounds of detention, public order likelihood of disturbance, or general public interest.
Right. If the police have intelligence that taking a particular gang leader to court will likely result in a shootout or a riot, a disturbance of public order, the government can step in and say, no, he stays in jail, we'll arrange for a video conference hearing instead.
We've reached the outro. Slide 21 is the master comparison. The 3 tracks.
Let's bring it all together now. A final summary.
The visual is really cool. It shows 3 colored beams of light merging into one. A blue beam for summons, a purple beam for summary, and an orange beam for plea bargaining.
Let's quickly recap the key differentiators on the slide. For summons trial, the key is no formal charge, just the substance. Evidence is recorded in full. The outcome is a full acquittal or conviction, and appeal is generally available. For summary trial, this is for specific minor offenses like theft under 20,000 rupees. The big restriction is the max sentence of 3 months, and only the substance of evidence is recorded. For plea bargaining, this is a negotiation-based process. It applies to offenses punishable up to 7 years. The outcome is a final judgment with no appeal, and the sentence is reduced based on those fractions we discussed, 12, 14, or 16.
That's a fantastic snapshot to have in your mind right before an exam.
Absolutely. Review the monetary limits, that $20,000 for summary trials. Review the sentencing caps, 3 months versus the plea bargain fractions. And review the absolute exclusionary clauses, crimes against women and children for plea bargaining.
And finally, slide 22, mentor's verdict and final tips.
As Satendra Sir always says.
The visual is a large gold trophy. The tips are 1. Precision in procedure leads to precision in marks. 2. Focus on the time limits we discussed, like the 30 days for the complainant or the 60 days for MSD negotiation. 3. Do not ignore the second-class magistrate restrictions in both summons and summary trials.
Those little details, the need for countersigning by the CJM, the need for high court authorization, that's where so many students lose easy marks.
There's a call to action here. Revise Section 293, the plea bargaining sentencing math, immediately.
Yes. Do it tonight while it's fresh. Take a few hypothetical offenses and calculate the sentence for a first-time offender versus a regular accused. Make it a practical exercise.
The green box says, Success tip. Reread the definition of socioeconomic offenses as notified by the government. The red box says, common error. Don't confuse discharge in summons cases with the concept of discharge in warrant cases. They operate differently.
And the final note on the slide is for you, the listener. Judiciary aspirants must master these flowcharts for mains answers. Don't just read them, draw them out yourself.
Well, looking back at this entire slide deck, those flowcharts really are the roadmap through this complex procedural maze.
In our judiciary classes at Target for IQ, we drill these procedural flows until they become second nature, like muscle memory.
This has been an incredible deep dive. I feel like I can finally explain clearly why the substance of accusation is sufficient in one case and why that U-turn to a warrant case is so important in another.
It's all about the procedure. If you master the procedure, you master the exam. The substance of the law is one thing, but the machinery that puts it into motion is everything.
Thank you so much for walking us through this with such clarity.
It was my pleasure. Let's keep learning. Let's understand the next point from here.
Welcome back, everyone, to the deep dive.
It's good to be back.
Today, we're doing something a little different. We're not just looking at a law. We're trying to understand the machine that makes the law actually work.
The engine room.
Exactly, the engine room.
Yeah.
We are opening a file that, honestly, a lot of people find intimidating or, just plain boring.
I get that. It's procedural law. It doesn't have the same drama as, say, the definition of murder.
Right. But it is, as you said, the engine room of the Indian criminal justice system.
Right.
We're talking about the Bharatiya Nagarika Suraksha Samhita, the Bnss.
And not just the whole thing, but a very specific, very mechanical part of it. Sections 301 all the way to 367.
It's a massive chunk of text.
It is. And you're right. People do gloss over it. They see it as administrative paperwork. But I love your analogy. If the substantive law, the Bnss, is the car, then these sections, they're everything else.
The transmission, the gears, the brakes.
Mm-hmm.
Precisely. Without sections 301 to 367, that car just doesn't move. Or, even worse, it just crashes straight into a wall because you don't know how to steer it.
Exactly. And to guide us through this engine room today, we've got some really unique source material. We are working off a comprehensive slide deck, some really detailed lecture notes from a special session that was designed for judiciary aspirants.
Ah, so this is exam focused.
Very much so. This is from the Target for IQ program, and it's all under the guidance of Successor. So what we're getting is let's call it the exam grade breakdown.
Okay, I like that. So this isn't just abstract legal theory.
Not at all. This is about how you pass the exam, how you become a judge.
And that context is absolutely vital. A program like Target for IQ, it's all about precision. What does the section actually say? Where's the trap the examiner will set for you? And how do you frame this for a mains answer?
So we're going to try and adopt that persona today. We're looking at this as if we're prepping for, the fight of our lives, whether that's in a courtroom or in that exam hall.
Sounds good. Let's do it.
Okay, so let's start with the first visual I have here. It's slide 1, the title slide. It's got this very imposing image, a gavel resting on a big book titled Bharatiya Nagarika Suraksha Samhita.
A classic, powerful image.
And the topic is stated right there. Procedural mechanics.
Procedural mechanics. That is the perfect phrase for it, because that's what these sections are, 301 to 367. They govern that whole middle phase of a trial.
The middle phase? What do you mean?
Well, think about it. The investigation is mostly done. The police have filed their charge sheet. Now, we're in the courtroom. We're in the day-to-day mechanics of the trial itself.
So things like, how do we get the prisoner here in the first place?
Exactly. And once they're here, how do we record what they say? What about a witness who's sick? What about an accused who is mentally unwell? It's all the daily grind of the court.
And the notes here from Successor really highlight that these sections are of high relevance for mains answer writing.
They have to be. I mean, think about it from the perspective of a judge. You can know every single element of a substantive offense, but if you don't know the correct procedure to try that offense,
We're completely stuck.
you can't be a judge. You can't sentence someone if you don't know how to legally bring them to the dock first.
Okay, so let's unpack the structure of this whole block. I'm looking at slide 2 now. It's a flow chart, and it's titled The Courtroom Chronology.
Ah, this is a great way to visualize it.
It breaks this huge block of sections into 4 distinct zones. I really like this. It makes it feel, digestible.
And it's logical. It mirrors the actual life cycle of a trial day. It's chronological.
Okay, break it down for us. Zone 1.
Zone 1 is attendance in prisons. This is the first hurdle. Simple but crucial. Getting the accused to court.
Makes sense. Then Zone 2?
Evidence mechanics. So once they're in the room, how do we actually record the evidence? What are the rules?
And Zone 3?
That's trial provisions. These are the big thematic rules of engagement, things like double jeopardy, pardons, legal aid, the sort of core principles of a fair trial.
And finally, Zone 4.
Special scenarios. This is for the curveballs. Things that don't happen every day, but you need rules for them. Mental illness, a witness who's hiding, things like that.
It's a really logical flow. You can't get to Zone 2, recording evidence, if you haven't succeeded in Zone 1.
You can't. If the guy isn't there, there's nothing to record.
So let's dive straight into Zone 1 then. Attendance in prisons. This covers sections 301 and 302. I'm looking at slide 3. It's a very simple flowchart. An arrow goes from court to order, which then points to officer.
On the surface, it seems incredibly simple, right?
Yeah.
The court just tells the jailer, hey, bring the prisoner. But, like everything in law, the devil is in the definitions. We need to look at what Section 301 actually defines as a prison and who is considered detained.
I have to admit, when I saw prison being defined, my first thought was, come on, we all know what a prison is.
And that's exactly the kind of assumption that can trip you up in a prelims exam. The notes here are right to emphasize this. The legal definition is much, much broader than just, TR jail.
Okay, so what does it include?
Well, this is a classic multiple choice question. Prison, under Section 301, specifically includes subsidiary jails, which are smaller local jails, but it also includes reformatories.
Like for rehabilitation.
Exactly. And crucially, borstal institutions.
Borstal institutions.
Yeah.
Those are for young offenders, right? Juvenile facilities.
That's the one. Youth detention centers.
Right.
So the law is making it clear. For the purpose of bringing someone to court, it doesn't matter if they are in a maximum security prison or a reform school for teenagers. The process is identical.
Okay, that's an important clarification. And what about the definition of detained?
Also very important. The slide points out it includes prevented detention. So this isn't just for people who have been convicted or are on trial. Even if someone hasn't been formally charged with the specific crime yet, but is being held under a preventive law, say for national security.
This section still applies to them.
This section applies. You still need a court order to move them.
Okay, so the process shown on the slide is the criminal court issues an order. It goes to the officer in charge of the prison. And the justification is when it's necessary for the ends of justice. That phrase seems vague.
It is, but it's intentionally so. It's the golden key. It gives the court discretion. The court doesn't just order prisoners to be moved around for no reason. It has to be genuinely necessary for the trial or some other proceeding.
Right.
But here's where it gets really interesting, and this is something as we teach at Target for IQ that you have to watch out for. It's not just what the order says, but who is issuing it. Look at the red box on the slide.
I see it. It's labeled TRAP.
Of course it is.
It says, if a magistrate of the second class issues the order, it must be countersigned by the Chief Judicial Magistrate, CJM.
And this is absolutely crucial. A second-class magistrate is a relatively junior judicial officer. Moving a prisoner isn't a trivial matter. It costs money, it requires police guards, it involves security risks.
So the law doesn't fully trust the junior judge to make that call alone?
Exactly. They need a sign-off from the boss, the CJM, who's the senior magistrate in the district.
Okay, so it's a procedural check.
It's more than that. Section 302, subsection 3, clarifies something vital. The CJM is not just a rubber stamp. They aren't just meant to sign on the dotted line.
So they can refuse.
They can, and they should, if necessary. The CJM effectively reviews the order. If the CJM looks at it and thinks, no, this isn't really necessary for the ends of justice, this can be handled by video conference, or the risk is too high, the CJM can decline to countersign.
Wow. That's a fascinating check and balance within the judiciary itself. The senior judge can effectively overrule the junior judge's order and say, denied, keep him in jail.
And it makes perfect sense. It saves the state money, and it mitigates security risks.
Okay, so speaking of keeping them in jail, let's move to the next slide. Slide 4, it's got a big shield icon on it representing exemption. This is sections 303 to 305.
Right, so sometimes it's not the CJM who says no, it's the government itself. The state can step in and say, no, we're absolutely not moving this person from this prison.
Under what grounds? The slide lists 3 of them under section 303, subsection 2.
Let's go through them.
First is the nature of the offense.
So, if it's an offense related to, say, national security, terrorism, something very grave.
Second, likelihood of disturbance of public order.
This is a big one. Think about high-profile terrorists or maybe powerful mob bosses or gang leaders. If you know that moving a particular gang leader from Bihar jail to a district court is going to cause a riot
Or an escape attempt.
or a planned attack on the convoy, if there's credible intelligence of that, the state government has the power to issue an overriding order.
And the third ground is just public interest generally.
A catch-all, but a powerful one.
So the court says bring him, and the government can just say, no.
In these specific exceptional scenarios, yes. The executive's concern for public order can, in a way, override the judicial order for physical presence. Of course, in modern times, the solution would be to use video conferencing. The trial wouldn't just stop.
Right, but there's an exception to this exception, isn't there?
There always is, and this one is the big exam alert on the slide.
I see it. It's in bold. Section 304 proviso, the 25 kilometers rule.
This is the kind of granular detail that Successor Sir always warns students about. It's a classic prelims question because it's so specific.
Okay, what's the rule?
The rule is this. Even if a person is under committal orders or remand orders that would normally keep them locked down in that specific prison, and even if the state has concerns, if the court where their evidence is needed is within 25 kilometers of the prison,
Then what?
then the officer in charge of the prison must produce them. The rule is mandatory.
Wait, let me get this straight. So I could be a high-risk prisoner, the government doesn't want me moved. But if the courthouse is just, say, 20 kilometers down the road?
Then you're going for a ride. The government's objection is overruled by this proviso.
What's the logic there?
The logic is that if the distance is that short under 25 kilometers, the argument about security risk, expense, and inconvenience loses a lot of its weight. It's a short, manageable trip. The physical proximity mandates production.
That is so specific. 25 kilometers, not 30, not 20.
It's funny how justice sometimes comes down to a literal measuring tape, isn't it?
Sorry, Warden, Google Maps says it's 24.8 kilometers. You gotta get the van ready.
That's pretty much exactly how it works. And as we always emphasize in our judiciary classes at Target for IQ, you cannot forget this number. If you write a reasonable distance in your mains answer, you get 0. If you write within 25 kilometers, you get full marks. Precision is everything.
Got it. Okay, so we've managed to drag the prisoner to court, or maybe we haven't, depending on the 25-kilometer rule. Now we can finally enter Zone 2, evidence mechanics. This is a big section, 307 to 336.
Right. The prisoner is now standing in the dock. The chaos of transport is over. The courtroom goes quiet. Now we need to actually record what happens next. And the Bnss, like the old criminal procedure code, makes a distinction between how we handle small cases versus the really big ones.
And slide 5 has a comparison table that lays this out. On the left, summons cases, which is section 309. And on the right, warrant case accessions, covering sections 310 and 311.
Let's start with summons cases.
For summons cases, it says the magistrate just makes a memorandum of the substance of the evidence.
Substance is the key word there. In a summons case, which is for less serious offenses, things punishable with less than 2 years, the judge doesn't need to write down every single word,
So it's a summary.
Exactly.
Yes.
The judge listens to the witness and then writes a summary of the important points. Witness stated he saw the accused hit the victim. Done. It's designed for speed and efficiency in high-volume courts.
But for warrant cases or sessions trials, the heavy stuff, murder, robbery,
The standard is much higher. For those, the evidence is taken down in writing, and it has to be in narrative form.
so not just a summary.
No. When someone's liberty for, say, 10 years or even life is on the line, a summary isn't good enough. We need the details. Narrative form means writing it out as a story, as the witness tells it. I went to the market at 5 p.m., then I saw the accused, X, arguing with the victim, Y, then X pulled out a knife. And the slide also notes, importantly, it can be dictated in open court.
And running through all of this is a key principle, highlighted from section 308. Evidence must be taken in the presence of the accused.
Or their lawyer, their pleader. And this is Natural Justice 101. It's the bedrock of a fair trial. You cannot have a situation where evidence is whispered to the judge behind the accused person's back.
They have to hear it.
They have to hear every word being said against them so that they have the opportunity to challenge it, to cross-examine on it. If evidence is recorded when the accused isn't present without a valid legal reason, the whole trial can be vitiated. It can be thrown out.
Okay, but there's a modern twist here. I see another trap box, this one for the section 310 proviso. The slide shows a little icon of a video camera.
Yes, this is the update for the digital age. The BNSS is trying to modernize the process. In those serious warrant cases, it explicitly says that evidence may be recorded by audio, video, electronic means.
So moving beyond just pen and paper or a court stenographer.
Right. We're talking about a formal, official video recording of the testimony.
But the safeguard is still there, isn't it? You can't just have a secret recording.
Absolutely not. The slide notes it very clearly. It must be done in the presence of the advocate for the accused. You can use a camera, you can use a recorder, but the defense lawyer has to be physically there, watching, ensuring the recording isn't doctored, that the witness isn't being prompted off camera.
That makes perfect sense. Now let's talk language. This is a huge issue in a country like India. We have so many languages. Slide 6 deals with this. Language and interpretation, covering sections 312 to 314.
And the visual is a document icon with little translation arrows going back and forth, which is perfect.
It seems to be a logical flow.
It is. Step 1 is simple. If the evidence is given in the language of the court, let's say the court's official language is Hindi and the witness speaks Hindi, then you just record it in that language. No problem.
Okay, but what if it's not?
That's step 2. If the evidence is given in another language, say the court works in Hindi, but the witness is from Tamil Nadu and speaks Tamil, then section 312 kicks in. The slide says true translation required.
So you record the original Tamil statement, but you also have to prepare an official translation into Hindi for the court's record.
Precisely, so that the judge and the lawyers can read it. But step 3 is arguably the most critical for fairness. That's section 314, evidence not understood by accused.
Right. If the accused doesn't understand the language being spoken in court, it has to be interpreted for them right there in open court.
Imagine being on trial in, I don't know, a German court. You don't speak a word of German. Witnesses are pointing at you, speaking angrily in German. You have no idea what's happening.
It would be terrifying. Are they saying I killed someone or that I stole a loaf of bread?
Exactly. So section 314 ensures that someone, an interpreter, has to stand next to the accused and translate in real time. He is now saying that he saw you at the scene of the crime at 5 p.m., so you can instruct your lawyer.
Now, this slide also has an exam alert. It's about the section 312 proviso, the English exception.
Yes, this is a very pragmatic rule born out of our legal history. It says that if the evidence is given in English, and if the parties and their lawyers don't object, and they all understand English, the court may dispense with the need for a translation.
Even if the official court language is, say, Marathi.
Even then, English gets a special pass, in a way, because it's the de facto common language of the higher judiciary and many lawyers across the country.
So if everyone in the professional circle understands it, we don't need to waste time translating it just for the sake of formality?
Correct. But, and this is a big but, if the accused doesn't understand English, section 314 still applies. You still have to interpret it for him. The accused's right is paramount.
Okay, moving deeper into Zone 2, let's talk about commissions for witnesses. This is sections 319 to 326 on slide 7.
The context here is when a witness simply can't come to court.
And the slide lists the reasons. Unreasonable delay, expense, or inconvenience.
Right. Think about it. Maybe your key witness is an 85-year-old woman who is bedridden. Or maybe they're a scientist working on a critical project in another country and can't leave. You don't want the trial to be stalled for years just waiting for them.
So the court issues a commission. What exactly is that? It's basically sending someone to the witness to record their statement, right?
That's a perfect way to put it. Instead of the witness coming to the mountain goes to the witness. The court essentially delegates the task of recording evidence.
And the slide shows 3 main scenarios with arrows.
Yes. Scenario 1. The witness is within the territory of India. The commission is directed to the chief judicial magistrate of the district where the witness is.
Okay. Scenario 2. The witness is in a non-Sanhita area.
This would mean certain tribal areas or other regions where this specific code doesn't directly apply. In that case, the commission goes to an officer specified by the central government.
And scenario 3 is for a witness outside India.
Right. That's directed to a court or an officer in that foreign country based on whatever arrangements or treaties the central government has.
But there's a note at the bottom about a special commission, the section 319 proviso.
Ah, yes. This is for the VVIPs.
It lists the president, vice president, governor, and the administrator of a union territory.
And notice the word the law uses. Shall. A commission shall be issued. It's not optional. The court does not have discretion here.
So you cannot just issue a summons to the president of India and demand they show up in the witness box of a district court for a robbery case.
You cannot. It's a matter of protocol, public duty, and the dignity of these high constitutional offices. They have immunity from personal appearance. So if their evidence is somehow crucial, the court must send a commission to Rashtrapati Bhavan to record it politely and respectfully.
Okay, that's clear. Now for slide 8. This looks like the CSI portion of our deep dive. Reports of God Scientific Experts, section 329. I'm seeing icons of a test tube, a fingerprint, bomb.
This is a really important efficiency section. Normally, in law, if someone writes a report, they have to come to court to prove it.
Yeah.
Yes, Your Honor, I wrote this report. This is my signature. It's called proving the document.
Right.
But imagine you're the director of the Central Forensic Science Laboratory. You and your team are handling thousands of cases from all over the country. If you had to personally go to court to testify for every single report,
You'd never get any actual lab work done.
you'd spend your entire life in courtrooms. So Section 329 creates a very important shortcut for a specific listed group of experts.
The slide lists them out. The chemical examiner, chief controller of explosives, director of the fingerprint bureau.
Director of the Havkeen Institute, the serologist. For these specific government experts, their official report is admissible as evidence without calling them to the stand.
So the paper itself speaks.
The paper speaks for itself. It's presumed to be genuine and correct to save time.
But I see a red TREP box again. Section 329, subsection 2. There's always a catch.
Always a catch. The law says the report is admissible, but it doesn't say it's infallible. The court always retains the power to summon and examine the expert if it thinks fit.
So it's not a blanket immunity from ever appearing in court?
Not at all. Imagine a defense lawyer looks at the chemical report and says, wait a minute, this analysis makes no scientific sense. The methodology is flawed. I want to cross-examine the person who did this. The court can absolutely say, okay, that's a valid point. Let's summon him.
So the report is evidence, but it's not conclusive, irrefutable proof if there's a genuine reason to doubt it.
Precisely. The court's truth-seeking function is never completely outsourced to a piece of paper.
Okay, one more efficiency tool in this zone on slide 9, section 336, evidence of public servants and experts. The visual here is a baton being passed in a relay race.
And that's a perfect visual for it. This section tackles a huge practical headache in the Indian system. Transfers. You have an investigating officer, an IO, who handles a murder case in, say, 2024. He does all the groundwork, collects evidence, records statements, but by the time the trial actually gets going in 2026, he's been transferred 3 times. He's now posted in a different state, hundreds of miles away. Or maybe he's retired. Or, sadly, maybe he has passed away.
And in the old days, the trial would just stall. The defense would say, we can't proceed, the IO isn't here to be cross-examined.
Exactly. It was a massive cause of delay. Section 336 provides a solution. It says the court shall secure the presence of the quorum. And this is a key phrase. The successor officer holding that post.
So the new person sitting in that same chair can come and testify.
Yes. He can't testify about what he saw because he wasn't there, but he could look at the official case file and testify based on the record. He can say, according to the case diary, which was signed by my predecessor on this date, this is what was recorded. He authenticates the official record.
This slide has a note here. Under the guidance of Satendra Sir, we always tell students to link this section to trial delays.
And that's exactly the right way to think about it for a mains answer. This section is a specific legislative tool designed to combat delays caused by administrative exigencies. It ensures the continuity of the judicial process.
So the office testifies, even if the original officer is no longer available.
That's a brilliant way to summarize it.
Okay, deep breath. We've made it through Zone 2. Now we're moving into the heart of the battle. Zone 3. Trial provisions, sections 338 to 366.
This is where we get into some of the most fundamental principles of criminal law.
And slide 10 opens with a massive one, double jeopardy, section 338. The visual is just a big red SOP sign.
As it should be. This is fundamental to any civilized legal system. The slide mentions the legal maxims, autrefois acquit and autrefois convict,
Which are just fancy French and Latin terms for.
previously acquitted and previously convicted. The core principle of Section 338 is simple. If a person has been tried by a court of competent jurisdiction for an offense and has been either convicted or acquitted of that offense, they cannot be put on trial again for that same offense, as long as that conviction or acquittal remains in force.
So the state doesn't get a second bite at the apple. You can't just keep prosecuting someone until you finally get the guilty verdict you want.
Correct. It's about finality and preventing harassment by the state. But, like all good rules, there are exceptions. The slide lists 2 main situations where a second trial is allowed.
Okay, what are they?
The first one is for a distinct offense under subsection 2, and the second is when new consequences happened after conviction, which is subsection 3.
Let's break those down. Slide 11 has illustrations to help. It shows two cards, case A and case B. Let's look at case A first, which is about the same facts.
Okay.
It says, A is acquitted of theft as a servant. He cannot later be charged with criminal breach of trust on the same facts.
This is the classic form over substance issue. Now, technically, theft by a servant and criminal breach of trust are different sections in the penal code. They have different ingredients. But if the underlying act was exactly the same, say, an employee stealing money from the cash register, and the court has already looked at those facts and acquitted him of theft.
The police can't just come back and say, okay, let's try again, but this time we'll call it breach of trust.
Exactly. The court looks at the substance of the accusation, not just the label. The core issue has been decided. He can't be tried again.
Okay, now for case B, this is the one that seems more complicated. New consequences, the slide says. A is convicted of causing grievous hurt. The injured person afterwards dies. A may be tried again for culpable homicide.
This is a really important exception to understand. Let's paint a picture. You get into a serious fight with someone. You punch them, they fall, hit their head, and go into a coma. You're arrested for causing grievous hurt. The trial happens relatively quickly. You're convicted and sentenced to, say, 2 years in prison. 3 weeks after your conviction, the person who was in a coma dies from their injuries.
But I've already been convicted for that punch. Double jeopardy should protect me.
That's the intuitive reaction, but it's wrong. Section 338(3) says no, because a new fact has arisen, the death of the victim. When you were first tried, the offense was grievous hurt. You couldn't be tried for homicide at that time because nobody had died yet.
So because the death happened after the first conviction, they can pull me back into court and charge me with culpable homicide.
That's exactly right. The bar of double jeopardy doesn't apply because the offense itself has changed due to subsequent events.
That makes logical sense, even if it feels incredibly harsh for the accused. Now, there's a TRAP noted back on slide 10, and it's about the distinction between a dismissal and an acquittal.
This is the #1 mistake students and even young lawyers make. Double jeopardy protection only kicks in if there's been a full trial resulting in a judgment. That is, a formal acquittal or a conviction.
So what about other ways a case can end?
If a complaint is simply dismissed, maybe because the complainant didn't show up to court for hearings, that's not an acquittal. Or, more importantly, if the accused was discharged at an early stage, perhaps because the judge felt there wasn't enough evidence to even frame a charge and start a trial.
That's not an acquittal either.
Not at all. A discharge just means there isn't enough evidence to proceed to trial right now. It doesn't mean you are innocent forever.
So if I'm discharged, the police could theoretically go find more evidence, fix their paperwork, and then arrest me again for the same thing.
Yes. A discharge does not trigger the double jeopardy bar. It's a crucial distinction.
Got it. Okay, moving on to slide 12. Public prosecutors and legal aid. Sections 338, 339, and 341. The visual is the courtroom bench and scales of justice.
And Section 341 is rightly highlighted here as having a constitutional link. Explain that.
Section 341 says, the court shall its mandatory assign an advocate to the accused at state expense if the accused doesn't have sufficient means to hire one themselves.
And this links directly to
Article 39A of the Constitution of India, the directive principle on providing free legal aid. And also, it's a core component of the right to a fair trial under Article 21. A trial simply cannot be fair if one side is a trained, experienced prosecutor paid by the state, and the other side is a poor, perhaps illiterate person with no lawyer to defend them.
Absolutely. Now, regarding the prosecution side, there's a specific don't do this rule in the Section 339 proviso.
Yes, this is a very important rule for maintaining the separation of roles.
It says, no police officer shall be permitted to conduct the prosecution if he took part in the investigation.
And this is all about conflict of interest and bias. The person who investigated the crime, the one who gathered the evidence, who formed a theory of the case, cannot be the same person who then stands before the court and presents that case as a supposedly impartial prosecutor. They'd be too invested in their own investigation being proven right.
Of course they would.
Yeah.
They would want to defend their own work. The roles are distinct. The police investigate and the prosecutor prosecutes. They must be different people to ensure objectivity.
Okay, now for slide 13. This one feels like a plot point straight out of a crime thriller. Tender of pardon to accomplice. sections 343 to 345.
This is the legal mechanism for what we commonly call an approver, or the king's witness.
And the visual is a flowchart. It goes from pardon to condition to consequence.
Let's use an example. Imagine a gang of 5 people commits a major bank robbery. The police arrest all 5 of them, but the evidence is circumstantial. Everyone is sticking to their story. No one is talking.
So the police are stuck. They need someone on the inside to talk. A rat.
Exactly. So the court, usually on the application of the prosecution, can make an offer to one of the accomplices, a tentative party. We will let you walk away from this IF.
And the condition is
Full and true disclosure of all circumstances. You have to tell the court everything you know. Who planned it, who drove the car, who held the gun, where the money is hidden. You have to implicate yourself and all of your friends.
a complete confession.
And testimony. And what's the consequence? This is where people get confused. The slide says the person is examined as a witness and detained in custody until the trial ends.
Wait a minute, detained? I thought I was getting a pardon and going free.
You get the final pardon and freedom after the trial is over, and the court is satisfied that you have testified truthfully. During the trial, you stay in jail.
Why is that?
2 very practical reasons. 1, to protect you. The gang you just betrayed might be looking for you. 2, and more importantly, to make sure you don't change your story or run away halfway through the trial. The state keeps you on a very tight leash until you've held up your end of the bargain.
That's a crucial detail. And what if I don't hold up my end? What if I lie? That's covered on slide 14. Violation of pardon conditions, section 345.
The icon is a broken chain. Right. If the public prosecutor stands up and certifies to the court that you have, in their opinion, willfully concealed important facts or given false evidence,
The deal is off.
the deal is off, the pardon is forfeited, the immunity you were given just vanishes.
And what happens to me then? Can I be tried for the original bank robbery?
Yes, you can now be put on trial for the original offense. And D, you can also be tried for the separate offense of giving false evidence, which is perjury. So you could be in double trouble.
But there's a lifeline here. The exam alert for section 345, subsection 3, it says, the accused is entitled to plead that he did comply.
This is a key procedural safeguard. Just because the prosecutor says I lied, that doesn't automatically mean my pardon is gone. The burden of proof shifts. It's now on the prosecution to prove to the court that I didn't comply with the conditions. I have the right to stand up and argue, no, I told the truth, the pardon should stand.
Okay, let's switch gears and talk about everyone's favorite topic, delays in the justice system. Slide 15, section 346, power to postpone or adjourn.
The visual is a calendar, which is perfect. And the main rule stated at the top is the ideal, the dream. Proceedings continued from day to day.
So the law envisions that once a trial starts, it should just run every single day until it's finished.
That's the ideal. And it also says remands should not exceed 15 days at a time. It's all geared towards speed. But of course, we know the reality is often very different.
And there's a trap here in proviso. This one is about professional ethics for lawyers.
This is a spicy one.
It says, and I'm quoting, the fact that the advocate is engaged in another court shall not be a ground for adjournment.
Now, in our judiciary classes at Target for IQ, we always tell students that this is a favorite question in interviews, especially when discussing court delays.
Yeah.
The law, the statute book itself, explicitly says that a lawyer cannot get a case adjourned just by saying, sorry, Your Honor, I'm busy in the high court today.
That happens all the time. You hear it every day in court. Passover requested, counsel is held up in another matter.
It does happen. But it's technically against the explicit command of Section 346. The legislative intent is clear. The litigant's fundamental right to a speedy trial is supposed to be more important than the advocate's busy calendar. If you've taken on the case, you're supposed to be there.
Okay, we are entering the final stretch. We're now in Zone 4, Special Scenarios and Powers, Sections 347 to 367. Slide 16 kicks this off with Special Powers of the Court. And the icons are a magnifying glass, a gavel, and a fingerprint.
These are the special tools the judge can use when just sitting on the bench and listening isn't enough to get to the truth.
So Section 347, local inspection, that's the magnifying glass.
Right. Sometimes looking at photographs and maps of a crime scene isn't enough. The judge might need to actually go there to see the lighting, the sight lines, the distances, to understand the testimony better.
But they can't just go have a look and keep it in their head.
Absolutely not. The rule is that the judge must record a memorandum of their inspection. They have to write down what they saw and what was relevant. It has to be part of the official record so that a higher appellate court can understand what influenced the judge's decision.
Okay, then there's Section 349, specimen samples. This is the fingerprint icon. Signatures, handwriting, voice samples.
All crucial for forensic comparison.
And the proviso here is really interesting. It says this can be ordered even if the person has not yet been arrested.
This is a very powerful tool for the investigation phase. The police might have a strong suspect in, say, a case involving threatening phone calls, but they don't have enough evidence to make an arrest yet. They can go to the magistrate and say, we just need his voice sample to compare it with the call recordings. And the magistrate can order that person to provide the sample even without a formal arrest.
Okay, next is slide 17. This is a comparison table between section 351 and section 353. It's about when the accused person speaks. Accused, examination versus competent witness. This can be tricky.
It is, and the distinction is vital. Section 351 is the court's power to question the accused. This is mandatory after the prosecution has closed its evidence. The judge turns to the accused and says, Mr. A, you have heard the evidence against you. The witness says you were at the scene. What do you have to say to explain this circumstance?
And crucially, the slide notes, no oath is administered.
No oath. And if the accused refuses to answer or gives false answers, he can't be punished for it. It's simply an opportunity for him to explain his side of the story.
Now contrast that with section 353, where the accused becomes a competent witness.
This is completely different. This is when the accused wants to testify in his own defense. He makes a request in writing to the court, I want to take the stand. In this scenario, he's treated like any other witness. He gives his evidence on oath.
And he can be cross-examined by the prosecutor.
Vigorously.
Yeah.
And if he lies on oath, he can be prosecuted for perjury. It's a high-risk, high-reward strategy for the defense.
Okay, slide 18 deals with something we touched on earlier, the so-called ghost trial. Section 356, trial in absence of a proclaimed offender. The visual is a wanted poster next to a 4-step arrow process.
This is for when the accused absconds. They run away, and the law can't find them. The trial doesn't just wait forever.
So what's the process?
It's a very deliberate, step-by-step process to ensure that every possible effort has been made to inform the accused. Step 1. Issue at least 2 warrants of arrest, with a 30-day interval between them. Step 2. Publish a notice in a newspaper and also try to inform a relative. Step 3. Affix the information on their house and at the police station.
So we're basically shouting from the rooftops, come to court.
Exactly. And only after all that, you move to step 4. You wait 90 days from the date the charge was framed. If they still don't show up, the court can say, okay, we're proceeding without you. The trial goes on, witnesses are examined, judgment is passed.
And what's the big safeguard or the stick to make them come back?
The slide notes it clearly. No appeal lies unless the offender presents himself. You cannot sit in hiding in London or Dubai and have your lawyer file an appeal against your conviction in Delhi. You want to challenge the verdict, you have to come back, surrender to the court, go to jail, and then you can file your appeal.
That's a powerful incentive. Okay, slide 19, compounding of offenses, section 359. The icon is a handshake. This is about settling cases out of court.
Right. And the law divides compoundable offenses into 2 categories.
Oh, are they?
Category 1 is offenses that can be compounded without permission of the court. These are generally seen as private wrongs. Things like simple hurt, defamation, insulting religious feelings. If you and I get into a fight and then we make up and decide to drop the case, we can just file a compromise petition. The court's permission isn't needed.
And category 2?
That's offenses that can only be compounded with permission of the court. These are more serious. Things like grievous hurt, theft by a servant, cheating, bigamy. Here, the court has to look at the settlement and say, okay, this seems fair and voluntary. The court acts as a gatekeeper to make sure, for instance, that a powerful person isn't forcing a vulnerable victim to settle at gunpoint.
And the effect of a valid composition is an acquittal. But I see another trap here, section 359, subsection 7.
This is a really important one. It says there can be no compounding allowed if the accused is liable for enhanced punishment due to a previous conviction.
So if you're a habitual offender.
Exactly. If you have a prior conviction for a similar offense and the law says you should get a harsher sentence this time, the state essentially says no more handshakes for you. You are now seen as a threat to society at large, not just someone who had a private dispute. You lose the privilege of compounding the case.
Okay, slide 20. Withdrawal from prosecution, section 360. The visual is a closed file or book.
This is the power of the public prosecutor, the PP or APP, to withdraw a case. They can do this, but only with the consent of the court.
And the timing matters, right?
Critically. The slide has a little flowchart. If the PP withdraws before the charge has been framed against the accused, the effect is a discharge. If they withdraw after the charge has been framed, the effect is an acquittal.
And the difference is, as we discussed, that a discharge doesn't prevent a future prosecution, but an acquittal does.
Correct. But look at the proviso here. This is a very important addition for victim rights. It says the court shall not allow the withdrawal without first giving an opportunity of being heard to the victim.
That's huge.
It's a massive step for natural justice. In the old days, the state could decide to drop a case, maybe for political reasons, and the victim would read about it in the newspaper, completely helpless. Now the judge has to turn to the victim and ask them, the state wants to withdraw this case. Do you have anything to say before they can approve it?
Just a few more. Slide 21 covers jurisdiction and commitment, sections 361 to 364. This seems to be about moving a case up the judicial ladder.
That's exactly what it is.
Yeah.
For example, section 361. If a magistrate starts a trial and then realizes they don't have the proper jurisdiction, they submit the case to the chief judicial magistrate, the CJM. Or section 364, which is very common.
What's that?
That's when a junior magistrate conducts a trial and finds the person guilty, but then thinks, wait, based on the severity of this crime, this person deserves 7 years in jail, but my own sentencing power is limited to only 3 years.
He can't pass the sentence he thinks is appropriate.
He can't. So he can't acquit, he can't sentence. He wraps up the file, writes his opinion, and forwards the accused in custody to the CJM. And section 364.3 says the CJM can then look at the evidence and pass whatever judgment or sentence he thinks is fit.
Got it. Slide 22, open court and in-camera proceedings. Section 366. The visual is a set of open doors versus a set of chained doors.
The general rule is simple and foundational. A criminal court is deemed to be an open court. Anyone from the public can walk in and watch the proceedings.
It's about transparency. Justice must not only be done, but must be seen to be done.
That's the principle. But the exception, the in-camera proceeding, is just as crucial. For the inquiry or trial of rape and other specified sexual offenses, the law says the trial shall be conducted in camera.
So behind the chained doors, no public, no media.
Correct. And there's a ban on printing or publishing the matter without the court's permission. And there's another important proviso. The in-camera trial shall be conducted, as far as practicable, by a woman, judge, or magistrate.
And the goal of all this is what?
To create a safe, non-intimidating environment for the victim to be able to testify freely and without the trauma of having to recount the events in front of a staring public gallery.
Okay, the final point in Zone 4, Slide 23. Section 367, accused with mental illness. The visual is a medical cross symbol and a process flow.
This is for when the court believes the accused is of unsound mind and, as a result, is incapable of making his defense. You cannot have a fair trial of someone who doesn't even understand what is happening.
So what's the process?
The flow is logical. First, the magistrate has reason to believe there's an issue. Second, they inquire into that fact. Third, they must get the accused examined by a medical officer, a civil surgeon, and that examination has to be reduced to writing. And finally, if needed, they refer the person to a psychiatrist for care and treatment.
So it shifts from a purely penal, punishment-focused approach to a therapeutic one.
It has to. The trial is paused and the treatment begins. It's a fundamental principle of human rights.
So that covers all 4 zones. Let's
Yeah.
understand the next point from here. Putting it all together for the exam, the main strategy. I'm looking at Slide 24.
And this is the target for IQ masterstroke.
Yeah.
This is how you score top marks. You don't just list out the sections one by one. You group them thematically to show the examiner you understand the underlying principles.
So the slide suggests 3 themes. Theme 1 is fairness.
Right. For a question on fair trial principles, you group together Section 308, evidence in the presence of the accused, Section 341, free legal aid, and Section 366, the general rule of open court. You show how these sections work together to ensure fairness.
Okay. Theme 2 is efficiency.
Here, you group Section 346, the rule of day-to-day trial, Section 329, admissibility of expert reports without calling the expert, and Section 336, the successor officer rule. These are all designed to make the trial faster.
And theme 3 is truth-seeking.
This is where you bring in Section 347, local inspection by the judge, Section 348, the power to summon any material witness, and Section 343, the tender of pardon to an accomplice. These are tools the court uses to actively find the truth.
And the final piece of the puzzle is the constitutional link.
Always, always, always link your answers back to the Constitution. It shows a deeper understanding. You link Section 338 to Article 22 for double jeopardy. You link all the fairness and efficiency provisions to Article 21, the right to life and liberty, which includes the right to a fair and speedy trial.
If you write a long answer about adjournments under Section 346 and you don't mention the impact on the speedy trial right under Article 21, your answer is incomplete.
Absolutely incomplete. You'll lose marks.
Which brings us to the final slide, slide 25, the outro. It says, target for IQ, master the Bnss with precision, mentor, Successor.
And that really sums it up. Mastering these procedural mechanics, these nuts and bolts, is what separates a good candidate from one who actually cracks the judiciary mains. It's not always the most glamorous part of the law, but it is, without a doubt, the part that matters most in the daily life of a judge.
Well, there you have it, a complete, hopefully digestible walkthrough of the engine room. Keep studying, keep revising with target for IQ and Successor, and please remember that 25-kilometer rule.
Indeed. Goodbye, and good luck to all the aspirants.
Thanks for listening to this deep dive. We'll see you next time.
Let's understand the next point from here.
Exactly. And we are about to embark on a very significant journey today. This isn't just a casual conversation about law.
No.
This is a specialized intensive session. It's designed specifically for judicial services aspirants. So if you are preparing for PCS-J, APO, or civil judge exams, this deep dive is constructed entirely for you.
That's right. And for today, we're stepping into the role of your faculty. We're operating strictly within the academic framework of target for IQ, and of course, we are following the expert pedagogical guidance of Successor. Our mission today is to decode the entire life cycle of a criminal case, but under the new law, the Bharatiya Nagarik Suraksha Sanhita, or Bnss.
And it's a massive chunk of procedure we're tackling. We're talking sections 366 all the way to 436. This is the critical phase of a case.
It really is.
We're looking at the transition from the heat of the trial proceedings, all the arguments and evidence, into the cold, hard reality of the judgment.
And what comes after? Victim compensation, and then that complex ladder of appeals.
It's the home stretch, as you said, the end game of a criminal case. So let's just dive straight into the material.
Okay, I'm looking at the first slide here, slide 1. It really sets the tone perfectly, doesn't it?
Slide 1 gives us our overview, and the visual is important. We see a gavel and a book, and the book is titled Sanhita. This isn't just, stock imagery.
Right.
It represents the authority, the weight of this new law. The title on the slide reads, Criminal Procedure, Trial, Judgment, and Appeals.
And the scope is laid out right below that. From the open court environment to the finality of appeals. It says this is about mastering the life cycle of a criminal case for judicial services.
That phrase, life cycle of a criminal case, is the key concept. As a judge, which is what you're training to be, you aren't just refereeing a fight.
No.
You are managing a life cycle from beginning to end. The key fact on this slide notes that this module covers the transition from those trial proceedings to the actual execution or perhaps the suspension of sentences. You have to know how to close the loop.
I'm seeing a big yellow box here that says exam alert. It's highlighted.
Yes.
It says, focus on the procedural differences between inquiry and trial for accused persons with mental illness. Why flag that so early? Why is that the very first warning?
Because that is a classic trap. It's where aspirants, even good ones, consistently lose marks. The procedure under the Bnss changes completely, fundamentally, depending on whether the case is at the inquiry stage or the trial stage.
Okay.
If you apply the trial rules to the inquiry stage, or vice versa, your answer is just plain wrong.
Yeah.
There's no partial credit. We are going to unpack that in excruciating detail when we get to sections 367 and 368, but you need to keep that warning in your mind from minute 1.
Got it. A mental note has been made. So let's move to the environment where this all takes place. Slide 2 is titled Open Court, and it covers section 366.
The visual here is quite striking, very symbolic. It's a split image. On the left side, you've got an open door with light just streaming in. That represents public access, transparency.
The
ideal, yes. And on the right side, you have a locked door with a big red restricted sign on it. That, of course, represents in-camera proceedings.
So section 366, subsection 1, gives us the general rule. It says the place of inquiry or trial is deemed an open court.
Correct. The default setting of our entire justice system is transparency. The public, generally, may have access. This is based on that old principle that justice must not only be done.
It must be seen to be done.
Exactly. It prevents secret trials and holds the system accountable. But of course, look at that arrow pointing down to the exception, the proviso.
Right. It says the presiding judge or magistrate may order restricted access at any stage. So that's discretionary.
Generally, yes, it's discretionary. If the judge feels the crowd is becoming unmanageable, or for, serious security reasons, or sometimes it's as simple as the room is too small,
Right.
they can restrict access. They can say everyone out except the parties and their lawyers. That is perfectly within their judicial discretion. But, and here's where it gets really important for your exams, there is a mandatory exception.
I see that on the right side of the slide. It's not discretionary at all.
Not all.
It lists rape and sexual offenses and specifically cites Bnss section 64, 66 to 68, 70 to 71, and PCS-J. And it says these must be conducted in camera.
Must is the operative word. In cases involving sexual offenses, the law removes the judge's discretion completely. You cannot hold these trials in an open court. It mandates privacy, primarily to protect the dignity and identity of the victim.
And right below that, there's a key fact. It says, in-camera trials shall be conducted as far as practicable by a woman judge or magistrate.
As far as practicable, it's not an absolute rule because a female judge might not be available in a remote area, but it's a very strong directive. It's about sensitivity.
That makes sense. Now, there are these trap boxes at the bottom. The first one talks about a ban on printing or publishing proceedings under Section 366, subsection 3.
This is absolutely crucial. You cannot publish the details of an in-camera trial. The media cannot report on the testimony. It defeats the entire purpose of privacy. However, the trap is in the nuance. The slide asks, can this ban be lifted for rape cases? And the answer is yes, but only with the court's permission and, crucially, subject to maintaining the confidentiality of the parties.
So you can't name the victim. Ever.
Never. Or provide any detail that might lead to her identification. That is an absolute red line.
And the exam alert box hammers this home.
Yeah.
Memorize the specific Bnss sections referenced in Section 366 too.
Absolutely. In a prelims question, the examiner won't always be so kind as to say, in a case of sexual offense, they will say, in a proceeding under Section 64 of Bnss, or Section 70 of Bnss.
If you don't know that those numbers map to rape and gang rape,
you will completely miss the mandatory in-camera trial question. You have to map the section number to the offense in your head. It's just rote memorization you have to do.
Okay, that's clear. Let's move on to slide 3. This is where we get into that tricky territory you mentioned right at the start. Section 367, mental illness at inquiry stage.
Right, and look at the visual. It's a medical clipboard and a stethoscope. It immediately tells you this is where law and medicine intersect, and that can get complicated.
And the first thing to note, highlighted at the top, is that we are at the inquiry stage.
You must burn that into your brain. The trial has not started yet. Charges have not been framed. We are in the pre-trial phase.
The slide lays out a process flow. Step 1. Magistrate has reason to believe accused has mental illness.
That's the trigger. The magistrate isn't a doctor. They might observe the accused's behavior in court, or their lawyer might raise the issue. It's just a reason to believe.
Step 2. That leads to an inquiry into fact of illness, which points directly to an examination by civil surgeon.
Exactly. The magistrate can't make a medical diagnosis, so they must call in the experts. The first port of call is the civil surgeon, who then might refer the accused to a specialist, a psychiatrist, or a clinical psychologist.
And then a report is submitted back to the magistrate. Now we get to the critical part, the magistrate determination under Section 367, subsection 4. The finding has to be whether the mental illness renders the accused incapable of defense.
That phrase is the legal standard. It's not just about being medically unwell. The question is, does this illness prevent them from understanding the proceedings? Can they instruct their lawyer? Can they comprehend the evidence against them? That is what incapable of defense means.
Okay, and the action box below that says the magistrate should examine the record of evidence, hear the advocate, but then there's a huge warning, a critical constraint.
Yes, and the exam alert highlights this in bright yellow. It says, note the specific exclusion without questioning the accused during the prima facie determination, S-367-4.
Oh, feels counterintuitive. Wouldn't you want to talk to the accused to see their state of mind?
You'd think so, but the law forbids it at the specific prima facie stage of the inquiry. And the reason is to protect the accused. A person suffering from severe mental illness might make self-incriminating statements. They could confess to things they didn't do or get confused.
So it's a safeguard.
A powerful safeguard. So you, as the magistrate, look at the police report, you look at the medical report, you hear from the defense advocate and the prosecutor, but you do not interrogate the accused to decide if there's a prima facie case.
That is a massive trap for an exam question. And the outcomes from there are clear. If there's no prima facie case, you discharge the accused. If a prima facie case does exist, you postpone the proceedings for treatment.
Precisely. And the red trap box at the very bottom warns us one last time. Do not confuse the inquiry stage, which is Section 367, with the trial stage, Section 368. They're different worlds.
Which brings us perfectly to Slide 4. Section 368, mental illness during trial.
Now the whole scene changes. The visual reflects this. It's a flowchart from a court icon, the gavel, over to a doctor icon, the caduceus symbol. We're now in the trial phase. Charges have been framed, evidence is being heard.
The core concept on the slide says, if mental illness appears during trial before a magistrate or court of session, they must in the first instance try the fact of such mental illness and incapacity.
In the first instance, that phrase is everything. It means you stop the main trial. You hit the pause button. The moment the question of sanity arises during the trial, you can't listen to the next witness talk about the crime. You must first settle this medical question. It becomes a trial within a trial, a mini-trial about sanity.
And the process looks similar at first. The court is informed, refers the accused to a psychiatrist, a report comes back. If they are found incapable of defense, the court then examines the evidence from the prosecution.
And here's a key difference from the inquiry stage. At the inquiry stage, we were just looking for a prima facie case to even begin. Here, we're already in a full-blown trial. If the medical report says incapable, and after reviewing the prosecution's evidence so far it seems like a case exists, we must postpone the trial for treatment.
I've seen a green key fact box here about appeals. This is new. Appeal lies to the medical board, head of psychiatry plus faculty member, if accused is aggrieved by the psychiatrist's information.
This is a significant new procedural safeguard. In the past, a single doctor's opinion was often the final word. Now, under the Bnss, if the accused or their family disagrees with the psychiatrist's finding, maybe the doctor says they're fit for trial when they are clearly not, they can appeal that medical opinion to a higher medical board. It adds another layer of review.
And the red trap box warns, the court must record a finding regarding the incapacity before postponing. So you can't just adjourn it informally.
No, precision is paramount in procedure. You need a formal, written finding on the court record. Something like, based on the report of Dr. X, this court finds that the accused is presently of unsound mind and incapable of making his defense. And then you postpone.
It has to be official.
It has to be. As we teach at Target for IQ, procedural law isn't about general ideas. It's about specific steps recorded in writing. If it isn't in the order sheet for legal purposes, it didn't happen.
Okay, so we've postponed. What happens next? That takes us to Slide 5, Release, Safe Custody and Resumption, covering Sections 369 to 372. The visual here is a bail bond scroll next to a hospital cross icon.
Right, this slide answers the practical question. Okay, we've postponed the trial because the accused is mentally ill. Now what? Do we just keep him in a regular jail?
And Section 369, Release on Bail, seems to answer that. It says if the accused is found incapable of making his defense, the order is to release on bail, and it says mandatory.
Yes, that's a strong word. It's mandatory. But look at the crucial condition attached. A friend or a relative must come forward and give an undertaking to the court.
An undertaking to do what?
Two things. One, ensure the accused gets regular outpatient psychiatric treatment. And two, prevent the accused from causing injury to themselves or to anyone else. It's a big responsibility.
So you need a reliable guarantor. What if no one steps up? Maybe the accused has no family or no one is willing to take on that risk.
Then the second branch of the flowchart on the slide applies. If no such undertaking is given, the court will order the accused to be detained in a place for regular psychiatric treatment. This is not a prison. This is a designated mental health establishment, and it's all governed by state government rules and the Mental Health Care Act.
So they go to a hospital, not a standard prison cell.
Correct. The focus shifts from punishment to treatment.
Then we have the resumption process under Sections 370 and 371. The flowchart shows the accused ceases to be ill, the trial or inquiry resumes, and the accused appears back in court.
Right. The hospital or doctor will eventually certify that the accused is now fit to stand trial. When that happens, the court proceedings kick back into gear, but the judge has to make a judgment call again.
There are two paths here on the slide. If the court now considers the accused capable, it says proceed, but if they are still deemed incapable,
then you go right back into the loop. You revert to the procedure under Section 367 or 368. It's a cycle that continues until the person is medically and legally fit to face the trial.
There's a trap noted here. The certificate of the officer appointed to produce the accused is receivable as evidence regarding capability of defense.
So the doctor's certificate itself is evidence.
Yes, that's a rule of evidence designed for efficiency. You don't necessarily need to drag the busy psychiatrist to court every single time just to say, yes, he's fit. The formal certificate they issue is admissible as evidence of the accused's fitness, which allows the trial to resume smoothly.
And a key fact at the bottom reminds us that any detention must follow the rules of the Mental Health Care Act, 2017. The Bnss doesn't operate in a vacuum. It works in conjunction with specialized laws like the Mental Health Care Act.
Okay, this is all about procedural incapacity. But what about the actual defense of insanity? That seems to be slide 6. Judgment of acquittal on mental grounds, S-373-374.
Exactly. This is a totally different concept.
The visual here is really evocative. It's the scales of justice, but instead of balancing weights, it's balancing a human brain.
And that's the perfect image for it. Sections 367 to 372 were all about procedural incapacity. The issue was, I can't understand the trial right now. Section 373 is about a substantive defense. The argument is, I did the act, but I was legally insane at the time I did it.
So this connects back to the general exceptions in the substantive penal law.
Precisely. This is the procedural follow-through for the defense of insanity, which is found in Section 22 of the BNS, what we all knew as Section 84 of the IPC.
The slide says the core concept is an acquittal on the ground of being incapable of knowing the nature of the act or that it was wrong or contrary to law.
That's the classic legal test for insanity.
Now, the finding here is very specific. The judgment can't just say not guilty. It says it must state specifically whether he committed the act or not.
This is a vital distinction. The court has to make a factual finding. So the judgment will read something like, the court finds that the accused did, in fact, cause the death of the victim by stabbing. However, the accused is acquitted of the charge of murder on the ground of insanity. The act is proven, the mens rea, the guilty mind, is absent.
And the consequence of this acquittal under Section 374 is not what you'd expect. It says, detain in safe custody or deliver to relative friend.
And this leads us to the big red trap on the slide. Acquittal here does not mean immediate freedom. It means safe custody.
So you don't just walk out of the courtroom a free person.
Absolutely not. You have just been found by a court of law to have committed a potentially violent act. The reason you're not going to prison is your mental state. So you are sent to safe custody, again under the Mental Health Care Act rules, until the authorities are satisfied that you are no longer a danger to society.
So it's a different kind of custody.
A therapeutic custody, not a punitive one. And the key fact reminds us that the magistrate or court must report whatever action they take to the state government. It's a state-monitored process from start to finish.
Okay, let's shift gears completely. We've talked about mental illness. Now let's talk about people who are of perfectly sound mind but intentionally try to disrupt the justice system.
Yes, like lying in court.
Slide 7. Offenses affecting justice. Perjury. S-379-383. The visual is a false evidence stamp being slammed onto a document next to a gavel.
Perjury.
That sounds like a long process.
It is, and that's why the law provides a shortcut. Section 383 gives the court the power of a summary trial. This applies when a witness knowingly or willfully gives false evidence or fabricates it right there in the court's view.
So it's immediate.
It can be. The sentence for the summary trial is a maximum of 3 months imprisonment or a fine up to 1,000 rupees. It's a quick, sharp punishment to maintain the sanctity of court proceedings.
But there's a trap in red at the bottom. This seems highly technical and very important for a mains exam answer.
It is.
It says, if an appeal is filed against the main judgment, the summary trial for false evidence must be stayed until the appeal is disposed of.
Think about the logic behind that. It's fascinating. Imagine a judge convicts you for perjury, for lying in his court. But then you appeal the main case, and the high court looks at all the evidence and says, actually, that testimony wasn't a lie, it was true, and we are acquitting the original accused based on it.
Then the perjury conviction looks, well, wrong.
Exactly. It would be a miscarriage of justice. So the law wisely says to put the perjury proceeding on hold. Let's wait and see what the appellate court says about the main case first. Once that's final, then we can decide what to do about the alleged lie.
That makes perfect sense. Okay, next up, slide 8, which takes us to a related topic. Contempt in view of court. S-384-389. The visual is a very stern-looking judge pointing a finger. It screams authority.
It does. This is for offenses committed right there, in the presence and view of a court. Section 384 covers things like, intentionally insulting the judge or causing an interruption to the proceedings. It references several Bnss sections like 209 to 11 and so on.
And the sequence is very direct. Offense in view leads to detain in custody, then a show cause opportunity, and finally the sentence.
You see how quick that is? There's no separate FIR, no police investigation. The judge saw it happen with their own eyes. They can immediately have the person detained, give them a chance to explain themselves or apologize. That's the show cause part. And if the explanation isn't satisfactory, they can sentence them right then and there.
And the penalty is a fine up to a maximum of 1,000 rupees, or simple imprisonment for up to 1 month if they fail to pay the fine.
Note the term simple imprisonment, not rigorous. But now compare that penalty to a different kind of contempt under Section 388, which is refusal to answer.
Okay, so this is for a witness who's on the stand and just refuses to answer a question or produce a document, and they have no reasonable excuse.
Yes, they're just being obstinate. The sentence here is simple imprisonment for up to 7 days, OR. And this is key, until they consent to answer or produce the document.
So it's coercive. The keys to the jail are in their own pocket.
Precisely. It's a coercive sentence, not just a punitive one. The court is essentially saying, we'll lock you up to make you cooperate. The moment you agree to answer the question, you can come out.
The exam alert box tells us to distinguish these penalties carefully. Section 384 is 1 month or 1,000 rupees. Section 388 is 7 days.
And the trap box points out another one, Section 389 for non-attendance by a witness, which is a separate summary trial with a max fine of just 500 rupees. Under the guidance of Successor, we always tell students to create a simple comparative chart for these fines and penalties, 1,000, 500, 200. It all gets jumbled up in the stress of an exam hall without a chart.
Good advice. Okay, so the trial is over, all the contempt issues are handled. Now we finally reach the conclusion. Slide 9, judgment. Pronouncement and timeline, S392. And the visual is a calendar with the number 45 circled in red.
And that number, 45, represents a very significant efficiency update in the new Sanhita.
The timeline on the slide flows from termination of trial to pronouncement immediately, or if not immediately, then at subsequent time not later than 45 days.
That 45-day cap is strict. The law is trying to put an end to that old problem of judgments being reserved and then just sitting there for months, sometimes even years. The judge now must deliver the judgment within 45 days after the final arguments are concluded.
And there are different ways to deliver it. The slide lists 3 modes of delivery. 1, delivering the whole thing. 2, reading out the whole thing.
Both of which are very rare for long judgments.
And the third, which seems most practical, reading operative part plus explaining substance in language understood by accused.
That's the one you see in practice 99% of the time. The judge doesn't read a 200-page judgment aloud. They read the final conclusion. Guilty of murder, sentenced to life imprisonment, or acquitted of all charges. And then they briefly explain the core reasons in simple language.
I see a key fact here in green. It says, upload copy to portal within 7 days of judgment. That's a definite digital age update.
Yes, it's about transparency and access. No more waiting weeks to get a certified copy. But now look at the trap at the bottom. Judgment is not invalid merely due to absence of party advocate on the notified day.
So you can't stall the process by just not showing up on judgment day.
Exactly. The court will pronounce it anyway. Justice can't be held hostage by someone's absence.
Right. So what actually goes into the judgment? Slide 10 details the contents of judgment, S393, showing a checklist document.
Every judgment needs a proper structure. It can't just be a random collection of thoughts. The slide lists the essentials, language of the court, the points for determination, the decision itself, and, critically, the reasons for that decision. And, of course, the specific offense and the section of the Bnss under which the person is convicted.
Then there's a section on special reasons required for certain situations. The first is a sentence of death.
That's the rarest of rare doctrine. If you are going to order the state to take a human life, you must provide a detailed, compelling justification explaining why a life sentence was not enough.
The second is for imprisonment less than 3 months, for offenses that are punishable with 1 year or more. Why special reasons for being lenient?
It's a check on arbitrary leniency. The logic is, if Parliament has decided a crime is serious enough to warrant a punishment of, say, up to 5 years, and you as a judge give a sentence of just 1 month, you need to explain why. You need to justify that departure from the expected sentencing range.
Okay, that makes sense. There's also an exam alert about an alternative judgment. This is interesting. When doubtful under which of 2 sections the offense falls, judgment passed in the alternative.
Right. For example, the facts might be a bit murky. It's clearly a crime, but is it criminal breach of trust under one section or cheating under another? The court can say he is guilty under Section A, or in the alternative, under Section B. This prevents the accused from getting off on a hyper-technical argument about which label fits the crime best.
And finally, a rather grim key fact. Death sentence must direct that he be hanged by the neck till he is dead.
It sounds archaic, I know, but that is the mandatory operative language required by the statute. A judgment that just says hanged is technically incomplete. Those specific words are required.
Understood. Let's move on to the aftermath of the judgment. Slide 11. Victim Compensation and Treatment, S395-397. The visual shows a medical cross and a stack of coins.
This is a reflection of the modern shift in criminal jurisprudence. It's moving from being purely punitive, focused on the offender, to being more restorative and thinking about the victim.
Section 395 discusses the application of fines. So when a court imposes a fine and it's recovered from the convict, where does that money go?
It's not just revenue for the state. The flowchart on the slide shows it can be used for several things. Defraying the expenses of the prosecution, compensating the victim for the loss or injury they suffered.
Which is recoverable in a civil court.
Yes, but this is a faster way to get it. It can also be used to pay damages in death cases under the Fatal Accidents Act, or even to compensate a person who, in good faith, bought stolen property that now has to be returned to the original owner.
So the fine is used to fix the damage caused by the crime.
That's the idea. And then there's Section 396, which is even more significant. It talks about the victim compensation scheme run by the state and central governments. And the key fact notes this is in addition to any fine imposed.
So even if the accused is acquitted, or if they're convicted but are too poor to pay a fine,
the victim can still get compensation from this separate fund run by the state. This is a huge safety net. It decouples the victim's relief from the offender's financial status.
And then Section 397 covers the duty of hospitals. Free first aid or medical treatment for victims of acid attacks, rape, and other sexual offenses. And the exam alert clarifies this applies to both public and private hospitals.
This is non-negotiable. A private hospital cannot turn away a rape or acid attack victim saying we don't handle medical legal cases or pay the deposit first. The law mandates they provide immediate free first aid and treatment. It's a legal duty.
There is a trap here regarding the timing of payment from fines. No payment shall be made before the appeal period has elapsed.
That's just practical. Imagine the court orders a 1 lakh rupee compensation from a fine and it's paid to the victim. A month later, the convict's appeal is allowed and he's acquitted. Now, trying to get that money back from the victim would be difficult and unfair, so the court holds the money until the appeal window closes or the appeal is decided.
That's a sensible rule.
Okay.
Slide 12 covers witness protection and groundless arrest, S398-400. The visuals are a shield and a pair of handcuffs next to some coins.
Two very important but often overlooked provisions. Section 398 is a big one. It mandates that every state government shall prepare and notify a witness protection scheme.
The word is shall, so it's not optional.
Not at all. Witnesses are the eyes and ears of the justice system. If they are too scared to come to court and testify truthfully, the entire system collapses. So this provision legally obligates the state to create a framework to protect them.
Then Section 399 deals with the flip side, groundless arrest compensation. This applies when a magistrate finds there was no sufficient ground for causing an arrest.
Right, so if a police officer or even a private citizen arrests someone maliciously or without any reasonable basis, the magistrate can order the person who caused the arrest to pay compensation to the person who was wrongly arrested.
And the compensation is a maximum of 1,000 rupees, the trap notes. The limit is Rs 1,000 per person.
It's not a huge amount of money, I agree, but it's not really about the money. It's about the official finding by a court that the arrest was groundless. It's a check on the abuse of power.
I see. And the exam alert mentions that in non-cognizable cases, a court can also order the accused to pay the costs of the prosecution.
Yes, things like process fees, witness expenses, even advocates' fees in some cases.
Okay, let's turn to slide 13, which is about probation of good conduct, S401. The visual is a helping hand, which suggests a reformative approach.
That's exactly what it is. It's the law saying, instead of sending you to prison, we're going to give you a chance to reform yourself in the community. But not everyone is eligible.
The slide splits the eligibility into two categories, A and B. Category A is for offenders who are under 21 years of age, or any woman, and the offense must not be punishable with death or life imprisonment.
So young offenders and women are given much broader eligibility for probation. They can be considered for it for almost any crime that isn't a capital or life offense, reflecting a more reformative stance for these groups.
Category B is for men over the age of 21. For them, the offense has to be less serious. It must be punishable with a fine only, or with imprisonment for 7 years or less.
Right. The scope is narrower for adult male offenders.
And the main condition for both categories is that no previous conviction is proved against them.
It's a first-time offender provision. If they are eligible, they are released on a bond, promising good conduct for a period of up to 3 years. If they break the bond, they can be brought back and sentenced for the original crime.
There's also a provision for admonition for very petty crimes like theft or cheating, where the punishment is 2 years or less.
In those cases, the court can just give them a stern warning, an admonition, and let them go. It's the lowest level of judicial response.
But the red trap box here is crucial. If a court does not deal with a youthful offender under this section, it must record special reasons.
This is a powerful directive. The law creates a presumption in favor of giving probation to a youthful offender. If a judge decides to deny probation and send a teenager to jail instead, they can't just do it. They have to write down in the judgment the specific, special reasons why probation was not appropriate in this particular case.
It forces the judge to justify a harsh sentence for a young person.
Exactly. It's a check on the system.
Okay, that covers probation. Now for the most serious sentence of all. Slide 14. Submission of death sentences. S-407-412. The visual is a grand golden courthouse representing the High Court.
Because a death sentence passed by a sessions court is not final. It has no effect on its own.
The process on the slide is clear. Session court passes death sentence, which then gets submitted to High Court. And the final box says, no execution unless confirmed.
This is the mandatory confirmation proceeding under Section 407. Even if the convicted person doesn't file an appeal, the case automatically goes to the High Court for review. The state cannot execute anyone without the High Court's seal of approval.
And Section 409 lists the very wide powers of the High Court. They can confirm the sentence, annul the conviction entirely, convict the person of a different offense, order a completely new trial, or acquit the accused.
They have total power to re-examine the entire case from scratch. They can look at the evidence, the procedure, everything.
The bench rule under Section 410 is also important. The confirmation must be signed by at least 2 judges.
A single judge of a high court cannot confirm a hanging. It requires a division bench of at least 2 judges to review it.
And the key fact addresses the obvious question. What if those 2 judges disagree? If judges are equally divided, the case is decided by a 3rd judge.
Yes, the case is then referred to a 3rd judge, and the majority opinion of the 3 judges prevails. That 3rd judge becomes the crucial tiebreaker.
It's a system with many, many checks.
As it should be when a life is at stake.
Right. Let's move into the general principles of appeals. Slide 15. The visual is a staircase, symbolizing the hierarchy of courts.
A perfect image. And Section 413 gives us the general rule, the starting point for all appeals. No appeal lies, except as provided by the Sanhita or any other law. This means appeal is a statutory right, not a natural or fundamental right. If the law doesn't give you a right to appeal, you don't have one.
The staircase on the slide shows the typical hierarchy. A conviction by a magistrate is appealed to the Court of Session.
Correct.
A conviction by a session judge where the sentence is more than 7 years is appealed to the High Court.
That 7 years is a key threshold. If the sentence is 7 years or less, the appeal would lie to the Court of Session, not the High Court.
And a conviction by a High Court in its original jurisdiction, which is rare, is appealed to the Supreme Court.
That's the basic ladder, but then there's a very important proviso on the slide about the victim's right to appeal.
Right. It says a victim can file an appeal against 3 things. 1, an order of acquittal. 2, a conviction for a lesser offense.
For instance, the accused was charged with murder, but convicted only of culpable homicide.
And 3, against inadequate compensation.
This is a massive empowerment for victims. In the past, if the state didn't appeal an acquittal, the victim had very limited options. This proviso gives them a direct right to challenge a verdict they believe is unjust. And in our judiciary classes at Target for IQ, we stress that this is a major area for mains questions.
And a final exam alert on this slide. Appeals against sentences for Bnss sexual offenses must be disposed of within 6 months.
Again, a statutory timeline. The law demands speedy justice in these sensitive cases. These timelines are classic prelims questions.
So not everything is appealable. Slide 16 is titled Cases Where No Appeal Lines is 416, 417, and the visual is a big red estate sign.
Exactly. The system would be clogged if every single case could be appealed. The law creates some bars for the sake of efficiency.
The first bar is plea of guilty under Section 416. If you pleaded guilty and were convicted based on that plea.
Then you cannot appeal the conviction itself. You admitted it. What is there to appeal? However, notice the crucial exception on the slide. You can appeal on the legality or the extent of the sentence.
So you can argue, yes, Your Honor, I admitted guilt, but the law says the maximum sentence is 5 years and the judge gave me 10.
Precisely. You can challenge the sentence, but not the finding of guilt.
The second bar is for petty cases under Section 417. No appeal is allowed if the sentence is very small. The slide lists the thresholds. For a high court, if the sentence is imprisonment for 3 months or less, or a fine of 1,000 rupees or less. For a session court, it's 3 months or less, or a fine of 200 rupees or less. For magistrate of the first class, it's a fine of 100 rupees or less. And for a summary trial, a fine of 200 rupees or less.
You need to memorize those numbers, 1,000, 200, 100. Those are the petty case thresholds that bar an appeal. As we often teach at Target for IQ, a flashcard for these figures is your best friend.
The trap here says an appeal is allowed if a petty punishment is combined with other punishments. But the key fact clarifies that imprisonment in default of paying a fine does not count as a combination.
That's a common point of confusion. If the sentence is just fine of Rs 100 and in default 7 days in jail, that's still considered a sentence of fine only. The default clause doesn't open the door to an appeal.
Got it. Now what about when the state wants to appeal? That's slide 17. Appeals by state, inadequacy and acquittal, with the national emblem as the visual.
Yes, the state is a party to the case, and it can be aggrieved by verdict too. Section 418 allows the state to file an appeal against the inadequacy of sentence. If the government believes the trial judge was far too lenient, the state government can direct the public prosecutor to file an appeal seeking an enhancement of the sentence.
And Section 419 is the big one, appeal against acquittal. This seems to have two different paths.
It does. If the case involves a cognizable and non-bailable offense, the district magistrate can direct the public prosecutor to file an appeal to the Court of Session. For other cases, the state government directs the appeal to the High Court.
So you have to know who has the authority to direct the appeal in which court.
Yes. The DM for some, the state governed for others. It's a procedural detail that can be a question.
There's also a special limitation period mentioned here for getting special leave to appeal an acquittal. A public servant complainant gets 6 months to file, but any other complainant gets only 60 days.
The government gives its own officers a much longer window, 6 months versus 2 months. That's a very significant difference to remember.
And a key fact at the bottom, no appeal to the High Court under S419 can be entertained without the leave of the High Court.
You have to get permission first. The High Court will do a preliminary screening to see if the appeal against acquittal has any merit at all before it agrees to hear the full case. It's not an automatic right.
Okay, so the appeal is filed. What's the procedure? Slide 18. Procedure for hearing appeals. S421, 426. The visual is a big dismissed stamp on a file.
That visual represents Section 425, which allows for summary dismissal. When the appellate court receives the appeal petition, it can read through it, and if it feels there is no sufficient ground for interfering, it can dismiss the appeal right away.
Without a full hearing?
Yes, but there's a condition. It must give the appellant or their lawyer a reasonable opportunity to be heard first. And if it's a court of session or a CJM dismissing it, they must record their reasons in writing.
So they can't just stamp dismissed, they have to explain why it's being dismissed.
Correct. It's a check on arbitrary dismissal. If the appeal is not dismissed summarily, then notices are sent out to all the parties for a full hearing.
The exam alert here highlights jail appeals under Section 424. This seems like an access to justice provision.
It is. If the person who wants to appeal is in jail, they don't need a lawyer to file the petition. They can simply write it out and give it to the officer in charge of the jail. That officer is then legally obligated to forward the petition to the appropriate appellate court. It ensures even prisoners can exercise their right to appeal.
So what can the appellate court actually do? Slide 19 details the powers of appellate court, S427. The visual is a hand adjusting a golden dial labeled sentence adjustment.
This is a favorite area for mains exam questions. The powers are very broad.
In an appeal from a conviction, the slide says the court can 1. Reverse the finding and acquit or discharge the person. 2. Alter the finding but maintain the sentence. 3. Alter the nature or the extent of the sentence, which means they can enhance or reduce it.
That third point, the power to enhance, is the scary one for an appellant. You file an appeal hoping for a reduction in your sentence, but the high court, after reviewing the case, might say, actually, the trial judge was too easy on you and increase your sentence from, say, 10 years to life imprisonment.
But the trap on the slide says the appellate court cannot inflict greater punishment than the original court could have.
Right. And it cannot enhance the sentence at all without first giving the accused an opportunity to show cause against it. That's a fundamental principle of natural justice.
And in an appeal from an acquittal, they can reverse the acquittal, find the person guilty, and sentence them.
Yes, they can turn an acquittal into a conviction. Their powers are immense.
Okay, a practical question. If you file an appeal, do you have to go to jail immediately while it's pending? Slide 20. Suspension of sentence and bail, S-430. The visual is an hourglass and a broken chain.
A very common question. Section 430, subsection 1, says that pending the appeal, the appellate court may suspend the execution of the sentence and grant bail.
The word is may, so it's discretionary.
It is. For serious offenses, it's not easy to get bail pending appeal. But now look at subsection 3, which deals with the situation right after you've been convicted by the trial court and you intend to appeal.
It says the trial court must release the person on bail to give them time to file the appeal, IF, and there are 2 conditions. 1, the sentence is for imprisonment of 3 years or less. Or 2, the offense is bailable and the accused was already on bail during the trial.
This 3 years rule is mandatory. It's a huge relief for people convicted of less serious crimes. If your sentence is under 3 years, the trial judge must give you bail so you can go and prepare and file your appeal. They can't just drag you off to jail immediately.
That's a very important provision. And the trap reminds us that any time spent out on bail is excluded when computing the term of imprisonment.
Which is just common sense. You don't get credit for time you spent free on bail.
Okay, 2 final concepts. Slide 21. Abatement and reference, S-435, 436. The visual is a silhouette of a person and a big question mark.
Abatement simply means the end of a legal proceeding because of an event, usually death.
The slide says that appeals filed by the state under S-418 or 419 abate on the death of the accused.
Obviously. You can't enhance the sentence of or convict a dead person.
Other appeals against conviction abate on the death of the appellant. But T, the trap notes a big exception. Appeal from a sentence of fine does not abate on death. Why is that?
Because a fine is a liability against the person's property, their estate. Even if the person dies, the fine can still be recovered from the property they left behind. So the appeal can continue to decide if that liability on the estate is valid.
And the key fact is that a near relative can apply within 30 days to continue the appeal, even against a sentence of imprisonment.
Yes. This is not about saving the person from jail, obviously, as they've passed away. This is about clearing their name, removing the stigma of conviction for the family.
And reference under 436.
That's when a lower court is hearing a case and a question arises about the constitutional validity of a law. If the court thinks the law might be invalid, and the High Court or Supreme Court hasn't ruled on it yet, it can pause the case and refer that legal question to the High Court for a decision.
Okay, let's bring it all together. Slide 22 is Main's answer writing analysis with a fountain pen visual.
This is where we apply the knowledge for the exam.
The slide lists some key Main's question types. First, a short note on the procedure for an accused with mental illness. Second, a differentiation question, like appeal versus revision. And third, a powers question, like discussing the powers of the appellate court to enhance a sentence.
And the common mistake, as we flagged at the very beginning, is confusing the inquiry stage, S-367, with the trial stage, S-368, for mental illness. Don't make that mistake. And always structure your answer well. State the provision, explain the procedure, highlight any exceptions, and add case law if you know any.
Finally, slide 23, the judicial life cycle. Final recap. It's a flowchart roadmap of everything we've discussed.
We've walked the entire path. We started in the environment of the open court in Section 366. We navigated the obstacles like mental illness and perjury. We reached the conclusion of the judgment, which has to be delivered within 45 days. We dealt with the outcomes like victim compensation and probation. And finally, we went through the entire review process from death sentence confirmation to the hierarchy of appeals.
It really is a complete story, a full life cycle.
It is. And as we wrap up this deep dive, it's worth remembering what we always emphasize at Target for IQ. The procedure is not just a set of boring rules. It is the very backbone of liberty. It ensures that the process of justice is fair and predictable.
We have certainly covered a massive amount of ground today.
We have. From Section 366 to 436 of the Bnss, it's the heart of the post-trial process.
Well, thank you for guiding us through this incredibly detailed and complex area of law.
It was my pleasure.
To all our listeners, keep studying, keep questioning. This has been a comprehensive session from Target for IQ, and we wish you all the success in your preparations.
And let's end today with a final provocative thought for you to consider. We've established that procedural law isn't just a set of rules. It's the mechanism that ensures justice isn't just done, but is seen to be done. So, here's the question. How would you, as a judge, balance the mandatory nature of Section 366(2) for in-camera trials in rape cases with the foundational principle of open court transparency? Where does one principle end and the other begin? Think about that.
A difficult balance to strike. We'll see you in the next deep dive. Let's understand the next point from here. We are stepping out of the trial room and, into the aftermath. The verdict has been read, the gavel has banged, but the legal machinery, it's really just getting warmed up.
Exactly. It's a common misconception that the judgment is the end of the story. In many ways, it's just the end of a chapter. Today, we're looking at what comes next, specifically within the new Bnss, the Bharatiya Nagarik Suraksha Sanhita.
Right. We're focusing on chapters 32 to 35.
Okay.
For our listeners who are, really aiming for the Judicial Services PCS-J civil judges, this is absolutely make or break territory. We are analyzing sections 432 all the way through 479.
It is. This is the procedural backbone of the post-trial phase. It's not as, let's say, glamorous as the trial itself, but if you don't know these sections, you can't function as a judge.
Absolutely. And we have a set of slides here that really helps structure this whole thing into a kind of narrative. It's not just a list of rules. It really feels like a life cycle. I'm looking at the first slide now. It's titled Bnss Criminal Procedure, Review, Transfer, and Execution. And it lists 3 very distinct phases.
Right, and the source material breaks it down very logically. Phase 1 is reference and revision, which is, essentially about fixing errors. It's the system's self-correction mechanism.
Okay, so that's the first check.
Yes. Then you have phase 2, transfer of cases. This is all about ensuring the playing field is fair, that there's no bias, and that justice is not just done, but is seen to be done.
Ensuring impartiality. Got it.
And finally, phase 3. This is the heavy one, execution in mercy. This is where the judgment becomes reality. It's the actual implementation of the punishment.
There's a very striking visual on this first slide. It's a wooden gavel, the judge's hammer, and it's resting on a thick, leather-bound book with gold lettering that says the Sanhita. It feels weighty.
That visual is absolutely deliberate. It represents the weight of authority. The gavel symbolizes the power of the court, the power to decide a person's fate. But notice, as you said, it is resting on the Sanhita.
So power isn't arbitrary.
Never. Power must be grounded in the text of the law. It's a constant reminder that procedure isn't just red tape or paperwork. It's the very foundation that holds up the entire justice system. It's what separates a lawful decision from a mere exercise of power.
The focus box at the bottom really summarizes the journey we're about to take. It says, from the correction of judicial errors to the physical implementation of sentences. It's a clean narrative arc.
It is. So just to recap that flow for everyone, first, we check if the judge made a mistake. That's your review and revision. Then we check if the court itself is the right place for the trial. If it's biased or inconvenient, that's transfer. And finally, if everything stands, we carry out the sentence.
And for anyone preparing for their mains exams, this is critical.
Oh, absolutely. Do not treat these as isolated, separate chapters. This entire block of sections forms the basis for any question on post-trial procedures. You have to understand the entire life cycle to write a cohesive, intelligent answer.
Okay, let's dive into that first phase then. The idea of fixing errors. I'm pulling up slide 2 now. As 432 and 435, evidence and abatement and appeals. And straight away, there's a flowchart here that deals with a very morbid but practical scenario, death of appellant.
Yes, and this is a scenario that comes up more often than you'd think, and it's a favorite for exam questions because it tests a very fundamental concept. You have an appellant, someone who is actively fighting their conviction, and they die before the appeal can be heard.
So the big question is, what happens to the case? Does it just disappear?
Exactly. Does the case die with them? This is the legal concept of abatement, which in simple terms literally means coming to an end. The flowchart on the slide breaks down when it ends and when it, surprisingly, continues.
Okay, the flowchart splits into a left path and a right path. Let's take the left path first. It says, appeal from sentence of fine. The arrow from that box points to a very clear statement. Does not abate.
This is crucial. And the logic is entirely based on the nature of the punishment itself. You have to ask yourself, what is a fine? A fine is a financial penalty. It's about property, about money.
Right, it attaches to the person's assets, not their physical body.
Precisely. If I die, my estate, my house, my car, my bank account, all of that passes to my legal heirs. But my debts pass to them too. A fine is a debt to the state. So if the state wants to collect that fine from my estate, my family has a direct financial interest in fighting that appeal.
So they're basically defending their inheritance from the state's claim.
You've got it. They have the right to continue the appeal to prove I was innocent. Because if they win, the fine is wiped out and that money stays in the family estate. That's why an appeal against a fine does not abate.
That makes perfect logical sense. The penalty targets the wallet, and the wallet in a legal sense still exists as the estate. Now let's contrast that with the right path on the flowchart. Appeal from conviction, death imprisonment. The general rule here is abates.
Yes, and the logic is just the opposite. You cannot imprison a corpse. The suffering of imprisonment, the deprivation of liberty, is intensely personal. It applies to the physical body of the convict.
So if the body is gone?
The punishment becomes impossible to execute. So the general rule is that the legal proceeding, the appeal, essentially evaporates. It abates.
But, and this is always the important part in law, there's a big but. I see an exception box right underneath that general rule. It says, near relative applies within 30 days, and that leads to appeal continues.
This is the game changer. This is where the law moves beyond pure logic and into the realm of dignity and social justice. Imagine a man is convicted of a truly heinous crime, something that ruins his reputation and his family's name. He appeals, claiming he's innocent, but dies in prison while waiting for his day in court.
Under the general rule, the appeal would abate, and that conviction would stand on his record forever.
Forever. His children, his spouse, they would have to live with that public stigma for the rest of their lives. The law, in its wisdom, says his near relative can step into his shoes, not to save him from jail, he's already gone, but to clear his name.
So the goal of the appeal shifts. It's no longer about liberty, it's about reputation.
Exactly. It's about washing the stain of a wrongful conviction from the family honor. It's an incredibly humane provision.
And the slide is very specific about who can do this. The green box defines near relative as parent, spouse, lineal descendant, brother, or sister.
You must memorize that list. It is an exhaustive list. A cousin can't do it. A business partner can't do it. It has to be one of these specified near relatives.
And there's a time limit. The flowchart has a red alert box that seems really important, highlighting a trap. It says, appeals from a sentence of fine do not abate on death.
S435.
This is the classic prelims MCQ. The examiner will give you two scenarios, one with a fine and one with imprisonment, and ask which one abates. You have to remember the fine survives.
And what about that 30 days detail in the exception box? That's the other trap. The near relative doesn't have forever. They have a very strict window of 30 days from the date of the appellant's death to apply to the court to continue the appeal. As we teach at Target for IQ, that 30-day window is a strict limitation period. If the family misses it, the window slams shut, the appeal abates, and the conviction stands forever.
So time is of the essence. The slide also mentions something else at the top, power to take evidence under Section 432. It says the appellate court isn't just for reading files, they can actually take additional evidence.
Yes, this is another important point. An appeal isn't just a dry academic review of old paperwork. If the appellate court feels that some crucial piece of evidence was overlooked or couldn't be produced during the trial, and it's essential for justice, they can act.
So they could almost become a trial court for a moment.
For a moment, yes. They can take the new evidence themselves, or, more commonly, they can direct a lower court, like a magistrate, to record the evidence and send it back up. But the key condition, which is paramount, is that the accused must be present. You cannot gather evidence that affects someone's life or liberty behind their back. It's a fundamental rule of natural justice.
That makes sense. Okay, let's move on. We're now at slide 3, Section 436, reference to High Court. The visual here is quite telling. It's a small, humble building labeled Lower Court, sending a scroll with a big, bold question mark on it to a grand, imposing building labeled High Court.
That visual tells the whole story in one image. Reference is a consultancy jurisdiction. The lower court is, in effect, raising its hand and saying, I am confused about a fundamental point of law. Your lordships in the high court, please help me. Please give me the answer.
It's admission of doubt, then.
An admission of a very specific kind of doubt. The slide lists the prerequisites for reference, S4361. I think it's worth reading them out because they're so precise.
Okay, I'll read them. 1, a case must be pending. 2, it involves a question as to the validity of any act, ordinance, or regulation. 3, the court is of the opinion that this law is invalid or inoperative. And 4, the High Court or Supreme Court has not yet declared it so.
Please pay very close attention to that second point, the validity of an act. This is the single most common mistake students make. You cannot make a reference because you have a doubt about the facts of the case.
So a judge can't refer a case to the High Court saying, I'm not sure if this witness is lying. What do you think?
Absolutely not. That's the judge's job to decide. Reference is only for a constitutional level doubt. The judge is thinking that law that the prosecution is using here, I think this law itself violates the Constitution. But I'm just a magistrate. I don't have the power to strike it down, and the Supreme Court hasn't said anything about it yet. What do I do?
So a magistrate in a lower court can't just wake up one day and decide a section of the IPC is unconstitutional and acquit the accused on that basis.
Exactly. That would lead to absolute chaos. Imagine every local magistrate in the country declaring acts of parliament void. It would be anarchy. The power of judicial review, the power to strike down legislation, is reserved for the high courts and the Supreme Court.
So if a magistrate has a serious doubt about a law's validity, they are stuck. Their hands are tied.
They are. And the procedure laid out in Section 436 is their only way out. They must refer it to the high court. They cannot proceed with the case based on their own opinion that the law is bad.
That explains the procedure note on the slide. It says the court states the case, sets out their opinion with reasons, and then refers it. And interestingly, while waiting for the high court's answer, the accused can either be committed to jail or released on bail.
Yes, the trial essentially hits a pause button. The entire case file is put on hold. Everything freezes at the lower court level while the high court deliberates and answers the big legal question that has been posed.
And to really drive this home, there's a bright yellow exam alert box at the bottom. It states, in no uncertain terms, reference is only for validity of laws, not for factual doubts.
It cannot be said enough. As we emphasize time and again at Target for IQ, you must remember that reference is almost always suo motu by the court itself. It originates from the judge's own intellectual or legal doubt. It's very rarely done on an application by a party. It's the judge who is the one asking for directions.
Got it. A very clear distinction. Now let's contrast that with the concept on the next slide. Slide 4 is titled Sections 438, 440, the power of revision. The visual here is different. It's a magnifying glass hovering over a legal document.
A perfect image for it. If reference is the lower court asking a question upwards, revision is the higher court looking downwards to audit the homework. The magnifying glass represents the higher court zooming in on the records of the lower court, actively looking for specific kinds of errors.
And the slide lists the scope, Section 438, with 3 very important keywords: correctness, legality, and propriety.
We often call this the trinity of revision. They each mean something different. Let's break them down.
Please.
First, correctness. This generally refers to mistakes of fact or calculation. Did the lower court add up the fine correctly? Did they get the date of the crime wrong in the judgment? It's about getting the basic record straight.
Okay, so that's factual accuracy. What about legality?
Legality is about the law. This is a more serious error. Did the judge apply the completely wrong section of the Bnss? Did they ignore a...
That's a powerful oversight tool. And who gets to wield this power? The slide says High Court or Sessions Judge.
This is what we call a concurrent jurisdiction. Both the High Court and the Sessions Judge have the power of revision. But, and this is a very big, but look at the point right below that, which mentions Section 438, subsection 3.
Ah, I see it. It says, if application is made to one, no further application entertained by the other.
So you can't go forum shopping. You can't try your luck with the Sessions Judge, lose your revision petition, and then say, okay, now I'll try again at the High Court. You get one shot.
You have to pick your door.
You pick your door. Once you knock on the door of the Sessions Judge, the door to the High Court for the same revision is closed to you, and vice versa. This is a crucial rule to prevent litigants from clogging up the entire system with repetitive petitions on the same point of grievance.
And just like the last slide, we have a red alert box here. This one says, Trap, no revision lies against interlocutory orders, S4302. Can you explain what interlocutory means for our listeners?
Certainly. An interlocutory order is a temporary intermediate order that a court makes during the progress of a trial. It doesn't decide the final outcome of the case. Think of things like granting an adjournment or issuing a summons to a witness or deciding on a bail application during the trial. These are all interlocutory steps.
And you can't file a revision against those. Why not?
Imagine if you could. The trial would never end. A clever accused person who just wants to delay the case could file a revision petition every single time the judge grants a one-week adjournment. The main trial file would have to be set to the high court. Everything would stop for months just for an adjournment order. The law says no. No revision for these small procedural steps. You have to wait for the final judgment to file your challenge.
That's a crucial distinction for practical purposes. Now, slide 5 zooms in even further. The title is Section 442, High Court's Revisionary Powers. And the visual is very stark. A big red octagonal stop sign with the words acquittal protected written on it.
This is probably the single most important protection for an accused person in this entire chapter. It's a fundamental principle. Before we even look at the other points, let's go straight to the crucial trap box at the bottom of the slide. It reads, Section 442, High Court cannot convert a finding of acquittal into one of conviction.
Okay, let's unpack that slowly. If I am accused of a crime and the trial court finds me innocent, acquits me, I walk out a free person. Then the state or the victim files a revision against that acquittal. You're saying the high court, in its revisional power, cannot say, we've read the file, the trial judge was wrong, and actually you are guilty.
That is exactly right. In a revision, the high court cannot directly convict you. They can do other things. They can look at the acquittal order and say, this is a terrible judgment, the trial was a sham, and they can order a retrial. They can say, go back and do this trial again properly this time. But they cannot sit in the revision chair with just the files in front of them and sign a conviction order for someone who was set free by a lower court.
Why is that restriction there? It seems so absolute.
Because an acquittal is a sacred thing in our criminal justice system. It carries a double presumption of innocence. The person was presumed innocent before the trial, and a court has now confirmed that innocence after hearing all the evidence. To overturn that requires the rigor of a full appeal, where the standards of review and evidence are different, not just a supervisory revision. Under the guidance of Successor, we emphasize this constantly in our classes. Section 4423 acts as a shield for the acquitted person. It's a critical limitation on the high court's power.
A negative power, as the outline puts it, a restriction.
Precisely. Now, let's look at the other powers mentioned on the slide. There's a right to be heard, S4422. This is pure natural justice, the principle of audi alterum partem, which means listen to the other side. If the high court is even thinking about passing an order that is going to hurt the accused, what the law calls passing an order to their prejudice, like enhancing their sentence or ordering a retrial, they must give the accused a chance to speak. You cannot do it behind their back.
Makes sense. And the last point is conversion, S4425. It says the high court can treat a revision as an appeal or an appeal as a revision if it was filed under an erroneous belief.
This is a very practical pro-justice provision. Lawyers are human, and sometimes they make mistakes. They might file a document and label it revision petition when legally it should have been an appeal. The court says, in the interest of justice, we won't punish the client for their lawyer's mistake with the label. If the substance of the petition is there, the court can just fix the label and hear the case on its merits, substance over form.
That's a relief for many litigants, I'm sure. Okay, slide 6 really brings these two big concepts, reference and revision, together in a side-by-side comparison table. This looks like a perfect slide for mains preparation.
This table is your best friend for a mains answer. If you get a question on the difference between reference and revision, you should draw this table. Let's walk through it.
Okay, row 1 is about the grounds. For reference, it's validity of act ordinance. For revision, it's correctness, legality, propriety, the CLP trinity.
A very clear distinction. Reference is about a constitutional question. Revision is about an error in the lower court's judgment.
Row 2 is the initiator. Reference is the subordinate court, suo motu. It's the judge asking. For revision, it's the high court sessions judge, and it can be suo motu or on an application by a party.
Right. So revision can be started by the higher court itself if it reads about a strange case in the newspaper, or it can be started because the accused or the victim files a petition. Reference is almost always the judge's own doing.
And finally, row 3, the subject. For reference, it's a question of law, specifically validity. For revision, it's a finding, sentence, or order, so the outcome of the case.
You see, the fundamental difference really boils down to the direction of the doubt. In reference, the judge is looking up and saying, I don't know the law, please help me. In revision, the higher court is looking down and saying, you applied the law wrong, let me fix it.
And the slide has a mains writing tip at the bottom. It says, in problem questions, check if the lower court is doubting the law, which would be reference, or if the party is aggrieved by the order, which would be revision.
That is the absolute key to solving those practical, scenario-based questions. You read the problem, and you ask yourself, who is complaining? If the question says, the magistrate is confused about the constitutionality of the new Gambling Act, your mind should immediately go to reference.
And if it says, the accused is angry because his application for discharge was rejected by the magistrate,
then he is aggrieved by an order, he will file a revision. As we teach at Target for IQ, always look for the source of the complaint. It will tell you which path to take.
Crystal clear. Okay, let's move into phase 2 of our journey, the transfer of cases. I'm on slide 7 now, section 447, power of Supreme Court to transfer.
The visual is very powerful. It's a map of India with a golden gavel literally flying from one side of the country to the other. And that's exactly what this section is about. It illustrates the supreme nationwide power of the Supreme Court. They can pick up a case from any high court and move it to any other high court. Or they can pick up a criminal case from a court in, say, Tamil Nadu and transfer it to a court in Punjab. It represents the unification of the Indian justice system under one ultimate roof.
The slide lists the grounds for this in a very broad phrase. Expedient for the ends of justice. That sounds like it could mean almost anything.
It is intentionally broad because you can't foresee every possible reason why a transfer might be necessary. Expedient for the ends of justice basically means, is this transfer absolutely necessary to ensure a fair outcome?
Can you give an example?
Of course. The classic example is a case involving a very powerful and influential local politician in State A. He controls the police, he has influence over the local judiciary, and his supporters are constantly creating a hostile atmosphere around the courthouse. The victim or the witnesses feel they can't possibly get a fair trial there. They're terrified.
So they can go to the Supreme Court.
Yes. They can go to the Supreme Court and argue that for justice to be done, the entire trial needs to be moved to a neutral venue in State B, where the politician has no influence. That's what expedient for the ends of justice means in practice.
And who can ask for this? The slide says the applicant, S4472, can be the Attorney General India, the country's top law officer, or a party interested. But I see there's a very important requirement supported by affidavit.
Yes, this is not a casual process.
Yeah.
You cannot just write a letter to the Supreme Court. You must file a formal application supported by an affidavit, which means you are swearing on oath that the reasons you've given for the transfer are true.
It adds a layer of seriousness.
It does. And look at the note on compensation at the bottom of the slide. This is there to prevent abuse of this power. If I just want to harass you, I might file a frivolous transfer petition to move your case to a court 2,000 miles away just to make your life difficult. If the Supreme Court finds that my application is frivolous or vexatious, they can order me to pay compensation to you for the trouble I've caused. It's a deterrent against misusing the process.
A necessary check and balance. Now, moving down the judicial hierarchy, slide 8 covers section 448, High Court's power to transfer. And there's a clear process flowchart here. It goes, application plus affidavit leads to notice to public prosecutor with 24 years mentioned, then hearing, then a potential stay order, and finally the transfer order.
So the High Court's power is similar, but it operates within the boundaries of its state. It can move cases from one sessions division to another, say from Lucknow to Meerut. The crucial step to notice in that flowchart is the notice to public prosecutor.
The 24-hour notice, why is that so important?
You must give the government's lawyer, the public prosecutor, at least 24 hours notice before the hearing for the transfer. You cannot try to sneak a transfer order past the state. In every criminal case, the state is the prosecuting party. So they have a right to be heard and to object to the transfer if they have valid reasons.
And the slide also lists some specific grounds for transfer under S448. They're a bit more detailed than the Supreme Court's grounds.
Yes, let's look at them. Number 1 is that a fair and impartial inquiry or trial cannot be had. This is the bias ground, similar to the SC's power. Number 2 is interesting. Question of law of unusual difficulty is likely to arise.
What does that mean in practice?
Imagine a massive, complex cybercrime case involving international treaties or highly technical financial derivatives. And the case is currently before a local magistrate in a small town who, with all due respect, may not have the expertise or resources to handle such a complex legal issue. The High Court can say this case is too difficult for this court and transfer it to a more experienced court in a bigger city.
And ground number 3 is general convenience of parties or witnesses.
This is a purely practical ground. If the crime was technically filed in District Y, but all 10 of the key witnesses live in District X, which is 300 miles away, it just makes practical sense to move the trial to District X so that everyone doesn't have to travel for hours for every single hearing. It saves time, money, and ensures witnesses actually show up.
Makes perfect sense. Now, there's an exam alert on this slide, too. It says, intra-session transfer must apply to sessions judge first before approaching HC for transfer within the same sessions division.
This is a rule about respecting the hierarchy. If you want to move a case from courtroom 1 to courtroom 2 in the very same court complex within the same sessions division, don't bother the high court with that. The sessions judge is the administrative head of that division. Go to them first. You don't leapfrog the system for minor administrative changes. The high court should be dealing with transfers between districts, not between rooms.
Speaking of which, Slide 9 breaks down those very local transfers. The title is S449451, Sessions and Magistrate Transfers. The visual is a simple pyramid. At the top, you have the sessions judge. In the middle, the Chief Judicial Magistrate, or CJM, and at the bottom, the magistrate.
And this structure represents simple administrative management of the caseload in a district. The power flows downward.
So the sessions judge, under sections 449 and 450, is the captain of the entire district.
Correct. They can withdraw a case from the CJM below them or transfer cases between different additional sessions judges who work alongside them. It's about balancing the workload.
And the CJM under section 451 is like the captain of the team of magistrates.
Exactly. The CJM is the boss of the magistrates in that district. They can recall a case from a junior magistrate if it's getting complicated, or they can simply transfer a case from a magistrate who has too many files to another one who has a lighter load. These are primarily administrative powers to ensure the smooth functioning of the courts.
And the slide has one very important requirement mentioned. Reasons must be recorded.
Yes, this comes from section 453. It's a vital check. You cannot just move cases around on a whim or based on personal preference. Transparency is key. If a judge transfers a case, even for administrative reasons, they must write down why they are doing it. Because it said so is not a valid legal reason. This prevents any accusation of bench hunting, where a lawyer might try to get their case moved to a judge they think is more favorable.
Okay, that covers the transfer phase. Now we enter phase 3, and this is the heavy stuff. Slide 10, S454455, execution of death sentences. The visual is very somber. A sealed letter, like an old-school envelope with a wax seal and a gavel.
This is the most solemn and irreversible duty of the court, the process of lawfully taking a human life, and because of its gravity, the procedure is extremely strict. Let's look at the steps.
Step 1 is confirmation. The slide says, and I'm quoting, Sessions Court cannot execute death sentence without High Court confirmation.
This is the first and most important safeguard. A sessions judge can pronounce the death penalty in open court, but they cannot actually sign the death warrant right then and there. A death sentence passed by a sessions court is, by default, a provisional sentence.
So it's not final yet.
Not at all. It is subject to confirmation by the High Court under what is Section 366 of the CRPC and the corresponding section in the Bnss. The entire case file must be sent up to the High Court. And even if the accused person doesn't file an appeal, the High Court must review the entire case to confirm the sentence. This is a unique, automatic safeguard only for capital punishment.
Okay, so once the High Court confirms it, we move to Step 2, receipt of order, and then Step 3, action, where the Court of Session issues the warrant.
Yes, and notice the distinction in the procedure box. It clarifies. The High Court confirms, but the Court of Session issues the actual warrant to the jail.
So the High Court doesn't have a direct line to the jail superintendent.
Not for the warrant, no. The High Court confirms the sentence and sends the file back down to the Sessions Court. It is the original Sessions judge who then signs the formal document, often called the Black Warrant, it's Form 42 in the schedule, and sends that official warrant to the jail. The authority to hang comes from the Sessions Court, but the permission to exercise that authority comes from the High Court.
What if something happens between the confirmation and the execution? Slide 11 is titled S456457, Postponement of Death Sentence. The visual is a hand physically pausing a button labeled Execution Date.
There are safeguards on top of safeguards. We never rush to execute. The first is Section 456. This says that if the convict wants to appeal to the Supreme Court, the High Court must wait.
So you can't execute someone while their appeal period is still running or their appeal is pending.
Absolutely not. You can't hang someone on a Tuesday and then find out on Thursday that the Supreme Court had accepted their appeal. That would be the ultimate irreversible error of justice. So the process has stayed.
And then there is a very different kind of postponement under Section 457.
The reason listed is pregnancy.
Yes. The slide states the rule. If a woman sentenced to death is found to be pregnant, and then it states the mandate, High Court shall commute the sentence to imprisonment for life.
Now, the exam keyword box here is highlighted. It says S-457 uses shall commute, not just postpone. What's the significance of that?
It's a massive, life-altering distinction. In the old days, or perhaps in other legal systems, the authorities might wait for the baby to be born and then execute the mother. The Bnss, just like the old CRPC, says an emphatic NO to that. If she's found to be pregnant, the death sentence is not just paused, it is erased. It is permanently converted or commuted to life imprisonment.
So bringing a new life into the world saves her own life, legally speaking.
Permanently. In our judiciary classes at Target for IQ, we always tell students to remember this. Pregnancy saves the life of the mother permanently under S-457. It's a humanitarian absolute. The law recognizes that an innocent child is involved, and that child should not be punished for the crimes of the mother. A very powerful provision. Okay, now slide 12 maps out the convict's final hope. Section 473, the mercy petition timeline. This is a detailed flowchart that moves from left to right.
And this timeline is a significant new feature in the Bnss. It has been strictly codified now to prevent the endless delay tactics that we used to see in death penalty cases.
Let's walk through it. Step 1. The jail superintendent informs the convict. Step 2. The convict then has 30 days to file a mercy petition to the governor of the state.
This is now a duty on the jail superintendent. He has to officially inform the convict, your final appeals are over. You now have a 30-day window to seek mercy from the governor.
Okay, if the governor rejects it, that's step 3. Then step 4, the convict gets another window, this time 60 days, to file a petition to the president of India.
Yes, a second, higher level of clemency. Previously, there were no strict timelines, so convicts would sometimes file these petitions years later, often just hours before the scheduled hanging, purely to stall the process. This new structure aims to make the process orderly.
And after the president decides, that's step 5, which the flowchart says is final, and step 6 is communication, which must happen within 48 hours.
Yes. The decision of the president is communicated back down the chain, and the process concludes. Now look at the green box at the bottom of the slide. Finality. S-473 says, President's order is final and shall not be inquired into by any court.
So the idea is to stop the cycle of litigation.
That's the legislative intent, to end the cycle of last-minute midnight hearings where convicts would file petition after petition challenging the mercy process itself just to delay the hanging. The Bnss is trying to bring a sense of closure and finality, not just for the convict, but for the victims' families as well.
Okay, moving from the ultimate penalty to other punishments. Slide 13 is S-458-465, imprisonment and levy of fine. The visual shows two things, a scroll labeled warrant and a pile of gold coins next to a gavel.
This covers the more common punishments. For imprisonment, covered in S-458-461, the basic rule is quite simple. The court passes a sentence and says, go to jail. But it's the state government that decides which jail.
So the judge doesn't typically say, send this person to Bihar jail specifically.
Generally not. That's considered an executive function. The judiciary determines the guilt and the length of the sentence. The executive branch manages the prison system and decides on the specific facility for security and logistical reasons.
Okay. Now what about the other part, levy of fine, S-462? How does the court actually get the money if the convicted person refuses to pay? The slide lists two methods. Method A is a warrant for attachment and sale of movable property.
This is the direct, straightforward method. The court can issue a warrant, and the police can go to the person's house and seize their car, their television, their fridge movable assets that can be easily grabbed and sold at auction to recover the fine amount.
And method B, it says, warrant to collector to be realized as arrears of land revenue.
This is the more powerful method, used for larger fines or when movable property isn't enough. The court writes to the district collector, who is the head of revenue collection in the district. The collector then treats the court's fine as if it were unpaid land tax. This is a big deal because it gives the collector very strong powers to go after immovable property, like the person's land or their house.
And what if the person is just poor? They want to pay, but they can't. I see a note about suspension under Section 465. It says the court can suspend imprisonment for default of fine to allow payment in installments, max 30-day intervals.
This is the humanitarian face of the law showing up again. Usually, if you can't pay the fine, the court orders you to serve an extra period of imprisonment. But if the person is honest but simply broke, the judge has the discretion to say, okay, I won't send you to jail today for not paying. You can pay me the fine in installments once every 30 days. It prevents the system from criminalizing poverty.
A very sensible provision. Now, Slide 14 covers a concept that's fundamental to fairness called set-off. The section is 469, set-off of detention. It's laid out as a simple equation. Total sentence imposed under trial detention equals remaining term.
And it is as simple as that. This is about giving credit for time already served. Imagine you are arrested during an investigation. You can't get bail. You stay in jail for 2 full years while the trial slowly moves forward. Finally, the judge finds you guilty and sentences you to 5 years in prison.
You don't serve 5 more years.
Of course not. That would be a grave injustice. You serve 5 minus the 2 you already spent in jail, so your remaining term is 3 years. The state cannot steal those 2 years of your life from you and then pretend they didn't happen. That under-trial period must be set off against the final sentence.
The slide has a special note. For life convicts, S-476, it says the set-off applies against the 14-year minimum period. We'll get to that 14-year rule in a moment, but this is an important point. But first, there's a clarification box. It says, this applies to imprisonment for a term, not imprisonment in default of fine.
Right. A very important distinction. The time you spend in jail because you failed to pay a fine is a separate penalty. It's a penalty for non-payment, not for the original crime itself. You cannot subtract your under-trial time from that separate default sentence. You have to either pay the money or do the time specifically for not paying the money.
Got it. Okay, now we're moving into the powers of the government. Slide 15, Section 474, suspension and remission. The visual is a government building with a big green check mark on it. And the first line says, appropriate government may suspend execution or remit reduce amount, whole or part of punishment.
Notice the critical shift in language. We are no longer talking about the court. We are now talking about the appropriate government. This is the executive branch stepping in after the judiciary has done its job. This is the power of clemency.
So what's the difference between suspension and remission?
Let's take remission first. Remission means reducing the amount of the sentence without changing its fundamental character. If I have a 10-year sentence for rigorous imprisonment, the government can remit it to 7 years of rigorous imprisonment. I still stay in jail, doing hard labor, but just for a shorter period.
And suspension?
Suspension is like hitting the pause button on the sentence. This is the legal basis for things like parole or furlough. The government can suspend the sentence and let you out for a temporary period, maybe to attend a family wedding. The sentence is still there, waiting for you, but its execution is paused.
The slide says this can be done with or without conditions. And it adds, if conditions not fulfilled, remission is canceled. The person can be arrested without a warrant.
Yes. This power is not a free pass. If the government releases you early on remission with a condition that you must report to the local police station every Monday, and you fail to do so, the deal is off. The remission is canceled, the police can arrest you immediately without needing a new warrant, and you go back to prison to serve out the rest of your original 10-year sentence.
So the benefit is conditional on your good behavior.
Absolutely. And the slide clarifies who the appropriate government is under subsection 7. It's the central government for cases involving the union's executive power, like CBI or other central agency cases. And it's the state government for all other cases, which is the vast majority.
A simple division of power. As we teach at Target for IQ, always check who investigated the case. That will usually be your biggest clue as to who the appropriate government is.
That's a very good rule of thumb.
Now, Slide 16 distinguishes remission from another power. Section 475, power to commute sentence. And there's a clear table here showing the possible conversions.
Right. If remission is about quantity, commutation is about quality. It's about changing the nature or the label of the punishment to a lighter one.
Let's go through the table. A death sentence can be commuted to imprisonment for life. Imprisonment for life can be commuted to a term not less than 7 years. And rigorous imprisonment can be commuted to simple imprisonment.
The trap box on the slide puts it perfectly. Remission reduces the amount. Commutation changes the character. So think of it this way. Remission is math, 10 years minus 2 years. Commutation is chemistry. Hard labor becomes soft labor. The key one to memorize for prelims is the one for imprisonment for life. If the government commutes a life sentence, they can't just make it 2 years. The law mandates that the new term must be substantial, not less than 7 years.
A very clear distinction. Okay, now slide 17 brings us to that 14-year rule we mentioned earlier, section 476. The visual is a calendar with a big red circle around the number 14.
This is a very, very important provision. It acts as a hard floor, a statutory minimum. It starts with the words, notwithstanding anything contained in section 474, which means this rule overrides the government's general power of remission.
And who does it apply to? The slide lists 2 conditions. People sentenced to life for an offense for which death is one of the punishments, or people whose death sentence was commuted to life.
So basically, the most serious criminals, people who have committed crimes so grave that the death penalty was on the table. For these specific convicts, the slide says, such person shall not be released unless they have served at least 14 years of imprisonment.
Let's be very clear about what this means. Does life imprisonment mean 14 years?
Absolutely not. That is the biggest misconception. Life imprisonment, in law, means imprisonment until the natural end of that person's life, until their last breath. But we know that governments use their power of remission to release prisoners early. Section 476 puts a leash on the government. It says for these most serious criminals, you cannot use your remission power to let them out before they have served 14 actual physical years in jail.
So 14 years isn't the sentence. It's the earliest point at which they become eligible for remission.
Precisely. After 14 years, the government may consider releasing them, but there's no guarantee. Release after 14 years is not automatic. It is just the minimum eligibility criteria to even ask for remission.
That clears that up. Now, slide 18 adds another layer of complexity, a political one. Section 478, Central Gov Concurrence. The visual is a puzzle piece connecting state gov and center.
This section is all about federalism and preventing the misuse of power for political ends. The slide says the state gov cannot remit or commute a sentence without the concurrence of the central gov if, and then it lists the conditions.
Let's list them. If the case was investigated by a central agency, like the CBI or NIA, if it involved the misappropriation of central government property, or if the crime was committed by a central government employee while on duty.
And that word concurrence is key. It means agreement is mandatory. The state government has to ask for permission.
Why is this rule in place?
Imagine the CBI, which is a central agency, spends years investigating and prosecuting a major terrorist. The state government, perhaps for local political vote bank reasons, decides it wants to release that terrorist early using its remission power. Section 478 says, stop. You cannot do that unilaterally. You cannot undermine the work of the central government unless the central government itself agrees to it. It maintains the integrity of federal investigations.
It's a check on the state's power. Okay, we're almost at the end of the process. Slide 19 is an interesting one. Section 479, Definition of Bail. The visual is an old parchment scroll, as if laying down a fundamental definition.
And it's interesting because historically, the old Code of Criminal Procedure didn't have an explicit definition of bail in its main definition clause. It was a concept everyone just understood from practice. The Bnss has now added this explicit definition in Chapter 35.
Let's read the 3 key points of the definition. 1, it is the release of a person accused of an offense from the custody of law.
So it's about getting out of custody.
2, upon certain conditions imposed by an officer or court.
It's never a blank check. There are always conditions.
And 3, including the execution by such person of a bond or a bail bond.
So it involves giving a financial security or a promise to appear. What this definition does is formalize and standardize the concept for the first time in the statute book itself. It clarifies for everyone that bail isn't just about paying money, it's the entire process of conditional release from custody.
A neat and tidy way to wrap up these procedural aspects. Now, slide 20 puts it all together in a summary flowchart. Summary, the judicial life cycle. It maps the entire episode we've just discussed.
Yes, it shows the whole flow. You start with the higher courts, SC, HC sessions, which have the power of transfer. They also conduct the review process, which includes both reference and revision. And once all that is done, you move to the final stage, execution.
And under execution, the map lists everything we covered. The death warrant, the mercy petition process, powers of remission and commutation, and that all-important 14-year roll.
This is the map that we've just walked through together. We started with the system's ability to find and fix its own errors, which is review. We then moved to ensuring fairness of the forum, which is transfer. And we ended with the hard reality of implementing the court's order, which is execution.
A perfect summary. And finally, slide 21. This is a very practical one for our audience. Satendra answer writing strategy. It's a checklist for mains aspirants.
These are the golden rules, the takeaways you need to have at your fingertips.
Okay, let's go through the 4 check marks. Number 1, distinguish clearly. Never mix reference S436 with revision S438. Use the table format.
We've covered that. If you get that question, draw the table. It shows clarity of thought.
Number 2, cite the timeline. For mercy petitions, S473, explicitly mention 30 days and 60 days to score extra marks.
Don't just say there's a timeline. Show the examiner you know the specific details from the new Bnss. Those numbers are marks on the table.
Number 3, keywords matter. Use expedient for ends of justice for transfer and correctness, legality, propriety for revision.
Yes. Don't just tell the story in your own words. Use the precise legal language from the statute. The examiner is literally looking for these keywords in your answer. Give them what they want.
And the final point, the big trap. Remember, HC cannot convert acquittal to conviction in revision, S4423.
It's the most important negative power. Never, ever make that mistake in a problem question. The High Court in revision can order a retrial, but it cannot convict an acquitted person.
The slide ends with a powerful quote. As we teach at Target for IQ, mastery of these procedural sections is what separates a judge from a student.
And it's absolutely true. The trial itself is the drama, but this post-trial procedure is the machinery of justice. If you know sections 432 to 479, you know how the machine actually works after the verdict is in.
Well, my brain is full, but definitely in a good way. That was a serious and incredibly detailed deep dive into the post-trial provisions of the Bnss.
It's a dense area of law, but it really is the backbone of how criminal justice is finalized.
Thank you so much for guiding us through it with such clarity. And for our listeners, I would say keep those flowcharts in your mind, especially the one on abatement of appeals and the new mercy petition timeline. Good luck with your preparation.
Yes, all the very best. Keep studying.
We'll see you in the next deep dive. Let's understand the next point from here.
Exactly. We're jumping straight in today. We've got a lot of ground to cover, a really critical chunk of the new legislation.
We certainly do. We are taking a deep dive into the Bharatiya Nagarik Suraksha Sanhita, or the Bnss, and we're zeroing in on a very specific, very dense portion. Sections 475 all the way to 516.
And just to frame this for everyone listening, we're approaching this as a faculty member from Target for IQ would. This isn't just a casual chat. It's a focused classroom-style session designed for PCS-J aspirants, all under the guidance of Satendra Sir.
The goal is precision, right? We're aiming to equip our learners to tackle both mains problem-based questions and those tricky prelims technicalities that can make or break your score.
That's the mission. We're talking about what I call the judicial life cycle. It's a journey that starts right after the verdict with sentencing, commutation, and executive powers.
And then it moves into the entire world of bail, which is, a universe in itself.
A huge universe. Then we'll touch upon property management during and after trial, and finally, we'll end with a topic that is so crucial for mains answers. What happens when things go wrong? We're talking about irregular proceedings.
Okay, let's set the scene with our first slide. It's a very symbolic image. In the center, there's this striking bright red book, clearly labeled Bharatiya Nagarik Suraksha Sanhita.
The Sanhita itself, the source.
To its left, a classic wooden gavel, and on the right, the golden scales of justice. It feels very formal, very authoritative.
And that's entirely intentional. The visual is a memory aid. The red book is your barak, the foundation. The gavel symbolizes the power of the court, the authority to pass an order, and the scales, of course, represent the balance we're always seeking. Justice, the weight and authority of this new Sanhita. As we teach at Target for IQ, linking visuals to concepts helps lock them in your memory. This image tells you we're dealing with the core machinery of the criminal justice system.
All right, let's open that red book. We're moving to our second slide, which is headlined Section 475, Power to Commute Sentence. Now, the main visual here is a vertical hierarchy chart. It looks like a ladder flowing from top to bottom.
It is a ladder. You have to visualize it exactly like that to understand commutation. At the very top rung, you have the most severe punishment, the sentence of death.
Okay, top of the ladder.
One step down from that, you have life imprisonment. Below that, a broader category. Imprisonment for various terms, which could be rigorous or simple. And right at the bottom, the last step, is a fine.
So it's a clear hierarchy of severity.
Precisely. And the core rule of Section 475 is right there on the slide. It says, the appropriate government may commute sentences without the consent of the person sentenced.
That phrase, without the consent, is in bold. I assume that's critical.
It is absolutely critical. Commutation is not a negotiation. It's an act of executive clemency or policy. The government doesn't go to the convict on death row and ask, "Excuse me, would you mind if we changed your sentence to life imprisonment?"
No, of course not. It's a unilateral decision.
It is. The term commutation itself means to substitute one thing for another. In this legal context, as the downward arrows on our ladder show, it means changing the nature of the punishment to a less severe one.
Yeah.
You're moving down the ladder.
So from death down to life imprisonment. That's the classic example.
That's the classic one. But here is where we separate the casual learner from a future judge. Look at the specific rules for moving down that ladder. The slide highlights a crucial detail about commuting a life imprisonment sentence.
I see it. It's in a yellow box labeled PCS-J alert. It says that a commuted life sentence becomes imprisonment for not less than 7 years.
Memorize that number, not less than 7 years. It's a statutory floor. The government can't just commute a life sentence and then release the person the next day or give them a 6-month term. The law mandates a minimum of 7 years.
And there's another one. Commuting a rigorous imprisonment of 7 to 10 years becomes not less than 3 years.
Another number for your prelims. These specific periods, 7 years, 3 years, are prime targets for multiple choice questions. They test if you've read the Bear Act carefully.
Now, there's also a big red box on this slide, a warning labeled trap. It's about the difference between commutation and remission.
This is one of the most common points of confusion for students, and it can be disastrous in a mains answer.
So let's clarify it once and for all.
Commutation, as we've just seen, changes the nature or character of the punishment. The label itself changes. Death becomes life. A rigorous imprisonment could become a simple one.
Okay, the very essence of the punishment is altered.
Exactly. Remission, on the other hand, only reduces the quantum or the duration of the sentence. The nature stays the same. If you have a 10-year sentence of rigorous imprisonment and the government remits 3 years, you serve 7 years of rigorous imprisonment. The punishment is still rigorous imprisonment.
You're just serving less of it.
Precisely. So commutation is a change in kind. Remission is a change in quantity. You must never, ever use these terms interchangeably. It shows a lack of conceptual clarity.
Crystal clear. Let's understand the next point from here. We're on slide 3 now, covering sections 476 to 478. The visual here is very striking. It's a large golden padlock, and engraved right on the front is the number 14.
That padlock is your memory key for section 476. We call this the 14-year rule. It's a lock on the prison door.
The slide text explains it. It reads, if a sentence of death is commuted to life, or if life imprisonment is imposed for a capital offense, such a person shall not be released from prison unless he has served at least 14 years of imprisonment.
This section addresses a fundamental question many people have. Does life imprisonment actually mean for the rest of your natural life? And the answer is generally yes. However, executive governments have powers of remission and release.
But this section puts a limit on that mercy.
It puts a hard stop on it. That golden padlock snaps shut for 14 years. Even if the government wants to release a person whose death sentence was commuted to life, Section 476 says they cannot do so until that person has actually served a minimum of 14 years.
So it ensures that a life sentence in a capital case has a real, substantial meaning.
Exactly. It prevents the concept of a life sentence from becoming, a mockery of justice through early release. That 14-year period is non-negotiable in these specific cases.
Now, below that padlock, we have a flowchart for Section 478, which is about consultation. It shows a decision tree flowing from the state government to the central government.
Right, and this flowchart is designed to bust a common myth. Look at the red misconception box right next to it. It says, false to think state government has absolute power. That's the trap aspirants fall into.
So the state's power to commute or remit isn't absolute, it's conditional sometimes.
It is. Section 478 carves out specific situations where the state government must, and I stress the word must, consult the central government before exercising its power.
And the flowchart shows those 3 situations as branches of the tree.
Let's walk through them. Branch 1. The state must consult the center if the offense was investigated by a central agency. The most common examples being the CBI or the NIA.
That makes sense. If a central agency built the case, the state shouldn't be able to dismantle it unilaterally.
Exactly. Branch 2. If the offense involved the misappropriation or destruction of property belonging to the central government.
Again, the center has a direct interest there.
A direct proprietary interest. And the third branch. If the offense was committed by a central government servant while acting or purporting to act in the discharge of their official duty.
So protecting its own officers, this really speaks to the federal structure of our country.
It does. It's a check and balance. And for our listeners, that branding insertion tip on the slide is for your mains answers. In our classes at Target for IQ, Satendra Sir always insists on linking Section 478 with subsection 2 regarding concurrent sentences. Showing the examiner that you can connect different parts of the Sanhita demonstrates a deeper understanding.
Excellent point. So let's move on. We're now in Section 2 of our deep dive, which you've titled The Vocabulary of Liberty. We're on slide 4, looking at Section 479, the Definitions Clause. And the icons here are great. They're very intuitive.
They're designed to be. Vocabulary is everything in law.
We have 3 icons. First, a simple piece of paper with a signature labeled personal bond. Next, a scroll with a pen labeled bond. And finally, a heavy-looking money bag labeled surety.
These icons represent the 3 distinct concepts you need to master. And it's important to note that Section 479 is a significant addition in the Bnss. In the old code, the term bail wasn't explicitly defined in this manner. The Sanhita rectifies that.
So let's start with the first definition then, Section 479A, bail.
The Sanhita now defines bail as the release of an accused person from custody. But critically, it's a conditional release. It's granted upon the execution of either a bond or a bail bond.
Which brings us to the difference between the scroll and the money bag. The slide has a trap analysis box in red warning us, do not use bond and bail bond interchangeably.
And this is a classic Viva or interview question. They seem similar, but they are not. Let's look at the icons.
Okay.
The bond, under Section 479B, is represented by the scroll and pen. It's a personal undertaking, an instrument you sign promising the court you will appear when required. Crucially, it is without a surety. It is your personal promise.
Just my word, my signature.
Your word, legally binding. Now, the bail bond, under Section 479C, is represented by the money bag. This is an undertaking that involves a surety. Someone else stands guarantee for you, often with a financial obligation attached.
So if there's a financial guarantee or another person's involvement, it's a bail bond. If it's just the accused person's own promise, it's a simple bond.
You got it. Precision in your language here is a sign of a well-prepared candidate. Using them interchangeably is a red flag for the examiner.
Let's understand the next point from here. That brings us to slide 5, which applies this vocabulary. Section 480, bails and bailable offenses. The visual is very powerful. It's a thick, heavy metal chain that has been snapped in 2.
The broken chain is the perfect symbol here. It represents liberty as a matter of right. In bailable offenses, bail is not a matter of discretion. It's not a favor the court grants you. It is your right.
And the flow chart on the slide makes this very clear. It reads, arrest, set for a bailable offense. Person is prepared to give bail, then an arrow points to the words, shall be released.
The word shall is the most important word in that entire section. It's a command. It's mandatory. The police officer or the court has 0 discretion. If the offense is listed as bailable in the Sanhita and you are ready to furnish the required bond, they must release you.
But what about people who can't afford it? The slide brings up the indigent proviso and the concept of an indigent person.
This is a cornerstone of access to justice. What good is a right to bail if poverty prevents you from exercising it? The law recognizes this. An indigent person is someone who is too poor to furnish the surety or the money required for a bail bond.
So what's the rule for that?
The rule is simple and humane. If the court is satisfied that a person is indigent and cannot furnish a surety, it shall discharge them on executing a personal bond without sureties. So just the signature, the promise. No money bag required.
That's a huge protection. But how does a court determine indigence? Does a person have to produce income certificates from jail?
No, the law provides a practical, time-based presumption. That's the 1-week rule mentioned on the slide. If a person accused of a bailable offense has been in custody for a period of 1 week and is unable to furnish the bail bond,
The law just presumes they're indigent.
the law presumes it. The fact that they have been unable to secure their release for a full week is considered sufficient proof of their inability to pay. It's a very pragmatic and just provision.
It really is. But it says, right, absolute. There's a red trap box at the bottom of the slide.
There's always an exception for those who abuse the system. Section 480, subsection 2, gives the court a power to refuse this mandatory release. The condition is if that person has previously failed to comply with the conditions of a bail bond on a prior occasion.
So if you've jumped bail before,
If you've jumped bail before, you forfeit this absolute right, even in a bailable offense. The law gives you liberty, but it expects responsibility in return.
That seems fair.
Okay.
Okay, moving to slide 6, section 481, which is about the maximum detention for under trials. The visual is a calendar page, and 2 fractions are circled in big, bold, red ink, 12 and 13.
This section is a crucial safeguard against endless pretrial detention. Those fractions represent the calculation matrix for under trials. People who are in jail awaiting the conclusion of their trial who are presumed innocent until proven guilty.
So let's look at the first fraction, 12. What's the standard rule?
The standard rule under Section 481 is that an under-trial prisoner shall be released on bail if the period of detention they have already undergone is equal to 1/2 of the maximum period of imprisonment specified for that offense.
Can you give some example?
Certainly. Let's say the offense carries a maximum punishment of 10 years. If the under trial has been in jail for 5 years and the trial is still not over, they must be released on a personal bond. The law says enough is enough.
Okay, that's the 1/2 rule. What about the 13?
The 1/3 rule is a special provision, an incentive for good behavior in a sense. It applies to a first-time offender.
And how is a first-time offender defined here?
It's defined as a person who has never been convicted of any offense in the past. If you're a first-time offender, you don't have to wait for half the term. You are entitled to be released if your detention equals 1/3 of the maximum imprisonment. So in our 10-year example, that would be after about 3 years and 4 months.
That's a significant benefit. But I'm looking at the exclusions box on the slide. This doesn't apply to everything.
No, and this is a critical point that Satendra always emphasizes. This provision does not apply to offenses punishable with death. And logically, it cannot apply to offenses where the punishment is life imprisonment because you can't calculate 1/2 of life.
Of course. And whose job is it to keep track of this? The slide mentions the duty of superintendent.
It's the duty of the superintendent of the jail. The law places a positive obligation on them. They must monitor the detention periods of all under trials. The moment a prisoner hits that 1/2 or 1/3 mark, the superintendent is required to make an application to the court forthwith.
So the prisoner doesn't have to figure this out themselves. The system is supposed to do it for them.
The system has a mandatory duty to do so. It's a proactive duty, not a reactive one.
One last trap on this slide. It says, delay caused by the accused is excluded.
Yes, this prevents misuse. If the trial is being delayed because the accused or their lawyer is constantly seeking adjournments, that period of delay is not counted towards the 1/2 or 1/3 calculation. You can't deliberately slow down your own trial to trigger your release.
That closes a major loophole. Let's understand the next point from here. We are now entering section 3 of our session, focusing on non-bailable offenses and special provisions. This is where things get more complex.
This is where judicial discretion really comes into play.
We're on slide 7, section 482, bail in non-bailable offenses. The visual captures this perfectly. It's the scales of justice, but one scale is labeled guilt and the other is labeled liberty. The judge has to balance them.
An excellent summary. In bailable offenses, it was a right. Here, it is a delicate balancing act. The slide presents this as a judicial discretion tree. The default position, the main trunk of the tree, is that the court may release. It has the discretion.
But then there are some very thick branches labeled shall not release. These are the restrictions.
These are the statutory restrictions on that discretion. The law says the court generally shall not grant bail in a few specific circumstances. Let's go through them.
Please.
First, if there are reasonable grounds for believing that the accused has committed an offense punishable with death or life imprisonment, this is the most serious category.
Okay, that's the gravity of the current offense.
Correct. The second and third restrictions look at the person's past. The court shall not grant bail if the accused has been previously convicted of an offense punishable with death, life, or imprisonment for 7 years or more.
So a history of serious crime.
Exactly. Or thirdly, if they have been previously convicted on 2 or more occasions of a cognizable offense punishable with imprisonment for 3 years or more, but not less than 7 years, this targets the habitual offender.
So the gravity of the current charge and the history of the accused are the main factors that restrict discretion.
Precisely. But even with these restrictions, the law carves out exceptions. Look to the right side of the slide at the proviso exceptions.
Ah, yes. Even if those conditions are met, the court can still grant bail to certain people.
Yes. The court can still release a person who is under the age of 18 years, a woman, or any person who is sick or infirm. This is a humanitarian consideration.
The sick or infirm ground is one we see used quite often in high-profile cases.
Very often. And there's also a general catch-all clause. The court can grant bail if it is just and proper for any other special reason, which has to be recorded in writing.
Now I see a bright green box on the slide, a key fact. It says that the mere requirement for witness identification is not a sufficient ground to refuse bail.
This is a crucial practical point for any litigator or judge. The prosecution often argues, "Your Honor, we need to keep the accused in custody for a test identification parade." Section 482 clarifies that this, on its own, is not a good enough reason to deny bail if the person would otherwise be entitled to it.
So you can't hold liberty hostage to a procedural step.
You cannot. The parade can be conducted, but it can't be used as a blanket ground for refusing bail.
Let's continue with Section 482 on Slide 8. The focus here shifts to delays in acquittal. The visual is an hourglass, with the sand quickly running out.
This slide deals with the consequences of a slow-moving trial. The hourglass represents the court's patience running out.
The first point is about magisterial trial delay, which brings in a 60-day rule.
Yes, this is under Section 482, subsection 6. It's a provision designed to speed up trials at the magistrate level. It states that if a trial for a non-bailable offense is not concluded within a period of 60 days,
2 months.
60 days from the first date fixed for taking evidence, then the accused, if they have been in custody during that whole period, shall be released on bail.
Another shall. So it's mandatory.
It is mandatory, unless the magistrate, for reasons to be recorded in writing, directs otherwise. So the default position shifts from custody to bail after 60 days of evidence. It puts pressure on the system to perform.
Now what about the next point, Section 482.7? This covers a very specific time, post-trial prejudgment.
This is a fascinating and just provision. Imagine this scenario. The entire trial is complete, all witnesses have been examined, all arguments have been heard, the judge has reserved the judgment and is now in the process of writing it.
So the accused is in a state of limbo.
Exactly. Now, if at this stage, after hearing everything, the court is of the opinion that there are reasonable grounds for believing the accused is not guilty, why should that person spend even one more day in jail?
They shouldn't.
And the law agrees. Section 482.7 says, in such a situation, the court shall release the accused on a personal bond without sureties for the limited purpose of appearing to hear the judgment when it is delivered.
That's a powerful statement about the presumption of innocence.
It absolutely is.
Yeah.
It ensures that a person the court already believes to be innocent is not incarcerated for purely administrative reasons.
And the trap here.
The trap is that the 60-day rule only applies if the accused was in custody during the whole of that period. If they were out on bail for part of it, this provision won't be triggered.
Got it. Let's move to Slide 9, Section 484. The heading has changed. It says, Direction for Grant of Bail, anticipatory, and the visual is of a person being protected by a large gleaming shield.
The shield is the perfect metaphor. This is the provision for what is commonly known as anticipatory bail. Bail in anticipation of an arrest. The Bnss has rephrased the heading to Direction for Grant of Bail, but the concept is the same. It's a shield against potential arrest.
And who can grant this shield?
The jurisdiction is limited to the higher courts. Only the High Court or the Court of Session has the power to issue such direction under Section 484.
And it comes with strings attached, I assume. The slide lists conditions under subsection 2.
Yes, the shield is not unconditional. The court will impose conditions, and the statute itself lists some common ones. The person must make themselves available for interrogation by the police as and when required.
So you can't just get the order and disappear.
Absolutely not. Second, they shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case to dissuade them from disclosing such facts. In short, no witness tampering.
And the third one.
They shall not leave India without the previous permission of the court.
These seem like standard, reasonable conditions. But the most important part of this slide seems to be the big red box at the bottom, labeled the Bnss exclusion, Sex 484.
This is a monumental change and a guaranteed exam question. This is probably one of the most talked about changes in the new Sanhita. The new law explicitly carves out an exclusion. It says that the provisions of Section 484, the shield of anticipatory bail, shall not apply to certain specific sexual offenses under the Bharatiya Nyaya Sanhita, the Bnss.
So for these offenses, anticipatory bail is simply not an option anymore.
It is completely barred. The slide lists them, and every aspirant must memorize these section numbers. They are Section 64 of the Bnss, which deals with rape.
Okay.
Section 66 of the Bnss, which is the punishment for rape that causes death or leaves the victim in a persistent vegetative state. And Section 70 of the Bnss, which deals with gang rape.
So for these three specific heinous offenses, the option to seek pre-arrest bail has been removed by the legislature.
Correct. This is a major policy decision embedded in the new law. The exam alert here is simple. Memorize these section numbers. They will be asked.
Understood. Let's understand the next point from here. We are now in Section 4 of our deep dive, bonds, sureties, and property. We're on Slide 10, covering the mechanics in Sections 486 to 489. The visual is a formal document, an affidavit with a red wax seal.
Right, we're getting into the nuts and bolts now, the procedural aspects. The affidavit represents the formal sworn statements that are part of this process.
Let's look at the first point, Section 488. It says a surety must declare the number of persons to whom he stands surety. Why is that important?
This is a crucial procedural check aimed at curbing the menace of professional sureties. In many court complexes, you find individuals whose entire business is to stand as surety for accused persons for a fee.
And they might not have the financial capacity to back up all those guarantees.
Exactly. If one person stands surety for 50 different people, their guarantee is essentially worthless. This provision forces them to declare on affidavit how many other undertakings they've given, allowing the court to assess their actual financial credibility.
Okay, that makes sense. Then we have Section 486, which says the amount of bond shall not be excessive.
This is a constitutional principle, really, rooted in the idea of fairness. Bail should not be a punishment. If the court sets an impossibly high bail amount for a minor offense, say 1 crore rupees for petty theft, it's a de facto denial of bail. The amount must be proportionate to the gravity of the offense.
And Section 487, it says the court may accept affidavits for the fitness of sureties.
This is a practical provision to speed things up. Instead of having every surety come to the witness box and be examined and cross-examined about their financial status, the court can rely on a sworn affidavit. It makes the process much more efficient.
Finally, Section 489 about the discharge of the person. There's a trap noted on the slide here.
Yes, a small but important procedural point. Once the bail bond is furnished and accepted, the court issues a release order. The trap is knowing where that order goes. It is sent directly to the jailer, or the person in charge of the prison.
Not to the police station.
Not to the police station. The order is a command from the court to the prison authority. Upon receiving that order, the jailer must release the person immediately.
Got it. Now, Slide 11 deals with what happens when things go wrong. Section 493, forfeiture of bond. The visual is quite dramatic, a judge's gavel smashing a pile of gold coins.
The visual represents the financial penalty. This is the consequence of violating the conditions of your bail, for example, by failing to appear in court on the required date. When that happens, your bond is forfeited.
And the slide has a flowchart that walks us through the process.
It's a clear step-by-step process. First, it must be proved to the court's satisfaction that the bond has been forfeited. The court then records the grounds for its satisfaction in writing.
So it's not an automatic process.
Not at all. The court then issues a notice calling upon the person bound by the bond, both the accused and their surety, to either pay the penalty amount or to show cause why it should not be paid.
They get a chance to explain themselves.
Yes, principles of natural justice are followed. If they fail to show sufficient cause and also fail to pay the penalty, the court can then proceed to recover the amount as if it were a fine imposed by the court.
And what if they simply have no money or assets to recover? What's the final step?
This is the ultimate consequence. If the penalty cannot be recovered, the court can order the surety to be imprisoned in civil jail.
Civil jail, not criminal jail. That's a crucial distinction highlighted on the slide.
It's a vital distinction. As we always teach at Target for IQ, understanding the difference between civil and criminal liability is key. Imprisonment for non-payment of a bond penalty is a civil liability, not a criminal conviction. And the maximum term for this is 6 months.
6 months in civil jail. That's a serious consequence for the surety.
It is. It underscores the gravity of the promise they made to the court.
Now let's look at Slide 12, Section 499. This seems very modern. The visual is a smartphone on a tripod, videographing a piece of evidence that's sealed in a plastic bag.
This is one of the most significant procedural reforms in the Bnss, a real game changer. We call it the digital evidence rule, found in Section 499, subsections 2 and 3. It addresses the massive problem of case properties or malkanas being overwhelmed.
You mean all the seized items just lying in police stations for years?
Exactly. Cars rusting away, valuables getting lost, warehouses full of seized goods. This section provides a modern solution.
So how does it work?
When any property is produced before the court during an inquiry or trial, the police have a new mandatory duty. The slide gives the timeline. within 14 days of its production in court.
14 days, a strict deadline.
A very strict deadline. Within that time, they must do two things. First, prepare a detailed statement or description of the property. Second, and this is the key reform, they must take a photograph and, importantly, a videograph of the property using a mobile phone or any other electronic device.
So a complete digital record is created.
A certified digital record. And then, under Section 499, these photographs and videographs can be used as evidence during the trial.
And what happens to the actual physical object?
The court can then order it to be released to the rightful owner or disposed of. The physical object doesn't need to be kept in storage for years until the trial ends. The certified video becomes the primary evidence.
That's incredibly efficient. The exam alert on the slide says the 14-day timeline is a probable prelims question.
Deadlines and numbers are always favorites for prelims examiners. And the trap here is procedural. A failure by the police to create this digital record within 14 days is a serious procedural lapse that a good defense lawyer will definitely highlight.
Let's understand the next point from here. We are now in Section 5, which covers disposal of property and irregularities. We're on slide 13, looking at sections 500 to 504, which is about disposal at the conclusion of the trial. The visuals are a paper shredder and an old, ornate key.
The shredder and the key represent the two main outcomes: destruction and restoration. Once the trial is over, the court has to decide what to do with the property involved in the case. Section 500 gives it three main powers: destruction, confiscation to the state, or delivery to the person entitled to it.
The slide highlights destruction under Section 503. What kind of things must be destroyed?
The law mandates destruction for certain items that are inherently harmful or illegal to possess. The slide lists some key examples: libelous or obscene matter, things falling under Bnss sections like 292, 293, or 354. You don't return defamatory pamphlets or obscene material to the accused.
Of course not.
The same applies to adulterated food and drugs, covered by Bnss sections 272 to 275. You destroy the fake medicine, you don't give it back.
Okay, that's the shredder. What about the key? Restoration of immovable property under Section 504.
The key represents giving someone back their house or land. This section applies when a person has been convicted of an offense that involved dispossessing someone of their immovable property using criminal force or intimidation.
So if someone was thrown out of their home?
Exactly. The court that convicts the accused can then order that the property be restored to the person who was dispossessed. The concept box on the slide adds a crucial detail. This applies even if the force was just a show of force. You don't have to be physically beaten. If someone threatens you with a weapon and you flee your property, Section 504 can be invoked.
Is there a time limit for the court to make this order?
Yes, and it's a very strict one. The limitation bullet point is key. The order for restoration must be made within 1 month of the date of conviction. If the court waits longer than that, it loses the power to make the order under this specific section.
1 month, another timeline to remember. Now, slide 14 covers sections 505 to 507, dealing with seizure and unclaimed property. The visual is a simple, weathered evidence tag tied to an object.
This is about property seized by the police where the owner isn't immediately known. Section 505 lays out the procedure. The police must report the seizure to the magistrate. The magistrate then issues a proclamation.
A public notice, essentially.
A public notice specifying the items and requiring any person who has a claim to appear and establish it. The timeline here is critical for exams. They have 6 months from the date of the proclamation to make their claim.
And if no one shows up in 6 months?
And if no one establishes a claim, then under Section 506, the property is considered at the disposal of the state government and can be sold.
But what if the property is, say, a crate of vegetables or something of very little value? It won't last 6 months.
That's where Section 507 comes in. It deals with perishable property or property of low value. The slide highlights the key fact here. The financial threshold is 10,000 rupees.
10,000 rupees.
If the property is subject to speedy and natural decay, or if its value is less than 10,000 rupees, the magistrate doesn't have to wait 6 months. They can order its sale at any time and hold the proceeds.
And the trap on this slide.
The trap is about the starting point of the 6-month period. It starts from the date of the proclamation, not from the date of the seizure. Examiners love to play with these two dates in MCQs.
A subtle but vital difference. Now we're getting into a very technical but very important area for mains answers. Slide 15, Section 508. Irregularities not vitiating proceedings. The visual is a green shield with a bold white check mark inside.
The green shield means safe. These are procedural errors that are considered curable. The law recognizes that judicial officers, especially magistrates, are human and can make mistakes in good faith. This section saves those proceedings from being nullified.
What's the core condition for this section to apply?
The condition is this. A magistrate who was not empowered by law to do a certain act does it anyway, but does so erroneously and in good faith. If these two conditions, not empowered but acted in good faith, are met, then the proceeding is not set aside merely on that ground.
This slide gives a list of these saved or curable acts.
Yes, and it's an illustrative list. For example, A, to issue a search warrant under Section 97. B, to order a police investigation under Section 174. C, to hold an inquest under Section 196.
And the exam alert points specifically to Clause G.
Clause G, to tender a pardon under Section 343, is a very common MCQ option. If a magistrate who wasn't empowered to tender a pardon does so in good faith, that pardon is not invalid. The defect is cured by Section 508.
So these are procedural mistakes that don't go to the root of the matter.
Exactly. They don't cause a failure of justice. But that brings us to the flip side on slide 16.
Right. Section 509, irregularities vitiating proceedings. And the visual here is the complete opposite. A big, angry red stamp that says void.
Red means stop. Void means the proceeding is a nullity. It's as if it never happened. These are errors that are so fundamental, so serious that they cannot be cured. They are incurable defects.
And the condition is the same, right? A magistrate not empowered by law does the act.
The condition is the same, but the acts are different. These acts go to the very core of jurisdiction. Look at the void list on the slide. These are crucial examples to remember.
Let's go through a few.
A, to attach and sell property under Section 85. This affects property rights. C, to demand security to keep the peace. This affects personal liberty. To try an offender. This is the most fundamental power.
So if a magistrate who is not empowered to conduct a trial does so anyway, that entire trial is void.
Completely and utterly void, from start to finish. Same with them, trying an offender summarily. Summary trial is a special power. If you don't have it, you can't use it. Q, to revise an order passed under Section 493. Revision is an appellate power. A magistrate cannot usurp it.
The trap noted here is about confusing Section 85 with Section 97.
This is a classic exam problem. Issuing a search warrant under Section 97 is on the green save list in Section 508, but attaching property under Section 85 is on the red void list in Section 509. You have to know which is which. A search is procedural, but attachment is a substantive deprivation of property, hence it's a jurisdictional error.
This distinction is so critical, and slide 17 brings it all together with an analysis curable versus incurable decision tree.
This slide is your mental flowchart for any problem-based question on this topic. It simplifies the analysis.
Let's walk through it. The first question at the top is, was the magistrate empowered? And the answer is no.
Right. If the answer is yes, then there's no irregularity. But if the answer is no, you go to the next level. You have to check which act was performed.
So if the act was issue search warrant, you follow the green path to Section 508, and the outcome is save curable.
Correct. If the act was tender of pardon, same thing. Green path, Section 508, saved.
But if the act was summary trial or attachment of property, you follow the red path.
You follow the red path to Section 509, and the outcome is void and curable. This flowchart is the key to structuring your mains answer.
And the main strategy tip on the slide drives that home.
It does. It says you must always cite Section 508, 509, Bnss explicitly in your conclusion. Don't just write, this is a curable irregularity. You have to write, this is a curable irregularity under Section 508 of the Bnss. That's what gets you the top marks.
Let's understand the next point from here. We're in our final content section, Section 6, Failure of Justice and Limitation. Slide 18 covers Sections 510 to 512 with the theme of the failure of justice test. The visual is a solid concrete block labeled technicality, and it's cracking and breaking apart.
That visual captures the modern jurisprudential approach. The law is moving away from hyper-technical arguments. The concrete block of technicality is being broken apart in favor of substantive justice.
So Section 510 deals with a trial held in the wrong place.
Yes. For example, a trial that should have been in District A was held in District B. Section 510 says no finding or sentence shall be set aside merely because the trial took place in the wrong session division or district.
There must be a catch, though.
There is. The exception is if it appears that such an error has, in fact, occasioned a failure of justice. That is the ultimate test.
And this same test applies to errors in the charge under Section 512.
Exactly. An error or omission in stating the offense or the particulars in the charge sheet is not, by itself, a ground for reversing a conviction. Courts will not invalidate an entire trial over a typo.
Unless
the Court of Appeal or Revision is of the opinion that the error has, in fact, occasioned a failure of justice. For example, if the error was so misleading that the accused was genuinely prejudiced and could not understand what they're being charged with and therefore couldn't mount a proper defense.
the exam alert tells us to focus on that exact phrase. Failure of justice has in fact been occasioned.
That phrase is your analytical tool. In any mains answer on this topic, you have to apply this test. Was the accused prejudiced? Did the error prevent a fair trial? If not, the technicality is overlooked.
Slide 19 takes us to the final sections of our scope, sections 515 and 516, dealing with limitation for cognizance. The visual is a stopwatch, ticking down.
This is the statute of limitations for initiating criminal proceedings. It's a fundamental principle that the threat of prosecution shouldn't hang over a person's head forever for minor offenses.
So, Section 515 defines period of limitation as the period specified for taking cognizance of an offense.
Yes, and that brings us to the bar created by Section 516. It says, no court shall take cognizance of an offense after the expiry of the period of limitation. It's a hard stop.
And the slide has a table laying out these periods.
It's a simple table, but you must memorize it for prelims. First, if the offense is punishable with a fine only, the limitation period is 6 months.
6 months.
Second, if the offense is punishable with imprisonment for a term not exceeding 1 year, the limitation period is 1 year.
1 year.
There are other periods for more serious offenses, but these two are the most frequently tested.
And the trap here is to not confuse this with limitation for filing appeals.
Correct. This is not about the timeline to challenge a conviction. This is about the timeline for the court to even begin the case, to take cognizance of the offense in the first place. They are two completely different concepts.
We've covered a huge amount of technical detail, so let's bring it all together in Section 7, our final strategy section. Slide 20 is on mains answer writing strategy. The visual is a simple notebook and pen.
This is where the rubber meets the road. It's about translating all this knowledge into marks.
Let's go through the framing advice. For bail questions.
For any question on bail, your first step must be to distinguish between bailable and non-bailable offenses. Start your answer there. And you must cite the Section 479 definitions of bail, bond, and bail bond. It shows you have your fundamentals right.
For questions on property.
You should always try to mention the mandatory videography rule from Section 499. Frame it as a significant modern reform in the Bnss to improve evidence management. Using phrases like that shows the examiner you're not just rote learning, you understand the purpose of the law.
And for irregularities.
You must use the void versus curable framework we discussed. Explicitly use Section 508 for curable defects and Section 509 for void proceedings. That structure is what examiners look for.
The slide also has a golden rule.
A simple but crucial one. Use the word sanhita in your answers, not code. We are under a new legislative regime. Using the correct terminology is a sign of a diligent student.
And there's a common mistake highlighted.
Yes. Forgetting to mention the first-time offender proviso, the 1/3 rule in bail answers under Section 481. It's a specific statutory benefit. If your answer on under trial detention misses that point, it's an incomplete answer.
Excellent practical advice. That brings us to our final slide, slide 21. Thank you and best of luck, featuring the Target for IQ logo, the gavel, and a target icon.
So as we conclude this deep dive, my main advice to every listener is to keep revising the bare text of the Sanhita. There is no substitute for reading the source material.
And there's some homework.
Yes. For our next session, I want you all to prepare specific problem-based questions on the topic of bail. Come prepared to apply these principles. And remember to read the PDF notes and excerpts we provide before you attempt to solve any MCQs.
This has been an incredibly dense and detailed session. We've literally walked through the entire life cycle of a case, from sentencing to its final procedural checks.
It is a complex machinery, but mastering these interconnected sections is what will give you the edge. This is a faculty member from Target for IQ under the guidance of Successor, signing off. Keep learning and keep striving.
Thank you so much for that masterclass. And for you, our listeners, a final thought to take with you. We talked at length about the 14-year rule and the executive's power to commute sentences. It's a delicate balance, isn't it, between the judiciary's role in handing down a just punishment and the executive's power to grant mercy. In our democracy today, do you think we have that balance right? Where should that line truly be drawn? Something to reflect on. We'll see you next time.
Let's understand the next point from here.
Yes, absolutely. We're shifting gears from the broader principles and diving right into the machinery of the law itself.
We really are. And today, we are cracking open a stack of material that, I have to admit, might look incredibly dry on the surface. We're talking legal procedure, miscellaneous sections, statutes, numbers. But I promise you, if you stick with us, this is actually the engine room of the Indian justice system.
That's a great way to put it.
We're looking at the Bharatiya Nagarik Suraksha Sanhita, the Bnss, specifically diving into that miscellaneous segment. It runs from Section 511 all the way to 533.
And, it's part of the law that people often just skim over because of that exact word, miscellaneous. It sounds like the junk drawer in your kitchen, The one with the dead batteries and rubber bands.
Exactly.
But in the legal world, and I mean this, especially for anyone preparing for the judiciary exams, this is frankly where cases are won and lost.
So it's not junk at all.
Not even close. We're covering irregularities in proceedings, which is a massive topic. Then there's the limitation period for taking cognizance, which is huge, and some very, very crucial miscellaneous powers that have shifted significantly from the old code.
And to guide us through all this, we're drawing very heavily from the senior judiciary faculty lectures provided by Target for IQ.
Yes.
We have the lecture notes, the slides, and the specific breakdown from Successor Sir on how these sections actually work for judiciary aspirants. So our mission today is really to take this high-level classroom material and, well, break it down for everyone.
Exactly. And the core theme we're going to see, you'll see it popping up again and again, is this tension between procedural perfection on one hand
and substantive justice on the other.
Precisely. Does a typo kill a trial? How long can you wait before you report a crime? I mean, these are the fundamental questions we're unpacking today.
Hey, let's do it. Let's dive into the first slide of our source material. This one gives us that bird's eye view, the overview of the whole module.
Right. It's setting the stage. You can see the image on the slide, a gavel and a law book. It immediately sets that legal tone, that sense of authority and procedure.
It does, and the title reads Bharatiya Nagarik Suraksha Sanhita, Bnss, sections 511 to 533, irregularities, limitation, and miscellaneous.
And then it breaks it down into 3 clean modules for us.
Module 1, that's irregularities and what are called curative provisions, sections 511 to 514.
Then Module 2 is all about the clock, limitation for taking cognizance. That's sections 515 to 521.
And finally, Module 3 covers miscellaneous powers and repeal, which takes us from 522 to the end, section 533.
And right at the bottom of this slide, you'll see Successor Sir has highlighted a key fact. It's a line that really, it sets the tone for everything we are about to discuss.
Let me read it. It says, these sections determine if a procedural error vitiates the trial or if it is curable.
Vitiates, that's the word.
It's a heavy legal word, isn't it? What does that mean in plain English for someone studying this?
It's a great question. In plain English, if an error vitiates the trial, it poisons it, it kills it. The entire proceeding is invalidated.
So the conviction is thrown out?
Thrown out. The whole process collapses. And often, the accused walks free, not because they're innocent, but because the process was fatally flawed.
Wow. Okay, so that's vitiates versus curable.
Right. And this is the other side of the coin. If an error is curable, the court effectively looks at it and says, okay, a mistake was made here. The paperwork wasn't perfect. We get it. But did it actually break the fundamental mechanism of justice? If the answer to that question is no, then we fix it, we cure it, and the verdict stands.
That distinction seems like, well, everything.
It's the backbone of criminal procedure.
Yeah.
Courts, at the end of the day, care about getting to the right result. Actual justice, not just technical, checkbox perfection. And that philosophy is what we're going to see play out.
I love that. Okay, so let's look at the first specific example of this. We're on slide 2 now, and the heading is section 511, irregularities in confessions.
And this is a very high-stakes area. A confession, as you know, is often called the queen of evidence. It's incredibly powerful.
But the law is also very strict about it. The slide mentions it applies when provisions of Section 183 or Section 316 haven't been complied with. Remind us what those are.
Right. So Section 183 is about the actual recording of confessions. Section 316 deals with the examination of the accused. These sections are full of safeguards, things designed to prevent police brutality or coerced statements.
So what kind of rules are we talking about? Give me an example of a safeguard.
Well, for instance, the magistrate has to sign the record in a very specific way. At the foot of the document, they have to write a certificate saying they believe the confession was made voluntarily. They have to explain to the accused in no uncertain terms, listen, you do not have to say anything, but if you do speak, whatever you say can and will be used against you. It's a very rigorous checklist.
Okay, so the core question of Section 511 is, what happens if the magistrate messes up that checklist? Maybe they miss a signature or they forget to write that one specific line in the certificate. Does the murderer now go free because of a paperwork error?
And that is exactly the question Section 511 answers. You see the visual on the slide. It's a legal document with a big red stamp over it that says checked.
Right.
That symbolizes the court verifying the validity of the statement, even if there was a small error. The law doesn't have a knee-jerk reaction. It doesn't automatically throw the confession out.
So what does it do? The slide says, the court may take evidence regarding such noncompliance.
It acts as a filter. It says, hold on, let's investigate the mistake itself. They don't just toss the file in the bin. They basically run a diagnostic test on the error.
A diagnostic test. I like that. So they're trying to figure out how bad the error was.
Exactly. And the confession, the statement, is ultimately admitted if the court is satisfied on two specific conditions. They are listed right there.
Okay, condition 1. The accused duly made the statement recorded.
So first things first, is this what the person actually said? Is the transcript accurate? That's just about basic factual reality. Did they say those words?
Simple enough. And the second condition.
This is the critical one. This is the heart of the test. The non-compliance must not have injured the accused in his defense on the merits.
Injured on the merits. That phrase, again, it feels like a very specific legal term of art. Let's unpack that. What does an injury on the merits look like versus just a technical injury?
It's a fantastic question because this is what students get confused about. An injury on the merits means the error fundamentally disadvantaged the accused's ability to defend themselves.
Give me an example.
Okay. If the magistrate completely failed to tell the accused, you have a right to remain silent, and the accused then gives a confession, that's a clear injury on the merits.
Because they were misled about their fundamental rights. They might have stayed silent if they'd known.
Precisely. That error goes to the very root of fairness. That would vitiate the confession. It's incurable.
Okay, so that's a major injury. What's a minor, curable one?
Now, let's say the magistrate gave all the warnings, the accused understood everything perfectly, gave the confession completely voluntarily. But the magistrate, in a rush, forgot to sign the bottom left corner of page 3. Or they used blue ink instead of black for the official stamp.
That's a clerical error, a slip-up.
Exactly. That does not injure the defense on the merits. The accused knew exactly what they were doing. The missing signature didn't change the substance or the voluntary nature of the confession one bit.
So in that case, Section 511 says,
Cure it. Accept the evidence. Move on. It prevents that gotcha moment where a guilty person could walk free on a ridiculous technicality.
that makes perfect sense. The source notes also point out a non-obstant clause here. What's that about? It says, notwithstanding anything contained in Section 94 of the Bharatiya Saksha Adhiniyam 2023.
Right. So this is Satendra Sura pointing out the hierarchy of laws, which is a very important concept. The Bharatiya Saksha Adhiniyam, that's the new Evidence Act, has very strict rules about documentary evidence. Section 94 of that act generally says, if a document is required by law to be in a certain form, you must produce the document itself. You can't just bring oral evidence to talk about what was supposed to be in the document.
But Section 511 seems to do exactly that.
It does. It overrides it for this specific situation. It says, even if the Evidence Act demands perfection in that document, we, the Bnss, are creating a special exception. We are allowing the court to take oral evidence from the magistrate to fix this specific mistake in a confession. It's a safety valve.
A safety valve built right into the code. And I see a bright yellow exam alert box here from the lecture notes. This must be important.
Very. It says this power applies to courts of appeal, reference, and revision, subsection 2.
What does that mean in practice?
It means this isn't just a power for the trial judge who first hears the case. Let's say a case goes up to the High Court on appeal, maybe 5 years later. The High Court judges can also look back, use Section 511, cure a technical defect in the original confession, and uphold the conviction.
So the power to cure travels with the case as it moves up the judicial ladder.
That's a perfect summary. It's not lost after the first stage.
Okay, let's move on to the next slide. Section 512. The source material labels this one error or omission in charge. And there's a flowchart here on the slide that seemed absolutely essential to visualize.
It is. The charge is the formal document. It's the piece of paper that officially tells the accused, you are being tried for murder under Section X, or you are being tried for theft under Section Y.
So it's the foundation of the entire trial.
Absolutely.
Right.
So the question becomes, if that foundation has a crack in it, Does the whole house fall down?
The slide has a big banner across the top that seems to answer that. It calls it the Golden Rule.
Yes, and every law student should, frankly, memorize this rule.
It reads, no finding sentence is invalid merely due to error, omission, misjoinder of charge unless a failure of justice has in fact been occasioned.
And there's that phrase again.
Failure of justice. It really is the mantra of this entire part of the Bnss, isn't it?
It is the guiding star for all these sections. It's the ultimate test.
Okay, let's walk through this flowchart that Satendra Sir provided. It starts at the top with appellate court opinion. So we're imagining a case has already been decided and is now on appeal.
Correct. The first question the higher court asks is the big one. Was there a failure of justice caused by the error in the charge? And from that question, you can see 3 distinct paths downwards.
Let's take the first path. On the left, it says omission to frame charge. This seems like the worst case scenario. The court completely forgot to write the charge document.
Whoa, yeah, I mean, how does that even happen? They forgot to tell the person what they're on trial for.
It can happen. You'd be surprised. Administrative chaos, a file goes missing, a judge is overworked. It happens. But even then, look at the remedy prescribed in the flowchart.
It's not an instant acquittal.
Not at all. The flowchart shows the court will order charge to be framed and then recommend trial from that point.
So they just hit a reset button on that part of the process.
Exactly. They don't cancel the whole game. They just replay the down. They say, okay, we messed up. Let's go back, write the proper charge now, let the accused respond to it, and then we continue the trial from there. Justice isn't thrown out the window.
Okay, that's path 1. Now, path 2, in the middle. Error, irregularity in charge. This is probably more common. Maybe they wrote robbery, but cited the legal section for theft, or they got the date of the offense wrong by a day.
Yes, minor mistakes. In that case, the flowchart says the court can direct a new trial. Again, the focus is on fixing the mistake, not on abandoning the pursuit of justice.
And path 3 on the right. This one seems to be the most extreme.
It's the rarest one. The box says, facts show no valid charge possible.
What does that mean?
It means the appellate court looks at the entire mess, the evidence, the testimony, everything, and realizes, wait a minute. Even if we fix the typos in the charge, the facts that were proven in court simply do not constitute a crime under any law.
Oh, I see. Or perhaps the process was so jumbled and confused that a valid charge simply can't be framed without inventing a whole new set of facts. Then, and only then, do we follow the arrow down to the final outcome, quash the conviction. That's when the person walks free.
So the trap here, and the source material has a literal red trap box on the slide to warn us, is thinking that any error automatically makes the trial invalid.
That's the #1 mistake students make. The text in that box is so important, and validity is not automatic. The test is failure of justice.
As we emphasize in our mains answer writing sessions at Target for IQ, knowing these nuances is what separates a top scorer from everyone else.
Absolutely. If you're writing a mains answer for a judiciary exam and you see a problem with a defective charge, if you just write, the trial is void, you will get 0 marks.
You have to do the analysis.
You have to analyze it. You have to ask, was the accused actually misled? Did this error prevent them from mounting a proper defense?
Yeah. It really circles back to that core philosophy, doesn't it? Did the person on trial know they were fighting a murder case? Yes. Then the typo in the section number probably doesn't matter.
Precisely. If the accused lawyer was cross-examining witnesses about the murder weapon and presenting an alibi for the time of the murder, he can't turn around at the end and say, oh, the charge sheet said culpable homicide instead of murder, so my client was confused.
Yeah.
The court looks at the conduct of the trial to see if there was any real confusion.
That makes a lot of sense. Okay, let's move to the next slide, which covers sections 513 and 514. This is about errors in orders and attachments. The visual here is a clipboard with check marks next to a list: summons, warrant, proclamation, judgment.
This is basically broadening the scope. Section 511 was just for confessions. 512 was just for charges. Section 513 is the catch-all. It covers everything else.
So summons, warrants, court orders, final judgments.
All of it. And the rule remains exactly the same. As the slide reads, no finding reversed for error unless a failure of justice has occurred. It's the same principle applied across the board.
But there's a fascinating twist here in subsection 2. The slide calls it the early objection rule.
Ah, yes. This is a favorite for procedural lawyers. The rule, as the slide notes, says the court will consider if the objection could and should have been raised at an earlier stage.
What does that mean? You can't keep an ace up your sleeve.
That's the perfect analogy.
Yeah.
You cannot. Imagine you are a defense lawyer, and you notice on day one that the summons sent to your client had their name misspelled. But your client figured it out and showed up to court anyway.
Okay.
You can't whisper to your client, "Don't worry, we'll keep this quiet. We'll go through the whole trial, and if you lose, we'll use this typo on appeal to get a retrial."
The law doesn't let you do that.
No. The court will say, "Why did you mention this on day one when you first appeared? The fact that you're here proves the summons worked, even with the typo." By participating in the trial without objecting, you waive your right to complain about that minor error later.
It prevents lawyers from gaming the system.
Exactly. It stops them from banking technical errors as a secret insurance policy against a guilty verdict. You have to object early.
And what about Section 514? That deals with attachments.
Yes. So if the police attach your property, say they seize your car as evidence or seal your house because you're on the run and there's a defect in the attachment paperwork, Section 514 says the attachment isn't automatically deemed unlawful.
And the person doing the attachment isn't considered a trespasser.
Right. It protects the officials. If a police officer is acting in good faith under a court order to seize property, they shouldn't be personally sued for trespass just because of a clerical error on the form. It protects the state machinery from frivolous lawsuits over, formatting issues.
I see another exam alert on this slide, highlighted in yellow. It points to the inclusion of error or irregularity in any sanction for the prosecution within Section 513.
Yes, this is a very specific point for prelims questions. Often, to prosecute a public servant like a corrupt government official, you need a formal sanction from the government. It's like a permission slip to start the case.
And defense lawyers often attack that permission slip.
Constantly. They'll argue, "Oh, the sanction letter was signed by the undersecretary, not the governor," or "it didn't mention this specific fact." Section 513 now makes it clear that kind of error in the sanction is also curable. Unless it caused a genuine failure of justice, a flaw in the sanction letter won't kill the entire corruption case.
Okay, that brings us to the next slide, slide 5, which is titled Analysis, the Curative Principle. This looks like a conceptual break to tie it all together.
It is. This is the synthesis slide for this whole first module, and the visual is very powerful. It's a classic weighing scale.
On one side, there's a tiny small weight labeled procedural error.
And on the other side, there's this huge heavyweight labeled substantive justice, and it's tipping the scales way down.
That visual really drives the point home. The code is built to prioritize substantive justice.
It is, and the concept breakdown on the slide says just that. The code prioritizes substantive justice over technical perfection. And the key phrase, once again, is failure of justice.
The slide also gives us the examiner's perspective, which is so valuable for students. Satendra Sir notes, in mains, you will be given a problem where a charge was missing.
And the answering tip right below it tells you how to handle that.
It says, do not acquit immediately, apply the test. Did the error confuse the accused? Did it prejudice their defense?
Right. Don't just state the rule. Apply the facts from the problem to the rule. That's what gets you the marks.
And the key takeaway at the bottom is worth quoting one more time. If the accused knew the case against him and defended it, the error is curable.
That is the line to memorize. That's the essence of sections 511 to 514. It's about the reality of the trial, not the perfection of the paperwork. In our classes, we often tell students to think about this for the interview stage as well. They might ask you about the philosophy of the code.
And your answer would be?
The philosophy is that criminal law is about punishing the guilty and protecting the innocent, not playing grammar games with legal documents. This is the curable versus incurable irregularity principle in action.
Okay, a complete shift in gears now. We're moving to Module 2. The slide says Chapter 38, Limitation for Taking Cognizance.
This is where we start talking about time. And the visual on the slide is, fittingly, an hourglass with the sand running out. The clock is ticking.
Section 515 just gives us some definitions, but Section 516 gets right to the point. It's called the bar. And it's a hard rule. No court shall take cognizance of an offense after the expiry of the period of limitation.
It's a strict bar. It's the law telling the police and complainants, you cannot sleep on your rights. You can't wake up 5 years after a minor slap and suddenly decide you want to file a case. It's too late.
And the policy reason for this is listed here. It says, this chapter prevents stale claims and ensures the police complainant act with diligence. Why are stale claims so bad for the justice system?
Because justice has a shelf life. In a way, evidence disappears, hard drives get wiped, witnesses forget crucial details, or they move away, or they pass away. If you wait too long, having a fair trial becomes almost impossible, so the law encourages prompt action.
That makes sense. But the real meat of this module, and the slide has a big yellow box saying direct prelims questions, is the numbers, the actual time limits. Let's look at the table in section 516.
This is the math part of the law. And for the prelims exam, you just have to know these 3 tiers cold. There's no way around it.
Okay, let's go through them. Tier 1, offenses that are punishable with a fine only.
For those very minor offenses, the limitation period is just 6 months. If the crime is so small that it only carries a monetary fine, you have 6 months from the date of the offense to file a case. If you show up on day 181, you're too late. The court can't even look at your case.
Got it. 6 months for fine only. Tier 2, imprisonment for a term of 1 year or less.
For that category, the limitation is 1 year.
And Tier 3, imprisonment for a term of more than 1 year, but up to a maximum of 3 years.
The limitation period for that is 3 years.
So the pattern is 6 months, 1 year, 3 years. That's what you need to burn into your memory.
Exactly.
Yeah.
But here is the critical question that Successor would always ask his class at this point. What about a crime that's punishable with, say, 7 years in prison, or life imprisonment, or the death penalty?
It's not on the chart.
It's conspicuously missing, isn't it?
It is.
And that's the point. There is no limitation for serious crimes. You can prosecute a murder that happened 30 years ago.
Yeah.
You can bring a rape case 20 years after the fact. This chapter, this entire limitation clock, only applies to relatively minor offenses, those punishable with up to 3 years of imprisonment.
So for anything more serious than that, the clock never runs out.
The clock never even starts. That's a crucial distinction that trips up a lot of students.
The slide also mentions section 516, subsection 3. What happens if a person is charged with 2 different crimes from the same incident? Say, a minor offense with a 6-month limit and a more serious one with a 3-year limit.
The rule is simple. You always go with the more severe one. The slide says the limitation is determined by the offense with the most severe punishment. So in your example, the 3-year limitation period would apply to the entire case. The law doesn't want to split a single trial into different pieces with different deadlines.
That simplifies things. And I see a computation box at the bottom of the slide. It clarifies the relevant date. It says this is the date of filing the complaint or the date of recording the information.
Right, this tells you when the clock stops ticking. The limitation period ends on the day you officially file your complaint in court or the day the police record the FIR. Doesn't matter if the trial starts months later. As long as you got your foot in the courthouse door before the deadline, you are safe.
Okay, so we know the deadlines and we know when the clock stops. Now, section 517 tells us about the commencement of limitation. When does the clock start ticking?
The visual here is a timeline graphic with different colored arrows. The first one, a green arrow, points to the general rule, and that rule is simple. The clock starts on the date of the offense.
You stole my watch today. The 1-year clock starts ticking today.
Simple as that. But as you said, life isn't always that simple. What if I don't know my watch was stolen? I just think I misplaced it. Or I know it was stolen, but I have no idea who did it.
Right.
That's where the amber-yellow arrows on the graphic come in. This is for the tricky situations. Offense unknown or offender unknown.
Let's take case 1. Offense unknown. I think my property is just lost, but a week later I realize it was actually stolen.
In that situation, the clock starts on the first day. The offense comes to the knowledge of either the aggrieved person, that's you, or the police. And the key part is whichever is earlier.
Whichever is earlier. Okay. And case 2, offender unknown. I know my car was vandalized on Monday, but I don't find out who did it until Friday.
Same rule. The clock starts on the first day.
Right.
The identity of the offender is known to either the aggrieved person or the police. And again, it's whichever is earlier.
And there is a big red trap box on this slide. It shouts, "Trap, it is whichever is earlier, aggrieved person or police, not whichever is later."
This is a classic exam trap, and it's a real-life pitfall for many people. Students, and even some young lawyers, they often think, well, I only found out who did it today, so my 3-year clock starts today.
But that might be wrong.
It could be completely wrong. Because if the police identified the suspect 2 years ago and just didn't tell you, the clock has been ticking for those 2 years. The law expects the state machinery to coordinate. If the police know, then for the purpose of the limitation period, the state knows.
That is a very tricky point. And subsection 2 of 517 adds that the day from which the period is computed shall be excluded.
That's a standard principle of legal interpretation. If the crime happened on January 1st, we start counting day 1 on January 2nd. It just ensures you get the full benefit of the calendar days.
You know, under the guidance of Successor, we always tell you to look for the exceptions. So we've learned when the clock starts and stops. Now, section 518 is all about exclusion of time. When does the clock get paused? The slide even has little pause button icons.
Right. The law recognizes that sometimes a delay isn't your fault, and you shouldn't be penalized for it. There are 4 main situations where you can hit the pause button on the limitation clock.
Okay, what's the first one?
It's labeled wrong court. If you filed your case with due diligence and in good faith, but it turned out to be the wrong court, maybe you filed in the Delhi High Court when it should have been a district court, or you filed in Noida when the crime happened in Ghaziabad.
The time you spent litigating in that wrong court doesn't count against you.
Correct. As long as you were honest and diligent, that period is excluded.
Makes sense. The second pause button is for an injunction or stay.
This one is obvious. If a higher court issues an order saying, stop everything, freeze this case, then obviously the limitation clock has to freeze too. You exclude the entire period of the stay, plus the day it was issued and the day it was withdrawn. You can't be penalized for obeying a court order.
Okay, third reason. Notice or sanction.
We talked about this. Sometimes you need the government's permission to prosecute. Getting that sanction can take months, even years. Bureaucracy moves slowly. So the time required for obtaining that consent or sanction is paused.
And the green fact box on the slide adds a detail here. Date of application for sanction and date of receipt of order are both excluded.
Yeah, so the entire duration from the day you apply to the day you get the order back, that whole chunk of time is carved out of the limitation period.
And the fourth one is quite dramatic. Absconding.
This is pure common sense, but it's vital to have it written in the law. If the offender runs away from India, or if they are hiding within the country to avoid arrest, the limitation clock stops.
So a criminal can't just commit a crime with a 3-year limit, hide in a basement for 3 years and 1 day, and then pop out and shout, "Time's up, you can't catch me."
Nice try, but no. The law says the clock was paused the entire time you were hiding. You cannot benefit from your own act of evasion.
That seems fair. So that brings us to the last few sections on limitation, 519, 520, and 521. These deal with some special scenarios.
Right. Section 519 is very practical. It's about a court-closed situation. If your 3-year limitation period expires on a Sunday or a public holiday when the courthouse is locked, you don't lose your right. You can file your case on the very next day the court reopens.
Simple enough. What about Section 520, continuing offense? The visual here is a refresh or a loop icon.
This is a concept that often trips people up. For a continuing offense, the slide says, a fresh period of limitation begins to run at every moment of the time during which the offense continues.
Can you give us a clear example of that?
Abduction is the classic example. If I kidnap someone and hold them captive for 10 days, I am not just committing one crime on day 1. I am committing the crime of wrongful confinement on day 1, day 2, day 5, day 10.
So every second they're held.
A new limitation period starts. The clock doesn't just start from the moment I first grab them. It restarts every single moment until the crime stops, which is when they are finally released.
That's a huge concept. It prevents an absurd argument like, oh, I kidnapped him 4 years ago, so the 3-year limit is up, even while the victim is still locked in the basement.
Exactly. As long as the crime is actively happening, the limitation clock is constantly resetting.
And finally, the last one in this chapter, Section 521, extension, condonation. The slide has a yellow bell icon that says, exam alert. This must be the safety valve.
Is the ultimate safety valve. Section 521 gives the court discretion. It allows a judge to override all those strict bars and deadlines we just talked about in Section 516.
Under what conditions? The slide lists 2. 1, the delay must be properly explained.
And 2, extending the time must be necessary in the interests of justice.
So what's a proper explanation?
Suppose there were massive floods in the region and the courts were shut for a month, or the complainant was in a coma after an accident, or there was a national lockdown and nobody could leave their homes. These are valid, genuine reasons for delay.
So in those cases, even if the 6-month or 1-year limit has passed, the victim can go to the court.
Explain the situation, and the court can say, under Section 521, we find your explanation satisfactory, and in the interests of justice, we are condoning the delay and allowing your case to be filed. It ensures that rigid mathematics doesn't defeat real justice when life gets in the way.
Okay, that wraps up a very dense but crucial module on limitation. Now we're into the final stretch. Module 3, Miscellaneous Powers and Repeal. And first up is Section 523, dealing with the military and court-martial.
This is a procedural section, but it's important for understanding the different spheres of jurisdiction in India. The diagram on the slide lays out a very clear four-step process.
Let's walk through it. Step 1. Person subject to military naval air force law brought before magistrate. So a soldier gets arrested by the civilian police.
Step 2. He's charged with offense liable to be tried by court or court-martial. The crime is something the military justice system can also handle.
Step 3. The magistrate considers rules made by central government.
And the step 4 is the accusation.
And the action is, deliver him plus statement of offense to commanding officer of unit station.
That's the crux of it. The civilian magistrate's job is essentially to hand the soldier back to the military. The military has its own judicial system, the court-martial, and for most offenses, especially those related to service, they have the first right to try their own personnel.
So the magistrate is more of a facilitator in this case.
Exactly. They facilitate the transfer, they don't usurp the military's authority, and you can see the note on the magistrate's duty. If a commanding officer sends a written request, the magistrate must use their utmost endeavors to help find and secure an accused soldier. They act as an arm of the military justice system in that specific instance.
Okay, next slide deals with a very important topic. Judicial integrity and disqualifications. This covers sections 527, 528, and 529. The visual is a gavel with a big red prohibition sign over it.
This is all about keeping the courts and the people who run them clean and unbiased. Section 527 codifies a famous Latin maxim that every law student learns. Nemo judex in causa sua, which is no one should be a judge in their own cause. The slide says it clearly. No judge-magistrate shall try commit any case in which he is a party or personally interested. And you can't hear an appeal from your own judgment, obviously.
And the slide has a helpful explanation. Viewing the place of occurrence does not equal personally interested.
That's an important clarification. A judge can and often should visit the crime scene. It's called a site inspection, and it helps them understand the evidence. That doesn't make them biased. Personally interested means you have a financial stake in the outcome, or you're related to the victim or the accused.
That's a clear line. Then there's section 528. No practicing advocate shall sit as magistrate in that court or local jurisdiction.
You can't be a lawyer in the morning and a judge in the afternoon in the same courthouse.
Right.
That would be a massive conflict of interest. The lawyers arguing before you would be your colleagues or your rivals from the local bar association. It would completely destroy the appearance of impartiality.
And section 529, a public servant with duty to sell property cannot purchase or bid for it.
Again, this is Corruption 101. If the court orders a foreclosure auction, the court officer conducting that auction cannot secretly bid on the house and buy it for a low price. The law strictly forbids that kind of self-dealing.
But I do see a green exception box for section 527 about the judge being personally interested.
Yes, there's a small escape hatch. Permission of the appellate court can allow a judge to try such a case. It's very rare, but you can imagine a situation in a very small, remote district where a big local issue involves everyone, and every single judge has some minor, distant connection to it.
I see.
In that extreme case, the High Court might grant special permission and say, we recognize the minor conflict, but it's unavoidable in this circumstance, so you have our permission to proceed. It provides flexibility.
Now, this next slide is monumental. I think every lawyer listening will sit up for this one. High court powers inherent in superintendents.
This is the powerhouse section of the entire code in many ways.
Yeah.
We are talking about sections 530 and 531.
Let's start with section 530, the inherent powers. It says nothing in the code limits the High Court's power to make orders that are necessary to do one of three things.
1. Give effect to any order under this Sanhita. 2. Prevent abuse of the process of any court. And 3, the big one, otherwise to secure the ends of justice.
So what does this mean in practice?
This is the successor to the legendary Section 482 of the old Code of Criminal Procedure, the CRPC. Every single criminal lawyer in the country knew and used Section 482. It's how you filed petitions to quash a false FIR, to stop police harassment, or to correct a bizarre order from a lower court.
So that incredible power now resides in Section 530 of the Bnss.
Yes, it's the God mode for the High Court. When there's no specific rule in the 1,000-page law book that fits a unique, unjust situation, the High Court can invoke Section 530 and do whatever is necessary to secure justice. It's the ultimate safety net of the criminal justice system.
And what about Section 531, superintendents?
That's the High Court's administrative duty. It's their job to ensure the expeditious and proper disposal of cases by all the subordinate judges and magistrates. It's not just about judging appeals. It's about managing the entire system. It gives the High Court the power to tell a lower court, you have 500 cases pending for over 10 years. Report to me why and fix it.
The power to crack the whip, basically.
In a manner of speaking, yes, to ensure the wheels of justice don't grind to a halt.
Okay, from the highest powers to the most modern ones. Section 532 is next, titled The Digital Shift, Electronic Mode. And the icons say it all. A webcam, a digital folder, and a Wi-Fi signal.
This is the modernization that the Indian legal system has been waiting for decades. The headline on the slide is bold and unambiguous. All trials, inquiries, and proceedings under this code may be held in electronic mode.
And it's not just one or two things. The list of stages is comprehensive. Summons, warrant issuance, inquiry and examination, the trial itself, recording of evidence, even appellate proceedings.
Everything, from the very first digital summons to the final appeal heard over video conference. This is a massive revolutionary departure from the 1973 code, where everything was premised on physical paper and physical presence in a courtroom.
The fact box on the slide mentions it uses electronic communication or audio-video electronic means.
Think about the implications. A key witness no longer needs to travel 500 kilometers and waste 3 days to testify. They can do it via a secure video link. It solves so many logistical nightmares and has the potential to drastically speed up trials. It's about bringing the Indian judiciary firmly into the 21st century.
In our judiciary classes at Target for IQ, we focus heavily on these transitional provisions because this is where a lot of confusion can happen. So our last substantive slide is Section 533, Repeal and Savings.
This is the critical handover section. What happens to all the old cases? The headline is blunt. The Code of Criminal Procedure 1973 is hereby repealed. The old CRPC is gone. It's history.
But what about all the ongoing cases that were started under that old law? The slide has a very specific transition table to explain this. Let's take the first row, pending appeal, trial, investigation.
The rule for these is that they continue under the old code, 1973, as if the Bnss was never passed.
Why is that?
Because you can't change the rules of the game halfway through. Imagine you started a trial under one set of procedural rules. To suddenly switch to a new set would be chaotic and deeply unfair to both the prosecution and the defense. So anything that had already reached the investigation, trial, or appeal stage stays with the old law until it's finished.
Okay, that makes sense. But the second row seems to be the exception. Pending inquiry, Chapter 14th Old Code.
This is the curveball. If a case was at the pending inquiry stage, which is the phase before the trial formally starts, it moves over to the new Sanhita, Bnss.
And there's a big red trap box about this. It warns, pending inquiries under Chapter 14th are the exception. They move to the new Bnss, unlike pending trials which stay with the old code.
This is the point students mess up all the time in exams. Trial stays old. Inquiry becomes new. You have to keep that distinction razor sharp. The logic is that an inquiry is a pretrial determination. Since the main event, the trial, hasn't started yet, it's easier and more efficient to switch tracks to the new system at that early stage.
And the final row. Sanctions, forms, notifications issued under the old code.
They are all deemed made under Bnss. This is a practical saving clause. It means we don't have to reissue every government notification or reprint every single court form overnight. The old ones are carried over and are treated as if they were made under the new law, ensuring a smooth administrative transition.
We have reached our final slide, the final review and strategy. This is where we distill everything down. Let's recap the 4 pillars that Satyendra Sir identified from this entire block of sections.
Pillar number 1, curative. The big idea from sections 511 to 514. Errors don't kill cases unless a failure of justice occurs. Substance over form.
Number 2, limitation. This is section 516. The key is to memorize the numbers. 6 months, 1 year, 3 years. And of course, to remember that serious crimes have no time limit.
Pillar 3, modernization. That's the game changer in Section 532. Electronic trials, from start to finish, are now the standard, not the exception.
And finally, number 4, transition. This is the tricky section of 533. You have to know the crucial difference between a pending trial, which stays with the old code, and a pending inquiry, which moves to the new code.
And the final quote on that slide is probably the best piece of advice for any judiciary aspirant.
Trust the bare act language. Precision is key.
That's it. At the end of the day, don't just rely on summaries or guidebooks. Open the law. Read the actual section. Pay attention to the precise words the legislature used. Words like shall versus may, or earlier versus later. That is where the marks are in the exam, and more importantly, that is where the law actually lives.
This has been an incredibly detailed deep dive into the real nuts and bolts of the BNSS. It really shows how the law is this constantly evolving thing, trying to balance the need for strict, predictable rules with the ultimate goal of doing justice.
Absolutely. It's a system that's designed to work in the real world, even when the humans running it make small mistakes, as long as that core principle, substantive justice, is always protected.
Thank you so much for walking us through this with such clarity. And a huge thank you to the source material from Target for IQ and Successor for laying this out so logically for us to follow.
It was my pleasure. Keep studying and keep revising.
And to all of you listening, especially those of you with exams on the horizon, maybe just check that limitation table one more time before you call it a day. Until our next deep dive, keep questioning.
This lecture is presented by Target for IQ, mentored and guided by